everyone. Hello, towel friends on the Towel YouTube. My name is Grant Smith Ellis, and I am a towel. It's so great to see you today. I am feeling a little bit better. If you missed it yesterday, it was a roller coaster of towel emotions, ladies and gentlemen. As we began the day with the Karen Reed and John O'Keefe trial, we went into the Lindsey Gaetani and Aidan Kearney trial happening at the same time in Dedham District Court. Hank Brennan decimated the final ARCA witness to the point where Brennan didn't even need to put on his rebuttal case. The defense rested in the Reed case. We now have the charge conference this morning at 10 a.m., just 2 hours and 57 minutes from now, if you're counting. And then the Aidan Kearney case, after Lindsey Gaetani did masterfully on direct and cross, ladies and gentlemen, and this has to do with an RO violation from last year on 2/26/2024. That case is heading to trial. That case is heading to its culmination today. We could see a verdict in the Aidan TurtleBoy Kearney case today, ladies and gentlemen. Oh, goodness, I hope your towels are ready. Now, a few things we got to do. One, we had a request from the Super Towel Murder by Maestro to do an overview of the consciousness of guilt instruction that Hank Brennan's going to argue for today. Murder by Maestro, we are going to do that, but it is a complex and nuanced overview that involves citing to footnote 2 of the reporter's notes to the model jury instruction in Massachusetts for consciousness of guilt. So, we're going to wait for some of the towel friends to get in. We're going to start Murder by Maestro. Don't worry, we're going to start with 2 other things. And then as people get ready, I'm going to reset, and Murder by Maestro is going to become an excitable towel, and then we are going to talk about the consciousness of guilt instruction. Now, you might say, why not just do it now? Well, because then, and I have a lot of patience, but today we have 2.5 hours together, and if I do the consciousness of guilt instruction now, there will inevitably be 17 people at various times who come in between now and 10 a.m. Eastern and say, Grant, what's Hank Brennan going to argue for today during the consciousness of guilt portion of the charge conference? And then I will have to do an explication in a truncated form, and I will feel frustrated. So, Murder by Maestro, where they say anticipation is the root of catharsis. So, I made that up, but you can quote it, Murder by Maestro. Anticipation is the root of catharsis. Now, ladies and gentlemen, I would like to refocus us all and say hello to the towel friends on the YouTube, of course, but also I want to begin with our mock jury overview. If you hear your name on the following list for Jury 1 or Jury 2, please get ready tomorrow if you can be with us. I think what we're going to do is actually, to make this even more interesting, we're going to have deliberations in open court, ladies and gentlemen. I've decided we're not going to do some kind of convoluted presentation where we try to go send you off into a room. Nope. We are going to let the world witness your deliberations live. I'm going to put the chat up on the screen. You know what we're going to do? We're going to do something like this. Watch, I'll show you a little preview. I'm going to take the chat, right? I'm going to bring it down here, and I'm going to not full screen, but I'm going to make the chat the primary focus tomorrow, starting for deliberations. All you jurors whose names are about to be called, and if we have people who aren't here, you can sign up at the last minute. You are going to be assigned special tags. I don't know how I'm going to do it. You are going to be designated as jurors in the chat, okay? Maybe you'll have to do an edit to your username to put like jury 1, whatever. Both juries are going to deliberate simultaneously in the chat. Now, this means the job of the foreperson is going to be a little bit more complex, okay, ladies and gentlemen? Thank you so much, Phoebes. This means the foreperson, as the chat is going by, your job is going to be to sit there. You know who is on your jury, okay, forepersons? Your job is going to be to track as your various jurors vote. You can watch their deliberations, whatever, but your jurors, that's what we'll do. When you vote, I'm going to announce this during your charge tomorrow, jurors, after Judge Canoni gives her charge. When you vote, okay, you need to say at each time you vote, open parenthesis, either Jury 1 or Jury 2, and my vote on count 1, 2, and 3 is thus. Now, we're going to do this on the screen. Do you see what I mean? You all are going to be deliberating for the world to see our mock juries. Now, I need to list our mock juries, okay? So I'm going to list them for you. I'm going to put the names up on the screen at some point today. I just have to kind of get working on it. Here are the mock jurors, okay? This is Jury 1. I'm about to announce the four people as well, okay? I'm ready to make my decision. for the 4 people, okay, ladies and gentlemen? It was a tough decision. I thought really hard. It's not necessarily which one of you knows the case the best, which one of you is the most amicable or anything. It's just a general towel vibe, all right? I did not do it randomly. It's just a sense. So, jury 1, ladies and gentlemen, get excited. Here are the people on jury 1. Marie 623TX, Kim Courteau, Alicia B, Christina Towel, Eva Towel, and Brewski. Colleen Henry, we say howdy here. Rachel McIntyre, Irene Grillo, Rita P. from Canada, Ange Whittick, and Sarah L. Shenanigans. Drum roll, please. I understand, Kim. The announcement, I have made a decision for the 4-person, if they shall accept the charge of the first jury, is Ange Whittick. Ange Whittick, if you accept your charge, you don't have to really do anything other than just sit and chat tomorrow like you would do normally during deliberations and monitor the votes of your jurors. You, Ange Whittick, if you accept your appointment, have been appointed the 4-person of mock jury 1. Please, ladies and gentlemen, wait for Ange Whittick to make their decision, but if we have an acceptance, we shall all celebrate the appointment of Ange Whittick as 4-person, towel 4-person of mock jury 1. Now, ladies and gentlemen, our bailiff is Karen, and Karen shall protect all of the jurors and the 4-person. If there are any bears that try to attack them, Karen will take a stick and protect the jurors. Do you understand, ladies and gentlemen? So, Ange Whittick, we have put a motion. Well, it's not a motion. It's more of an executive towel decision on the floor. And if you accept, you shall be designated the towel 4-person of mock jury 1. So, yes, ladies and gentlemen, it is a glorious towel day. Put your celebration emojis in the chat. Ange Whittick has accepted the position of 4-person. Well, we're going to call this 4-towel, actually. So, you are the 4-towel, Ange Whittick. We are just making a slight adjustment. We are being very inclusive of all towels, and you are the 4-towel, okay? So, congratulations, Ange Whittick. You have been appointed the 4-towel of jury number 1. And if anyone asks you what is a 4-towel, you just explain to them you are a 4-towel. All right, wonderful, ladies and gentlemen. Oh no, Christina Towel, don't worry. You can still participate. You can just pop in chat and give your vote. You don't have to deliberate. It's okay. Ladies and gentlemen, congratulations to Ange Whittick. Alana, we decided we're going to do the deliberations in open court. I'm going to have the screen. I'm going to have the deliberations in the YouTube comments in real time. And Ange Whittick, who's 4-person, 4-towel for jury number 1, is going to keep track of their votes. Now, jury number 2. I've thought, listen, we have a lot of candidates in jury number 2 for 4-person, okay? We had a lot of candidates on jury number 1. Don't get me wrong, but 4-person, 4-towel number 2. Here comes the announcement. I'm going to read off the list. If you hear your name, remember you're on jury number 2. And don't worry if you are Towelette Dewdrops. We have a first alternate, which is Diana Natali, and Steph is also a potential alternate. The jury number 2, ladies and gentlemen. Def Otter, commander of the Towel Expeditionary Force in Europe. Tiger Lily Girl, Chastity, Artworks 2, Dewdrops, Jack D65, Sun-Eyed Girl, Luisa Ramirez, Curly Girly, POG 3909, Mandy Strong, and Z Travels. Now, ladies and gentlemen, this was a very difficult choice. I thought long and hard about it. It needed to be a person who was, and it's a vibe, right? Because all of you are very interested in the case. You're very informed, cogent, erudite towels. You, regardless as to your beliefs on guilt or whatnot, or what charge you feel most strongly about, you all are very insightful. But a 4-person has to be someone who, even though this is going to be a live deliberation in front of a lot of people with different chats going on, they have to be someone who, when a decision is made or when they're making a decision, is the type of person who would ruminate on it for weeks, even if it's a small thing, based on ethical principles. That's just my general summation of this vibe. And you all have elements of that in your soul. I'm not saying any one of you was better than another at this. But ladies and gentlemen, it is Def Otter. Ladies and gentlemen, if Def Otter accepts, they have been appointed 4-towel of jury number 2. Now that, I thought long and hard, ladies and gentlemen. It came to me in a burst of towel-based inspiration. And Def Otter shall, if they shall accept the honor, hello Val, if Def Otter shall accept the honor, that was deaf honor shall accept the honor. If deaf otter shall accept the towel honor, they have been accepted as appointed as four towel of jury number 2. So, ladies and gentlemen, it is a glorious day. Deaf Otter has accepted the role of four towel of jury number 2. Oh, ladies and gentlemen, it is a glorious towel day. It is a wonderful towel day. Towels around the world are rejoicing. We have designated our 2 four towels. It is Ann Dwittick for jury number 1 and Deaf Otter for jury number 2. And if you're just joining us, it's 7:30. We don't have court till 10 a.m. We have 2.5 special towel hours together, 2 hours and 17 minutes to be precise right now, as it's almost 7:45 a.m. here in Boston, Massachusetts on this Thursday, June 12th, 2025. Ladies and gentlemen, we're going to have dual coverage of the charge conference and the Karen Reed and John O'Keefe trial at 10 a.m. Then at about 11 a.m., the TurtleBoy Kearney case is going to come into session. What I think I'm going to do is actually summarize that for you. I'm not really sure what we're going to hear. I don't know if we're going to hear very much. It's Kearney's defense today. Maybe we'll listen to Paul O'Keefe if he gets called to the stand on direct. It'll be very interesting because Kearney's lawyer then can't ask leading questions. He has to ask open-ended questions. It's going to be a pretty bad day for Kearney. If a conviction will be incoming, we don't know. If we go to closing arguments in the Kearney trial today, whether the charge conference is going on or not, we're going over to closing arguments. It'll be quick, 5 to 10 minutes each side. Then the judge will render his verdict. If Kearney gets convicted, we are having a parade. We are making a float for Lindsey Gaetani. The float shall be towel-themed, and then we shall walk down the street saying, "We love Lindsey Gaetani." And you might be saying, Towel, is this just cover for you to get a lot of people to say they love Lindsey Gaetani and you can join in the chorus? Well, maybe, ladies and gentlemen, but that's what being a towel is all about, bearing one's soul and trying to be a towel. I don't know how, right, because the dueling hearing. So the conviction, ladies and gentlemen, if that verdict comes down today, whatever the case may be in the Aidan Kearney case, we'll be there to hear it live. And then furthermore, ladies and gentlemen and fellow towels, I'm going to say ladies and gentlemen a lot today as a sardonic mockery type thing. But also, we are going to take a look at the Karen Reed and John O'Keefe charge conference. And the reason why I was talking about that is Murder by Maestro wants to hear about the consciousness of guilt instruction and what Hank Brennan's going to be arguing today and why the Brian Lucky Lofgren testimony about TurtleBoy's article that came into the record while Lucky was on cross about Lucky kind of targeting Lucky, etc. The same day it ran on June 5th, 2023, which was the same day that Lucky met with Karen's defense investigators. And if you look at the standard under McCarthy from footnote 2 of the model jury instructions for consciousness of guilt in Massachusetts, you'll see, and I'm not a lawyer, this is not legal advice, I'm a towel. Get a lawyer if you have questions about the law. Get a towel if you want to prove unconditional love exists in a world defined by self-interest and greed. Now, ladies and gentlemen, let me rephrase. Okay, not rephrase, refocus. This is not legal advice, and I was saying that footnote 2 of the model jury instructions from the consciousness of guilt section related to, in particular, acts of a joint venture to prove a conspiracy. If you want to charge something like witness intimidation through consciousness of guilt as an instruction to the jury. What this means is, ladies and gentlemen, when tomorrow during the charge conference before deliberations after closings, or the charging of the jury after closings, Judge Cannoni is going to relay to the jurors the same thing we heard in the first trial, the elements of the offense, what are the different components, and then these different instructions. No jurors more superior than another. The questions by lawyers weren't evidence, except unless the witness says yes. And then there's one at the end about consciousness of guilt. Now, during the first Karen Reed and John O'Keefe trial, there was a motion for consciousness of guilt that it did not include witness intimidation that was denied. Now, Hank Brennan, I think, is going to win this motion because we'll talk about the enumerated precedent, but the way that it plays out is that under this case called McCarthy, and then there's another case which is called in the matter of a grand jury from 2001 in Middlesex County or something. Both of these cases enumerate a kind of specific standard if you want to make an argument for establishing that two people conspired in a joint venture to intimidate witnesses in order to win a consciousness of guilt instruction. Now, you don't actually need to charge the underlying witness intimidation. You don't need to charge Karen with witness intimidation or in the case, or Aidan with conspiracy with Karen. All you need to do is prove, and the standard, whether it's probable cause or preponderance, is a little up in the air, but it's not reasonable doubt. All you need to do is prove by a scintilla, I would say, of evidence that Aidan Kearney and Karen Reed took a deliberate step in furtherance of a joint venture to intimidate witnesses, any witness in the Reed case. And because Hank Brennan got that TurtleBoy article in from June 5th, 2023 about Lucky, and the evidence that that was the same day that Lucky met with defense investigators, he's going to argue he met the standard under McCarthy. There was at minimum a joint venture between Karen Reed and Aidan Kearney to torment witnesses in the case, and therefore Brennan should be permitted to get the consciousness of guilt instruction based on witness intimidation pursuant to the case law as enumerated and applied in this specific case because of Brennan on cross of Lucky getting Lucky to admit he knew about the TurtleBoy article by way of his friends and family, even though he didn't read it directly. So do you see what I mean? The evidentiary standard is you must get in the TurtleBoy article. It must have a connection or nexus to Karen Reed and her defense team. It was a brilliant tactical play by Hank Brennan. I'm sure you're going to hear him argue it today during the consciousness of guilt instruction. Get Lucky to admit his friends or family told him about the June 5th, 2023 TurtleBoy article tormenting Lucky. Then get Lucky to admit that that was the same day he met with Karen Reed's defense team, the investigator or the PI. Okay, that's more than enough foundation or nexus between the two camps. Okay, then you go into the consciousness of guilt argument and you say, listen, I have the witness intimidation factors met here under McCarthy. There was a joint venture. This was the same day Lucky read the article. This should be enough under McCarthy to be afford me the consciousness of guilt instruction pursuant to the witness intimidation. Now, it's bifurcated in a little bit in the sense because Brennan's also arguing for deletion of evidence consciousness of guilt instruction. Now, the consciousness of guilt instruction, we'll read it. As I told you, we're going to read it when more of the Towel friends kind of gather, and let's plan for like a little bit after 8 o'clock, maybe 8:25, okay? We'll do a review of the consciousness of guilt instruction. I will read you Hank Brennan's proposed consciousness of guilt instruction and his model jury instructions, which went in last week onto the docket. They're public. Then we'll talk a little bit about the reporter's notes to the model consciousness of guilt instruction and explicate the standard under McCarthy, which Judge Cannoni will use to determine if Hank Brennan will have met the evidentiary threshold pursuant to Lucky's cross and the TurtleBoy article coming in on the same day that Lucky met with defense investigators from the Reed team on 6/5/2023, whether or not Brennan's going to be able to tell the jury, or Judge Cannoni will be able to read this instruction to the jury. Now, if you're wondering what is a consciousness of guilt instruction, a consciousness of guilt instruction, basically, as I mentioned, when the jury is getting charged and told about the different elements of the offenses and the different things about evidence rules and whatnot, it's technically a limiting instruction. It's supposed to actually help the defendant. No defense attorneys ever invoke it. It's a tool for the prosecution to say, listen, this person did actions that demonstrated they had a consciousness of guilt about their own criminal liability for the incident in question. So it's normally like after the fact, someone did something like deleting evidence or fleeing or intimidating witnesses that indicates a consciousness of guilt. Now, there's 6 different options you can choose under a consciousness of guilt motion for an instruction. Brennan picked 2 of the 6. Witness intimidation and deletion of evidence. We just enumerated, I think, the argument for the witness intimidation and the legal standard, although this is not legal advice, is pursuant to the case McCarthy, which we'll talk about. You can find it in footnote 2 of the model reporter's notes on the model jury instruction for consciousness of guilt in Massachusetts. That standard, I think Brennan's going to win. I'm predicting a win for Hank Brennan, but that's the big thing we're watching today. The charge conference is pro forma. A lot of stuff, maybe a little bit of a curative instruction debate from Bob Alessi. He already lost that motion, though. So nothing really is going to get debated at the charge conference of substance other than the consciousness of guilt motion. We are not going to miss that consciousness of guilt argument. I don't care if the Kearney case is going on. If a verdict's being read, I don't care. We are listening. I'm sorry, I don't mean it that profanely. We will, of course, listen back to the verdict, but we have to listen to the consciousness of guilt argument because it is the whole kit and caboodle. Now, I think Hank Brennan's going to win on the witness intimidation component of the consciousness of guilt argument, but Brennan's also going to make a play for a second line in the consciousness of guilt argument, and these are independent arguments. You can get consciousness of guilt just on witness intimidation. You could get consciousness of guilt instruction just based on deletion of evidence, or you could get it based on both. So say Brennan wins the witness intimidation, consciousness of guilt component of the instruction. He'll then move on to his argument for deletion of the ring videos. 17 of 18 ring videos on John O'Keefe's system deleted between 12:37 a.m. and 5:08 a.m. on 1/29/2022, which was, of course, the exact time in the minutes following when Karen Reed, between 12:32:04 and 12:32:09, allegedly backed her car up while drunk with a BAC of between 0.14 to 0.28, which is 2 to 4 times the legal limit. And that's generous because the BAC analysis is actually shifted forward by 2 hours, so her real BAC was probably between 0.3 and 0.4, which is near the LD50, which would kill most humans. After Karen Reed allegedly backed that car up and then collided in a side swipe impact with John O'Keefe, causing him to fall to the ground, strike his head, the back of his head, which caused a skull fracture that radiated forward, inducing trauma in his brain and swelling in his eyes. John's phone stopped moving for the last time at 12:32 a.m. and 16 seconds, just as that backup event was recorded on Karen Reed's text stream data in her Lexus. And of course, folks, we know that this second trial was really so interesting because 2 of the 3 chips on Karen Reed's Lexus board, 6.4 gigs of crucial data, including the relevant backup event recorded on the text stream section of the chip, was not extracted by Karen Reed's expert Maggie Gaffney during the first trial, or discovered. How that happened, why the prosecution let a defense expert do a partial chip off and didn't realize it, nobody will ever know because Maggie Gaffney didn't get called. The defense rested. Hank Brennan's not calling rebuttal. But anyway, so Karen Reed, it's horrible, after 12:32 a.m. and 16 seconds, then leaves, allegedly, John O'Keefe on that lawn in a blizzard where he never moves again until after the next morning when he's discovered having succumbed and passed away as a result of those traumatic brain injuries, coupled with hypothermia, as indicated by reddening of John's pancreas, as testified to by the medical examiner. Now, ladies and gentlemen, it gets even more horrifying because, as I mentioned, the 17 deleted ring videos, Karen Reed drives from where she had allegedly struck John on the lawn, near the lawn of a home in Fairview Road in Canton, drives back to John's house in Canton on Meadows Ave. It takes about 5 to 6 minutes to get there. She connects to the Wi-Fi at John's house around 12:37, and then she's in John's house by about 12:38 to 12:40. Ladies and gentlemen, 17 ring videos go missing between 12:37 and 5:08 a.m. One ring video was left on John's system showing Karen very badly staging a backup into John's car as a form of preemptive reasonable doubt, in my opinion, to try to say that's where I broke my tail light, but that did not work. In any event, ladies and gentlemen, at 5:07 a.m., Karen Reed drives allegedly back to Fairview Road around 5, and there's evidence of this because at 5:08 a.m., she's on video leaving John's house in Meadows Ave. At 5:11 a.m., Karen's on video, which she has admitted, heading past towards Canton Center, where John and her were drinking that evening before Karen drove him over to that house on Fairview Road and allegedly struck John. Then, folks, at 5:18 a.m., Karen Reed is seen on video coming out of Canton Center over by the Purple Line station in Canton. Now, why is this so interesting? Well, if you follow that route, it actually would be Karen heading in the direction of Fairview Road. And at about 5:23 a.m., 5:21 a.m., Karen makes the call, connects to John's cell phone, and then at 5:23 a.m. leaves a voicemail screaming, "John, is that you?" Now, this is weird because Karen Reed then goes to pick up 2 witnesses at 5:35 a.m. on that snowy January morning of January 29, 2022. But the timeline of her picking up those witnesses is strange because it's 5:08 that she leaves John O'Keefe's house. And then to get to Jen McCabe's house, where she picks up Jen McCabe and Carrie Roberts, who were John's friends, who Karen didn't even have their number, by the way. She had to wake up John's niece and get John's niece to call Jen and Carrie because Karen didn't even know these women that well. But anyway, ladies and gentlemen, there's a 17-minute gap, okay, 5:08 to 5:35. It doesn't take 17 minutes to get to Jen McCabe's house, okay? It just doesn't. It's like 5 minutes, 4 to 5 minutes if you went right out of John's house, and like 11 to 15 minutes if you went the long way through Canton Center. It doesn't take 5 minutes. It doesn't take 17 minutes, okay, at all. Maybe 11 to 13 minutes the long way. So there's this 5-minute window there where Karen, I think, went back to Fairview Road before going to pick up Jen McCabe and Carrie Roberts. In any event, at about, I don't know, what is it, 5:35, Karen gets to Jen McCabe's house, and eventually Karen, Jen McCabe, and Carrie Roberts get into 2 different cars, okay? I think Karen was like drunk, so she didn't want to drive, so they drive Karen's Lexus and Jen McCabe's Ford Explorer back to John John O'Keefe's house. The women arrive there sometime after 5:35. There is video of this. Karen's Lexus gets parked in the driveway. Carrie Roberts' Ford Explorer's parked in the driveway. Carrie and Jen go inside John's house and are frantically looking around for him. Maybe he passed out on a couch. Maybe he's like sleeping somewhere he doesn't normally sleep in the house. They can't find him. During that time, Karen's not even looking for John. According to testimony, she's standing in a bedroom alone upstairs in John's room, or maybe her room, because John and Karen didn't share a room. Karen thought it was archaic. Anyway, she's standing up there alone in the dark doing nothing. But then Karen starts screaming, "We have to go back to Fairview. We have to go back to Fairview," the lawn where Karen allegedly had hit John, the street where the lawn was. And then Carrie Roberts, Jen McCabe, and Karen Reed get into Carrie's Ford Explorer. Carrie's driving, Jen McCabe's in the passenger seat, Karen is in the back seat. Okay, as they're driving over to Fairview Road, they get there a little past 6 a.m. Karen is frantically screaming the whole time, and somehow, in a blizzard, in the dark, she sees John O'Keefe's body on the side of the road, on the lawn, 7 to 10 feet from the side of the road, and then gets out of the car before the tree line of the home and runs over to John. Now, this is an indication that Karen had indeed gone back to Fairview Road and knew that's exactly where John was, because the women in the front seat of the car didn't see John's body or anything through a blizzard in the dark, but Karen somehow did. Reminder, it's January in Massachusetts and it's a blizzard. It's dark in Massachusetts in January until way after 6, and a blizzard makes it way worse. So Karen could not have seen that John's body, in my opinion, in those visibility conditions. Nonetheless, Karen then gets out of the car, runs over to John's body, straddles it, starts trying to do CPR and warm him up. I think she took her shirt off or something, because she's just panicking. And then Karen starts telling Jen McCabe to Google how long does it take to die in cold, and that's caught on audio recording from 2 different sources. Jen McCabe's 911 call at around 6:03, and then also Karen had called John's phone and left a voicemail that was running, so the recording around then catches Karen saying it to Jen as well. So Karen's frantic at the scene, and then Jen McCabe within a few minutes calls 911 at 6:03, and then the firefighters arrive and the police arrive right away, by 6:10. Now, here's what's interesting. Karen never called 911 at all. She called Jen, Carrie in a panic. She was saying she thought John was dead, but never called 911 herself. It wasn't until Jen called, Jen McCabe, John O'Keefe's dear friend, that 911 was called. So anyway, the first responders get there. Okay, it's a panic scene. Karen, Jen McCabe, Carrie Roberts running around. Well, Jen McCabe's calm, but Carrie Roberts is trying to help John. Karen's screaming. One of the firefighters, EMT Katie McLaughlin, testified that when she got to the scene sometime after 6 a.m., maybe after 6:10, she asked Karen some basic questions about John. Was he on medication? What's his name and date of birth? And then she asked Karen, did John suffer any trauma that would have caused him to be left on the lawn? Karen exclaimed, sua sponte, "I hit him. I hit him." Jen McCabe then said, "Karen, what are you saying? Stop saying that. You're going through a lot," tried to stop Karen. Karen was like, "No, I hit him." And then the EMT was just shocked. And then one of the Canton cops next to the EMT said, "What did you say?" And Karen said, "I hit him." And then the Canton cop called his sergeant, who came down to the scene. Now, to make this even more chaotic, what happened next was Karen Reed then goes to Carrie Roberts' car and gets on the phone with her parents. And then Karen hands the phone to Carrie Roberts, and Carrie Roberts talks to Karen's mom or dad, who says that Karen has medication in her purse that she can use with alcohol to take her life. So then Karen's parents call the police in Canton and have Karen sectioned. Now, whether Karen doing this and whether Karen's parents attempt where I left off was Karen's parents had her sectioned, okay? And I don't necessarily know if that effort to have Karen sectioned was to insulate her from questioning by the police or just as a result of them actually caring. Nonetheless, it ends up coming back to hurt Karen, because when Karen gets brought over in the ambulance to the hospital, one, she's asking the police how long, or the EMTs, how long does it take for someone to die in cold, which was just proving that she asked Jen and McCabe to Google that a little bit earlier. Then when Karen gets to the hospital, she gets processed. She's very combative. She doesn't, this is the same hospital where John O'Keefe is taken and pronounced dead, by the way, good Sam. Karen doesn't really want to give her blood, and she doesn't want to get into it, Johnny. Eventually at 9:03, maybe 9:06 a.m., Karen's blood is drawn. At 9:53 a.m., the blood results come back. Karen has a BAC of 0.093, which is over the legal limit of 0.08 at 9 a.m. the next morning. That allows the state police and the crime lab to do a retrograde BAC analysis indicating Karen's BAC at the time she allegedly struck John was 0.14 to 0.28. So Karen's parents' plan, although it may have insulated Karen from initial questioning by the police, along with Karen being smart enough to not bring the murder weapon back to the scene, alleged murder weapon, it also resulted in key evidence being collected against Karen. But here's where the last deleted ring video comes in. So Karen and her parents spend time at the hospital. Eventually, Karen's dad says, or her brother, one of them says that Karen collapses in her dad's arm at in the hospital, then composes herself and says, "Dad, he's dead. What's the plan?" Now, and then her brother was like, "Yeah, she doesn't get lost in the loss," like quoting some like true crime documentary or something. But anyway, Karen and her brother and dad, as part of that plan, I guess, and Karen's sister-in-law, Caitlin Bordeaux, who's Nathan Reed, her brother's wife, they all go, instead of, so you have to understand this map. Canton, if Boston is kind of up north, okay, about 20 miles south of Boston is Canton, at the juncture of 128 South and 24, okay, that's Route 24 South. That may be, a little past the 95 split. So that's where Canton is, okay? It's like 20 miles south of Boston, 10 kilometers, maybe 8 kilometers, whatever, 7 kilometers south of Boston. Now, 7 kilometers south of that is Brockton. So 20 more miles or so south of that is Brockton. I might be off on my kilometer to whatever, but conversion, it's probably more like 10 kilometers. But the point is, so now we're 40 miles south of Boston. That's where the hospital is, Good Sam. Now, Karen's parents live in Dighton, which is another 20 miles or another 10 kilometers south of Good Sam. For some reason, Karen and her dad and her brother and her sister-in-law go from Brockton north 20 miles back to Canton in a blizzard, when Karen's dad had just said he didn't feel comfortable driving earlier that morning to one of the police departments and tried to get a ride over to the scene where Karen was. They said no. Karen's dad then and her brother and her sister-in-law and Karen go back to John's house. Karen calls John's sister-in-law, Erin O'Keefe, John's brother Paul's wife, and says she wants to come over to comfort the kids. Well, Karen didn't really have a great relationship with especially John's niece, and the relationship was ending, and the niece had actually testified, I saw it firsthand happen, that she saw it just a few days before John died. Karen and John's relationship was breaking down. John had asked Karen to leave the home. She refused to go, ran upstairs and banged on the door of John's bedroom, and he wouldn't let her in. And so anyway, ladies and gentlemen, and Karen also admitted she was in an argument with John in the moments before he was allegedly struck. She said that to one of the firefighters or something like that. And she also said it during a documentary interview, which was used against her. We'll get to the Karen clips in a second. So Karen calls Erin O'Keefe, says she wants to visit the kids. They drive back north to Canton for some reason. Well, it's not. We'll see clearly why they come back to Canton in a few seconds. And when Karen and her family, her father, her brother, her sister-in-law get to Canton, it's around like 12:05 or something that afternoon, okay, 1/29/2022. Karen goes inside, doesn't really say anything to the family or the children, and her father and Karen go upstairs into John's room, which Karen did not sleep in. She had her own room in Canton. They go into John's room, and they spend 30 minutes there. Now, why is this interesting? Well, ladies and gentlemen, because Karen leaves with a bag. It looks like she collected her laptop or something. Who knows? You can see her bag full when she leaves. They leave the house without saying much of anything, okay? Although Karen claims that John's mom said to her, you'll see the Karen clip. Karen's like, John's mom said to me, it looks like he got hit by a car, like mocking John's mom. But John's mom, when she testified, Peggy O'Keefe, said she didn't say that to Karen in those moments at the O'Keefe house after 12 p.m. on 1/29/2022. Nonetheless, Karen and her family gather then into two cars, and this is why I think they went back to Canton. They get the murder weapon, alleged murder weapon, Karen's Lexus with the broken tail light. They get in the other cars. They have two cars now. now, and then they make a trip down to Dighton. Now that 40-mile or 20-kilometer trip from Canton to Dighton should normally take like 40 to 50 minutes. It took them like an hour and 50 minutes. That's how bad the roads were, okay? They got to Dighton at like 2:12 or something p.m. that day. Now here's why this is relevant. Guess what other ring video is missing from John's house? A video at 12:35 p.m. when Karen and her brother and her sister-in-law and her father pull out of John's driveway in those two cars. Two cars, ladies and gentlemen. Now, interestingly, when the state police arrived to serve a search warrant on Karen's phone and her car at 4:12 p.m. in Dighton, they find Karen in her living room. They allow her to be questioned in the presence of her dad. They find her on her laptop with her cell phone despondent, basically. Not despondent, disattached. Like she was, I believe they said she wasn't. She was just answering their questions. Now, what's also interesting is Karen Googled for a DUI lawyer that afternoon, ladies and gentlemen. That came out during the first trial. She made a Google search. It didn't come into evidence. It came out during a motion hearing. She made a Google search for DUI lawyer on that very afternoon, folks. And then the state, but her being on her computer, the reason that's relevant is it's very possible that Karen deleted those ring videos because Karen's niece and nephew testified Karen had access to John's ring system. Who knows how she did it? Who knows if the records are kept? Who knows if she Googled whether records are kept? But in a way that couldn't be tracked, like through incognito mode or something, whether she Googled that in incognito mode. Karen, I think, deleted those 18 ring videos. So Hank Brennan to wrap it all up, Hank Brennan has a bifurcated consciousness of guilt argument. Half of it is about the witness intimidation by way of Lucky Lofgren's Cross and the article about TurtleBoy that ran on the same, from TurtleBoy about Lucky, that ran on the same day, June 5th, 2023, that Lucky was meeting with the defense investigator for the Reed team. That's part one. And then part two is the deletion of the ring videos that I just explained. Murder by Maestro, are you content with my overview? Is that coherent and sufficient explication of was that a coherent and sufficient explication of the entire case and how Hank Brennan's argument during the charge conference today after 10 a.m. Eastern is going to be bifurcated based on as to the consciousness of guilt component based on witness intimidation and deletion of evidence. Does that make sense, everyone? Oh, good. People are pleased, and I think enough towel friends came in. If you're just tuning in, court in the John O'Keefe and Karen Reed retrial doesn't start until 10 a.m. today, but I somehow provided a very succinct overview of the case, and then Murder by Maestro wanted an explication of how the consciousness of guilt jury instruction plays into all of this, and then I tied that into the case overview, and that's the motion argument we'll hear at the charge conference outside the presence of the jury today in the Karen Reed and John O'Keefe trial, which of course is just a lead up to the 11 a.m. conclusion of the Aiden TurtleBoy Kearney and Lindsey Gaetani trial in Dedham District Court, where we could see a verdict today depending on how long the defense takes to put on its case. Oh, goodness. Well, so I'll show you how this works. Murder by Maestro. We're going to watch the Diana Natali interview next, but so many of you are here, and we did our full overview of the foundation of the consciousness of guilt. So you know what I want to do next? Let's actually look at what Hank Brennan has proposed as the language for the consciousness of guilt. I love Brewski, the Irish territorial acquisitionist. You can have Greenland, Brewski. You are a wonderful towel. Sometimes people are like, why do people tune into the stream and watch it? And then you get a moment of like that, and you're like, oh, I understand. Good morning. Yeah, Towel had his eyes closed for that. So I'm sorry if I missed some of your chats. Sometimes to relay that kind of complex information, I have to go into my mind map. It's like a computer in my head where I have all these folders with information. And I kind of like visualize. It's like a hybrid storyboard where I'm seeing everything I'm describing. I have a very vivid mental image of it. But then when I need specific times or blood alcohol content or witness testimony, there's like a picture-in-picture. Well, there's actually like 40 of them. And I can like look into folders of data and documents or play like a witness testimony. And I'm simultaneously playing it and listening to it in my memory. It's a little strange, but that's how I'm explaining it to you. Like I'm looking at it all happening in real time. And then there's these little picture-in-picture windows with like documents or witness testimony. But it's weird because the witness testimony is playing as I'm recalling this to explaining it to you and explaining it to you all. It's like I have multiple channels in my head that can play multiple different sources of audio simultaneously while reading documents. So I'm like, oh yes, like that was the testimony from Katie McLaughlin. Then the testimony plays in like a second, and I'm like, I remember what she said, and then I relay it to you. Or it'll be like, oh, and that was the blood alcohol content, and this was the doctor who said that the draw was at 9:06 a.m. and that the results came back at 9:53. Like, I hear the whole testimony in like a millisecond, and then I can just relay it to you verbatim. It's very cool. But yes, Brewski the Irish Settler, ladies and gentlemen. And we also are going to take a look at this beyond just Towel. Don't you love Towel's mind map, though? Towel has such a wonderful mind map. I think we should give Towel some kind of mind map medal. This man has a mind map. Also, folks, I have wonderful news. I managed to figure out, oh yes, I wanted to make sure the Twitter broadcast was still working. It is. I managed to figure out how to get us shirts. Are you ready for this, ladies and gentlemen? You're not going to believe it. You are going to lose your ever-loving Towel minds. I figured out a way to get us shirts. Yes, ladies and gentlemen, I'm going to show it to you in a second, but first I have to get the consciousness and guilt instruction, or Murder by Maestro will think I'm a little towel. And you might be saying, but yes, you are a little towel, and Murder by Maestro appreciates that. I know, but if I get distracted and start talking about Call Me Hank shirts before I show Murder by Maestro the text of the consciousness of guilt instruction, he will say I am a towel. Now, I know that for a lot of you, you are probably going to think to yourself, but Grant, that is a compliment. Murder by Maestro loves you. You are a towel. Well, I know that, but I need to actually bring up the consciousness of guilt instruction that Hank Brennan has proposed, and since I have a complete archive of every document ever uploaded in this case, I can do so relatively easily simply by going over to my wonderful handy-dandy little search bar. Did you know I'm Towel the Explorer? Yes, we're going to make a cartoon called The Brave Little Towels, and I'm going to be called Towel the Explorer. Oh, yes, my handy-dandy towel notebook, ladies and gentlemen. TurtleBoy, no TurtleBoying. Can that become a thing? Can we have a catchphrase that's TurtleBoy, no TurtleBoying? Stop TurtleBoying, TurtleBoy. Sir, what does TurtleBoying mean as a verb? I don't know. Ask Murder by Maestro. They are very good with words. They have an expansive English lexicon. They speak binary. They are 0001 years old in binary. Now, did you know consciousness of guilt is actually hard to spell? I have to use spell check every time I spell the word consciousness. I don't know why. It shouldn't be that hard, but I cannot spell it correctly. I was born and raised on spell check. I don't know what to do. You are doing towel-tastic, Deaf Otter. You know why? Because you're a super towel. Oh, goodness. No, Murder by Maestro is a binary-speaking anthropomorphic computer. That is the answer, ladies and gentlemen. They are clearly a computer. Hold on, I have to get the consciousness of guilt instruction. I'm getting distracted because I'm a little towel. I got it. Murder by Maestro. I found it. Oh, glory day, ladies and gentlemen. Celebrate with your towels. I am a towel. You are a towel. I have located the consciousness. This is what Hank Brennan's going to be doing today. This is what we're talking about, ladies and gentlemen, today. You want to see it come up on your towel screen? Oh, look at that. Who is an efficient towel? I am an efficient towel. And you might be saying to yourself, sir, you really are. How did you find Hank Brennan's proposed consciousness of guilt jury instruction in like 20 seconds? Well, yes, Deaf Otter, you are an otter. Okay? That's how we'll go with it. You are just an otter. Some of you I have anthropomorphized into things that you might not be in human life, so you are a male otter. Hello, Dark Side of the Moon. So this is the Commonwealth's instructions for jury This is the Commonwealth's request for jury instructions. We're going to go over all of these today. I really don't want to read 17 pages right now. I want to take a little break and play the Deanna and Natali interview. But so I guess we'll go over it. I'm a committed little towel. I'm committed to my... Actually, you know what? We're going to pause. Murder by Maestro. We are going to go over this consciousness of guilt instruction and all of the elements of the charges. But I got to play the Diana and Natali interview because I have some administrative towel things I must deal with. One of is I have to figure out if the Call Me Hank shirt is going to look good. You want to see a little preview? Well, first we'll look at a preview of the consciousness of guilt instruction. Okay, hold on. You see it? Hold on. It's coming. It's coming. Don't get too excited, little towels. There it is. Nope, that's not it. Nope. There it is. Consciousness of guilt. You have heard evidence suggesting that the defendant may have intentionally tried to destroy, conceal, or falsify evidence in this case, and may have intentionally attempted to harass and intimidate witnesses whom the defendant believed would testify against her. If the Commonwealth has proved that the defendant did, you may consider whether such actions indicate feelings of guilt by the defendant, and whether, in turn, such feelings of guilt might tend to show actual guilt on these charges. So that's part of it, but that's the big deal. Friday, Taylor. Friday, closing arguments, Taylor. Friday for closing arguments. Now, I want to watch this Deanna and Natali interview, though, because I have a few administrative towel tasks to go on. I'm trying to think. Should we do Karen clips or the Deanna interview? All right, hold on. We're going to put it to a towel poll. I am a Democratic towel. Not necessarily, I'm a Democratic Republican politically, but I believe in democracy. Karen clips or, hold on. Karen clips or towel being interviewed by Deanna, I think it's yesterday. Next, you choose. You're a towel. Okay. Deanna interview. Karen, this is not a push poll. You can pick either one. All right, go ahead. As soon as it gets to 30, ladies and gentlemen. So you got to be one of the first 30 voters. We have a live towel poll. Oh, goodness, we got a live one, ladies and gentlemen. The towel, oh, it's split. Oh, the Deanna interview is winning. Oh, this is going to be close. I might allow a little more than 30 votes, depending. All right, it's up to 10 votes. Oh, it's split. It is ferocious. Oh, the competition is absolutely ferocious. The Deanna interview is leading 53 to 47. Oh, my goodness, this is ferociously close. 54 to 46. The Deanna interview is taking the lead. 59 to 41. We're getting close to 30 votes. I'm going to close it, ladies and gentlemen. I'm going to close it after the next vote. Oh, it's closed. All right, let's see the results. Oh, goodness, ladies and gentlemen. You all were voting furiously. 53 to 46. Don't worry, you're going to get your Karen clips next. The Deanna interview is only 25 minutes, but it's really good. Yes, here we go, ladies and gentlemen. It's time to watch the Deanna interview. Murder by Maestro, you are a super towel. I know you were thoroughly thrilled with that explication of the consciousness of guilt instruction interwoven into a mosaic of towel beauty that was an explication of the John O'Keefe and Karen Reed retrial. I am some kind of well-rested, efficient super towel. Someone should get me a medal. I don't actually want a medal. I just want to be a towel. In fact, if I could just have a towel, I would consider that as good as a medal. Have you ever thought to yourself, I wake up in the morning and all I want to do is think about how if someone were to give me a towel, I would be happy. Think of how simple life would be, ladies and gentlemen, if all it took to bring about your eudaimonia or your summum bonum, the greatest good in the ancient Greek and Latin respectively, for your life would be to simply be in the presence of your warm, fluffy towels each day. Oh, how simple a life would be to be defined by just simply being around one's towel and finding happiness. Now, a lot of people will be utterly baffled and perplexed at that, but that's okay. We love baffling people. Ladies and gentlemen, if you can't baffle the public with very confusing meta-commentary that is designed as a hook to engender cogent public discourse, are you really living? Have you really lived up to Lord Reed's vision for the British Broadcasting Corporation if you are not doing that? Now, I would say nay, ladies and gentlemen. I may not be a horse, maybe one day, I am a towel, but I would say nay, you are not living. Now, hold on 1 second here, little towels. I'm going to bring up yesterday's stream for you, and we're going to watch the Deanna interview with Grant. It was really good. I'm a towel. I just have to play this for you so that you can understand how glorious it is when a man who thinks he's a towel gets interviewed by a brilliant human being who supports justice for John O'Keefe and also asks amazing questions. It pulls the very best out of towel even after 11 hours into a stream, and I think I have it pulled up for you now. So let me get this ready, and then I have to do some towel administrative things, and then I'll be back in 25 minutes. Hold on, little towels. Here it is. Where is it? Come on, stop being a little towel. It was date 32. I got it, little towels. There we go. Oh, sorry, I burped. Well, I burped because I'm a towel and my esophagus and airway penetrate into each other. Hello, 65CJ5. I'm a horse towel. That's true. Hello, Paul. Hello. Hello, Antron Hemingway. I love your username. I must promote you to the ranks of honorary towel. Enjoy your new standing among the blue wall of justice. Your towel friends are thrilled to have you with us. Now, let me just zoom in on this interview so we can make this all professional-like. I am so excited, ladies and gentlemen. I am so excited. Have you ever wanted to be a towel and watch Towel be interviewed by a brilliant human being? Well, yes, that is what I've always wanted to do with my life towel. How did you know? Can I please watch the interview? Yes, of course. All right, here we go. So let me just make this nice here. I'm going to expand this. Murder by Maestro, you're going to really like this interview. Hi, Paul. I'm a towel. Righty. I'm so excited for this. I loved this interview. Deanna is a brilliant interviewer. And Deanna has like 300,000 followers on Twitter, and I follow her coverage of the case. And then I did the interview, or she interviewed me, and I was like, yep, perfect. I understand why this person should have a excellent, large platform. They know how to ask good questions. All right, enough being I'm not being obsequious. I am respecting and complimenting my towel host. It was a towel... it was an interview of Towel by someone else on Towel Street. It was very meta.
Okay, cool. So I'm just going to introduce you real quick, and then we can. And you actually have been inside the courtroom, right?
Yes, and I should also let you know I'm still streaming live, so I know you're recording the interview too, but the Towel friends were very excited. So I have been in the courtroom for John O'Keefe's niece testimony. I'm excited to talk to you about it. But as a forewarning, yes, we are live. I know you are recording. The Towel friends were so excited I had to dual broadcast it.
Okay, cool. So I'm streaming. I'm on your live channel right now?
Yes, and they're all thrilled. They're waving at you, and they would like to let you know you are an honorary towel.
Oh, thank you so much. I'm so excited to be an honorary towel, and we'll get into that in just a minute with what that means. But hello, towel friends. It's good to see you. And now for my Shots Fired audience, we have a very special person here, a reporter, a journalist, a very good one at that, and honest, named Grant Smith Ellis. Grant Smith Ellis has been actually covering extensively this Karen Read trial. He's been inside the courtroom, which is a very unique vantage point. Not very many people have been able to get into the courtroom. And he's been doing these incredible streams every day. Love your coverage, love your snark, love your entertaining, just everything you say, everything when I watch this show. It's kind of almost feels like the Super Bowl. It feels like we're watching sports, and I love sports. I love football. And it sounds terrible because we're talking about a death here, but we're also talking about potentially justice. And I think that's what people are so revved up about, especially when we go to channels like yours who are covering this honestly. It's not we're excited about something that's entertaining. It's we're excited that I think we feel closer to justice being served in this John O'Keefe trial. John O'Keefe is the victim, but it's Karen Read that's on trial. And I'm hoping, we can talk about this in a minute, but I really think there's only a few people out there that are covering this in the way I think it should be covered. And you're one of them. Now, why is this? Before you got on, I was just telling the audience just how I've been so obsessed with this trial ever since I saw the Netflix show A Body in the Snow about a month ago. And I don't know why I've been so captivated by it, because I usually cover more political news, more things like Trump and Elon and just, other things that are more in the political world. But I think one of the reasons why is because for me, it feels like a giant IQ test for America. It feels like an IQ test. It feels like a sanity test. And it feels like if you are someone who can seriously believe that Karen Read, this horrible, heinous, unlikable woman, is innocent, there's something wrong with you, and I want to have hope in Americans that we can believe we actually can have common sense and see all the facts and understand she is guilty as sin. But what do you think? Why do you think this trial is so significant, and why has it captivated so many people?
Well, I think it really comes down to, and you nailed it, people want to be educated and informed. I believe that in my heart, but they want to be entertained. And whether you're a public service broadcaster, a broadcaster like us, or a news organization that's operating in traditional journalistic spheres, people want to be entertained. And it's unfortunate, but that is what catches the public eye. And in this case, we had a PR apparatus, the Karen Reed defense, that was well suited. It comes straight out of Hollywood to grab the attention of people who aren't willing or don't have the time to really dive into a case, but maybe pick on surface level details, attach themselves to a cause that gives their daily life meaning. But the reality is that's not how we try cases in the criminal justice system. And when the Karen Reed defense was stripped down of its theatrics by Judge Cannoni and the confirmed end of the federal probe into the investigation of John's death, you're exactly right. It's not that we are celebrating or treating this like a sports event. It is that the culmination of 3 years of defense PR nonsense was Hank Brennan being assigned to the case, the defense's narrative falling apart, and justice for John O'Keefe coming very quickly towards Karen in a way that's obvious every single day when you watch her on the Karen cam.
Exactly. And it's sad because this seems like this is a death of a beloved person and police officer, very respected in his community. And yet this whole thing has turned into the Karen Reed reality show. She thinks she's a Kardashian. This has become a total circus. Every day she's waving to the media, laughing, flirting with the camera. I have never seen a murder defendant so giddy before and so excited and eating up all this attention. Do you think that, like, the jury sees this? And do you think that they take this into account? I know you're just supposed to take the facts and the evidence into account when it comes to a trial like this, but how much do you think her behavior and her giddiness and all of her bizarre behavior, how much do you think that plays or is going to play with the jury's decisions?
Oh, I think you go right to the heart of it, which was the difference between the first trial and the retrial beyond the confirmed end of the federal probe was the Karen clips. Karen didn't testify. She's not testifying in the retrial. But those Karen clips from Hank Brennan, there was 26 of them. I know because I cataloged them all, synced them to the Karen cam, clipped them, combined them together, and then watched them like 3 times a day. And those 26 Karen clips, they're devastating. She basically confesses. One of them, she talks about Unetti saying she had criminal liability. One of them, she talks about glass being pulled out of John's nose. And, you know, I was just rewatching Hank Brennan's cross of the last ARCO witness, the last defense witness before the defense rested, and Hank Brennan was subtly reminding the jurors, not so subtly actually, subtly about those Karen clips throughout the testimony. Oh, Dr. Rentschler, didn't you hear the defendant's words about Karen pulling glass out of John's nose? Oh yes, I heard those. You know, it's not the clip again, but it's enough to remind them, and I'm excited to see which of Karen's own words from that ill-advised documentary during the first trial are going to be used against her in Hank Brennan's closing. I can see where this is going. I was in that courtroom. I know Hank Brennan has the jury in the palm of his hands. I know he forewent a rebuttal because he knows the jury wants this case to convict. I'm just waiting to see how he brings it home.
Okay, so that's what I was going to ask you. I have a million questions to ask you, but we don't have 5 hours. We have about a half hour. So one, how do you think overall this prosecutor, Hank Brennan, has been performing throughout this trial? And how well do you think, the jury trusts him? How well do you think he resonates with the jury? And we'll just kind of start from there.
Oh, so I think Hank Brennan is a difference maker. Hank Brennan is a former DA in Suffolk County, a former federal defense attorney, and I think a federal appellate attorney. So I don't know how much folks may know about the distinction between, first of all, a state trial attorney versus a federal trial attorney, and then the distinction between an appellate attorney and a trial attorney. To have all of those in one person is a very rare breed. You're talking Supreme Court justice level of intelligence.
He's so smart.
Oh yes, combined with the fact that he was Whitey Bulger's lawyer and intimately knew the corruption that went down under the DOJ during William Delahunt's time as Norfolk DA in the 90s, and was able to figure out that Karen Reed had a wink and a nod from the old liberal DOJ in Boston. I'm sure you'll love this. Josh Levy, who's now suing President Trump, by the way, a friend of my family, which upsets me. He shouldn't be suing President Trump. Suing President Trump, Josh Levy, Rachel Rollins, the disgraced former U.S. U.S. attorney who got booted out of office for launching a pretextual probe against the Suffolk DA, Kevin Hayden, to punish Hayden for beating a political opponent in a DA primary. Rollins had a record for it. The DOJ did something shady with Karen's lawyers. The ARCA testimony hints at it. Hank Brennan was the perfect man for this because he was the one who understood how the DOJ can be weaponized, and it was Leah Foley coming into office thanks to President Trump in January of 2025. That's the story no one realizes. That was the real difference maker, combined with Hank Brennan in this retrial.
Yeah, and honestly, I just am so impressed with Hank Brennan. The way that he just kind of surgically and very brilliantly elicits information out of each witness, and also to each witness or situation come up. He has turned multiple witnesses for the defense into his own witnesses, and very good witnesses, especially that Officer Deaver was just incredible. I mean, it's just brilliant how, and it seems like he just doesn't miss a thing. He's a fighter, and I think the defense underestimated him. You know, he's this guy that kind of seems nonchalant with glasses and everything, and I think that they, you know, with Jackson, he's so over the top, he's flashy, he's this LA lawyer, celebrity lawyer. I think they underestimated him, and I think a lot of people did. And then after a few weeks, I think it became obvious that, wow, Brennan is sharp, and he is incredible, and he thinks every little thing through. He does not let them get away with anything, and he's been brilliant this whole time. I am so impressed with him, and he's a sexy guy. At this point, you know, I think a lot of women are just like, oh my God, Brennan, he's so incredible because of how much he fights for justice for John O'Keefe and how good at it he is.
Yeah, you absolutely nailed it. I mean, first of all, I'm not too ashamed to say it. Hank Brennan has a lot of fans out there who like his socks, who like his swagger, who like his style. I'm not going to deny.
Man crush.
But I will also say that the element of surprise here is that Hank Brennan used to, like I was saying, practice in federal court. There's no cameras in federal court. So this defense really didn't know what they were up against. You know who did know what she was up against, though? That Dr. La Posada, who Hank Brennan clearly had a falling out with at some point. You can see how Hank Brennan psychologically profiles a witness. He doesn't just know the facts of the case and the overall schema and what's going on. He wants to bait that witness into having a meltdown and doing something like saying the BS word in front of the jury when Hank Brennan asks her about media coverage of why she was forced out as the medical examiner. That's his brilliance in a neat little package repeated over and over until the Karen Reed defense literally aged, I'd say 20 years in 60 days or something. You don't want to go up against Hank Brennan. I'm telling you, Hank Brennan, the world is his oyster at this point. This man is raw talent.
Okay, so you are in the courtroom. Do you look at their faces? Do you look at the jury's faces? And without getting into too much specifics, I don't want to dox the jurors or anything, but do you see, is there any difference noticeably about how they respond to Hank and how they've responded to like Alessi or Jackson or any of the defense attorneys when they speak? Can you see it on their faces at all? Can you give us anything?
Sure. So I had to pull out my special piece of paper from when I was in the courtroom for John O'Keefe's niece testimony. On the back of this piece of paper, there's 18 jurors. I'm only allowed to know their, or to remember their race and general age and such, no specific descriptors. There's 18 jurors. This is a very young jury. I'd say jurors are I'd say 18 of the jurors, so there's 18 of them. 14 are in their 20s or 30s. One juror is in his 60s or 70s. Another, that's a male, another juror I think is in his 50s. But for the most part, there's no one that's really an elderly person. And this, I was looking at my analytics on YouTube. This true crime genre, most of the people who watch it are older. So I think Hank Brennan was precise with who he allowed onto this jury through voir dire. And I noticed that there are some 20-year-olds. I'd say, let's see, there's probably 5 to 6 30-year-olds, 3 to 4 20-year-olds, and then the rest are 40-year-olds with then 1 to 2 people over 50. This is a very diverse jury. There's about 3 to 4 African-American people. There's a lot of, definitely 5 to 6 white people. There was a few Latina people that were female, and it's split evenly 9 to 9, male and female.
Good. Now, I'm a little concerned about, you said it's so young. That worries me a little bit because young people tend to be very social media influenced. And, really dominated by social media. It's their life. So it worries me, like, how could they not sneak a little bit of social media here and there? Or, I know it's against the rules heavily, but it worries me because they tend to be more heavily influenced by public opinion, and especially by kind of police corruption or that kind of narrative. And a woman is getting framed, a young, attractive woman. I don't think Karen Reed's attractive, but I feel like they might be more gullible and easily swayed and less likely to use logic. So why is that a good thing that they're so young, in your opinion?
So being in the courtroom, I'd say it's more than just the youthful nature. I think that is a very broad indicator of what Hank Brennan's strategy was. It's that this jury seems like they were obviously hand-selected by the prosecutor and the defense, but it seems like they're a very specific kind of jury. They were very attentive when I was in there for KF's testimony, the niece. They were hanging. I watched one juror when one of the Karen clips played before KF took the stand, open her jaw and gasp at one of the clips. And they actually eventually had to be told to stop doing that a few days later.
Because they're supposed to have like a poker face, right? The jurors?
Oh, yeah, and that's how I knew. This jury, even when I was in there 2 weeks ago, loathed Karen. They wouldn't look her in the eye. There was this dark atmosphere. Like the Hank Brennan atmosphere was calm, cool, collected. He was sitting in a windowsill with one leg up. The defense was just absolutely shook, very nervous, and the jurors just looked like every new Karen clip they saw made them loathe her more. So I think that's really the impression. It's not just that they're young, it's that the jury that got picked, and yeah, they might read social media, and that's the point I was going to get to. The jury that got picked was very attentive to detail. And if you're reading social media right now, I mean, the Free Karen Reed movement was pretty artificial. I think a lot of it was bought and paid for, not, literally.
I know, and I could see right through it, but maybe they can't. I worry that they can't, I hope that they can.
Oh, I totally get what you're saying. I just think the deluge of the FKR movement, the deluge of it, the artificial Overton window manipulation, the way it used to be so big is gone. So there's less FKR voices, more pro-justice for John O'Keefe voices. Therefore, the narrative is changing, and even limited social media exposure will only reinforce your belief in Karen's guilt. That's what I think the big difference has been.
Okay, I hope so. What do you think, if any, do you think it was a mistake, or how big of a mistake? Because up till this week, I would say Hank Brennan has been meticulous with everything. No oversights, just incredibly meticulous and organized. But there seems to be a little bit of mishaps this week, and I wasn't expecting that. One with that, the holes in the hooded sweatshirt incident. The others with this whole X-ray thing that just came out. And a third, he's not bringing any rebuttals, no Welcher on again. So I'm like disappointed and worried at the same time. Like, is Hank losing it? Did he like make some mistakes this week, and now he's trying to make up for it, or he thinks that he's lost the case? Or what is your opinion this week of these potential blunders on Hank's part, and if they affected the outcome potentially?
Sure.
Or were they blunders?
Sure. So to take it in backwards order, so I was talking about this on Towel Chat earlier. It's so interesting. The reason I think Hank Brennan chose to not go with rebuttal witnesses is the same reason why earlier, very towards the end of Rentschler's cross today, there was a point where Brennan said it was a tip-off. He said to Judge Cannoni, "I'll just rephrase this question rather than going to sidebar." And he was kind of a wink and a nod to the jury. He knows the jury wants the case. I think he senses they're ready to convict. 3 minutes later, the defense, showing that they don't really care what the jury wants anymore, they're just desperate, asked for a sidebar. It was Alan Jackson. That was sort of an embodiment. Now, taking your questions in reverse order. Regarding the X-ray, so I can understand, I don't know if this was a diagnostic X-ray versus something that was done at the scene, but my understanding was that it didn't get taken into consideration by the other experts because it wasn't where the injuries were located that were discernible on the various parts of the arm and the head. And then, because I think it was an X-ray of the hand or something. And then the going backwards, so the shirt moment was interesting. Yes, Hank Brennan went down a line of questioning about the holes in the shirt, but really, and then obviously the curative instruction came and jurors were told, no, that was from a crime scene tech. But really, the big takeaway, and Hank Brennan closed on it in his cross today with Dr. Rentschler basically, was there were big pieces of taillight in that shirt. And that's what Hank Brennan really wanted to leave with the jurors. So yes, you got to own up and say, hey, those holes weren't from the night in question. But that only gives you more credibility with the jury, in my opinion.
Okay, so you don't think he was trying to do something sleazy or underhanded or anything with these two?
No, I totally got the sense that he was going down, because there was a whole line of questioning about the holes in the shirt, whole line of questioning. So I got the sense he built it on his good faith assumption, which is why he asked for the curative instruction, that he thought those holes were from the night of. Now, you got a case with 711 items on the docket. Myself, I've read all of them, okay? I've followed this case for 36 months or so. And even something like that, I could see myself overlooking. You know every detail, you know the timeline, 12:32, 16, the last time John's phone moved, you know the movements from the waterfall to 34 Fairview, and then Karen going to John's house, and the trip back, and then going to Jen's house. You know it all, but you can easily overlook something like that. Think the holes came from the night in question, develop a line of questioning about it, and then get caught on it. It's not an intentional thing, and if anything, I think it really buttressed Hank's credibility with the jury when he got up there and allowed Alessi to hold it up like that and make it clear it was a mistake. It doesn't go to the key issue, was there tail light in the shirt, but it's an important issue when your credibility is at stake to own up to it, which Hank did. Okay,
and you think he did it in a way that landed with the jury?
Oh, yeah, sure, because he immediately circled them back to, okay, so yes, the holes not from the night in question, but the tail light in the shirt. Let's talk. There was tail light in the shirt, big pieces of tail light, and then today again he did that again with Dr. Welcher. So that was with the first witness from ARCA, Dr. Wolf, and then today with Dr. Rentschler, Hank comes in again, tail light in the shirt. That's the image he's leaving with the jury, that there was tail light in John's shirt. So they're not going to remember the holes. Okay. They're going to, in that being held up, they're going to remember the tail light in the shirt.
Okay. And how damaging do you think the testimony of the ARCA was? You know, when they kept going over the video of the dummy, and, Randy, rescue Randy and everything getting hit. But then they kept saying over and over that these injuries couldn't have happened. He couldn't have been hit by a car. But yet they kept playing that video over and over again, or Hank did. So he was leaving the jury with these images of, like, kind of probably how it actually happened, how Karen hit John O'Keefe with her car, but yet they were saying it didn't happen. I mean, what effect do you think that actually had with the jury? Do you think it just almost solidified in the net result? Do you think it helped the Commonwealth, or do you think it helped Karen's case?
Oh, I think it absolutely helped the Commonwealth's case, the more so than the defense. And I tend to agree with John DePetro, or believe John DePetro's reporting, the local journalist here in New England, who said that Bob Alessi was so furious about Karen Reed's decision to force the defense to play those videos in question that he refused to do the cross, or do the direct. And if that's true, I can see why. Because I'm in law school. I'm not a lawyer. I go to law school in New England Law, but in Boston. But I could see myself in that position where I'm like, listen, you want to, my client saying, I want to play these. You want to play videos with basically showing what probably happened to John. You want to reinforce for the jury that this happened with videos? You're out of your mind. I refuse to partake in this charade. I'm going to sit down and just sit there and fume. And that's what Bob Alessi basically did. And I fully believe that's exactly what happened, because those videos were antithetical to how you put on a defense. That's something the state shows during their case in chief. I was blown away they did it. I was happy they did it because it's going to lead to her conviction, but they never should have done it, and I can't believe it was allowed to happen. I think she drops off right here, so what we're going to do is jump forward.
Oh. Recording stopped.
So hold on. She comes back for the end of it, so let me just... Deanna is very an excellent interviewer, as you can see, so let's just watch the end of this. Oh no, I hit reload. 6:40. All right, give me 1 second, little towels. We're getting ready for the 10 a.m. start of the John O'Keefe and Karen Reed retrial. Karen clips are coming up next. Karen clips coming up next, little towels. You know you love Karen clips. I love Karen clips. My name is Grant Smith Ellis. Just past 8:45 a.m. Extra an hour and 15 minutes of towel time today, little towels. All right, we got Deanna right back up. Let's watch it. Oh, it looks like she's back. Hello. We'll wait for Deanna to just rejoin, and I will continue to sit here and be a towel. This is an interesting situation.
Recording in progress.
All right, she's joining. But yes.
Okay.
Hello, you're back.
I'm so sorry about that. I have a little one, a 3-year-old, and he pulled the plug out by accident and did something. Okay. Can you see me?
No, we don't have video from you, but I can hear you just fine.
Okay, cool. My video is going to be turning up in just a second. So, overall, so we were talking about how, the net gain, you think, the net result overall of the ARCA testimony is you think it ultimately helped, and you think the jury saw that it ultimately helped the, John O'Keefe's case, the Commonwealth's case, instead of Karen Reed.
Yeah, and I think that was the theme of the case. I think the defense, if you notice, they didn't call Richard Green. I call him stumbling, mumbling
right.
Richard Green, the debunked, the wrong Google search expert guy. They didn't call him because I think if you're the defense, you started to realize every witness you were calling, not just Kelly Devers, but everyone was turning into Hank Brennan's witness. And so ARCA was just the perfect summation of that sort of storyline in the trial, which was Hank Brennan found a way to make sure that ARCA's videos and their testimony and their sort of general shadiness and all of their weird behavior, their ham sandwiches, their violations of the sequester order, their wife's interest in Free Karen Reed Facebook groups, it all came out. Maybe it all didn't get into evidence, but Hank got what he needed. And then the best part was, of course, and this is what folks should be looking forward till tomorrow, you want to talk about turning a witness around. Brian Lucky Lofgren, the colorblind snowplow driver who crashed into a basketball apparatus, Hank Brennan's move on cross to introduce that TurtleBoy article was brilliant. Tomorrow is the charge conference at 10 a.m. Eastern, and there's no doubt in my mind that Hank Brennan's going to make his consciousness of guilt argument, which he's trying to get a consciousness of guilt instruction based on witness intimidation and deletion of evidence. Hank Brennan's going to stand up there and say, when Brian Lucky Lofgren was on the stand, I got him to admit that his family and friends said that they sent him this specific TurtleBoy article, which was published on June 5th, 2023, which was the day Lucky met with Reed's investigators. That satisfies the test under McCarthy, which means that Karen Reed can get the consciousness of guilt instruction on witness intimidation. Hank will then argue the same related to the deleted Ring videos. He might lose that, but he's winning the consciousness of guilt instruction on witness intimidation because he got that TurtleBoy article in through Lucky Lofgren, and I think the defense realized Hank's going to do this to us with every witness. Less is more. We have to stop.
Okay, got it. I would be very disappointed if he didn't bring that up in his closing argument. But do you think that it was a good move and not a mistake, and it was a strategic move that he's not going to call Welcher up again or do a rebuttal, that he's just going to go right to the closing arguments? You think that's a good move, a good sign overall?
Yeah, so Hank's in the courtroom, but my read of it is that he felt that this jury isn't just ready for the case, they're ready to convict. And so prolonging it at all might alienate it. And as a prosecutor, remember, you need 12. 12 of those 18 jurors are going to get selected by a random wooden box or something. They pull a little, like a bingo ball out of a wooden box in Norfolk Superior Court. And you can't alienate one of them. So if you got all 12, if you think you got it, just close it, bring it home, give them what they want, send them into deliberations, hope that it takes 1 to 2 days and they come back guilty on 2 of the 3 charges. That's how I'd be thinking.
Got it. And one of my last questions is, for me, she does not only does the evidence to me, make me believe that she obviously got wasted drunk, was jealous, mad, in a fit of rage, reversed her car, hit him, didn't realize how hard she hit him, drove off, and then realized what happened when she slept it off after a couple of hours and realized what happened. I mean, the facts are so obvious to me that she did this. And then everything she said afterwards in all the interviews that she said, and then acting the way she acts afterwards, that is not the way somebody who's not guilty acts. That's not the way how you would act if you truly lost your loving, the boyfriend that you loved, and then somebody else did it. I mean, common sense would tell you a gut feeling about how somebody would act in that situation that was innocent. And that is not Karen Reed, right? It is absolutely not. So common sense, how she's acting and behaving afterwards, plus her own words, plus all the evidence, I just don't see how they could not convict her. But then again, I look at social media and these stupid polls out there, and it looks like it's 75% saying not guilty somehow, 25% saying guilty. And it makes me wonder, are Americans really that stupid? And that's why I'm so invested in this, not only for justice for John O'Keefe, because God knows he deserves it. His poor mother and his family deserve to have Karen behind bars and be accountable for what she did. But also, it just kind of will help me restore a little bit of faith in Americans that they see what's going on here and they're smart enough and logical enough to do the right thing here and convict. So your thoughts, final thoughts, and then what are you really believing is going to happen with this conviction here?
Yep, and I'm right there with you. With my faith in my fellow Americans is so strong. I love this country so dearly, and I believe that when Karen Read is found guilty, what we're going to find is a lot of people come forward and saying, listen, I was scared to say I believe she was guilty because I thought, I'd get attacked by this mindless mob and whatnot. But the whole time I really believed it, and I can just breathe. The weight has been lifted off my shoulders, and that will redeem my faith in America. And I already have a lot of faith in America, but my fellow Americans, who I think were kind of bullied into being like, oh yes, free Karen Read, that's the popular thing to do. It's not high school. Think for yourself. That's what being an American's all about. And then furthermore, as to where I think this is going. So I feel murder 2 in Massachusetts, the third prong, does not require intent to kill. It just requires intent to do an underlying reckless act that a reasonably prudent person knew or should have known posed a strong and plain likelihood of death. The distinction between that and manslaughter, OUI manslaughter, is very negligible. One is recklessness plus a theory of the act, and then one is just recklessness. This jury, I think, is just going to say she committed OUI manslaughter and she left the scene. I don't see murder 2. I think she did commit murder 2, in my opinion, under the third prong, but that word murder just screams to people intent to kill. It's not what it means here. That's not what depraved heart malice murder is. But they're going to say OUI manslaughter and guilty, leaving the scene. I'd say 7 to 12 years, and she'll be out in 5. She should have taken that 18-month plea deal with the mandatory lifetime license disqualification for OUI manslaughter. Too late, Karen, you screwed up.
Yeah, wow. Unbelievable. But I would be so sad if she walked away innocent from this, because she needs to be held accountable with all her and her demon friends putting their, John O'Keefe's family and friends through this horrible nightmare and re-victimizing them over and over and over again. Their nonstop harassment. I hope TurtleBoy goes to jail also. God, he needs to be in prison too. What a psychopath. But just that whole lot of psychopaths, because they're all kind of the same type of people, I need them to get slapped in the face. I mean, I need them to have a big FU, case closed. Yes, these are the kind of people that we don't want and that need to learn a lesson, a hard lesson. Good will prevail. I do believe that. I think good will prevail. This will be kind of a story in that. Will good prevail? Will justice prevail? Will truth prevail? Or will, evil continue on here? And I do have faith in my fellow Americans too.
So well said. It was such an honor to be interviewed by you. And by the way, TurtleBoy is facing a verdict tomorrow in a district court case out of Dedham District Court involving the named victim, Lindsey Gaetani. He's got 14 more felony trials to come. Keep an eye on it. I'll be covering it, and I'm so grateful for this time. I had a wonderful interview. You know a lot about this case. You're out there doing good work, and God bless you for it.
Thank you so much. God bless you too, Towel. And last question too. Tell everybody again, or at least my audience, why you're called a towel. Why we're called towels again.
Oh, so back in January of 2024, this random YouTube account, when I was doing a motion hearing review or reading a document, said, Grant seems to call himself a towel. I wonder if that's his pronouns. And I said, you know what? That's it. I'm adopting an anthropomorphic towel as my pronoun. I identify as an anthropomorphic towel, and then it went from there. Now there's towels all over the world, 94 countries, towelettes, washcloths, etc. It's wonderful. One day, Hank Brenner will say the phrase, I am a towel, and then my life will be complete.
Awesome. All right. Well, bye towels, bye honorary towel. We really appreciate you. And we will stay tuned on Friday or Monday. Hopefully it's just a very quick deliberation and it's guilty.
Yeah. See you soon.
All right. All right. See.
Wasn't that great? Ladies and gentlemen, did you like the interview? By the way, yes, I do think Karen Read was offered a deal, 18-month plea deal. but it would have come with, ladies and gentlemen, a lifetime mandatory license disqualification for the OUI manslaughter, and that's why she turned it down. All right, towel friends, I'm so glad you liked the interview and the way that it ended. I thought it was so interesting, and of course we got a conclusion question about why I'm a towel. Oh, yes, I am a towel. Now, thank you so much for those who watched. I really enjoyed that. And Deanna is such an excellent interviewer. I was not kidding. I gave you a little preview. I was not being obsequious. I was not bloviating like Alan Jackson, the blowfish. The bluster of blowfish. Alan Jackson and his bluster of blowfishes, ladies and gentlemen, a.k.a. the Karen Reed defense that is in shambles. I was not being obsequious. Deanna is an excellent interviewer. That was a wonderful discussion. I thought it really did a good job highlighting a lot of the key points of the case. And as you can see, Towel likes to explicate a little bit. Towel goes on soliloquies. They're erudite, I believe, and relevant and factual, in my opinion. And they are tied to the evidentiary record. But when you're interviewing Towel, you get like 40 different threads in a single answer. So picking a question is very hard. And she was doing that live, Deanna. That was very, very impressive. Picking a question is hard because it's like, okay, there's so many things in there that you just said that I want to ask you about. Do I ask you a 6-part follow-up question or pick one question that kind of encapsulates what you were driving at? Deanna nailed it. Every single question. I was like, yes, that's what I want to talk about next. This is wonderful. 10 out of 10, towel approved. Deanna is an honorary super towel. Apparently, Deanna designated me an honorary towel. So that means Deanna is actually some kind of like pontifical towel, ladies and gentlemen. So there you go. No, also, I do think Hank Brennan, of course, can play videos during cross, just like during opening. Hank Brennan played videos that were not already in evidence. Openings and closings are not evidence. Closings are a little bit more limited in scope, but thank you so much, Jay Farmhouse. And now I am excited to go over with you all the consciousness of guilt instruction that Hank Brennan is proposing. And you might be saying, Towel, I have waited all my life just for the opportunity to look at the consciousness of guilt instruction that Hank Brennan is proposing. I know, me too. Ladies and gentlemen, great towels think alike. If you love consciousness of guilt instruction wording and the precedential implications of footnote 2 of the reporter's notes of the Massachusetts model jury instruction for consciousness of guilt, well, ladies and gentlemen, you came at the right time. My word. We should build a whole fan club. Can we have a fan club centered around the model jury instruction for consciousness of guilt, and in particular the reporter's notes and footnote 2? Now, one time, just as an aside here, I raised my hand in class. I raised my hand in class one time. And we were having a lecture. I think it was from a very excellent public defender. I forget what class it was in. Maybe advocacy, one of the criminal advocacy classes. And I raised my hand and I said, I am very interested in Odell, DiBenedetto, and I think that case is also called McCarthy. I'm very interested in Odell, DiBenedetto, and McCarthy motions, and I would like to ask you about how they interplayed in your motion to dismiss. That man, first of all, just started grinning and then was like, you are the first person I've ever heard say that. Well, you know what, ladies and gentlemen, if it's wrong to be interested in the progeny behind motions to dismiss in Massachusetts, in particular Odell, DiBenedetto, and McCarthy, then I don't want to be right, okay? Write it on my epitaph. Grant Smith Ellis was a towel who loved the progeny involved in DiBenedetto, McCarthy, and Odell motions to dismiss in criminal trials. We're not really sure why, but he found it hilarious, so that's why we're writing this sentence. I want my epitaph to say that. Oh, yes, Eva, I'm so glad you waited your whole life. All right, don't worry, I can zoom in even more. You know why? Because I'm a super towel, ladies and gentlemen. I am a man who thinks he's a towel. Yes, I am a man who thinks he's a towel. Oh, yep, there we go. Can I zoom in even more? Nope, that's too much zoom. No, too much zoom, ladies and gentlemen. You can't have too much zoom. Ladies and gentlemen, that is absolutely not appropriate. All right, so we're going to make this text very, very wide here. We have to read the consciousness of guilt instruction, and then we have to read the progeny involved in the consciousness of guilt instruction so we can preview the argument that's going to be made today. All right, so we're going to read this slowly here. Sorry about that 8 out of 8 on the bottom there. I can't make it go away. I'm a little towel. Why do you have to be there? We don't need that. I don't need that. You may go away. All right. Consciousness of guilt. You have heard, this is Hank Brennan's proposed final jury instruction. You have heard evidence suggesting that the defendant may have intentionally tried to destroy, conceal, or falsify evidence in this case, and may have intentionally attempted to harass and intimidate witnesses whom the defendant believed would testify against her. If the Commonwealth has proved that the defendant did, you may consider whether such actions indicate feelings of guilt by the defendant, and whether, in turn, such feelings of guilt might tend to show actual guilt on these charges. You are not required to draw such inferences, and you should not do so unless they appear to be reasonable in light of all of the circumstances of this case. If you decide that such inferences are reasonable, it will be up to you to decide how much importance to give them. You should always remember that there may be numerous reasons why an innocent person might do such things. Such conduct does not necessarily reflect feelings of guilt. Please also bear in mind that a person having feelings of guilt is not necessarily guilty in fact, for such feelings are sometimes found in innocent people. Finally, remember that standing alone, such evidence is never enough by itself to convict a person of a crime. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations along with all the other evidence. I caution you, in considering such evidence, that the defendant is not on trial for destruction of evidence, misleading a police investigation, or witness intimidation, and you are not to consider such evidence as a substitute for proof of guilt of the offense with the defendant is charged. You may use such evidence only for the purposes I have instructed. That is, whether it shows a consciousness of guilt for the crime charged. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations along with all the other evidence. So this is what Hank Brennan bought. What? I'm saying that the reason why Amber is, yes, there is. It's the luck. You can draw an inference. Okay, it's the lucky article, the lucky cross when Hank Brennan introduced the TurtleBoy article and got Lucky to admit that Lucky knew about the content of the article around the time of June 5th, 2023, and that was the same day he met with the defense investigators, and that's why Hank Brennan immediately moved for a sidebar after Lucky admitted to knowing that, and there was a lengthy sidebar because that was the evidentiary foundation for the consciousness of guilt motion pursuant to witness intimidation. QED. Write it in stone, ladies and gentlemen. Write it in stone. I'm telling you, it's not as high of an evidentiary standard as you think, and you know why? We're going to review it right now. I have to get you the model jury instructions for consciousness of guilt. So give a little towel a second. I have it here. Hold on. I have the model jury instructions. Where is the model jury instructions? How dare you? You don't understand. I am a towel. All right, model jury instructions. Oh, here's the, I got it. No, that's the absent witness one. Model jury instructions, Massachusetts, consciousness of guilt. I am a towel. I'm actually a towel. You don't understand. When I'm looking up legal documents, I am a towel. All right, here we go. I got what I needed. Oh, it opens in Microsoft Word. Why? No one likes Microsoft Word files. The standard is PDF. Do you not understand? I am a towel. All right, I got a backup plan. What we're going to do is I'm going to render this in Microsoft Word, and then I'm going to save it as a PDF. Now, I don't understand. This seems entirely perfunctory, and I wish the file was just a PDF. It should be a violation of all principles within domestic, international, and local law for any file to be uploaded on a government website that is not a PDF. And you might be saying to yourself, sir, I don't think the government thinks that much about this. What would stop bothering me? I don't think the government thinks that much about this. Why are you thinking so much about this? Well, do you understand, ladies and gentlemen, I have to now sit here and convert this file to a PDF when all I wanted to do was show it to you all. No, this is outrageous. I refuse to believe that this is possible. All right, there we go. I want to save it as a PDF. Don't you understand? I want to save as. I just want to change it to a PDF. There we go. And then I want to click the save button. Thank you so much. I am thrilled that you have figured out how to convert a simple file from doc to PDF computer. It's not your fault that the Massachusetts government is operating as if it were 1743. I don't think Word files or PDF files existed in 1743. Maybe they did. I'm not an expert in that kind of thing. All right, let's get rid of that. Thank you very much. We don't need to save. Thank you. I know you don't need to open the PDF. This is outrageous. This is a travesty. This is a mockery. It's a trebuchet mockery. All right, I got the file we need, ladies and gentlemen. I got the model consciousness of guilt instructions. We don't need it for the actual model. We need it, ladies and gentlemen, because it has very interesting reporter's notes at the end, which I want to use to explicate and predict what I think Judge Cannoni is going to analyze when Hank Brennan makes his argument during the charge conference today at the Karen Reed and John O'Keefe trial after 10 a.m. for his consciousness of guilt instruction. Now, the charge conference is going to take a little while because it is roughly 8 pages, I think, for each side, and they got to figure out how they're going to do each part of the instruction. Now, ladies and gentlemen, this is the model jury instruction for consciousness of guilt. I want you to look at it. I want you to come to know it. I want you to come to love it. We are going to learn all about this today because this is going to be the biggest moment of the John O'Keefe and Karen Reed retrial, and we want Hank Brennan to win. And when we want Hank Brennan to win, we do special towel analyses, and then we become erudite, informed, and explicated towels. Now, here we go. Let me make this text even larger. Watch this. I got a plan. Don't worry. You can go full screen, but I'm going to make it even larger for you there. Oh, goodness. That's too large. Oh, goodness. The ponies are not in the stables yet. We don't need to get that excited. All right. There we go. There we go, little towels. This is the model consciousness of guilt instruction. Now, we don't really need it for the model language. Do you know what we need it for? We are going to go down to footnote 2. You ready for this? Now we're gonna read the whole thing. Okay, it's a very important. It's on page 4. Okay. Oh goodness, we're gonna have to zoom in a little more. Hold on, little towels. Okay, more. No, that's too much. Well, okay. We're going a little overboard there. Hold on, I got a plan. I'm the towel man with a plan. All right, there we go. All right, thank you very much. And then that text is nice and legible now. Thank you very much. I appreciate your cooperation. I am a towel. All right, very good. There we go. All right, now give me 1 second. Just make this a little bit larger here. All right, and then here we go. Oh, that's not large enough. Oh, no. All right, we're going to have to zoom this in even more. Ladies and gentlemen, I have a plan. I am a towel. All right. So the reason why we're zooming in is because this is a very complex footnote, and this is the whole argument today. And you're going to see the case that comes up. It's called McCarthy. All right, here we go. What constitutes evidence of consciousness of guilt? The most common forms of consciousness of guilt evidence include flight or hiding to avoid apprehension, Commonwealth v. Roberts. This is not what we're looking at. Commonwealth v. Stewart, not what we're looking at. Commonwealth v. Smith, not what we're looking at. Delay in surrendering. Giving intentionally false statements to police after crime, we're not looking at that. False name or address, we're not looking at that. Threats or bribery of a witness, Commonwealth v. Sowell, Tony Mass at 584, CUS v. Pena, threat against witness made after witness has already testified, should not be allowed as consciousness of guilt, we're too late to effect trial, but we're not dealing with that. Commonwealth v. Stanton, inordinate interest in a crime, we're not dealing with that. Refusing to provide saliva, hair, or blood samples pursuant to a court order, not dealing with that. Or altering his appearance, we're not dealing with that. Actions by others. Okay, everybody, we need to pay very close attention to this section. It is second paragraph of the footnote 2 of the reporter's notes on the model consciousness of guilt instruction in Massachusetts. Generally, only a defendant's own statements or actions can institute consciousness of guilt, and the judge should not charge that the jury may infer a defendant's consciousness of guilt if they disbelieve the defendant's alibi witness. Not relevant. This is relevant. There is a limited exception to this general rule for acts of a joint venturer amounting to consciousness of guilt, which may be attributed to another joint venturer if the acts occurred during the course of a joint venture and in furtherance of it. Now, I realize, okay, that this sounds a little complicated. What is a joint venture? Okay, we have to look at a case. There's a number of important cases we're going to look at. The most interesting one is from 2011. It's called Elmazian from the Fifth Circuit. But for our purposes, okay, we want to look at Commonwealth v. Mahoney, okay? What does this mean? Acts of a joint venture amounting to consciousness of guilt may be attributed to another joint venture, which means Kearney's acts can be attributed to Karen related to the Lucky article if the acts occurred during the course of a joint venture and in furtherance of it. Now, we got to go to Commonwealth v. Mahoney, okay? We actually got to go take a look at this case. We would not be erudite, cogent little towels if we did not do so. So we go ahead and we pull up the case, and I really think this is what it's going to all come down to, Commonwealth v. Mahoney. So we go ahead and we bring up Commonwealth v. Mahoney. We're going to do an erudite little towel analysis of this. All right, hold on. I got to scroll in. I got to zoom in because I'm a little towel. Zoom more. Okay, can we zoom a little more? Okay, that seems to be a good amount of zoom, but now I need to go this way. All right, hold on. So give me 1 second, little towels, while I center this for you. We're going to examine the Commonwealth v. Mahoney standard. And you can see this was a case from, what was it, 1989. Yeah, I remember. And then there's some progeny after it. It's like a matter of the grand jury from a little later. But this is what we're going to read for now. Here we go. And I think we can actually zoom in even more on this. 1 second. Little towel is being a little towel. Oh goodness, this might actually work. I'm so excited. Okay, so let's hold on. Everybody, calm down. This is actually working. I didn't think I could zoom in this far. I'm an excitable towel. It's just I want you to be able to read the decision, and you won't be able to read it at that level of scroll out. But this level of scroll out, I think you'll be able to read it. It's going to be like very slow going. Hold on. All right, so this is what it says. A jury found the defendant guilty on a theory of a joint venture of breaking and entering in a building in the nighttime with intent to commit a felony and breaking and entering. We want to look at a reasonable juror, whether the crimes have been charged. The question as to the defendant's involvement as a joint venture is whether the Commonwealth has proved that the defendant was, 1, present at the scene of the crime with knowledge to intend to commit the crime, or by agreement was willing to help others if necessary. Hold on. And then on September 21st, 1986, at approximately 1 a.m., what we're looking for is the acts of a joint venture. So we're going specifically, acts of a joint venture. I found it. Okay. The judge did not err in his instruction on consciousness of guilt. The defendant's principal objection is that by a single reference... this is perfect. The defendant's principal objection is that by a single reference at the beginning on his charge of consciousness of guilt, the judge permitted the jury to consider as evidence of the defendant's consciousness of guilt the fact that the defendant's husband was found crouched down in the vehicle that the police stopped shortly after 6:30 a.m. on Route 2. So it's the defendant's husband's acts being attributed to the defendant, in this case, Commonwealth v. Mahoney. The balance of the charge on consciousness of guilt faithfully confirmed to the requirements of Commonwealth v. Tony, 385 Mass. 575, 1982. Certainly, a charge on consciousness of guilt was warranted because of specific conduct of the defendant herself. The defendant objected to the charge as given. Acts of a joint venture amounting to consciousness of guilt may be attributed to another joint venture if the acts occurred during the course of a joint venture and in furtherance of it. And we have to go back to the progeny from Commonwealth v. Andrews there, Commonwealth v. Pringle, and the judge did not explain this principle to the jury, nor was he asked to do so. Here, the husband's act of hiding tended to prove that he broke into the Great Road Pharmacy, an event material to the proof of the defendant's guilt. On the other hand, the evidence was not relevant to the question whether the defendant had the requisite knowledge and intention before the break-in to justify your conviction on a joint venture theory. Although it would have been better if the judge either had not focused on the husband's conduct in discussing consciousness of guilt or had explained more fully the limited extent to which the husband's conduct in the vehicle bore on the defendant's guilt, reviewing the charge on the whole, we find no reversible error. So that's the summary, folks. Like, you don't need an underlying criminal charge. You can have just an act of someone around while you're doing something. Now, we need to look at Commonwealth v. Pringle or Commonwealth v. Andrews, which probably incorporates Pringle by reference. And we'll get a little bit more of an updated explication. We'll really dive in on this. This is how law works. I'm not a lawyer, but you can see how we really focus in, where we go precedent to precedent to precedent. We focus on this narrow issue, and then it becomes, okay, why is that the standard in the modern day? Where did the standard evolve from? How do we trace the lineage of the case law? It's why cases are written like this. It's why you have to write legal opinions like this. You better know how to do this if you're going to be a lawyer or any type of person involved with the judicial system, because you have to leave a record. Like, people are like, why are you doing this? Why do you write this way, you lawyers? It's so weird. And it's because of this. It's because even though this was written in 1989, I think this case, Mahoney, we're reading, I need to be able to take it and then go back and find Commonwealth v. Andrews, and then I need to be able to show it to you. Do you see what I mean? And that's why they write the way they do. So we're going to take a look at the progeny in Andrews. Let's just take a look at how this worked. And I want to take a look in particular, and we're going to really trace this back, because I also wrote a paper on this that's very interesting that I want to read for you, that has to do with the joint venture theory. But let's read Commonwealth v. Andrews first, okay? So this was the retrial after a mistrial caused by jury inability to reach a verdict, and it wasn't barred by double jeopardy. Prejudice, so we're looking for the joint venture. Joint venture. Okay, hold on. So then we do Control F, joint. This is like a 6-part appellate opinion. We do, nope, what do you mean? Control F, joint venture. All right, so there we go. At a murder trial, sufficient evidence was presented of 3 individuals continuing joint venture to conceal the killing, so that the evidence of one joint venture's flight and use of a false name was admissible against the other. So it doesn't even matter. This was 2 charged defendants. The defendants acknowledge, so we know this is a false name in flight. But if there was a joint venture during the course of a joint venture, the judge so charged. Thus, if the jury had some basis to find, oh, this is where the model jury instruction comes from. Oh, this is wonderful, ladies and gentlemen. This is the exact wording. Oh, I am such a happy towel. You don't understand. I love moments like this. It's like when you figure out where everything came from and it all makes sense in the context of putting together the reporter's notes and why the language of the model jury instruction looks the way it does. Oh, ladies and gentlemen, Commonwealth v. Andrews, I am a happy towel. I don't think there's anyone who gets quite so excited about explicating case law precedent as Little Towel. If the jury had some basis to find that there was a continuing joint venture to conceal the shootings, then Ferroli's flight and use of false name were admissible as evidence against the defendant herein. And we cite to Pringle for that. So we're going to take a look at Pringle as well. It's so nice that this has interline text citation. The defendants argue, citing Pringle, that their mere presence in the same location at the time of the arrest was an insufficient basis for the jury to find continuing joint venture to conceal the shootings. In Pringle, it was held that the mere presence of both defendants at the time of the arrest could not establish a joint venture, so just presence isn't enough. And therefore, one defendant's use of a false name was admitted improperly against the other defendant. Pringle is distinguishable from the case before us, however, because there is additional evidence in this case from which the jury could infer that the defendants did have a joint venture to conceal the shootings. The evidence as to the sequence of arrests was not clear. It is inferable that Ferroli's flight did not precede the arrest of Andrews and Comier, and that thus it was for the jury to determine whether the joint enterprise was still in effect. The judge in his charge properly left the question to the jurors. The jury could have found that Ferroli's actions were committed during the course of a joint venture. The judge's instructions in charge concerning former co-defendant Ferroli were not in error. See Commonwealth v. Griffin. So we got 2 more cases. We got to look at Pringle. Here it seems like mere presence wasn't enough. But let's see if we get some explication in Pringle on what exactly a joint venture is. Remember, a joint venture is not a conspiracy. It's a lower standard. The Commonwealth contends that, and this is Commonwealth v. Pringle we're reading, the Commonwealth contends that the defendant participated in the crime as a joint venture by acting as a lookout while Gaines attempted to break into the cash register. The defendant contends, however, that his actions did not rise to the level of participation required of a joint venture. Oh, tell me all about this. There is no question that a person who acts as a lookout while others are engaged in a criminal enterprise can be convicted on a joint enterprise theory. Commonwealth v. Saez, and cases cited. However, in order to prevail on a motion for a required finding of not guilty, you can't rely merely on evidence that places them at the scene. All right, so we're going to Commonwealth v. Saez. We're really diving into this, ladies and gentlemen. I wonder if this is what Judge Cannoni was reading overnight. At the trial of an indictment, no, we want just the word joint venture, please. Okay, here we go. The Commonwealth contends that the defendant participated in the crime as a joint venturer by acting as a lookout while Gonzalez had H in his possession with the intent to distribute. The defendant argues that his actions did not rise to the level of participation as required of a joint venturer, and also that the evidence did not show that he had any possessory interest in the H. It is clear that a person who acts as a lookout while others are engaged in a criminal enterprise can be convicted on a joint enterprise theory. Commonwealth v. Conroy, Supered 755. Commonwealth v. Pope, Supered 509-511. A reading of the lookout cases discloses that in order for the Commonwealth To withstand a motion for a required finding of not guilty, it cannot rely on evidence that merely places the defendant at the scene of the crime and shows him to be in association with the principals. Rather, the Commonwealth must present additional evidence which implicates the defendant in the crime. See Commonwealth v. Conroy, defendant gave false statements to police. Commonwealth v. Drew, defendant had knowledge that robberies were to be committed. Commonwealth v. Gallagher, same. Commonwealth v. Armal, defendant fled the scene. Commonwealth v. Pope, defendant gave false name. Commonwealth v. Murphy, no evidence offered except the defendant was present at the crime. As the basis for its contention that the defendant was part of a joint enterprise, the Commonwealth relies on the evidence showing that the defendant looked up and down King Street on 2 separate occasions. The Commonwealth claims that the jury could infer from those 2 physical acts that it was the defendant's job to act as a lookout. The problem here, however, is that the evidence presented was notable for its lack of detail. The lack of that lack is a serious weakness in a case such as this one, where the Commonwealth attempts to prove the defendant's guilt by evidence of commonplace actions of looking up and down the street. A little bit different than we're talking about, but I get the usefulness of that. That's actually where the 5 witness intimidation comes later, but that's where the 5 conditions of that's where the model jury instruction on consciousness of guilt comes from. It's, what is this? I don't think this is Andrews. We were really deep in it. This is Saez. Yeah, Commonwealth v. Saez from 85 into 86. That's where it really comes from. And let's take a look at Griffin v. Commonwealth. I just want one more overview of the joint venture, because that's really going to be the standard that I think Judge Cannoni is going to dive into. At a criminal trial, the admission of evidence of statements of one joint venturer made after the crimes had been committed presented no substantial risk of a miscarriage of justice with respect to the other joint venturer, where the judge gave appropriate limiting instructions to the jury at the time the statements were admitted, and where he correctly instructed them in his final charge that the declarations of one joint venturer could be considered the declarations of another only if they were made during the commission of a crime and in furtherance of it. A little bit different than what we're talking about here. The judge, so little bit different, but similar concept to what we're looking at. It has a basis in joint venture. It was the Commonwealth's theory at trial that the defendants were engaged in a joint venture at the time the crimes were committed. The issue of culpability of the defendants under the concept of a joint venture has been frequently discussed by appellate courts. One who aids, commands, I found the standard. Oh, God bless America. What? This is it. This is what Brendan has to meet, and it's Commonwealth v. Soares from 79, S-O-A-R-E-S. One who aids, commands, counsels, or encourages commission of a crime while sharing with the principal the mental state required for the crime is guilty as a principal. Now, we're talking about a lower threshold than reasonable doubt, but if you think about the way we enumerated joint venture, it's more like a preponderance, maybe like probable cause standard. This is the standard. If Karen Reed aided, commanded, counseled, or encouraged commissions of a crime, it doesn't matter if she's charged with it or Aiden's charged with this specific Lucky incident, while sharing with Aiden the mental state required for the underlying crime, is guilty as a principal. Now, change the phrase guilty there to subject to liability for a consciousness of guilt instruction pursuant to witness intimidation as a joint venturer, and that is what's going to get Hank Brennan this instruction. I know it. I just sense it. I'm reading it, ladies and gentlemen. We had to do 7 cases deep to get to this case. You understand, my dear towel friends? And it was hiding. It hid from us. It's Commonwealth v. Griffin from 84 and 85. It hid deep down, ladies and gentlemen. We had to control F joint venture. And what did we find? Oh, we hit the jackpot. Oh, check it off, ladies and gentlemen. Towel jackpot. Oh my word, I am the most excitable shepherdizing towel you can imagine. I am a shepherdizing towel magician. Hank Brennan's a magician in the courtroom. You can call him Hank. I am a towel magician when it comes to clicking through obscure case law to find the gold. I did it. I am a towel. Yes, Ange Whittick, thank you for that reminder. It's very important. Hello, Harvard Yard. What am I highlighting? I am struggling, ladies and gentlemen. You don't understand. We're doing a complex, juridical, precedential, shepherdizing-based analysis of what's going to happen during the charge conference at the top of the hour. Ladies and gentlemen, the Karen Reed and John O'Keefe retrial is going to come down to this obscure case, or at least part of the argument related to the consciousness of guilt instruction by way of witness intimidation is going to come down to the very complex series of precedential interpretations applications we just explicated or shepherdized dating back to like 1984. It took us 6 cases. We had to read very closely. We had to really dive into it. I hope this was a fundamental and insightful lesson for you all in how to trace back in an IRAC form, issue, rule, application, conclusion, while using Control F, very specific sections of cases, pulling out the parts of the ruling that we need, siphoning out the noise, distinguishing the cases in real time from the case we're thinking about. What's relevant? What's not? How are we building the standard? How is the timeline evolving? How is the precedent building on itself and complementing itself? All right, I got to take this call. One sec. Hello, little towels. I'm so sorry. That was my dear aunt. She is amazing. All right. Hello. I'm back. Okay. So we got to watch Karen clips. That was a wonderful explication. I just have to do one little thing. We're doing Karen clips. Everybody relax. I really think Hank Brennan's going to win this consciousness of guilt instruction. Did everyone enjoy that overview? We really dove into it. I'm going to read you my joint venture paper as well coming up. But just please, ladies and gentlemen, I would like to watch the Karen clips because I love Karen clips. The world loves Karen clips. Oh yes, the world loves Karen clips. So one second. The world loves. I love Karen clips. The world loves Karen clips. Say that 5 times fast. All right, here we go. The latest Karen clip compilation for the little towels. Here it is. Here it is, ladies and gentlemen. Wait, where's the? No, I need the 20. Karen clips. I need the 26 clip. There's been 26 clips played. What better way, ladies and gentlemen, to get us ready for the towel day than to watch Karen clips? All right, my name is Grant Smith Ellis. I am a little towel. Let me get this ready. Hold on. Don't worry. Hold your towel friend's hands. I have frozen. It actually saves a lot of computer resources when I do that, so... All right, here it is. I got the Karen clips, ladies and gentlemen. I got them ready for you. I know you're excited. I'm an excitable towel. All right, now let me just do this one thing. Get ready. Enjoy.
Play clip 26.
So... I thought, could I have run him over? Did he try to get me as I was leaving and I didn't know it? I mean, I've always got the music blasting. It's snowing. I got the wipers going, the heater blasting. Did he come and hit the back of my car and I hit him in the knee and he was drunk and passed out and asphyxiated or something? And then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if, I don't know, what if I ran his foot over or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out and David said, yeah, then you have some element of culpability.
Exhibit 207.
Your Honor, the Commonwealth rests.
Karen, what can we expect from the defense? Will you testify?
TBD.
How long will your case last?
1.5 to 2 weeks.
How are you feeling after today?
I feel very good, thank you.
So we approach from the north, we actually missed the turn, and John says to me, it's fair we just
Like the next play, clip 25.
At 12:41, I leave a voicemail to John. You can clearly, and this will probably be played on Monday, you can clearly hear me pull into John's garage. You can hear my car sensors beeping as I come close to the sides of the garage truck. And then you hear the car go off, and then you hear the sled ding, ding, ding as I open the door, shut the door. I had high heels on that night. You hear me walk in, go into the stairs up into the kitchen, shut the door. You hear me walk in the kitchen. It's like a full minute long. That's at 12:41.
And finally, clip 24.
I do. I mean, I'll tell you, John and I argued the morning of the 28th, Friday morning. So we think he died right around 12:25, 12:30 on the early morning of January 29th.
Thank you.
Hey, very good. How are y'all? Any reaction to the clips, Karen, that are being played?
No.
So John's laying there, his left and his right, and I approach John from the left. That's where the street is. And he had a piece of glass, like, perched on his nose, like, just wedged like a splinter would be. And I just pulled it, and as soon as I pulled it, it just gushed blood down his face. Totally more than Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
There's any window here that you guys have really been going at it. This was sort of had like a last date element to it. Was that going on?
That was not going on. John made it clear to me, I'm never breaking up with you. You know, not never that we're in this good or bad, but you're the best person I've ever.
The Commonwealth would ask to show clip 19.
Okay.
I don't see how John would have known about my text with Brian. And I'm not sure if he knew he would have reacted very strongly. I think we would have broken up, but I don't think John would have lost it and caused a fight. I didn't feel like John's emotions with me got really strong. I mean, I didn't think I hit him, but could I have clipped him? Could I tapped him in the knee and incapacitated him? He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out and in drunkenness and in the cold did he come to again?
And this was the moment you would drop him off at the party.
Yeah, would have had to. And his mother leans over the kitchen island and says to me, I think it looks like you got hit by a car. It looks like you got hit by a car.
All right, who's your next witness, Mr. Brennan?
Next witness is Jean DeMoulis.
Karen,
Did you see John go in the house?
I did.
You saw him go in the house.
I saw John go in the house.
Can you describe him going into the house? Which door and how and when?
No, I have, though, and I'm sure the prosecution will play it.
John looked like a buffalo on the prairie. It was just a lawn and a heat that it wasn't a bush or a hydrant or a dog. It was a weird shaped lump at that time in those elements. And I was looking to find him on the side of the road. I was expecting I'd find him. I was looking to find him on the side of the road. I was expecting I'd find him. So when John got out of the car at Brian Albert's house, he took my full vodka soda, which is sitting in the cup holder.
Thank you.
Comment? Thank you.
All right, your next witness.
One more, please, Your Honor. The Commonwealth moves into evidence and seeks to play clip number 17, please.
Okay.
I gave an interview with ABC with Matt Gutman. I think this was whom I gave the interview to, and I said, he asked why was I saying, could I hit him, did I hit him? And I said, yeah, my first thought was, I've been out late, I've been drinking, and he's in the general vicinity of where I last saw him. I mean, they talk about the left side of the property and the right as if it's, Hammersmith Farms. It's a postage stamp. It's 50 feet. So he's in the front yard to the left of the front door, and no one's coming out of the house. Jen's telling me nobody's seen him. So I'm thinking, Jesus, was I starting to pull away and I ran over his foot? Like, he's roughly where I left him. So yeah, when I found him, I was thinking, did I clip him somehow?
Anything more to say about the clip that was played today?
No, thank you.
What about the clip that's inaudible? Can you say what's in that clip?
I'm sorry, Matt. Just hit you.
How about do you remember making those phone calls, Sam?
Yes.
What was your emotion?
All right, Ms. Roberts, please. Okay, thank you.
We'd like to play this first and then call Ms. Roberts.
Okay, I'm sorry.
Thank you, Your Honor.
I remember it, but I questioned but I remember it because it's been relived so much. I mean, when I see the video of me driving from the waterfall, like what I just described, tapping the brakes when I crossed the intersection, Washington over Sherman Street, do I actually remember that I kind of slowly proceeded through that green light? No, I don't actually remember that. But I've seen the video so many times that you then question, did I remember it on my own? Or was my memory jogged? But I also wondered, did I say, could I have hit him? Or was it told to me that I said I hit him? And I knew I never could have said that, so the closest I must have said was, did I hit him? I know I said I hit him, but did I really say it as many times as law enforcement's claiming I said it?
Thank you. I now call Kerry Roberts.
When you walked out of the bar, how many drinks had you had?
I had probably about 4. And not 4 that I completed either. I didn't drink maybe more than a few sips at the waterfall.
And 4 drinks you felt fine to drive?
Yep.
Clip 8, please.
Okay.
And is the level of intoxication pretty high here for everybody?
It's happy.
Yeah.
It's
because you'd had a lot to drink, right?
I wouldn't say I have a normal amount. Like a vodka tonic every 40 minutes.
Okay. And so are you feeling buzzed? And I'm not judging, I'm just trying to get a sense.
Buzzed.
Yeah.
each drink was being counted as a double. So I would get a vodka tonic, and then I would pour a shot into it, so that would count as 2. Frankly, it just felt like a regular cocktail. It was just a really weak pour, so I asked for a shot. So for my taste, it just tasted like that's the normal strength of what a drink should be. So I had maybe 2 or 3 that are being counted as 4 and 6, and I don't know. I felt fine. I felt like I was buzzed. And then there was one drink, the last one that was given to me, which I would have counted as 3, but they're counting as my 6th cocktail. The guys that we were with brought around shots, and they gave me one that I didn't drink, but I poured it in my drink. So that's now my 5th and 6th drinks, with the 7th, which is a shot that all the men did, and I poured it. So that one glass that I'm holding, that I go into the waterfall with, has 3 drinks in it, a vodka tonic and 2 shots. And which is why John said to me, you're not leaving that drink here, like you haven't touched it and just poured a bunch of onions, like just take it with you, which was something he always did. So then I go into waterfall, and I put that drink down, and I would socialize most of the time. So that would have been my 5th, 6th, and 7th drinks. Then John orders me a drink at the waterfall that I don't drink, that he takes with him. And then there was a round of shots that Chris Howard bought that I did take. So that would have been the night. But I did not consume 9 vodka martinis or take 9 shots, depending on how you count it. And the last 2 drinks I didn't touch.
Clip 10, please.
And I'm not as clear as I would be if I hadn't been drinking. I mean, I had drank, so, and that led me to question, like, could I have hit him? Did I run over his foot or hit him in the knee? Did I incapacitate him? I mean, I always drive with my music blasting ever since I was 16. And I know when John got out of the car to go into Fairview, I know my car was blasting because when I got in it the next morning to go look for him, I had to immediately turn it down. And I don't know, it's stormy. I have had a few cocktails. I didn't black out, but I wasn't as lucid as I would have been if I had gone to bed at 9 and drank a tea. But so I was fuzzier than I would have been if I had had no alcohol.
Clip 11, please.
How did you feel after that many drinks? When you got in the car, did you feel like you could drive? And did you feel how
I wouldn't have gotten on the expressway. I wouldn't have gotten on the expressway at 12:15 on January 29th. I mean, it was quiet. The roads were very quiet. You can see it on the videos. And I was going, you know, when I've had a few drinks and I drive, I always drive extra slow. So I know my alerts aren't as sharp as they should be. But I shouldn't have been driving. But I don't think I was driving. I know I wasn't driving recklessly. I mean, I've got plenty of video of myself driving all over the place. I put my car in John's garage, which is incredibly narrow, and I had a very oversized SUV. You see me, there's a video of me driving through the intersection when we leave Waterfall to go to Brian Albert's, and I was always taught by my father, even when you have a green light, you always should tap the brake. You don't know who's going to run red. And I see me doing that multiple times between 12 and 1 and 5 and 6 a.m. So I know I was driving safely, not as safely or as alert as I would be if I had no alcohol. But I was not driving recklessly by any measure.
Thank you.
Heard it, folks. There you heard it. That was the moment. That was the moment Karen Read was forced to watch videos of herself admitting, first of all, evolving stories about how much she had drank in that night, but admitting she shouldn't have been driving, admitting she was under the influence of alcohol. 9 drinks over 3 hours. You heard it in Karen Read's own words from the unaired footage, from the ill-advised 400 hours of interviews Karen Reed did with the ID Discovery and HBO Max documentary. That footage has now come back to haunt Karen Reed. You saw it in real time right there, folks, with Hank Brennan playing clip after clip after clip after clip for the jury to crescendo into the end of the half day of today's presentation of evidence in the Karen Reed and John O'Keefe retrial. My name is Grant Smith Ellis. I'm clipping this to upload. You can watch more of this Karen multicam fascinating coverage in the future for the trial at youtube.com/@GrantSmithEllis. And after I clip this, I'm going to go back to talking to all the towel friends. So thank you for your patience.
10 seconds.
I'm sorry.
All right, you can play them now.
Okay. May I proceed?
Yes.
I'd like to play clip 12, please.
There was a woman who was a mother to kids that were close to John's kids who lived very close to the outlets. In fact, when Jen was navigating John to the outlets when I was driving, she said, it's near Ashley's house. Ashley and John were hooked up prior to John and I dating. There was a woman...
Hold on. Hold on before you play it
We've
again.
already played that one. We don't need to play it again.
Okay.
12A, please.
Two things. Either he's hurt himself and is incapacitated. He could be passed out on someone's couch, which is just weird. We're not on a campus. Everyone lives in their own home with children, or he's sleeping with someone. And there were multiple women in the neighborhood of Fairview that John had been with. And one of them very recently, before I started dating John.
Clip 16, please.
We'll backtrack later to the time. Let's start at 3:30. So, who are you with? Pull up and let us see.
I'm with Jen McCabe and Carrie Roberts, and Carrie Roberts is Ford Explorer. And I'm in the back, leaning over the front two seats. Carrie's driving and Jen's in the passenger seat. And I described this to everyone, so you've probably heard this before, but John looked like a buffalo on the prairie. It was just a lawn and a heat that it wasn't a bush or a hydrant or a dog. It was a weird shaped lump at that time in those elements. And I was looking to find him on the side of the road. I was expecting I'd find him. And the fear of what I was going to see is the worst feeling I've ever experienced. The anticipation of what is awaiting me was as extreme a feeling. I wouldn't say it was as extreme a feeling as the grief of realizing what happened to him.
And finally, clip 17, please.
And that's
All right,
the
hold
end.
that, please.
That was the last clip, folks, in the Karen clip compilation. My name is Grant Smith Ellis. We just got 10 minutes until court comes into session, folks. Oh, my word. Just 10 minutes. Are you ready? Are you ready for the charge conference? I think I'm ready. We got a lot of good case law reviewed. Commonwealth v. Tony is going to come up. We know that. Oh, ladies and gentlemen, my name is Grant Smith Ellis, and we are about to come into session in the John O'Keefe and Karen Reed retrial for the day. Now, you may be saying to yourself, Towel, I know that there's a clip you want to play, and I know you want to play it because Colleen Henry will go absolutely mad. And the answer, ladies and gentlemen, is yes, Towel does want to play that clip. Yes, it is the clip that you're thinking about, and yes, Colleen Henry is a super towel. Can you please just actually show me all my uploaded media and not just the past 3? That is incredibly annoying. Why are you going to make me do this? Do you understand, ladies and gentlemen, that to scroll back through an entire day of towel clips is literally impossible? Therefore, we have but one solution to this. I have a plan. I am a towel, and I have a plan. So I'm going to search Call Me Hank. I'm literally the only person who would ever post something. Well, a lot of people reshare it, but I'm literally the only person who would share the Call Me Hank clip. You can search Twitter for Call Me Hank, and you will immediately find the Call Me Hank clip, ladies and gentlemen. Yes, it is going to be pulled up on your screen right now. All right, stop being annoying. It is loading on your screen right now. There we go, little towels. Yes, it's everything you've wanted and more. Colleen Henry is going to lose her towel mind. Ladies and gentlemen, it's going to become a towel trebuchet mockery in a good way, ladies and gentlemen. Yes, I think we're going to see clips in closing. We don't know exactly which ones. Remember, closing is not evidence, so rules are a little different. Here we go. Only one closing each side. You as well, Mr. Brennan. Okay, sir, I will, Hank. Defense goes first in closing, Commonwealth ends. Commonwealth goes first, the state goes first in opening and last in closing. Let's run it again for Colleen Henry, for the towels everywhere. Call him Hank, call me Towel. You as well, Mr. Brennan. Okay, sir, I will, Hank. One more time. You as well, Mr. Brennan. Okay, sir, I will, Hank. Oh, goodness. Ladies and gentlemen. Oh, hold on. Ladies and gentlemen, I'm back. Sorry, I know I'm muted. We watched the Call Me Hank clip, and then I muted myself because I was so excited about the Call Me Hank clip. You don't understand. Yep, I was muted. I'm back. I promise I'm back. Don't worry, it was only like 10 or 15 seconds. The only reason it muted it was because I was so happy about the Call Me Hank clip that I literally forgot to unmute my microphone. Now, have you ever said to yourself, oh my goodness, I love the Call Me Hank clip so much I forgot to unmute my microphone, and then the Towel Friends reminded me and then I unmuted? Yes. Now, if you're wondering, Towel, did you get a special on-the-ground update from Reporter Towel Artworks 2? Yes. Now, I know Artworks 2 is going to literally be feeling a special towel connection in their soul right now. They can feel it, ladies and gentlemen. They know what's coming. Now, are you ready for this? I don't know if some of you are truly ready for this, ladies and gentlemen. I have an exclusive image from now designated honorary Reporter Super Towel Artworks 2 himself. It is the greatest thing you've ever seen. Ladies and gentlemen, I present to you a meme in honor of Dr. Rentschler from ARCA, the Rentschler, ladies and gentlemen, the best ham sandwich Hank Brennan has ever eaten for lunch in Boston, ladies and gentlemen. Yes, Hank Brennan walked out of that courthouse having eaten the Rentschler sandwich, and Reporter Towel Artworks 2 was on the ground and brought us the scenes, ladies and gentlemen. Now, you may be saying to yourself, I love ham sandwiches. Are you besmirching them? I'm not besmirching ham sandwiches. Dr. Rentschler is a ham sandwich, and Hank Brennan ate him for lunch. Now, let me lay out the proof for you. Okay. Dr. Rentschler, ham sandwich. Okay. Hank Brennan ate lunch on cross yesterday, and the witness was his lunch. Therefore, Dr. Rentschler is a ham sandwich. Okay? All right? Wait, we got to switch this around. Okay. Dr. Rentschler is a ham sandwich. Okay? Hank Brennan ate Dr. Rentschler for lunch yesterday. Okay? Therefore, Hank Brennan ate a ham sandwich. Do you see what I'm saying? Oh my goodness, it's a formal logical proof. Ladies, truth exposed. Oh no. You're going to get Allie 90211 all wound up and it's only 9:55 a.m. in the morning. Oh, ladies and gentlemen, my name is Grant Smith Ellis and I am a towel. I just want to let you all know that I have made a formal logical proof. Oh, hold on. We've had a special request. Listen, I am not going to turn down a towel request for a ham sandwich emoji. You don't understand. Artworks 2, you have just come to famous status upon Towel Stream. Your ham sandwich emoji, your reporter towel brilliance will now be preserved forever, ladies and gentlemen, forever in the form of an emoji. I am going to render this emoji right now. It is going to be uploaded as we're watching the Charge Conference. You are going to have the opportunity, thanks to the Super Towel Artworks to himself, and we have an update coming at lunch from Reporter Towel Christina that involves the Grinch. Long story, no time to explain. But if your name is Artworks 2, you have just made it. You join Bella the Cat. You join Brewski the Irish Setter, you join Randy the Crash Test Dummy. Oh, you have taken your place among the pantheon of towel heroes, my dear friend, because your ham sandwich meme is about to become. You've joined Murder by Maestro as well. You've joined Def Otter, the commander of the Towel Expeditionary Force in Europe. You have literally created us a meme that will become an emoji. That is a very noble honor in the towel world, ladies and gentlemen. I don't think you understand what it means when you create a ham sandwich-based emoji and it becomes an emoji. There is a very specific phrase for this, ladies and gentlemen. It is called emojiification. Now, you may have said, Grant, emojiification is not a word. You just made that up. We are now going to enter it into the English lexicon. Yes, ladies and gentlemen, you were here for the birth of the word emojiification. That is the word of the day. Emojiification is the word of the day. I verbified the word emoji. Now, I may have also just invented the word verbify, which means to take one word that is not a verb and make it a verb, such as emoji, which is a noun. Making it into a verb would be emojiification. So I have verbified emoji. Ladies and gentlemen, let it be known on 6/12/2025, as we wait for the Charge Conference in the Karen Reed and John O'Keefe case to come into play, or to come into session, I defined the word emojiification, and then I defined the word verbify in a recursive, metaphysical, beautiful, Joycean style recursive circle. Ladies and gentlemen, I have taken my place upon the pantheon of Webster's beautiful dictionary, and I have defined two words, emojiification and verbify. Now, I know a lot of you are... oh, Eva, hold on. You sent me a photo of Hank. I absolutely will, but hold on. We got to remember, folks. Towel, we are about to come into session in the Charge Conference. I have just invented two words, emojiification and verbify. Eva Towel, I absolutely will send we'll post the image that you sent, but just remember, Towel has a lot going on. I'm not ignoring you. It's just we're literally getting caught up on things from yesterday, so you are in the queue, my dear friend. And we also are waiting for court to come into session. And remember, as much as we will show everything we can, we'll do updates during lunch, and I will share them on X, but I sometimes forget, and I can't always get to everything. Oh, but this one we will absolutely share, Eva Towel. I actually forgot you sent this to me. You can tell little Towel's getting overloaded when he starts forgetting amazing pictures that get sent to him because he's overloaded. And by the way, if you send me Facebook messages or IG messages or things like that, I'm not ignoring you. It's just they don't go to my main inbox. They go to an others inbox, and I don't get a notification. I then have to go through all of the messages one by one, which I will do, and it takes a while. If you send me messages on X, I will get them relatively quickly. If I ever don't respond, I promise I'm not ignoring you. Just send a prompt, and I will follow up. Now, ladies and gentlemen, there he is. There he is. I know you're excited. Look at it, ladies and gentlemen. It is a picture of Hank Brennan, the Super Towel. All right, just being nosy, what is it that you're sharing here? I'll take a look. We got to get into session, though, folks. If you're going to share a link, by the way, please try to describe what you're sharing. For me and the other towels, like, it's hard if you just post a link, so please just let us know what you're sharing. Because if I can't bring it up on stream right away if you don't describe it. So I'm thrilled you all are sharing content. Remember, you have permissions as mods to do that. I'm so glad you shared that. All right, that's getting shared at lunchtime. That's the ham sandwich Arca Man in the style of a puppet. I am so glad I looked at that. But yes, by the way, it's not like a nitpicky thing when I'm asking you. No, just being nosy. Please, it's not a nitpicky thing. It's just when I go to click something, if for example, now I don't want you to give away the surprise, but if you give a general descriptor, I can bring it up right away, but otherwise I have to screen it. It's not you. It just say you link to like some very interesting picture of like TurtleBoy where he was doing something ridiculous, I have to screen it. All right, we got to get ready though, folks. We got to get ready. Court's about to come into session. I don't have time. I should have done this earlier. That's what happens when Towel gets distracted. Do you understand? Towel has obligations, ladies and gentlemen. We can't just be wonderful super towels all the time. All right. We don't need the Call Me Hank clip again. I get you. Murder by Maestro is wonderful though. All right, so close that. You all take a look at that. Now we'll go, hold on one second. Let's go. Yep, I know little towels. There's a reason why we should not put little towel under so much stress because it drives little towel crazy. Now hopefully the charge conference begins a little bit after 10 a.m. I would really like that because then I can be a towel. All right, here we go. So I'm going to click that. I'm going to get the court feed up. I'm going to get the Zoom feed up. We're going to get the Karen feed up. We're going to get ready for Aidan Kearney's case at 11. Is Aidan Kearney heading towards conviction? Will Hank Brennan get his consciousness of guilt motion approved based on witness intimidation? Those are the questions of the day, ladies and gentlemen. And also, we're going to get our new emoji. It's just going to take a second to get that uploaded. I need to get the feed going. Then the next thing I'm going to do is upload the emoji. All right, so hit that. Then we move that. Okay, now give me a second. I'm just waiting for the Karen Cam to connect, and then I'm also going to jump right into the Karen Reed live here on the Law and Crime feed. Thank you so much to them for their excellent feed. I don't believe court is in session yet, but I didn't have the feed loaded up like I normally do because I am a busy towel today. I'm an administrative towel. Oh, by the way, donations today are very important. The Karen Cam is not live yet. I have great news. We're just monitoring court. The fan is still spinning. The second court comes into session, you are going to hear it. Donations today, ladies and gentlemen, if you send them, they are going to a very good purpose today. I saved them all from yesterday. They are going to a good purpose. But yes, I will talk to you about it in a little bit. It is a big day. People going to support Lindsey Gaetani in court. God bless you. We're gonna give them the support they need. You know, the towels who are listening know how to come into action.
So much for
no,
Karen
not you.
With us, but
I wasn't cueing you, sir. I was giving an important message. Listen, don't donate to me today. I'm going off your screen. Hold Ange Whittick's hand if you need a towel, buddy. Don't donate to me today. Please send your donations. If you love Towel Stream, if you want to help Towel, if you want to help the world, send a donation with the note that says Lindsey. Okay, it'll go directly to Lindsey's fundraiser. Ladies and gentlemen, it's very important. And then please consider throughout the day keeping an eye on updates. I'm going to let you know how the Aidan TurtleBoy Kearney case plays out. We're getting ready for the John O'Keefe and Karen Reed retrial to come into session. The reason I know it's about to come into session is look at that. The Karen Cam isn't live yet, but it's about ready to be live. Oh, little towels. We're getting into horse racing announcer towel mode. And yes, please do consider sending a donation today. If you support Towel Stream, do not send a donation if you've already sent a donation. Only send a donation, please, if you are in the position to do so. And if you do send a donation to Towel Stream and you leave a note in the comments for Lindsey, please note that that will go directly to Lindsey's legal fundraiser, and it is greatly appreciated, ladies and gentlemen. In fact, the donations yesterday are definitely going to find their way to Lindsey's legal fundraiser, and they were wonderful, and I'm excited to tell her about them, hopefully later today if there's a verdict in the case. Otherwise, I'll wait till tomorrow if Aidan really continues his trial until tomorrow. Oh no, we are not watching the fan. That is a violation of intergalactic towel law. You do not understand, ladies and gentlemen. So, as a result, I must bring up the Oh My Fan. Where is the Oh My Fan? Oh goodness. Where is it? Where is it? There it is. Ladies and gentlemen, we have been saved from the fan. Oh, look how happy Chewbacca and the Stay Puft Marshmallow Man are. They saved us from the fan. Oh, I agree, Colleen. My mom is a prescient towel mom. Ladies and gentlemen, did you know my mom is a towel mom? Her name is Wendy Murphy, and she is a towel mom. She does make prescient predictions. I wonder if she's listening now. Hi, Towel Mom. She listens to the case a lot during the day. I don't think she listens to Towel Stream. My aunt does, though. Sometimes my aunt calls me during stream. I'm like, Auntie, I have to mute the stream. Do you realize that? And she's like, yes, I think it's funny. Hi, Auntie. How you doing? I hope you're having a good day. Oh, goodness, ladies and gentlemen. We're waiting for the Karen Reed and John O'Keefe trial to come into session. My mom, Allie 90211. My mom's Wendy Murphy. She's a towel. We're waiting for court to come into session. As you can see, it's 10 o'clock, 10 a.m. Eastern, 10:05. Court should be starting soon. Judge Cannoni's readying the readying the horses. Judge Cannoni is the horse racing official, ladies and gentlemen. I am Grant, David R. Murrow, Howard Cosell, David Attenborough, Towel Smith Ellis. And I am monitoring. The horses are back from down the pack. Ladies and gentlemen, they went down the pack because the horse children, which are called foals, were galloping freely with Chloe the dog, her pigs, and her comfort Chewbacca. Now, my name is Grant Smith Ellis, and we're waiting for court to come into session because Judge Cannoni is a horse racing official, and I am talking about horses down the pack. Now, you might be saying, Grant, are you just saying that? Oh, my goodness, someone sent a Lindsey donation. Oh, goodness, God bless you, towel friend. This is perfect. It's going to go, I hope, maybe I can get them a pizza for lunch. I don't know, ladies and gentlemen. But needless to say, God bless the people supporting Lindsey today. You know who you are. God bless the super towels. You are all super towels. All right, now, continuing, if you were wondering, sir, have you been referring to Judge Cannoni as a horse racing official and the lawyers as horses, just so you can say the phrase, the horses are down the pack? Yes, and do you enjoy saying the phrase down the pack? In particular, the word pack. Yes. Now, a lot of you might be saying, sir, I don't understand what the word pack is. Well, you got to spell it out, P-H-A-K. Now, if you transliterate that from New Englander, it means park. P-A-R-K. But we say pack, all right? You want to go down the Cape, you got to go down the pack, all right? It's a very simple equation, ladies and gentlemen. Now, I also want to be very clear that we are 7 minutes late. Judge Cannoni, I know the charge conference doesn't have jurors involved, but if we could just have the charge conference, then I can be a towel. Now, I already am a towel technically, and I think I had an energy drink today. So I'm not necessarily saying that we should all be towels, ladies and gentlemen, but I just want to be a towel and watch the charge conference. And then we have to get ready for 11 a.m., the start of Aidan Kearney's case, which means Aidan Kearney is going to miss the whole charge conference. And if his case goes longer than today, his defense, he's going to miss closing arguments tomorrow. What a precarious position to have been put in for the little towel. Oh, ladies and gentlemen, we might be getting ready. Oh, I think that's an early preview. Get ready, ladies and gentlemen.
Was now open, you may be seated.
Get ready. Get ready, little towels. About 20 seconds. We got an early preview because of the super towel cam. Oh, my fan, ladies and gentlemen, get ready. The horses are at the stables. Chloe the dog is seated at the defense table. Here we go, my friends.
Was now open, you may be seated.
Good morning, Your Honor. May I call the case? Please. For the record before the court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present. The jury is not present. The matter is on for trial. If the parties could please identify themselves for the record.
Good morning, Ms. McLaughlin. Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Robert Alessi from Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti from Karen Reed.
Good morning, Mr. Yannetti, and good morning, Ms. Reed. All right, so Mr. Yannetti and Mr. Alessi, you're standing in also for Mr. Jackson and Ms. Little?
We are.
Okay. All right, so first thing we left off yesterday was whether KKKK for identification, the PowerPoint of Dr. Rentschler would be entered into evidence. It will not be based on the objection, so it is excluded from evidence. So it's marked still for identification, and your rights are saved on that. So we ready to go forward with the charge conference?
Yes, Your Honor. I guess I have a question first as to whether the court would like to entertain the argument on the motion for required finding not guilty of all the evidence.
So, no, we can do that now. So now that my ruling is on this, evidence is closed. Evidence is closed as it was yesterday. So go ahead on your required finding argument. Sure.
And this is not lengthy, Judge, 5 or 10 minutes.
Take your time.
Thank you. We are renewing our motion for required finding of not guilty at the close of all the evidence, and in so doing, Your Honor, we're incorporating our oral argument in support of this motion that we made at the close of the Commonwealth case. At that juncture, Your Honor, the Commonwealth had produced no witnesses to testify that John O'Keefe's injuries were consistent with his having been hit by a motor vehicle, and if he was not hit by a motor vehicle, none of these three indictments may stand. The Commonwealth, we believe, at that time fell woefully short of proving their case. Now that the defense has put on a case, the Commonwealth's case has been further weakened, such that none of these charges can stand. Nearly every witness, Your Honor, we have called, we would submit, has destroyed the Commonwealth's theory of the case. Dr. Russell testified for the defense. She's a leading expert on dog bite wound pattern recognition in the country, and she testified about medical injury causation and provided the jury with her expert opinion that John O'Keefe's injuries were consistent with dog-inflicted wounds, both bites and scratches. I would remind the court at this juncture that there was a dog at the very residence where John O'Keefe was found, a dog which was a longtime member of the family, which the family gave away after John O'Keefe's death, a dog which mysteriously was absent from the home at 6:30 in the morning on January 29th, when Jennifer McCabe claimed that she burst into Brian Albert's bedroom where the dog always slept, a dog which was absent from the home when the Canton police entered the home later that morning. Importantly, Dr. Russell agreed with the Commonwealth's medical examiner, Dr. Scorti-Bello, that John O'Keefe suffered no injuries that were consistent with having been in a motor vehicle collision. And again, if there's no collision, there's no case. Dr. Lopesada, one of the most experienced and accomplished forensic pathologists you could find anywhere, agreed with Dr. Russell that John O'Keefe's injuries were consistent with an animal attack. And she agreed with both Dr. Russell and the Commonwealth's expert, Dr. Scorti-Bello, that John O'Keefe was not hit by a motor vehicle. So the question is, in what type of murder case would a judge ever allow a motion for required finding of not guilty? In a murder case where expert testimony on both sides is that the evidence is inconsistent completely with the Commonwealth's theory of the case, that's exactly what we have here. But it doesn't stop there. Both witnesses from ARCA drove a stake through the heart of the Commonwealth's case. Dr. Wolf concluded that the damage to Ms. Reed's Lexus was inconsistent with having come from a collision with John O'Keefe. Unlike Dr. Welcher, who created, we would submit, a meaningless experiment based on no scientific method, Dr. Welcher actually did the proper force analysis and concluded that Ms. Reed's Lexus was not damaged by the body or the arm of John O'Keefe. His testimony was unimpacted by cross-examination, and it's devastating to the Commonwealth's case. Dr. Rentschler further cemented that there was no collision between the Lexus and John O'Keefe. It is simply not possible that this 6,000-pound SUV hit John O'Keefe at 24 miles an hour and caused only superficial wounds to his right arm with no injuries to his legs or lower body. The SUV did not hit him. John O'Keefe was not hit by the SUV. The case is over. But on top of all that scientific evidence, Your Honor, there were three additional fact witnesses who testified for the defense who corroborated that the Commonwealth's theory of the case is false. Sergeant Nicholas Barros, a sworn police officer, testified that when he saw Ms. Reed's SUV that day, before it was towed to the Canton Police Sally Port, the taillight was merely cracked. When he was shown photos of what it looked like in the Sally Port after Michael Proctor had access to it, Sergeant Barros confirmed that it was absolutely different. Karina Kolakithis confirmed that there were no problems between Karen and John O'Keefe that night, even remarking on just how sweet he kissed her on the forehead shortly before they left the waterfall. But perhaps more importantly, that kiss happened right in front of Brian Higgins, the same Brian Higgins who had been flirting with Karen Reed that month, the same Brian Higgins whom Karen had ghosted for several days before January 28th, the same Brian Higgins who had texted Karen that very night, well, and received no response, the same Brian Higgins whom Karen had given her back to all night, the same Brian Higgins who had to be restrained at the end of the night by Chris Albert on video, the same Brian Albert who is on video, hot, angry. I meant Higgins, yes. Yeah, the same Brian Higgins, who was on video hot, angry, and gesturing to John O'Keefe to meet him outside shortly before they left the waterfall and shortly before John O'Keefe was killed. And finally, Brian Loughran, plowing Fairview Road at 2:45 in the morning, was attentive, watching everything in front of him, very familiar with the Alberts residence, and had every reason to protect the Albert family. You recall that he did protect the Albert family to a degree that night by choosing not to follow protocol and call the DPW or the police about the Ford Edge parked on the street outside their property during a snow emergency. Brian Loughran confirmed that John O'Keefe was not on the front lawn at the Albert residence at 2:45 a.m. That means that Karen did not hit him. There was no collision. All the experts agree on that, including the Commonwealth's expert, and the only eyewitness that morning confirms it. Taking the evidence in the light most favorable to the Commonwealth at this juncture, with their evidence weakened by an airtight defense to these charges, these indictments cannot stand, and we urge this court to enter required findings of not guilty on all three indictments.
Thank you, Your Honor. The Commonwealth requests that the defendant's motion for required finding not guilty at this juncture, as it was at the close of the Commonwealth's case, be denied. The state of the evidence is not dramatically changed since the Commonwealth rested its case in chief. Counsel makes reference to dog or canine. I would remind the court that there is absolutely no evidence, none, not even a scintilla of evidence of a dog. There is no evidence of an absence of a dog. You have Ms. McCabe testifying that she didn't see it in the morning, which does not equate to there being an absence of a dog there. The arguments from counsel of the Commonwealth would suggest grossly exaggerates the strength of the defense witnesses in their case. The bias and advocacy exhibited by those witnesses from that witness stand do not amount to credible witness testimony that undermine the Commonwealth's case in any way, shape, or form. A couple of specific examples. When it came to Officer Barros, his testimony was also that the cruiser camera footage from 8:22 in the morning at the driveway at One Meadows Ave, he indicated the damage to the taillight was consistent with the damage that he observed in the driveway at the defendant's parents' home, which was then consistent from the video or the photographs within the Sally port. It's also consistent with 5:07 a.m. at One Meadows Ave on the still frame shots from that ring camera video. Essentially, the Commonwealth would submit that the defense witnesses all conflict with each other. You have a couple witnesses testifying about dog or animal bites. Then you have the ARCA witnesses testifying about superficial abrasions. You have Dr. LaPosada talking about the drop in body temperature, which conflicts with Mr. Loughran's testimony as far as his confusion, as far as the hours of when he sees or claims to have driven by there and not seen a body. This is the same witness who is, I would submit, very confused on times, and then also backed into a basketball hoop during the course of his plow duties on that particular early morning as well. And as the court could see from the cruiser camera video, drove by the scene countless times, essentially rubbernecking it as he's going past doing his duties. Your Honor, what the Commonwealth would submit is that his case was more than sufficiently strong at the close of the evidence in his case in chief. There has been nothing presented in the defendant's case to diminish, particularly to the standards in the light most favorable to the Commonwealth, and we request that the defendant's motion be denied.
So, Mr. Yannetti, you know I have to view this in the light most favorable.
I do, Your Honor.
And viewing it that way, the Commonwealth has met its burden, so the motion's denied.
Thank you, Your Honor.
Okay. All right. So regarding the charge, so we'll start with the defendant's missing witness request. Who's arguing that motion?
We're not arguing that, Your Honor. And I apologize, but we made the decision last night to withdraw two of our requested instructions, which would shorten things today. I think it's
Oh, okay. So everything on this is done, right? The defendant's motion to present a missing witness argument and request for instruction. You're withdrawing that?
With regard to the absent witness instruction, we're withdrawing that request.
Okay. And what else from your proposed instructions? You said there were two. What's the second one?
The second one is that there's an entry on our request for lost or destroyed evidence. We're withdrawing that.
Okay, I had a question about that. All right. Thank you.
There is a supplemental instruction that we're asking the court to give regarding the display of the sweatshirt.
Oh, that's right. You filed, I saw it in email. I don't have a hard copy of it.
That's Mr. Alessi's.
Your Honor, if it's helpful to Your Honor, I'll hand up my hard copy.
Okay, if you could do that, I'd like to go back through the rest of it and come back to that after I've read it, okay? Who's arguing for the rest of the defendant's proposed instructions?
I am, Your Honor.
Okay, so we're gonna go through them one at a time. Who's arguing for the Commonwealth? Okay, so I think you're sort of in agreement on the basis of the law, right?
Yes.
All right, so model homicide instructions and just as last time. So that takes a lot of time out of today.
The only thing I would draw the court's attention, the Commonwealth does have a request for, and I understand the court's position might be on this, but as far as the instruction relating to murder charge, Commonwealth is only seeking an instruction on murder problem.
All right, so we will deal with that. I'm going to go through the defendant's instructions, or sort of the general instructions first, so it's probably easier to go through those, and then we'll have the argument on that. So, presumption of innocence. I think my presumption of innocence is a little more robust than what you've requested, so I will probably. Okay. And I will give some version. I know that there was a lot of attention paid and some appellate decisions on the each individual indictment. I'll give some further language on that. You've got an instruction proposed on page 4, reaching a verdict. I will make it crystal clear, though I think it was, and I was upheld on it, so I will make it crystal clear. Okay? So I'll give you that, Ms. Giannetti. What is evidence? I probably won't give verbatim what you have. I'll take a look at it, but I will certainly cover all these topics. So, Ms. Giannetti, you're telling me that your client wants me to give a defendant did not testify instruction? Again, if you want to take a look at what I gave last year, I think it's a little more robust than this.
I think we answered satisfied with the court's instructions on that, so we would be satisfied again with the court's language.
Okay. Humane practice, I will give you Bowden. I'm going to take a look, size this up with what I gave last year. I gave Bowden last year. I gave a Bowden instruction. I don't think the Commonwealth objects, right?
We would object to the instruction.
Okay. Go ahead. Do you want to make an argument?
Just briefly, Your Honor. When it comes to the Bowden, and I would incorporate, and I know there's no request for instruction from third-party culprit, but the Commonwealth would be making a similar request that counsel be prohibited from making a third-party culprit or Bowden argument.
Or Bowden? Or Bowden?
I'm sorry?
You don't think the Commonwealth, the defense should be allowed to make a Bowden to argue Bowden?
So I would submit, Your Honor, that the entirety of any testimony or evidence related to either Bowden or third-party culprit in this trial has come from questions from the defense, not from actual evidence in the case, not from testimony from witnesses from the stand, exhibits that have been put into evidence, or anything of the like. So in the instruction and arguments are based or predicated in the case law on evidence, not obviously, as the court is well aware, there's a specific instruction that no matter how powerful they are, questions to counsel are not evidence. So what the Commonwealth would submit is if the court looks at what is actually in evidence in this case, there is no basis whatsoever for not only a Bowden or third-party culprit instruction, but specifically for even counsel to make that argument during the course of the closing. And I understand Bowden is a little bit more loose as far as the court certainly.
So I'm going to ask Ms. Giannetti to explain to me All right, so I disagree with you on Bowden, but I'll take a closer look at it. Mr. Yannetti, what is the Bowden evidence that warrants an instruction?
I think it's multifaceted, Your Honor. The police did not secure the crime scene properly. They used inadequate material to pack the evidence. Chain of custody was contaminated and corrupted. There was evidence of the bias of the lead investigator, failure to pursue other suspects, specifically telling his friends that the homeowner was sacrosanct because he's a Boston cop too. There was just a focus on Ms. Reed to the exclusion of everybody else. It was not an open-ended investigation. From day one, it was focused on one person and one person only. And just responding briefly to Mr. Lally comments about how he didn't introduce affirmative evidence of the proper way to do an investigation. We tried, Your Honor, we made a motion and renewed it, asking for reconsideration of the court's ruling that Mike Easter could not testify about an investigation. So to say that we didn't introduce that evidence when we tried to do it,
I think what Mr. Lally was saying, that you asked questions but weren't given answers, and so I think that's what was said. I'm going to Mr. Yannetti, I'm going to allow you to argue Bowden, and I am going to give an instruction. So third-party culprit's an entirely different animal here. I know, but tell me, are you going to argue it? Is the defense going to argue that Brian Higgins did this?
No, we're going to argue that the police failed to investigate whether Brian Higgins did it.
Okay, so just so that it's clear, that you all know, I believe, third-party culprit separately is a lot different than third-party culprit as it goes to Bowden. I ruled pre-trial that there could be no attempt at introducing third-party culprit evidence regarding Colin Albert. So that was separate. But I did say that I would give you the opportunity to try and develop testimony regarding Brian Higgins and Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as three-party culprits, has not been made by the defense. So you cannot argue that either Brian Higgins or Brian Albert committed or had the motive and all of that. Not third-party culprit, pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
We understand the distinction, Your Honor, and we're strictly going with a Bowden defense.
Okay, so you can get into third-party culprit with Brian Higgins, that the police were aware of whatever you're going to argue and failed to act on it. But it's strictly for that purpose, okay? Okay.
And that's really what I was seeking, this clarification.
Yeah. So Mr. Yannetti, and of course I take him at his word, tells me that they're not going to do pure third-party culprit. Okay, that's great. That makes that easier. So I will give. Sure, go ahead.
While we're on page 8, I just wanted to almost let's have an objection to the teaching instruction that's at the top of page 8.
Yeah, I have a check mark next to that. Mr. Yannetti, tell me about this, the absence of a recording. Are you saying that the police should have recorded Ms. Reed at her parents' house?
Right. So, obviously it's not the strongest Batista argument that we would have. It did not occur at a police station, but, these days, Your Honor, it's common knowledge that everybody has access to a recorder, even on their own cell phone. It could have been done. It wasn't done. We had to rely on police memory of what my client said or didn't say when there was a possibility for a recording. So we still think we're entitled to it.
Do you think it was custodial interrogation? Or I guess I should say, do you think the evidence supports?
I think there's an argument that it was custodial interrogation. We had police officers who, refused to sit down in the living room. They were surrounding her. Someone who was not familiar with dealing with the police at all. So yes, I think there's an argument that it could be considered custodial.
All right, what do you say about all this, Mr. Haley?
And I would also add, Your Honor,
sure.
They did seize her vehicle. goes to, I think, the issue of custody and my client being able to deny it.
All right. What do you say?
That's the very nature of the objection, Your Honor, is the non-custodial nature of this. So the troopers spoke to Ms. Reed at her parents' house, as they did with a number of different witnesses on that day as well, for the course of that day. They spoke to her while she was seated on the couch in her parents' living room. The parents were present. No one was restricted from eating. And it did not end in any sort of custodial situation. She was taken into custody. She wasn't arrested. Yes, they did seize her cell phone and her vehicle based on information that they had developed throughout the course of the day and from statements from Ms. Reed herself. But I don't think that that transforms that conversation or interview in a parent's living room into a custodial interrogation. The bigger issue that I have is placement, as far as there's already been within the same requested jury instructions or requested main practice, and then following the DAG and Batista language in the defendant's requested jury instructions, there goes on to all of these other requests regarding her compromised mental state and all of these other things that, while if it were to be given by the court, should be given in the same context of the main practice. I don't think it's something that should be highlighted in two different sections. And I would submit that there is no evidence of her having a compromised mental state or anything to that effect. She exercised her judgment as far as when she was speaking with Sergeant Gaetani and having his testimony from the stand, that initially she said she wanted to be fine with answering questions, but didn't want to get into any details. And then when the questions became centered on, or more centered on details, at that point, and I know that's not admissible to the jury, but of course, well aware, she then ended the questioning at that point. So I don't think there's any evidence of her having a compromised mental state during the course of this interview, and I don't think that it rises to the level of these instructions. So I would ask basically that everything on page 8 prior to the 12 instruction be excised.
All right. I'll take another look at this and I'll just let you know in the morning.
And Your Honor, with regard to the compromised mental state, we agree that that would not apply to the interview at your residence. But we believe that it applies within the humane practice context.
That is where it makes sense. So, all right.
If it's going to happen, it should happen once, not
Yeah.
I think that's fair.
Okay. Okay. All right. Prior statements, I will give some instruction on prior inconsistent, and I'll give a prior consistent statement. I will talk about the view. The absent witness instruction is withdrawn. So is the...
Not to interrupt.
That's okay. That's okay.
With regard to the view, Your Honor, we did include a language reinforcing the fact that the rock that they saw on the view was not present on January 29th. We asked the court to repeat that one sentence.
Okay. So I did not see this when I took a quick look at the view. All right. I'm not going to repeat it. All right. Lost or destroyed evidence you're withdrawing.
Yes.
Direct and indirect evidence. I'm going to try and give a shorter instruction on that. So I will, even the one I gave is too long. I'm trying to cut down the time the jury needs to hear general instructions that I think they're perfectly capable of hearing in a shorter period of time. All right, thank you. Credibility, the same. Law enforcement witness, I think I gave some instruction on that. I'll include that somewhere in it.
If I might just in reference to that,
Sure.
only language in there that I would object to.
Okay.
That's when a police officer or someone else works for a law enforcement agency.
Oh, what do you mean by that?
I think that was taken into account for the dispatcher, perhaps. We're not...
Yeah, I'll do police officer because they're police testimony. I'm not going to go beyond that.
I think that might be possible.
Okay, thank you. I'll do the photographs, the opinion testimony, notes. I'm not saying I'm giving exactly this, but I will give, I'll cover all those topics. What page you on? Okay.
One suggestion there was indicate Commonwealth has introduced photographs and evidence, I would submit.
Yeah, I'm just going to say there are photographs that are in evidence. Was that the nature of your objection?
I actually think the defense has introduced more graphic.
Yeah, so I would just say you've seen photographs. Or there were photographs in evidence. I instructed twice anyway, maybe 3 times on it, so I'll give some version of that. Juror notes, I'll give some version. The implicit bias instruction, I'm going to give exactly what the SJC told me I should give. All right, so the Commonwealth's requests are sort of in the, you start with the law and then you get into the general instructions, Mr. Lally, so let's skip to your, it's not numbered, your supplemental instructions, use of a dangerous weapon. All right, so I'm going to give that, Ms. Giannetti. I gave a dangerous weapon instruction last year on the motor vehicle.
Understood.
All right, so I'll give probably what I gave last year, and this looks like it's it. What is not evidence, evaluating, I'm going to give what is not evidence, evaluating the evidence, there's some instruction. Ms. Giannetti, what do you think about the short instruction on jurors? It sort of makes sense to me after such a long trial. No juror is better qualified to determine the truth of the facts in controversy or to deliberate upon a verdict than any other juror, or solely because of that, solely because of that juror's occupation, education, experience, or any other characteristic. Okay. Thank you. Charts and summaries, I'll talk a little bit about chalks. And inferences, I will give some. I'll give the redacted exhibits instruction. Witness preparation for trial. Do you both want this? There was testimony on both sides. It's simply, there was testimony at trial that the attorneys, and I may say if you find, or something, preface it. Witnesses when, the attorneys interviewed witnesses when preparing for and during the course of the trial.
No objection.
You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the attorneys are obligated to prepare their case as thoroughly as possible and may interview witnesses. I don't know if there's a sequestration order, if this is appropriate, though, where it says during trial, during the course of the trial. I'll just say when preparing for trial.
Yeah, we're joining in the request. I don't know that we included that in our instructions, but we're joining in the Commonwealth's request for that instruction.
All right. Okay. Expert witnesses, electronic communication. So I'm going to go through the limiting instructions I gave. I need to just do this again here. So electronic communications, I have that on my list. The emotional impact photos, humane practice. We'll get back to consciousness of guilt in a minute. I'm also going to give the prior bad acts instruction. I did that in regard to the Aruba incident, if you want to call it that. I gave a prior bad acts instruction before that testimony came in. I also gave the instruction that I will also give on the state of mind of John O'Keefe as to his state of mind being known by the defendant and the likelihood that she would act on it. So Commonwealth versus Binns in those cases.
Your Honor, with regard to Aruba, we don't believe that there was really any guilty that came in.
I thought it came in through Kaylee. I should say it did come in through Kaylee. That's when I gave the prior bad acts instruction. She testified. Okay. All right, so did I give it any other time that there's another event that I should highlight? I don't think so.
I don't think there was an instruction at that point.
All right. I think I have to add that here. So, all right. And I will look at it and decide whether I need to add it specifically. It might be covered enough. Might be covered enough when I give the electronic communications instruction. So I will think about that. All right, those were the limiting instructions I wanted to get to. So
We would object to the part of that act being linked to the Higgins text message.
all right, I'm going to take a look at that, Mr. Lessie. All right, consciousness of guilt.
You're on call.
Okay. All right. All right. So tell me where the difference is in what I gave last year from the model homicide instruction on second-degree murder and where you're saying I should not this year, Mr. Lally.
No, so the only.
1 second, let me just pull that up. Okay.
Your Unfollows request is merely not for any change or alteration in the instructions that were given, other than there are three-pronged malice, and essentially the Commonwealth is requesting is that the jury be instructed.
Speak up.
Merely on third-pronged malice, as that's the only one that really applies to these facts and circumstances.
Okay.
The Commonwealth here, the first two prongs are essentially extraneous to this equation and don't need to be explicated in the jury. Avoid confusion.
Do you have supportive case law for me to single this out?
I do.
What do you say, Ms. Giannetti?
I mean, Mr. Brennan essentially stated that in his opening statement.
Stated what?
Well, in his opening statement, he stated that he's not alleging that she intended to do him grievous bodily harm, not intend to kill him. It was just the third prong. He stated that in his opening. I imagine that's what he'll likely argue in his closing. You know, I don't have a position on this. I just don't know, and I think the court's going through this analysis in your head as well, whether it's permissible or not. I just raised that as an issue, but I don't have strong feelings about it.
I could say the parties agree that the first prong and the second prong are not applicable here.
I think we're just at a position where we'll defer to the court on this.
Well, I'm not going to say you agree if there's no agreement. If you can get me a case by this afternoon.
I will endeavor to do so, Your Honor. We will. I don't have anything.
I'm inclined to go with the model. I'll see if there's something I can find. You're probably better at finding it than I am, Mr. Lally, but I'll see if there's something I can find to support the position that it's just the third prong, and therefore I only have to give that instruction. I don't think I'll find anything, but let me see. Because I can understand why both of you don't want it. Just let the jury focus on what they need to focus on.
That's really the only reason for this. I understand, and I don't certainly want to take.
You know, I suppose I could always tell the jurors that the Supreme Judicial Court has come out with jury instructions that I must give in their entire format. And that sort of explains why I say something that doesn't apply. Maybe.
I would be fine.
We wouldn't have an objection to that.
Maybe I'll do that. But let me see if I can find something. If I can find something that says I don't have to give those first two prongs, I'll let you know before you begin. All right.
And Your Honor, before the court makes a decision on that, we see what the court is proposing if you are going to alter the model.
If I alter it, it means I remove those two. That's all.
Right, no, we just want to.
Yeah, sure. My guess is that won't happen, but we can see. All right. So, lesser included offenses. Did you want an OUI instruction? You were.
We're asking for that.
All right. Right, I think that's it, aside from Mr. Alessi's motion regarding the exhibit. Right, is there anything else that we're missing?
Just a couple of other issues. One is with regard to the Proctor text messages, we have a redacted version now, which we'd like to submit to the court of the Commonwealth. You recall that we had agreed essentially on a redaction subject to the court's ruling.
Okay.
But it wasn't in final form. We believe it's in final form now.
And you all agree that it's in final form?
Well, they haven't seen it.
Oh.
But I'm going to give it to them now. Can I hand this to the court?
Sure, thank you. All right, so
The only other issue, Your Honor, is we do have a...
hold on one second on this issue still. So I will give the Commonwealth this afternoon to take a look at this. And tomorrow morning, if you don't have agreement, then we'll have to deal with it. And I'd prefer not to have to deal with it, so.
I'm sure we can be in touch this afternoon. I do not believe there's going to be any problem.
Okay.
Just a couple other things before we get to Mr. Alessi.
Yeah.
One is that we do have the Dr. Wolf PowerPoint to be introduced to the evidence from.
Dr. Wolf or Dr. Rentschler?
Dr. Wolf.
All right. And this was allowed into evidence unobjected to. I thought we already had it. We didn't?
We have to redact it, so we
Okay.
redacted. It's on a phone drive.
Okay. And the Commonwealth has seen it? All right. So they'll have to see it. So Mr. Lally, Mr. Brennan, Ms. McLaughlin, one of you has to take a look at it.
And then will the court allow more than an hour?
I'll allow more than an hour. I'll allow an hour and 15 minutes.
Thank you.
All right.
And I think I did mention that we had a proposed verdict slip for count 2, Your Honor, if I didn't.
You did not.
Okay. We do have one. We've given a copy to the Commonwealth. Can I hand the proposed copy to the court?
Sure. Is it the same as last year's, but now with a...
It's different.
Okay. All right.
You'll have a chance to digest that.
Oh, I digested it, Mr. Alessi. Go ahead, I'll hear you.
I'm actually Yannetti.
Yannetti, jeez, I'm sorry.
So, Your Honor, you'll recall we had some spirited argument both before and after trial regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment because of the number of lesser included and the number of elements that are different for each lesser included. And we were uncomfortable with there being one option for not guilty at the top of the form, and then multiple options for multiple different types of guilty verdicts throughout the remainder of the form. So what we have done is to fashion this in a way where the jury, pursuant to the court's instructions, would first decide the offense as charged, and if it's a guilty verdict,
Madam Clerk?
the analysis is over. If it's a not guilty verdict, they go into the next lesser included offense, and again, same analysis applies. If it's not guilty, they then go to the next until they finally reach the final verdict, which the lessest, or the least, I should say, of the lesser included offenses is simple operating under the influence, where they have an option for not guilty or guilty. We've also changed a little bit of the wording, you'll see, which I think makes it clearer and less confusing. When the jury is given options for theories of guilt on at least like three of the charges, including the main charge, because there's this issue of either under the influence or 0.08 or greater. The way it originally read, Your Honor, manslaughter while operating a motor vehicle under the influence of alcohol was repeated twice, it was repeated once where there's an option for guilty, and then it was repeated again with both of the other options. We think that this is simpler, it's cleaner, it's clearer, and we believe that this verdict slip is the most appropriate one.
Mr. Lally?
Your Honor, as the court is probably well aware, the Commonwealth is not requesting any lesser included, and I certainly understand that if the evidence supports it, the defense requests it, that the court must give it. Having said that, the verdict slip that was used in this matter last year, the Commonwealth will submit is more than sufficient and adapted to the defendant's request. The only other thing I would bring to the court's attention, I don't know if Your Honor is aware, there was a case recently, while this case was going on, tried before Judge Lau, in which he had similar issues and had, I believe, used at least part of the verdict slip from the first trial, in this case, as sort of a template for the lesser included that he instructed and the verdict slip that they utilized in that case. I don't have a copy of it on me, but I can certainly get the court a copy of it. Looking at some copy of the docket, but that may be somewhat helpful if the court is thinking of
Okay, was that on murder case?
It was not, but it had to do with the felony motive homicide.
Yeah, I'll take a look at it.
Mr. Turk.
Mr. Turk. Mr. Yannetti, I don't believe I'm going to give this, but I'll take a closer look at it.
Well, we appreciate that. Judge Lau is an excellent judge. We think that this verdict slip is, it provides the most clarity for the jury. That's why we're
Okay, and that's where I think we disagree. So I will take a closer look at that. And so has it been filed officially and docketed?
I just handed it, I believe.
All right, so Madam Clerk, you have a copy up there?
The proposed, I think this is the only copy.
Okay, that's what I was wondering. Okay.
Do you need an extra copy, please?
Sure. Yes. Or, you know what, just mark it for identification, Margaret. We'll do that. Chrissy, please. Just for ID.
It's LLLL for ID.
Thank you. Mr. Lally.
Your Honor, just one request circling back to the constitutional instruction. So the Commonwealth is withdrawing its request for the instruction.
Okay.
However, would be seeking to make some argument or reference to his arguments to the jury related to specific areas which we would need judicial approval before we did. So the two areas that are sort of listed within that we would like to make some argument to the jury regarding is the defendant's taking of the Lexus from one metal that came to her parents' residence indictment, and then certain statements made in reference from the various clips that were played of her statements.
Okay.
In particular, would be the one where essentially she says it's a certificate to her.
Okay.
The exact quotation of it.
All right. Mr. Yannetti, do you want to weigh in on that?
Yes, we would object to that. I don't see it's her or me being evidence of consciousness of guilt. And the notion that she's driving from one residence that the police know of to another residence that the police know of, which is her parents' house. The car is open and obvious in the driveway. In fact, when the police call, she says, yes, come on over. I don't see that as being any evidence of consciousness of guilt.
Okay, so I'm going to allow them because they're permissible inferences from what's in evidence, but I'm not going to give, even before it was withdrawn, I wasn't going to give a consciousness of guilt on those.
And just to be further clear, there may be other clips.
Yes, so I did want to ask you, though, Mr. Yannetti, I think it's an argument that can certainly be made by the Commonwealth regarding the video clips that your client gave during various interviews. I think consciousness of guilt is a permissible inference from some of those. Are you sure you don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it as well?
No,
Okay. Okay, I just wanted to give you the opportunity. Okay. All right, anything else? Anything else, Mr. Unetti? We're going to hear from Mr. Alessi, but
The Commonwealth does not object to the redactions.
that's great. Thank you. One less thing you all have to do today, okay? I know. All right, so let's make that, are we switching that new redacted version with the exhibit number? Do we know what it was before? Excuse me. The redactions on the Higgins messages, that's what you're saying you're fine with, right?
Proctor Communications.
Proctor Communications, okay.
Right, this is the testimony that came in.
Of Proctor, yes. All right, so we'll find the exhibit number and we'll just... 209, is everybody in agreement that it's exhibit 209?
Yes,
Okay.
Does the court have a copy or do they need the Commonwealth?
No, I wrote on it. I need the Commonwealths.
So this is a clean copy.
So that will now be 209 in evidence. You know what? Can we make that 209A? We need, Mr. Unetti, we need to keep record of the first one that was not redacted. So any objection to making this 209A?
No objection to that. And so original 209 will not be sent in. Is that?
It becomes.
What do you think? Yeah.
It should become.
Yeah, so we'll switch it back to ID, and this will just be 209. All right, did we have an ID number on it originally? Can it still be that?
Is it redacted, the NNN? Or is it, no, it can stay that.
Okay.
Right, 'cause this is the-
Oh, it's just NNN, it's not,
Well, where did it?
no, it became 209.
So that
Our thinking is it needs to be sent back to letters for ID. I think.
Yeah.
So it'll be marked MM for ID.
That's great.
Perfect. And then the redacted version will now just.
209.
Yes.
Yep.
And we'll hear from you this afternoon. Just somebody send us an email to the clerk's office. So someone send an email to the clerk's office today letting us know if the Wolf PowerPoint is ready to be put into evidence after the Commonwealth looks at it. Okay, so we'll take care of that. All right, Mr. Alessi, I'll hear you.
Thank you, Your Honor. If I might suggest respectfully a procedure to the court, I have spoken with the Commonwealth about what the topic is. It's obviously not new to anyone, but perhaps to expedite this matter, if I might suggest to Your Honor to avoid a more lengthier argument, it might even truncate it down to 30 seconds. If we could hear from the Commonwealth on what we have requested, and the topic specifically is entitled Defendant's Motion for Curative Instruction regarding Exhibit 88 and Introduction into Evidence of Exhibits. The exhibits is taken care of. That's no longer an issue. But I did speak with Mr. Lally, and if I could suggest that Mr. Lally could state his position as I understand it, and then I can go from there, and it may not be necessary for me to continue on.
All right. What's the Commonwealth's position?
But Your Honor, Commonwealth's position is ultimately I defer to the court as far as whether or not it's an appropriate instruction to give in the final charge. What the Commonwealth would submit is that the contemporaneous instruction was more than sufficient to address the issue, and that it doesn't require any sort of differing language or further instruction given to the jury during the court's final charge.
Okay. All right, I'll hear you, Mr.
Thank you, Your
Alessi.
Honor. May I go to the podium?
Yes.
Thank you. Your Honor, I have given, and Your Honor has provided me previously with a generous opportunity to be heard on this, but I do need to cover some points with regard to the matter. I was was hoping to avoid doing this, but given what we just heard, it needs to be done respectfully. As Your Honor knows, we have submitted this motion, and as part of the motion, it really consists of two parts. The first part is the text and the basis for what we're requesting. I'll come to that in a moment. And then attached to it are is Exhibit A and Exhibit B, and those exhibits are our best effort at transcribing, because there's not an official transcript at this point of exactly what happened. Why did we put in the exhibits? We put in the exhibits because we believe it really sets forth and illuminates quite vividly what occurred. It occurred rather rapidly, but I think this allows for a much more these exhibits allow for a much more reflective analysis. So just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88 encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand. And then at a certain time in the cross-examination of our witness, Dr. Wolf, confronted Dr. Wolf with it as part of an accident reconstructionist cross-examination, and challenging Dr. Wolf on several aspects. And this one was particularly apt, the subject matter, not the manner of the examination, was, Dr. Wolf, you're saying this, these are your theories. However, did you consider and take into account the holes in the back of the hoodie? And that led to a series of questions and a series of answers. And I want to go right to the end, because I think going right to the end better elucidates what actually occurred and the depth of the issue and the problem here in this misconduct, which we believe was intentional. Specifically, the end is, we know, and I believe it is completely undisputed, that the holes in each and every hole in the back of the hoodie was caused by the criminalist, a witness in this case, Ms. Hartnett, who made those cuts as part of her analysis. And that was in May of 2023, long after the alleged incident of January 29, 2022. So that's sort of the end, undisputed. Now let's go back to what happened in the examination, the cross-examination of Dr. Wolf. So he's confronted, and I think, we put in Exhibit A and B of it, but what is particularly striking is on page 7 of Exhibit A, and it's the colloquy that starts in the middle, which we've yellow highlighting, Attorney Brennan saying, when you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm? Dr. Wolf started to answer, well, I know that there was cutting to, and I emphasize cutting, and then he was cut off by Attorney Brennan, and Attorney Brennan said, may I approach and receive the exhibit, Your Honor? And we note that in the context of many other statements in this regard as to what happened. So now this comes to the requested relief, and I'm going to move to the part of the argument, Your Honor, that we believe respectfully compels what we're requesting. So now I want to just state what we request. We believe what we've requested is quite modest given what happened. And our proposed curative instruction is on page 2 of our motion. It states, during the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022 from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police, I've got the acronym MSP, Crime Lab, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Please juxtapose that with regard to the instruction Your Honor had given, which was a sentence, so, jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt.
Didn't I include the date you requested, the May 18th date? I thought I did.
You know, Your Honor, I think the answer is no, but because I'm doing it from memory and I don't...
This is not an official transcript, right?
Exactly, Your Honor, so I can't say it with certainty. I don't believe it was.
Okay, because that date you told me was important to you, right?
Among other factors, the date was important.
It's May 18th, right?
Yes, Your Honor.
Okay. Go ahead.
And so, Your Honor, I believe what is fair in the analysis and as objective as I can be here is, I think the curative instruction has to tether to and relate to in its details the degree of what happened. This was on a very significant topic, accident reconstruction, a significant piece of evidence, the hoodie. There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident. And then to show the witness on this for the defense, it clearly left the impression to any objective observer that Dr. Wolf had somehow been incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury, therefore, should not weigh and value his opinion. This is very, very significant, and I underscore, Your Honor, we didn't cause this problem. We didn't cause any of this issue. So, to me, I do not understand why the Commonwealth would not support this. What we have written down here supports the truth. We all, I believe, should have the common goal of the jury receiving the truth. I looked at the jury, I'm no soothsayer or mind reader, but I looked at the jury and they looked confused when I looked over at them. But I think even aside from looking at a jury, what Your Honor did in good faith, I don't believe is clear enough on this key issue. And I'm not understanding why there would be any real contest over making it clear to the jury on this very important point. The defense, to my point of being measured at the time and being measured now, we could be requesting a lot more statements about what occurred. And I've been in situations in other trials where things have happened and there's been many more significant things stated. So in conclusion, Your Honor, the defense not having contributed at all to this issue, the significance of the issue, the significance of the error, it's undisputed about the error, to me, respectfully, all augurs for more clarity here. And the final point, there's two issues here. There's the fact of when these holes occurred, these cuts, and how they occurred. That's one bucket. But the second bucket, which is not in the current instruction, is our expert witness, Dr. Wolf, and the impression left upon him And that is why we have the language in there, again, we believe quite measured, just the sentence at the end to take care of the harm to our witness with regard to what occurred. So, therefore, Your Honor, we respectfully request that this be given so that the jury has a clear and complete and truthful understanding of not only what happened, but also to make sure that it is what's created for the jury is accuracy, hence truth can be concluded. Thank you, Your Honor.
Okay, thank you. I do just want to point out one thing. It was not objected to at the time it came in. That's my only comment. I will consider this. I'm going to hear from Mr. Lally. I will consider this.
What is it that was not objected?
The testimony was not objected to. I didn't hear this until I think after another witness.
Your Honor, if I could, thank you for raising that. 10 seconds for that. I will, and I made this point the very time that I made the argument last time. We were not shown that Exhibit 88 in the encasement. It was behind the witness. We didn't even know that it was behind the witness. So what happened was Attorney Brennan went up, retrieved it, and immediately went to the witness with it, showed it. We couldn't even see what was happening. There was no physical nor other ability for us to object at the time. So I appreciate you giving me the opportunity to respond to that.
All right, Mr. Lally.
Very briefly, Your Honor.
Keep your voice up, please.
Yes, very briefly. I'm not going to get into a belabor the point as far as the back and forth about conduct of counsel. During the heat of trial, during the heat of the extended exchange with the witness on the stand, things can happen. Mistakes can be made. It was recognized, acknowledged, and accepted as a mistake. There were numerous offers by the Commonwealth to offer a stipulation as to the truth as far as the evidence is concerned that were rejected by the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in. There have been many instances of similar type conduct that didn't result in a curative instruction, and to accentuate it further in the final charge to the jury is simply improper. It was a situation that arose as far as whatever misstatement was made at the time, as far as whether it's from the testimony from the witness or the question from counsel, was immediately remedied, was taken care of. I don't think that there's any confusion by the jury, and furthermore, as I indicated, the Commonwealth offered a stipulation at the time that this occurred, which was essentially rejected by the defense. They got the curative instruction at the time. That is all that is required. It is more than sufficient, and it doesn't need to be accentuated or addressed further in the final charge.
Okay. So I'll consider it, Mr. Alessi. Okay?
Thank you, Your Honor.
All right. Anything else? Two things I'd like to talk about for scheduling. The jurors get here early. I'm going to ask if the court officers to call the jurors and ask them two things. To ask them if they can get here a little bit earlier so that we can all be in the courtroom at 8:45 ready to start. So things take a little while generally. That will assure us the closing arguments will start right at 9, maybe a few minutes earlier. The goal would be to hear arguments from both counsel and then take an early lunch break. I would ask the counsel plan on just a half an hour lunch break. I'd like, the point being, I want the jurors to start deliberating. I don't want to end the charge and send them home for the weekend. That's not fair after they've waited so long. So a short lunch, you're free to stay in the building, and court officers will help you with accommodations for that. But a short lunch, and then I'll come out and do the charge. And then at least, hopefully, there'll be some time for them to deliberate. I'm going to ask the court officers to call the jurors to see if they can stay as late as 5 o'clock or 5:30 tomorrow night. I just don't think it's fair after they've sat through so much of this trial with the various delays that we've had to not let them start deliberating.
We have no objection to request we have, Judge, is during the last trial, during deliberations, the court had asked us to be within 5 minutes of the courthouse. My office is about 10 minutes away.
I'm sure we can make accommodations for that. But at some point, we may have to talk about security issues. So a lot may depend on that.
Understood.
All right. Does the Commonwealth have any objection to that schedule?
No, Your Honor, not at all.
All right. So we'll see counsel in here no later than 8:30 tomorrow morning?
Sure.
We'll counsel here at 8:30. All right. Thank you.
All rise for the court, please.
Oh, there you heard it. Folks, mock jurors. Mock jurors, get in the chat.
Goodbye.
Get in the chat, mock jurors. We got more to go, by the way. The Aiden TurtleBoy Kearney case is going to come into session. Mock jurors, get in the chat. You are about to get charged tomorrow. You are going into deliberations on the public stream in the chat. Tomorrow, ladies and gentlemen, deliberations begin. Jurors will be staying late. Oh, we got to stick around. The Aiden TurtleBoy Kearney case is not yet in session. Oh, Super Hank, ladies and gentlemen, he's saving his strength. Super Hank is saving his strength. It's about how long it takes them to get to the courthouse, giving the state police notice that they're coming. You like 10 minutes is enough, but they just got to talk about how they're going to get to the courthouse, etc. Ladies and gentlemen, the state withdrew their consciousness of guilt instruction, but does get to argue about some elements of it in closing. My name is Grant Smith Ellis. We're waiting for the Aiden TurtleBoy Kearney case to come into session. Ladies and gentlemen, we might go on verdict watch tomorrow. We're going on verdict watch tomorrow in the Karen Reed and John O'Keefe trial. We are going on, yes, there might be a verdict today in the TurtleBoy trial. Do not go anywhere. Ladies and gentlemen, we are getting ready. I need to make an announcement. Hold on, little towels. Hold on, little towels. Just in the charge conference in the John O'Keefe and Karen Reed retrial is done. Closing arguments at 9 a.m. sharp Friday. Deliberations to begin in the afternoon. Now, we await a verdict in the Lindsey Gaetani and Aiden TurtleBoy Kearney trial. I am a horse racing announcer, clearly. I need to get lunch. Ladies and gentlemen, I need to get lunch. Also, I am very grateful to those of you out there spending time supporting Lindsey at court today. God bless you, little towels. You are wonderful humans. Towel is so grateful. Towel is a little towel. Now, we're waiting for the Aiden Kearney case to be called. Ladies and gentlemen, I am monitoring. Get ready. Mock jurors, we're about to do the announcement again. I'm going to put the list up on the screen. Oh, ladies and gentlemen, I hope you're ready to find out who is on the mock jury. I know you already know. Oh, my goodness, Harvard Yard. Oh, dear goodness. Oh, my word, ladies and gentlemen, Harvard Yard, the super towel themselves. Oh, you are so kind. My dear friend, I am overwhelmed. Hold on, Harvard Yard. Hold on. I must shrink this. Ladies and gentlemen, please say hello to Super Towel Harvard Yard. It's not just because of the super chat. Harvard Yard is someone who will reach out and say, little towel, isn't this the most interesting thing you've ever heard? And I will be like, yes, that is absolutely fascinating. You are a super towel. Oh, ladies and gentlemen, let us drop some thank yous in the chat for Super Towel Harvard Yard. There is no one like the super towels around here, ladies and gentlemen. Towel is grateful. Towel is shouting out Harvard Yard, not just because Harvard Yard said before the verdict madness starts, thank you, Grant and the Towel universe, for your coverage, community, and education during the trial. Justice for John O'Keefe. Grant, please explain the importance of jury instructions in Grant's style. It's all very important. Big love and hugs to all. Now, you know I absolutely would have done this for you, little towel friend, if you had just sent me a message. I think your super chat is wonderful. Now, and I want to let you know you can ask any questions you want. If I see them in the chat, I'll answer them. But this is a wonderful super towel chat. I literally have to come onto chat so I can like it, and even though I'm waiting for the Aiden Kearney trial to start. So here's how jury instructions work. Ladies and gentlemen, if you're on our mock juries, this is actually the best way to do it. Hold on, let me turn down this volume. This is the best way to do it, little towels. I'm going to announce our mock jury again. If you hear your names called, little towels, if you hear your names called, oh, get ready, because tomorrow is the day you are going to be sent into public deliberations. Now, I'm going to read these names off. We have our 4 towels selected. If you are a 4 towel, drop your 4 towel salute in the chat. Ladies and gentlemen, the mock juries are Jury 1, Marie 623TX, Kim Cordeau, Alicia B, Christina, Eva, Colleen Henry, we say howdy here, Rachel McIntyre, Irene Grillo, Rita P, Sarah L. Shenanigans, and the 4-towel themselves, Ann Twittick. Jury number 2, ladies and gentlemen. Oh, God bless you. Romans 8:28. I love it. Jury number 2, Tiger Lily Girl, Chastity, Artworks 2, Jew Drops, Jack D65, Sun-Eyed Girl, Luisa Ramirez, Curly Girly, POG 3909, Mandy Strong, Z Travels. And the 4-towel of jury number 2, the commander of the Towel Expeditionary Force in Europe, the towel sometimes misgenders, Deaf Otter themselves. Can you really misgender an otter? I don't know. Ladies and gentlemen, if you are listed, here's how we're going to do it. We had a long discussion on Towel Chat. This is what I want to do. 1, did you know we have new Super Towel emojis, ladies and gentlemen? We have an emoji of a ham sandwich for Dr. Rentschler and also Hank Brennan with his Super Towel cape. Now, I'm going to just take these pictures down for 1 second, although I love both of them. The Rentschler is staying, though. The Super Towel Hank can stay, but I need to find a place for him. The Rentschler, where's the Rentschler going to go? I got to be a creative little towel here. Hold on. All right, little towels. I'm going to put the Rentschler right over here. All right, now, my dear little towels, my dear wonderful little towels. We have things to do. Oh, we're looking at Christina Rex and Nevercracker. Really, I had that up so I could show the total view count. We are doing well, folks. 7.3K over on the X. Now, I don't think we need this. Let me get rid of that. All right. Now get this up. All right. Now we did a bunch of case law for no reason because they didn't argue consciousness of guilt. I think they would have won it. I really think they would have won it, ladies and gentlemen. But needless to say, Judge Cannoni wasn't leaning that direction. So, what do we got to look at? We were going to do our the importance of the oh goodness, the Aidan Kearney case is about to come into session. Okay, so the jury instructions tomorrow. When you all get your charge, it's incredibly important, ladies and gentlemen. When you get charged, you are going to be told the elements of the offenses, okay? The different types of second-degree murder, OUI manslaughter, the lesser included offenses, maybe not the lesser included offenses, but also leaving the scene of an accident. Then you're going to get some other instructions about how to handle evidence. It's going to take an hour. Judge Cannoni is going to read them to you. At the end of that, you'll go into deliberations publicly on Towel Chat. Now, the way we're going to do that, ladies and gentlemen, is I'm going to take Towel Chat, and you are all going to deliberate publicly with your towel friends right here. Brewski the Irish Setter is going to be one of our court officers, as is, hold on, I have the name here. Hold on, I have the name. We're getting ready for the Aidan TurtleBoy Kearney case to be called. Get ready, little towels. It's going to come over your screen soon. Carrie-Ann is one of our bailiffs. So, little towels. I'm going to jump forward. First of all, God bless you. I just want to say again, watch this. I'm going to do it right now on stream for you all. You can do it like this. God bless you, Harvard Yard, for all of your amazing questions, love, and support of Towel Channel and your towel friends. You are loved and embraced in this fluffy universe, my dear friend. Heart, heart, heart. Oh, yes. You love it. I love it. Now, I can't miss too many of your comments. Now, watch what happens when I click this comment scroll, ladies and gentlemen. Oh, goodness. Oh, goodness. We missed hundreds of comments. I'm so sorry. I feel terrible. All right, here we go. A little bit. Hi, Harvard Yard. You're a super towel. So this is where deliberations. This is what deliberations are going to be like tomorrow, ladies and gentlemen. We're going to see it fly. I'm going to make as many comments as I can fit on the screen. And let me just say, oh, hold on. I hope the defense is, Jennifer. I hope. Towels for Justice, Crime Cricket, you are a super towel. Now, we're getting ready for the Aidan TurtleBoy Kearney case to be called. Are you excited? I'm excited. Ladies and gentlemen, we're going on verdict watch tomorrow in the Reed case, and then we're going on verdict watch today in the Aidan Kearney case. Oh, goodness. Oh, goodness, little towels. Now, let me see what I can do here, little towels. I don't think that's going to work, but hold on. I got a little towel plan. Did you know, ladies and gentlemen, that I am the man with the towel plan? Now, you might be saying, sir, you are a towel. I know I am a towel, but I am also a man with the towel plan. So here's what we're going to do. We're going to watch the Aidan Kearney case. I don't think we're going to actually be able to watch it, but we are going to be able to listen to it. So let's go over here, ladies and gentlemen, and let's do this. I think I want to add the image. So hold on. Yeah, it's going to be an awesome deliberation. We're going into verdict watch today in the Aidan Kearney case, I think. We're just waiting for the case to be called. Ladies and gentlemen, I'm going to order towel lunch soon, but as Towel gets ready to order towel lunch, guess what we get to do? I'm going to bring up a picture, which we're going to use while we wait to get an audio feed. I'm taking a look at the different YouTubers to see if we can get an audio feed of the Aidan Kearney case. Now, you are going to listen right up until the 1 o'clock lunch break. I'm going to eat lunch before the lunch break. Then over the 1 to 2 p.m. lunch break, we're going to talk more about jury instructions. We're going to talk to our 4 towels. We're going to get ready for deliberations tomorrow. We are just genuinely going to be little towels. Now, I know you're all very excited for that. I'm very excited for that. I am a towel. Now, you might be saying to yourself, sir, you are clearly not a towel. Well, how do you know I'm not a towel? What if I am indeed some kind of anthropomorphic towel man who runs around like a towel man? Yes, ladies and gentlemen, I am a towel. All right, so with that out of the way, someone was like, Grant is clearly someone who knows he's a towel. I know you all love it. I love it too. We're getting ready for audio coverage of the Aidan Kearney and Lindsey Gaetani and Aidan TurtleBoy Kearney trial. Just give me one little towel second here as we get this ready. I'm checking around for streams, getting ready for the court. The reason why there's no streams is the court isn't in session yet. Little towels. So I'm taking a look here. I'm being a little towel. I'm also saying hello to Super Towel at Dewdrops and our other towels who have been recovering. Anyone who might be in the hospital, we are keeping you in our thoughts. Towel is not going to have a breakdown today. I can do this, ladies and gentlemen. Now, you might be saying, Towel, you're already doing this. You are on my screen right now. Well, yes, but we're going into verdict watch in the Aidan TurtleBoy Kearney case. That's intimidating. You don't understand. All right, so my little towels, we are just waiting. All right, we're just waiting. As soon as the Aidan TurtleBoy Kearney case is called, you will know, I will know, we'll all be little towels. And every single one of us, ladies and gentlemen, will be little towels. I'm excited, you're excited, and we are little towels. All right, so my dear friends, as we sit here, as we wait, there is no movement yet in the Aidan TurtleBoy Kearney case. I'm like a David Attenborough towel as we await. Oh, ladies and gentlemen, nothing yet. We're waiting. We are waiting. Little towels. We are waiting. Will indeed we get any movement in the Aidan TurtleBoy Kearney case? Now, I don't know, little towels. I am just an observer, but if we get it, if I can find a stream, if we can do this all together, oh, we're going to have a towel day, ladies and gentlemen. And you might be saying to yourself, sir, we are already having a towel day. But yeah, if we get to see if we're on verdict watch, we might go on verdict watch in the Aidan TurtleBoy Kearney case. Oh, lordy, ladies and gentlemen. That's what you want to see. Now, I'm here. I'm monitoring. I'm being a little towel. Oh, Macy, it was just the jury charge argument. The defense withdrew the defense is not doing third-party culprit at all. They got a Bowden instruction, which is just attacking the quality of the investigation. And furthermore, there is also very little that the defense is going to be able to do. Very little that the defense is going to be able to do, little towels. Oh, goodness. The defense withdrew their missing witness instruction request. They withdrew their destroyed evidence jury instruction request. They're cornered. It's bad news bears, ladies and gentlemen. So now we're monitoring. We're keeping a close eye on the Aidan TurtleBoy Kearney case. As soon as that comes into session, you're going to hear it, ladies and gentlemen. You are indeed going to hear it. We're going to keep a close eye on it. We're going to listen right in, little towels, and we're going to hear if one of these streams will pick up the case. Now, of course, ladies and gentlemen, the way that this works is the Aidan Kearney case is in district court, so you haven't missed very much. Oh, no, little towels. I dropped my water bottle. I got it. You haven't missed very much in the Karen Reed trial. Oh, the other update from the Karen Reed trial, little towels, is that there's going to be opening arguments to 9 a.m. sharp. So 8:45, everyone's in court. 9 a.m. sharp, opening arguments tomorrow in the John O'Keefe and Karen Reed retrial. Now, the jury's going to take a 30-minute lunch after closing arguments, okay? After the jury takes their lunch, they're coming back, they're getting charged. You all mock jurors are going to get charged by Judge Cannoni too. And then, as I mentioned, all you mock jurors are going to deliberate in real time. Now, we're about to listen in on the Aidan Kearney and TurtleBoy, the Lindsey Gaetani and Aidan Kearney case. I hope you are excited. We might see a verdict today in the Aidan Kearney case. Oh, my word. Now, the court is not yet in session, Little Towels. I'm monitoring. I'm going to pause this to save us resources. Out. All right, I'm going to pause that to save us resources. All we are waiting for now, Little Towels, is for court to come into session. Oh goodness, Little Towels. Now, I'm monitoring. Sorry, I didn't mean to make that. That was a system sound. I am monitoring, Little Towels, and we are watching. What are we going to see? What are we going to hear? That's okay, Sun-Eyed Girl. You know, that's absolutely okay. You can join deliberations at 4 p.m. Eastern. We're going to allow it. So, ladies and gentlemen, I'm going to make a note on this, on my towel note here. I am the towel executive. Sun-Eyed Girl, you are on jury 2, 4 p.m. Eastern arrival. That is perfectly fine, Sun-Eyed Girl. We will not allow a formal vote from jury 2 until 4 p.m. Eastern. So don't you worry about it, Sun-Eyed Girl. No, Paul O'Keefe might be a witness today, though, in the Aiden Kearney case, which is why that's what we're going to watch, Little Towels. So we're sitting here. We're waiting for the Aiden Kearney case and the Lindsey Gaetani case to come into session. Isn't Lindsey beautiful, by the way? I think we should just let her know that. Oh, Little Towels. I think Lindsey Gaetani, and I think all of the towels of the world are beautiful. And we are just, make us proud, Lindsey, make us proud, jurors. Let's get this case going, ladies and gentlemen. We're waiting for the Aiden TurtleBoy Kearney case to get called. It's past 11:30 a.m. When are we going to come into session? Oh, Little Towels, I'm in horse racing announcer mode, and as soon as the case comes into session, you are going to hear it, and you're going to see me up on the screen. Oh, my word, what's Paul O'Keefe going to testify about? What are the other witnesses going to talk about? Is Towel going to get his lunch? The answer to these questions and more, ladies and gentlemen, today on... Here we go. Here we go, Little Towels.
Commonwealth versus Aiden Kearney.
Well, go away, please. Thank you. Go away, please. Thank you. You finished your direct examination, is that right? I have, Your Honor. All right. Witness, can you take the witness stand? Okay. All in the case. All in the case.
And do you swear in the now hearing to tell the truth, the whole truth, and nothing but the truth, so help you God?
Thank you very much. Good morning, sir.
Morning.
You're Colin McCabe,
That is correct, yes.
and you are related to some of the witnesses in the Karen Reed matter.
Yes, I am.
And who are those folks?
My brother Matthew McCabe and my sister-in-law Jen.
So back on 2/26/24, you were here as part of a group of people going to court in the Karen Reed case, right?
That is correct.
And it was a 2 o'clock hearing.
I don't know what time.
Well, you were there in the afternoon, weren't you?
Yes, I'll be there.
All right. And so you know that the court goes till 1. There's a lunch break from 1 to 2, and then they start up again at 2, right?
Yeah, I have no idea what time they're going.
Okay. So do you know what time you were here with this group that day?
With the group? I know I was there in the afternoon. I don't know the time exactly.
Okay. How did you come to be informed that you should meet at that location?
I spoke to my brother and I said, I'll meet down at the courthouse.
And that's Matt McCabe?
That is correct.
Okay. What was your understanding of what you were going to be there for and what was going to happen that day?
I was coming in to support the O'Keefe family and the witnesses in the case. So, support group.
Have you ever met had you ever met Lindsey Gaetani before that day?
No, I had not.
Okay. And when you got there, did you have any conversation with her?
No, I had not.
How many people approximately had gathered at that area behind the registry of deeds in your group?
It was a good sized group. It was kind of broken up into multiple groups, but maybe 20 or 30 people, maybe. I have no idea.
And was Paul O'Keefe there?
I have no idea. He might have been. I have no idea.
So, did someone introduce you to Ms. Gaetani?
No, I never met her.
And you said it broke down into 2 groups as everyone came towards the courthouse, is that right?
That is correct.
Who was in your group?
In my group, multiple people, I have no idea who they were. My sister, my aunt, my cousin.
What are the names, please?
My cousin?
Yeah, the names of the people that were in this group.
I don't know everybody knows in the group, but Kathy Faulkner, my aunt. Shannon Sullivan is my cousin. Megan McCabe is my sister. I think a few of my sister-in-law's sisters were there. I don't know their last names off the top, man, but Michelle and Denise and everybody else. I don't know who else was there.
What was your understanding of the hearing that was going to happen that day?
My understanding was just it was a quick hearing that day, go in, see what happens, and then leave.
Okay. So you walked towards the courthouse from the Registry of Deeds, correct?
That is correct.
And which way did you walk? Let's say you're walking towards the courthouse from the Registry of Deeds. Did you go to the right around the building, or did you go to the left around the building?
Came up the driveway side, so I think that's the left around the building. If you come from behind, or if you're looking at it, to the right. So it depends on which side you're on.
Okay,
So
so
the rear, it's on the left side. You're looking at the front of the building.
okay, so can we say it this way, that you came up between this building and the registry?
Yes,
And that's when you came into the court?
that is correct.
What happened when you got inside the court?
When I got inside the court, I then went through the metal detector and everything, came in the building, walked up the set of stairs to where there was a group of people waiting to get into the court.
Did you see Ms. Gaetani inside the courthouse at all?
No, I did not. She wasn't in.
Did you end up getting into the courtroom?
No, there were too many people and there was a head count on the numbers that can get in, so I was at the back of the line, so I did not get in.
To your knowledge, did Mr. Carney get into the courtroom?
Yes.
At some point, so just to set this right, you're outside the courtroom, but in the courthouse.
That is correct.
What did you do while you were in the courthouse waiting around?
Just sat there waiting.
How long did it take?
Wasn't long, maybe half hour.
And what happened after half an hour?
Then after that, when the court let out, everybody started coming down the stairs. I waited for the group that I was with to come out, and then I proceeded to fall behind them and exited the courthouse.
And did you see Ms. Gaetani as far as exiting the courthouse at all?
At that time, I had no idea who she was, but she was in the group of people that was exiting.
So I'm glad you brought that up. A lot of these observations that you have, that you've offered, are from you looking at video and then realizing stuff later, right?
Me looking at a video and realizing, yes.
And one of them is figuring out who Ms. Gaetani is, right?
Well, no, when we were in the back parking lot, I then found out who she was when we were back.
So did you recognize her in the courthouse or not?
Yeah, I saw her when she went into the courthouse.
Did she have a piece of paper in her hand?
Yes, she did.
And what was your understanding of why she had a piece of paper in her hand?
My understanding of what that was all taking place when I was standing at the doorway waiting to get in. She had said to the court officer that she had an order against Mr. Gaetani.
Did you talk to Jennifer McCabe about Ms. Gaetani at all?
No, I did not.
It's true that Ms. McCabe was with Ms. Gaetani on the way in and on the way out, wasn't she?
She was part of the group, yes.
Did you hear them talking?
No, I did not hear them talking.
Did you hear them approaching the courtroom?
No, they were in a different group than me.
So back to leaving. You leave the courthouse, and is it still two groups or is it one big group now?
When I left the courthouse, it was one big group.
So Ms. Gaetani's in that group?
Yes, she was.
Ms. McCabe, Jennifer McCabe's in that group?
Yes, she was.
And you're in that group?
Yes, I was.
And how many people roughly in the group?
I don't know, probably about 25 people maybe.
And when you were leaving, the hearing had concluded and a lot of people were streaming out of the courthouse, weren't they?
Yes.
Some people went to the right down the handicap ramp. Some people went down straight, right?
That is correct.
There was probably over 100 people out in front of the courthouse when you left, right?
It was probably more than that, sir.
More than that, okay. And you and your group went out of the courthouse and you went down the handicap ramp, right?
That is correct.
And you came to the bottom of the handicap ramp and you were jawboning with some of the protesters out there, weren't you?
Yes, some things were being said to me, and I responded to the things that were being said.
Sure. And you called somebody retarded and you said something about somebody could be committed or something. You're waiting for them to be committed, right?
Yes, might not have been the best choice of words at that time, and I regret saying that, but yes.
And as you're leaving, Ms. Gaetani's in your group and everyone's sort of walking together away from the courthouse, right?
Correct, to go across the street to where the cops are parking.
Right. So everyone's walking at first along High Street towards Dedham Center, right?
That's the name of the street. I don't know the name of the street, but.
Well, let's do it this way. In the street in front of the courthouse.
Yes.
You exit, you get to the bottom of the handicap ramp, you make a right, you're walking towards town.
Yes.
And you're kind of walking towards this building,
Yes.
but across the street.
Correct.
Then you get to the crosswalk, you walk over to the same side of the streets that this building's on, right?
Yes.
And then you walk down that little street that's in between this building and the Registry of Deeds building, right?
Yes.
So all this time, you're walking away from the courthouse.
Walking away from, yes.
And you're walking away from the Registry of Deeds building, I should say the front of the Registry of Deeds building.
Well, no, technically when we're crossing the street, I'm walking towards the registry. And then as we're walking down the side of the street, then yes, I'm not walking away from the Registry of Deeds until I get kind of.
Okay, so you get to the side of it, you're walking along the building, away from the front of the building, right?
That is correct.
I'm going to show you some photos. May I approach, Your Honor? I'm going to show you these three photographs. I've shown these to counsel. Take one of those. Tell me when you're trying to familiarize yourself with those. Okay, are those close-ups of you and your group leaving the courthouse?
Yes.
Are they fair and accurate representations of your and your group's departure from the courthouse that day?
Well, this one here, yes. These ones right here, I don't know exactly where it's at.
Well, do they show the same people that you were with that day?
There was multiple people there. It shows a few of the same people that I was with that day. I don't know if it's everybody.
And so can we agree that it's a partial representation of some of the people in this group when you left?
Yes.
And offer these judges the next three exhibits.
No objection.
Thank you. Okay.
Exhibit 41, 42, and 43.
Okay. You just take those back.
Sure.
Thank you.
There you go.
Thank you. Show you, exhibit 41. Who's the gentleman in the red desk?
I'm thinking that's me.
And that's a picture of your group requirement, right?
That is correct.
All right. And then exhibit 42, who do you recognize in the photo? In that photo?
I recognize my sister-in-law.
Names, please.
That is Jen McCain. Recognize, I don't know her name, but that appears to be my sister-in-law's cousin. And I recognize one of my sister-in-law's sisters. Not sure which one it is, either Denise or Michelle. Terrible one, you know.
Okay.
There's no one there, and I think, it might be a sign of maybe my sister, but I can't 100%.
Exhibit 42 for the record. Thank you, Madam Clerk.
Thank you.
Exhibit 43. And, do you recognize him at all?
See, that is Chris Albert. One of my sister-in-law's sisters, either Denise or Michelle, and then that's, one of my sister-in-law's brother-in-laws, that's, Bob. And then I see, looks like my sister-in-law's cousin, I'm not sure her name. I see the side of one of my sister-in-law's, sisters, which is, Denise and Michelle. And, then that appears to be, Lindsey Gaetani and the side.
Exhibit 43.
Thank you.
So when you walked out, there was a pretty raucous crowd, yelling and screaming. You're engaging with them. They're giving it to you, right?
Yeah, it was a pretty chaotic situation, yes.
And you never heard anyone yelling, liar, liar, did you?
I don't know what I heard. I only heard a couple of things being stated myself, and those are the things I responded to.
Sure. Now, in all the video you looked at, all the photos you dealt with, there's no photo, there's no representation of Mr. Carney and Ms. Gaetani in the same frame or the same video. Isn't that correct?
From the photos you just sent me, no.
From everything you looked at, you said that you looked at some things to figure out what happened, right?
Well, yes, in one of the, in the video that I took.
So it's a yes or no question. I'm not asking you for a narrative. I'm asking you if in all those reviews, you saw any frames, pictures, stills of Mr. Carney and Ms. Gaetani in the same picture or still.
So not a video, just a still.
Any of it.
Well, in the video?
A still of a video or a photograph. There's no picture where they're both in it.
No.
So were you aware that day that Ms. Gaetani had a restraining order against Mr. Carney?
I heard about that after the fact.
So at the time you didn't know?
No, I had no idea.
Did you speak to Paul O'Keefe that day at all?
No, I did not.
May I have one moment, please, Your Honor? Thank you. Nothing further, sir. Thank you. Thank you, Your Honor.
No redirect, may the witness be excused if he wishes to leave. All right, thank you very much.
Brian, Commonwealth. Council of scheduling. I'm just going to address the motion of quash.
Thank you, Your Honor.
Council, thank you for your patience. Where are we on this right now? Have you folks talked at all? You remember the court's partial ruling is that the motion of quash is denied as relates to testimony.
Yes, he's our third or fourth witness, I think, Your Honor. And we would like to get a look at his text messages with these other people about this notion of inviting Ms. Gaetani with her restraining order to this court session.
What's the witness's position relative to that motion for?
Let me state, if I may, Your Honor, because I've sat here for a couple of days, so I think I understand the case a little bit better than I did before it started. This is still Rule 17, subpoena summons. Relevance is still relevant. At the beginning, I said to you, Your Honor, and I can see that you witness. I agreed at that time, or I heard what is coming today. If I understand the facts correctly, the operative time frame is leaving the property. I accept that there was testimony that came in yesterday that there may have been some communication with my client about arriving at the courthouse that day. But the question for this case is what happens when leaving the courthouse or back to the registry of deeds and whether there's a violation of an ordinance. I've looked at every one of those photos, every one of those videos. My client is nowhere to be found. He was not there. He was no longer a precipient witness to those facts.
What's your position on Mr. Brado seeking some of these phone records that you're opposing?
I oppose it vehemently. I mean, he's asked for unlimited scope on
We're
4 different people.
going to talk about that.
We did talk, Judge, and I narrowed the request to 30 days prior. And
what's your offer of proof of what you believe is going to be relevant from that?
Sure. So we contend, Judge, that there's a conspiracy between Ms. Gaetani, Mr. O'Keefe, Ms. Jennifer McCabe, and probably other members of the Albert McCabe family to, now that Mr. Carney's out of jail, a couple days out of jail, they know that she has a restraining order. They invite her to the courthouse to kick Mr. Carney out of there and sort of exact some revenge on Mr. Carney, interfere with his reporting, etc. So what do we have for that? We have.
Let's assume that's the case.
Okay.
Where does that go relative to this charge? Just. In my role as a judge only here.
Sure.
Not a fact.
Well, it goes
Let's assume
to credibility, Your Honor, in terms of that they're trying to create a restraining order violation.
Bad motive.
Yep.
So
Bad
now
motive.
where do we go from there? Relative to this charge?
Yeah.
Bad motive.
So Ms. Gaetani testified that she was invited by Mr. O'Keefe or the O'Keefe family. She involved another nemesis of Mr. Carney, Kate Peter, that she was the broker of this thing. And, you know, Paul O'Keefe is sitting in the courtroom. He's on video and it's in evidence, walking in with Ms. Gaetani. And I think he's a relevant witness to what transpired and why it transpired.
He's going to be in this courtroom testifying.
Right.
But as far as the prelude to that.
Right. Well, it's a conspiracy, so they had to have communicated. And, you know, we want the communications of how this was set up to try to create a situation that Mr. Carney would fall into the trap.
I appreciate your offer. I'm going to deny the text message rule 17, but you are going to be able to call him as a witness. I don't know what the timing is across the street. I want to be obviously sensitive to it, but we have to move on. So we'll keep that in mind. The motion to quash is denied as it relates to him as a testimonial witness. It's allowed as it relates to documents.
Your Honor, Vice President.
Thank you.
Thank you.
All right. You rested.
Yeah. Motion for required finding not guilty, Your Honor.
Yes, sir.
Yeah. Oh, thank you, Your Honor. I appreciate that. So, Judge, even in the light most favorable to the Commonwealth in this case, Judge, there's no evidence of any criminal intent. There's no evidence whatsoever that Mr. Carney was trying to violate any court order. Mr. Carney did everything right. He was at his place of work. And again, no different than if he's at the Exxon station down the street in the mechanic station. He's working. She knew he was going to be there. She goes there to evict him. He goes with it. He gets up and leaves. And he walks a circuitous route down, away, and he checks in with the government. This is the key point here, Judge. This is what's fatal to the government's case. He checks in with a policeman. He reveals the situation. The policeman says, go over there for now. He goes over there. Then things change. The hearing ends early. She comes down. Hundreds of people come down, over 100 people, however you want to see it. You have the video, you've seen it. People come out. Everyone's got a black coat on. Everyone's got black glasses on, black hair. It's a sea of people. Mr. Carney's there. He's live streaming. He's talking about what just happened to him. And he's in the general vicinity of where the policeman told him to go. I would suggest that as a matter of law, the government is stopped from then prosecuting him for doing what they told him to do. And, you know, the only reason we're here is because of the poisonous atmosphere that surrounds these cases with respect to the Norfolk County DA's office and my client and the Reed matter. Any reasonable prosecutorial agency, Judge, would look at the case and say, wait a minute, they're saying there was a violation 10 minutes ago. A cop was there 10 minutes later and they don't report it. And it's just a ridiculous scenario that if they had seen him, in other words, if there was contact, they would have made sure he got arrested. And this is all reverse engineered. They looked at the video later on. They saw that he was there, and then they called, hey, he was there. We just looked at the video. And they trying to create contact after the fact, Your Honor. Mr. Carney is not doing anything outside of what he was told to do. He left, he walked that route, he went right to a policeman, he was told to go somewhere, and he went there. He was waiting there, Judge. The evidence will show, if we have to do a defense case, the evidence will show that he was waiting there to report to the officer who was busy at the time. He didn't want to go off alone because he didn't know where she was going to go. That's his state of mind with respect to Gaetani, is that he doesn't know what she's capable of. He doesn't know what she's going to do next. He just got out of jail from her locking him up for 60 days. So he wants to stay with the policeman. He stayed where the government told him. He wanted to get a chance to report and document and get the officer to take some notes and write a report about what had just happened. He didn't want to go off this direction or that direction or to a car or whatever, because he didn't want to end up like Frank Keegan. He didn't want to end up at her mercy. She goes to him, she calls the cops. He had just seen that video, the evidence would show if we had to do a defense case. He had just seen that video a few days earlier, and he sees what she's capable of. He's terrified of this woman. He doesn't want to engage with her. He doesn't want to provoke her. He doesn't want to give her any ammo whatsoever. That's what the evidence showed here in the Commonwealth's case, is that he did everything right. He followed the Commonwealth's representative at the time's directions, and that should end the case, Your Honor. So that, as a matter of law, I respectfully submit, should require the court to enter a required finding based on the government's actions, based on the unequivocal, uncontested testimony surrounding Officer Crump, that he said, go over there for now, and he did that. I would ask you to dismiss the case, Judge.
Mr. Bradle has just treated Your Honor to a lot of pseudo testimony about the defendant's state of mind, and he's focused on his defense. He said very little about the Commonwealth's evidence, but if Your Honor is instructing a jury, I believe if you follow the model jury instructions, you would instruct the jury that there are 4 things that the Commonwealth has to prove beyond a reasonable doubt. 1, that a court issued a protective order. That's not even in dispute, I think. 2nd, that the order is in effect on the date the violation occurred. That's not in dispute either. 3rd, that the defendant knew the order was in effect. I think we know that, if nothing else, from Mr. Bradle's conversation with the police officer, that he knew the order was in effect. And finally, that the defendant violated the order by failing to stay 100 yards away. I'll talk about that if necessary, but in the meantime, as to Mr. Kearney's state of mind, the law is that violation of a no contact order requires no showing of mens rea other than knowledge of the order itself. That's Commonwealth versus Tanasi, 435 Mass at 312, Your Honor. There is no requirement of a showing on the Commonwealth's part of intent on the part of the defendant to violate the order. That's Commonwealth versus Delaney, 425 Mass at 596 to 597. There is no proof that the defendant intended an act that resulted in the violation. That's Commonwealth versus Colley, 427 Mass at 388. All the Commonwealth has to show is that there was an order that said he had to stay 100 yards away, and if he knew where she was or had an idea where she was, he didn't stay 100 yards. I said in my opening statement, Your Honor, that the defendant did the right thing when he saw Ms. Gaetani enter the courtroom. He got up and he left. And if he had kept on going, he would have been fine. He should have kept on going until he got 100 yards away. We can argue about whether or not going down the stairs constitutes the yardage, or whether it's a straight line or whatever. But the fact is, whichever way you calculate it, when Ms. Gaetani walks out of that courtroom in full view of the defendant, he's about 35 yards away. And he remains 35 yards away. And by the way, he's not staying where the police officer told him to stay. The police officer pointed over towards the street, according to his own testimony, and thought that Mr. Kearney was headed in that direction, and then his attention was drawn to the traffic. There's no testimony that he ever came back to consult with the police officer further, or that he was afraid to leave. Rather, all the evidence, including the photos, shows Mr. Kearney following along Ms. Gaetani as she proceeds down the street and getting even closer to him by the end of that journey, so he's well within 100 yards. I introduced some photographs of Ms. Gaetani, Your Honor, that Mr. Kearney posted the next day on the blog. I think there are about 26 of them. I don't know why somebody who's terrified of Ms. Gaetani would provoke her by filing all those photographs the very next day on his blog. Apparently he managed to overcome his terror somehow. But in any case, I recall Mr. Brado objecting that he didn't object to the photographs as long as there was no implication that Mr. Kearney took them himself. Well, I don't know whether he took them himself, Your Honor, but I do know that in every single photograph we introduce from those videos of Mr. Kearney, he's standing there opposite Ms. Gaetani holding up his cell phone camera. So he's well within 35 yards. I would suggest that not only has the Commonwealth proved its case beyond the directed verdict standard, it's proved its case well beyond reasonable doubt.
If I could just have one brief response. Nice having the case law, but you have to know the person's there. There's knowledge. You can't just be, it's not strict liability if a person, if the government can prove they're within 100 yards of each other. That's not it. There has to be contact. There's no contact there. The government can't prove contact, and the government is, speculating about where they were relative to each other. They have no evidence whatsoever before you that where they were relative to each other and when. There's no evidence of it, and even in the light most favorable Commonwealth, they have not made it to that threshold that a rational jury would go in that direction. So I ask you to dismiss it. Thank you.
Appreciate the motion. The motion is denied. Are you putting a defense on?
Yes, Judge. Meredith O'Neill, please.
Spell Meredith O'Neill.
Meredith O'Neill? Meredith O'Neill?
Would you raise your right hand? Do you swear in the matter now in hearing to tell the truth, the whole truth, and nothing but the truth to help you God? Thank you.
May I inquire, Your Honor? Good afternoon. State your name, spell your last name. And where do you live, ma'am, just generally? What do you do for a living?
Yeah.
And who do you work for?
I work for Barcelona.
And what's your educational background?
Management in French, and then the master's in accounting and MBA from North University.
How long have you been an accountant?
Both 12 years.
And do you know Aiden Carney? How do you know Mr. Carney? And how long have you been dating? How long have you known him?
Years.
You know that he's charged here today with violating a restraining order, right?
Yeah.
And you were with him that day, weren't you? Tell us how that came about, that you and he were together and coming here on coming to Dedham on 2/26/24.
Sure. There are motions that again case. We both have obviously been following the trial for quite some time, so we decided to attend the hearing together.
And just for the record, so the factual background is clear, Mr. Carney is probably the most prolific commentator and journalist investigating on the Karen Reed case. Is that a fair statement?
Overruled.
Yeah, that's a fair statement.
And you actually do too, right? You
Yes.
comment on Twitter or X about it here and there, right? And you assist him with that endeavor as well?
Yeah, sometimes.
Sure. So on that date, there was an afternoon hearing on the Reed matter, right? And at the time, Mr. Carney had just gotten out of jail a couple of days earlier, right?
Yes.
And that was from a case that was out of this court, right? You know a little bit about it, right? And that you know that the charge in that case was among the charges in that case was a charge of assault and battery, right?
Your Honor, this is Mr. Brady's witness.
I'm just trying to move it along for some preliminary matters, Your Honor.
It's leading, but it's all anecdotal. We all know most of this anyway. Let's go.
So on the day of 2/26, how do you and Mr. Carney come to get here?
So work together with our friend Brad Goldstein.
And what was the plan that day among you guys to watch this hearing?
So, we're on it. So we got there then.
Where did you park when you got here?
I parked in the right.
And did Aiden have a car in some other location as well?
Yes, about 5 or 10 minutes down the road, he in park, so I met him coming from his house and then we drove together.
Then you drove together closer.
Close, correct, to the Red Street.
And where did you park your car?
In the Red Street parking lot.
So in like the back of the building, behind the building?
Yeah.
Did he leave some items in the car when you guys departed the car?
Yes, his computer and his car key.
So what was your path, the three of you, what was your path to the Norfolk Superior Court?
Into the courthouse, we walked around, I believe this building, between this building and the Red Street, across the street, and crosswalk, in the front of house, around 1:30.
Was there anything unusual that occurred in the walk, or was it just the typical assemblage of people outside?
Not at all, very typical. Reporters, Karen and Dave outside.
And did you have some conversation with them, or did you see Mr. Carney having any conversation with them?
Yes, many conversations.
Do you know who Lindsey Gaetani is? And did you see her outside anywhere during your arrival into the courthouse?
No.
What happened when you got into the courthouse?
About 1:30, we weren't letting people in just yet, so we went to security and then went upstairs and waited in a line before they started letting people in about 10 minutes before.
Did you and Aiden and Mr. Goldstein, did the three of you get into the court hearing?
Yes, we did.
And where did you go when you got in there?
That is the third, towards the outside, so, well.
And if you were looking up at the bench, at the judge's bench, were you on the left or the right?
We were on the left.
All right, so kind of near the windows on the left. Did you sit in the same row as Mr. Carney or a different row?
Same row.
What time did you sit down roughly, if you remember?
So would have been 1:50, sort of before start time.
Did you have any knowledge of the hearing that was about to commence and what kind of a hearing it was?
Yes, it was a motions hearing. There were several motions to be heard, including a vote.
So was this the type of a hearing that you anticipated would be 5 or 10 minutes, or a longer type of a hearing? So you were sitting down. Did the hearing commence at about 2:01 in the afternoon? And right around the time that it commenced, did you see Ms. Gaetani? Where did you first see her? All right, and just to summarize, you've seen video of this and you're aware that there's video and evidence about this very snapshot of time, right? Okay, and you remember it though, right? All right, so we're going to just go with your testimony. So when you turned around and you saw Ms. Gaetani, what did you see? Set the scene for us.
Right away, identity, and right now I'm being that McCabe and some other family members. So we had to start McCabe her and was turned to you and said, "You want to be here? We need to leave now."
Did you notice whether she had anything in her hands? Did you make any eye contact with her or communicate with her in any way?
No, as soon as I saw her from afar, I didn't know.
When you turned around to see Ms. Gaetani, you were looking kind of towards the back of the room?
Yeah.
You kind of had to turn over your shoulder. What about Mr. Carney? Did you see him, whether he was looking with you or whether he was looking straight ahead?
It was not her. I was just looking to see who was coming in, just wanting to see if it was the judge gave it to other witnesses that he.
Okay, you just listen to the question you're asking, just answer that question, and then just wait for the next one.
So when you, right at this snapshot of time, when you're looking back at Ms. Gaetani, you see Mr. Carney. Did Mr. Carney react in any verbal way, to your knowledge, when he saw or you saw Ms. Gaetani?
No, correct.
Did he get up?
Did get up and said, "God, that
Was he facing the direction of Ms. Gaetani when he said that, or was he facing the direction of some other people in the rows?
stay forward."
And what happened next? Right next.
Got out. Also standing in there in between us, the crowd standing between us, when we left, walked out the door, and downstairs.
Did anyone have to tell you or Mr. Carney what to do?
No, I told him to leave the left us, not speaking at the
What was the time period that went by from the time Gaetani walked in the room till you and Aiden had walked out of the room? Where did you see Miss Gaetani go when she came into the room, if you saw?
I didn't even like
Did you see, do you know who Paul O'Keefe is? Did you see Mr. O'Keefe in there? If you remember.
don't listen, I mean, looking at videos after the fact, and I can't say that at that time, when I was walking out, I saw any of them because I was just focused on getting out.
Sure. In the 10 minutes or so that you were waiting there, can you recall looking around the courtroom and seeing who was around?
I think some of you have been there before, but certainly not Mr. Tanya or Jeremy Gates, which walked out after they.
So you leave with Mr. Carney out the door of the courtroom.
Correct.
Where do you go?
We head down the stairs, security area where we came in, and a couple people stopped us and talked.
Just gotta listen to the question you're not.
So you walk outside and you're going to leave the courtroom?
Yeah.
As you guys leave, did anybody from the Alberts or McCabe's or O'Keefe's make any comments about you or Aiden having to leave?
Objection, relevance, overruled.
What did Chris Albert say?
At the ITPH shop at the Eden.
Okay. Where did you go, just physically, where did you go when you left the courtroom?
Right downstairs.
Did you speak with anybody as you were leaving?
One woman, Eden.
Okay. What was Mr. Carney's kind of demeanor when he was leaving?
Objection to the characterization and to what he wanted.
Oh, the anxiety stays, the rest doesn't. It's a question.
When you say he was in a state of anxiety, can you give us some things that you observed about him that made you conclude he was in a state of anxiety?
Like he told me he was worried and followed him out.
So you get down the stairs to the first floor, and what happens on the first floor?
A woman approached us and gave some information about entering the courthouse before.
Do you know that lady by any chance?
Yes.
Was that in the vicinity of the metal detectors, or where was that on the first floor, just generally? Did you stay with Aiden for that, or did you go ahead of him, or were you still together, or what? You exited the court, the front doors of the courthouse? And what was the scene that you first saw when you went outside?
There was it's a smaller crowd of people outside, smaller than what we think. A lot of people are not just be hearing, but for these strong people, were also police officers.
Approximately how long after 2 o'clock were you guys standing outside?
Probably within 2:06, 2:07.
A few minutes after 2:01 or so, a few minutes later. What did you see Mr. Carney do when he came out of the courthouse?
He immediately walked up to a police officer across the street,
And where was the police officer?
directing traffic in the crosswalk.
Okay, so that's kind of a, is that a busy area there or is that a quiet area? So did Mr. Carney stay on the court side of the street or did he walk to the registry side of the street?
He walked to the registry side.
Did he try to have a quick conversation with the officer? And what did you see?
The officer, things restraining order situation, the officer said, go over there for now.
And did you see any physical gesture that accompanied that statement?
Pointing towards there.
Okay, so he kind of made a physical gesture pointing in that direction? And did you see Mr. Carney do anything in response to that gesture?
He went over towards the registry, the actual building.
All right, and did he, where did he stand in relation to the actual facade of the Registry of Deeds building?
He was all the way up against the wall, far away.
Okay. Did you and Mr. Carney intend to do anything at that time period to memorialize what had just happened inside?
Objection to what she
Yeah, objection sustained. It's to the form of the question.
Sure. What was the plan between you and Mr. Carney about what to do about what happened inside?
Again, I memorialized what happened in there to ensure that this could happen, even going to speak what happened and make it found to be some type of violation.
At some point, was Mr. Carney reporting, doing his job, I guess, about what had just happened to him?
Yeah, started live stream courthouse, and we both agreed it was a good idea so that everything was documented in case we could kind of see back out all of those.
And what is live streaming?
It's just when you have a camera and you project a live video to an audience, whether it's YouTube or kind of platform.
Was Mr. Carney live streaming, to your knowledge, as he came down the courthouse steps?
He was.
Was he live streaming when he was talking to the officer?
Yes.
Did he continue to live stream as he followed the directions of the officer? When he got to the facade of the registry, was he still live streaming? All right. Did you want to get involved with him in his live streaming at the time?
No, I purposely kind of stayed out of the church that on.
At some point, did hundreds of people stream out of the courthouse?
Yeah.
How much time had passed between when, let's say, when he gets to the facade and then when hundreds of people come out of the courthouse?
Probably 1 or 2 minutes.
Was that an expected, strike that? Was that the departure of the folks that you saw in the courtroom earlier?
Yeah.
Did you expect that hearing to end, causing all those people to leave?
No. Was still in there, keep with us.
You mentioned that the officer that Mr. Carney spoke with was in a little bit of a busy area, right? Did it get less busy or did it get more busy when those hundreds of people came out?
Because we were.
With this event occurring, did it get more difficult or less difficult to get the officer's ear to get something going with respect to the police report? And was Mr. Carney continuing to live stream?
Was for a period of time, yes, but yeah, so.
Did many of those hundreds of people kind of come across the street to the registry?
Yeah.
Do many of those people know and communicate with you and Mr. Carney? And they do typically on a regular basis. These are people that you guys know, supporters, friends, colleagues, acquaintances, right? Did you and Mr. Carney kind of separate off from each other in terms of talking to these people and doing whatever you guys were doing?
Yeah.
And where were you and where was he, to your knowledge?
Still around that same area, around to where the officers are. So at one point, my friend Brad, my team was, but he wandered a little bit towards the parking lot.
At some point, did you see Lindsey Gaetani and her group come out of the courthouse? Was it something that was open and obvious, or was it something that was mixed in with everyone else coming out?
All wearing coats.
Was there something unusual about, you know, the colors? Was there contrasting colors? Was it a majority of similar clothing, or what was the scene?
A lot of dark winter, but black winter.
Did you, at some point when they came out, when Gaetani and her group came out, were you paying attention to Mr. Carney at that time?
I don't know exactly, but you know, the only time I saw her was when I went back to my car parking lot, get some stuff there.
So before you left, did you, and when you were in the vicinity of Mr. Carney, did you ever hear him calling anyone a liar, screaming out liar, liar? Did you ever see him make any outward manifestations that he had seen or spoke to Ms. Gaetani?
No.
And was he still live streaming?
Yes.
When you live stream, do you hold up your phone in the similar fashion as you would when you're videoing someone or photographing someone?
Hold it up.
So just, is it a similar way or is it dissimilar?
It's different. Really trying to get yourself.
And was he doing that to your observation that day? So you were able to discern that he was holding it towards himself versus memorializing the scene. At what point do you and Mr. Goldstein decide to go head towards the rear of the building?
Within a minute or two of everybody. He gave a bound, he got it, and then he went to my car because he left his still there.
Okay. So, did you say that you saw Ms. Gaetani in the back parking lot?
I did, she was already there by this. I didn't need to see her. Brad, when I stepped out of my car, Brad pointed out that there she is, and it took me a few minutes to even represent Stephen Field to recognize her. She was another group of women and pretty much wearing the same thing, so it just took me a lot far to see her. But
She was parked all the way at the far end of the registry of deeds parking lot, right?
further towards the end than I was, yeah, I was closer to that one.
More than a football field away from the registry building, or about a football field, or less than a football field from the registry building, from the back of the registry building? So she was almost to the back of that registry parking lot?
Yes.
Was the rest of her group also parked there and congregated there?
They were all congregated, I don't know if others are, but they were.
So if Mr. Carney, when he left, if he had gone to the back of that parking lot, he would have been going right to where Gaetani was going.
Sure.
It was the same location as where Gaetani went, right?
I got the picture. Next question.
When Mr. Carney went to the back with you, was Gaetani still there or was she gone?
That was much later, no, I went back and found him. When I saw her back there, I needed to text him and said, do not come back here.
Okay, so then you go back to where Mr. Carney is?
All the way on Court. To the right of Superior Court where Gary Street Interchange parked down that way. So.
All right, so he had departed and gone the other way. And that would be, as you're looking at the North Superior Court, the street to the right along the side of the court, right? And you went and found him? Did you bring him his items? When, Ms. O'Neill, is the first time you saw Ms. Gaetani? Departing the court?
In the parking lot.
In the back of the building?
Yes.
Okay. What were your observations of her demeanor? Was she gesturing? Was she looking back? Was she looking forward? What were your observations? Did anyone in the group appear to be agitated or upset by anything that may have transpired. May I have one moment, please? Thank you very much, Ms. Nothing further.
Cross-examination.
You know, I think you told Mr. Brayville, no, defendant for a couple of years and that you've been dating, 8 months, that's right.
That's correct.
Did you know anyone who was dating at the same time?
Yeah.
Really? You don't much like Mr. Time, do you? That wasn't the question. Did you hear the question?
Yeah.
What was the question?
Do I like Mr. Tanya? Of
Yes. Now try my question.
course, I don't think so.
Thank you. Did you execute an affidavit in some mail on June 5th of this year?
I did.
And did you say, Ms. O'Neill, paragraph 3? Actually, I'll show it to you, those. And you can ignore what I circled. Take a minute to read that.
Okay, number 3.
Yeah, just read it to start. So did you say in number 3 of your affidavit at approximately 2:05, I turned around and saw Lindsey Gaetani into the courtroom holding a white piece of paper in her hand. Immediately told me it would need to leave. We were surprised to see her there because she never attended Karen Reed meeting prior to that and was not friends with any of the witnesses or the victims' parents.
Correct.
By the way, have you attended all of the Karen Reed hearings at that point?
Most of them, not all.
And you don't know of your personal knowledge whether Mr. Gaetani was setting it on any previous service or not, do you?
I do watch these, I watched every single hearing.
Oh, you kept a vigilant eye. So at the moment that Mr. Gaetani walked in, you checked out every single person in the courtroom.
Well, at that point, she said, also you would know if she was there.
I'm not sure I see the connection, but maybe if I think about it, it will become clear. Now, did you happen to read an affidavit that Mr. Kearney wrote?
One,
This one.
Does I object to impeaching a witness with someone else's statement?
See what the question's going to.
that's so long. Well, I'm not familiar with all of it, so there's nobody else that thinks like that. I'll take a look.
Just wait for a question. You don't have to respond.
Did you happen to watch, did you watch all of these attorney shows? Do you remember whether you watched the Saturday Night Live show on February 24th?
I don't remember off the top of my head, but that was so long ago.
Well, can we agree that February 24th of 2004 was 2 days before February 26th that you're in the United States?
2024?
Yes, right, 20.
Yes, I agree with this.
Thank you. And do you know that Mr. Kearney said that on that live show, he announced that he would be defending Karen Reed here in the course very important that.
You're saying that very nuts.
And you know that he stated that,
Give me one. witnesses don't have to agree or disagree, just whatever you know or don't know.
And you know that he stated that on that show, he expressed concerns that the mechanics and Alberts would show up with Lindsey Gaetani as a human shield in order to remove him from the courtroom due to the restraining order she had. Well, still for the moment, he did. Can you explain why, in light of the fact that he's broadcasting on the live show 2 days before the ceremony, he was worried about Lindsey Gaetani showing up? He was surprised to see Lindsey walk into the court.
Sustained. No, excuse me. The objection is sustained. Next question.
So you and Mr. Kearney see Lindsey Gaetani come in and you get up and you go down the stairs and out the door of the court. Is that correct? And at what point does Mr. Kearney start live test? Stepped outside the courtroom or stepped outside the building? Okay. And that was always the plan, was it not? What's the point of the visit? Was it Kearney was going to do a live cast on the scene? So you pretty much always do that when that was the camera meeting?
Before, I always got that.
How often would you say that it's not to the live cast stuff?
It's only he doesn't want to be the morning one. It is that day we keep camera on to document what happened downstairs.
He told you, I want to document what happens there.
That's the time he followed him, he wanted it on camera.
So you're outside of the courtroom, he talks to the officer, and the officer directs him, you say the registry. You hear the officer say registry of deeds?
So he said, go over there and point the registry.
Stop and point like this, or was it a gesture like that?
Are you pointing at the building?
Straight ahead.
Absolutely.
Wasn't pointing at concert.
I don't want
Mr. Kearney goes over there. Are you still with him at this point?
Yeah.
And you're standing next to him or nearby him by the registry of deeds building?
Bye. Not sure.
And you're familiar with the Norfolk Superior Court, the entrance and the exit, are you not? And you've attended a number of the hearings that you've seen. And you know that typically when the hearings get over, people who have attended the hearing, quite a number of them can't read that. Would you agree that quite a number of people typically attend the Karen Reed hearing? And on this particular day, it was so crowded, everybody couldn't get in, right? So you know when the hearing ends, what typically happens is the people go out that main exit door, same way they went in, right?
Yeah.
Now, at some point, you notice that people are coming out the door, right?
Yeah.
Are you standing next to the defendant at that point?
Or a little bit, you're still a little bit away, the crowd started.
Well, did you observe whether Mr. Kearney, who was worried that Ms. Gaetani might follow him, is looking at you or at the door was in the position to notice the crowd coming.
On his camera live stream, so.
So is it your testimony his view was totally obstructed by the phone?
I can't tell you what he was thinking at that point, because I was having a conversation.
Well, you've been very good about telling us when I'm soaking it up. Counsel, should we wait for her to answer the question? Thank you. You can finish your answer.
I can't tell you what he was thinking about his assessment of what was going on. So I was having a conversation, people were rushing up to me, he was on his phone, so.
So in any case, you noticed that people were coming. Did you have any reason to believe that Ms. Gaetani would not be coming out that door with the rest of the crowd attending here? What was the question after that?
I don't know if it's times where he has plans to close the door for him.
No. I asked you, did you have any reason to believe that Ms. Gaetani would not be walking out that door with all the rest of the people who attended the camp?
Objection, Your Honor, is inviting speculation. Someone else's state of mind.
I'm sorry, I was being wrong for insisting. Well, at that point, did you say to Mr. Kearney, I see people coming out. I see people from the Karen Reed hearing coming out the door across the street. Did you say that, John? And you only talked to him when you're directly next to him.
I was talking to other people.
So you had no concern at all that Lindsey Gaetani to come out and pursue him and get him in trouble. You weren't worried about that at all at that point.
I was trying to figure out what happened because
I didn't ask you what you're trying to figure out. I asked you if you were worried at all that Lindsey Gaetani would come out and pursue him. I thought that was your big worry. Did you tell Mr. Brady that? You and Mr. Kearney were very
I would like her to be able to get an answer. And
one question at a time at the crossroad.
we were too crazy about that. Monica. Or next time, we'll come out.
And you didn't think that in the blue this one, please.
No.
No, I didn't ask you why. So you don't tell Mr. Kearney that people are coming out. You don't call that the attention. Because you're talking with somebody, or for whatever reason, you don't call it to this. And you don't say, hey, Lindsey might be coming out that door. Why don't you go back to my car and get the hell out of here so she doesn't track you?
I'm here at that point.
So was it your plan to wait until she was on top of you before you left?
No, we didn't have a plan, so we didn't expect to carry them in 5 minutes.
Well, it hasn't, right? People were coming out the door regardless of your expectations. You could see that, could you not? And in fact, before people even started coming out, you were so worried about Lindsey Gaetani. Why didn't you say, let's go back to my car and get the hell out of here so there was some problem?
We wanted to be more than the report, so that's fine, report, page.
And there was a police station in the town of Devon.
Everyone else.
And do you know when Mr. Frank filed a police report? Relative to that visit. Couple of days after. So you couldn't leave because you wanted to file a police report, but then a couple of days passed before the security gets there. Is that what you're telling us?
At that point, this had already, we already started with this, so.
But you think it would have been proved to get it recorded before she did?
He did, like, that night, so.
So you would say she was very quick about reporting this alleged violation?
Not when it happens, not until later.
Bit of a moment to it. Yes. So Mr. Kearney did not stay up against the wall of the registry of deeds. Yeah.
No, he actually went out to the down Court Street, like I texted him, not come back here to the parking lot.
Well, when he starts moving, he moves in the direction of this court, correct?
No, we moved around in back towards Superior, down Court Street.
Really? Could I have, 15, please? Remember what Mr. Kearney was dressed as that day? The blue tie, dark blue tie. You see him in that photo, towards the back. But at that point, he's not in the front of he's not on the steps of the registry of deeds.
There were different steps, but I can't tell where exactly he is from that photo.
All right. Well, would you say, looking at the registry of deeds building, would you say he's moved to the right or he's moved?
Judge, I object. This is all speculation because we don't know where Mr. Gaetani is. We don't know when he is.
Objection sustained. I don't need to give a open. You can't tell from, can you tell from that photo what direction he went? Yes or no?
No.
Next question.
All right. I'll take a look at 16, please. Well, wherever he is, it's fair to say he's not on the front of the registry of deeds at this point, is
I can't tell where he is. I don't, it doesn't look like the front of.
all right. Let me move on to another line of questioning. You had your cell phone there. Mr. Kearney obviously had his cell phone. Did you ever call him and suggested it would be a good idea to call?
I did not serve it there.
I'm sorry?
I didn't call him, but I went already down for this.
Whenever you're in the courthouse or whenever you were outside?
That is your general, I can't hear your terrible service.
Who's your carrier?
Thank you.
And when you were there were a lot of people in the crowd shouting things. And you were, at times, you were some distance from Mr. Kearney.
Yeah, and then we went back to the parking lot.
Right. So you really have no idea whether he happened to shout liar, liar, or somebody at some time or not.
Well, by the time I got to the parking lot, Ms. Gaetani was there, so we couldn't have found it.
All right. And when you were apart from Mr. Kearney, were you down in the parking lot the whole time, or?
For most of the time, and then walk back, yes.
So you weren't necessarily next to him at all times before you got to the parking.
Before I parked on, we were most of the time.
I'm sorry?
Before I went to the parking lot, when we got separated, I was with them most of the time. Fairly close to me.
You were most of the time fairly closely. All right, so the answer to my question, which was you weren't with him at all times, is yes. Does how complicated then?
Not in here, but yes.
Still have the text message, do not come back here.
I got to scroll that far if I didn't delete it, which I wouldn't see the view in there.
All right, thank you. No further questions.
Just a brief question, Your Honor. So you were asked Ms. O'Neill about why didn't you go find the police station and report it afterwards? Something to that effect, right? Were you in the car with Mr. Carney for a little while after kind of this whole thing had subsided? Was he in any sort of state of mind to be able to report anything to the police?
On the verge of tears, coming to go get his picture.
I'm sorry, I didn't hear you.
He was on the verge of tears, he was shaking, and he was trying to calm down enough to be able to go at least pick up the kid.
All right. And is that why you didn't pursue any police documentation at that point?
I'll be with so.
Thank you. Nothing further.
Yes, correct. And from the break of tears and he was really on the condition. That's fun. I noticed him crying during the live broadcast. The live cast he was doing across the street, registry to be. So he only collapsed into this emotional state after he got that. He held it together bravely during the broadcast. No further questions.
No further.
You may step down. Thank you.
Judge, sets to break. I have a very quick witness who's got to pick up her kids, and I was hoping to maybe just get her on for 5 minutes or so.
So this happened across, but we started.
Sure,
Go for a
appreciate it.
short period of time.
Thank you, Lauren Cologne. Lauren Cologne.
No idea who this is.
Or go well.
Lauren Cologne.
Yep.
Yep, thank you.
Anyone know how to spell this name or who Lauren Cologne is?
Raise your right hand. Do you swear in the matter now in hearing to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
May I inquire, Your Honor? Ms. Cologne, good afternoon. State your name and spell your last name, please.
O-L.
And where do you live, just generally?
In the Norfolk County.
What do you do for a living?
I am a project manager at a large company. I work out of their headquarters.
And are you married?
I am.
Family? What's your educational background?
I have my undergraduate and an MBA degree, both from Northeastern University.
You've taken an interest in the Karen Reed and Aiden Carney cases here in Norfolk County?
Yeah.
And from time to time you attend these hearings?
I've attended one here.
Was that 2/26/24?
That one.
And you were there inside the courthouse or outside the courthouse when that Karen Reed hearing was going on?
Okay.
Shortly after 2 o'clock, were you outside the courthouse? Do you know who Aiden Carney is?
I do.
And it's the gentleman here with me, right? And did you see him emerge from the courthouse a little bit after 2 o'clock?
I did.
And what exactly were your observations? And first of all, where were you situated when you first saw him?
Yes, I was on the stairs. It was the first stair or two leading up to the courthouse doors.
Okay, so the base of the stairs at the Norfolk Superior Court main entrance. You see Mr. Carney. What do you see?
Mr. Carney came out. He looked visibly anxious, very, very anxious. He had really a great concern that was.
Objection.
Anxious will stand. Next question.
Was he using his phone at all?
Not at first, but then I did observe him make the comment that I should.
Objection to the comments.
You answered that question. What's your next question, Mr. Brennan?
What did you see him do, just physically with respect to his phone? Do you know if he was recording out to the world or recording himself? If you know.
I believe he was recording himself.
Where was he when he started to do that?
I want to say, maybe it was like around the base of the stairs. Maybe leading out into the sidewalk.
I'm sorry. Okay. When he came out, did he draw your attention or were you looking at other things besides Mr. Carney when he came?
No, I was looking.
And what did you see him do and where did you see him go?
Well, I saw him, there was a state trooper that was there on the stairs as
Objection. The
well.
question is, what
Good.
did
I've
you see him
heard the
do?
question. Thanks. Yeah.
What did you see
Listen
him
to
do?
the question and just answer that question, please.
He began moving down the stairs and started to cross the street. He approached a dead police officer.
Okay, you were going to talk about a state trooper. Did a state trooper approach him as well?
Yeah.
What happened?
The state trooper was concerned about.
Objection.
Just what did you see happen?
So I saw the state trooper usher folks off the stairs and to continue moving across the street.
And was Mr. Carney part of that group of people that were being ushered around? Where did he go?
He then was walking into the street. He approached a Dedham police officer.
Was that Dedham police officer busy doing things or was he just completely focused on Mr. Carney?
No, there was a lot of people around.
Next question.
Did you see Mr. Carney speak to him?
I did.
What was said?
Objection.
Notice and knowledge on state of mind.
Grounds for your objection.
Seriously. It is also already in evidence. Your Honor's used the recording of the conversation.
Overruled.
What did he say to the officer?
I did not hear what was said.
Next question.
What did you see as far as any physical gestures by either Mr. Carney or the officer?
I saw the officer lift his hand and point towards the registry of deeds. I then
Next
saw.
question. And then what did you see Mr. Carney do in terms of gesture?
I saw him do the same.
And where did you see Mr. Carney proceed after that?
He then walked over to the registry.
Was he still doing his thing with his phone?
Yeah.
At some point, hundreds of people stream out of the Norfolk Superior Court, right? Was it close in time after this interaction?
It was.
What did you observe about people streaming out of the court?
Just generally, I really didn't observe. I don't know.
Okay, was there a large number of people or a small number of people?
There's a large number.
Now, were they going towards the handicap ramp, down the main stairs, or where were they going in general?
There were folks using both the handicap, handicap rail and the.
Were you near Mr. Carney when those folks started to stream out of the courthouse?
No.
Did you see Mr. Carney doing anything else outside the courthouse when these folks were coming out of the courthouse?
I did not.
Can you just have one more, please, John? Thank you very much, Ron. Nothing further. Thank you.
Hello, towel friends. Hello, towel friends. Let's see what's going on in the Ian Kearney case.
So he follows friends comments.
I see his YouTube.
Just once.
No.
When was the most recent time you saw him?
Last night we had one of the jurors from the first hearing trial.
Have you watched others as well?
Yes.
Do you have a paid subscription to any of these channels? Some of them are free, some of them are paid.
No.
And can I ask you if you executed this affidavit of March 6th?
Yeah.
And, how did you come to run this affidavit, or how did you come to execute this affidavit?
I cannot recall if somebody sent me a tweet or if I saw it myself, but it was basically a request from Mr. Carney. If you were there, let me know if you're going to give your observations.
So he put out the request and you responded to it?
Yes, I felt as though.
Tell me what you felt.
Yes.
Answer the question. So, after you responded, what happens if you're still clear?
I sent it over to the paralegal who works for.
Did you draft the whole application yourself, or did the paralegal before you were?
I drafted it mostly myself. She cut out parts of it that I had originally drafted.
All right. And then you read it over and signed it?
Yes.
So some of this language, like I am of age and a resident of Commonwealth of Massachusetts, that's not your language, right?
Objection, Your Honor. Legally, she signed it and adopted it. It is her language.
If you understand the question, were you the one that wrote that, or was that suggested, writing that you signed?
I wrote the affidavit.
Thank you. No further questions.
Anything on you?
Nothing further. Thank you.
Thank you, your excuse.
Thank you.
Residents.
Court's in recess until 2 o'clock.
All right.
You heard it.
The front door. Thank you.
Zoom will resume at 2 o'clock. Thank you.
All right, folks, you heard it. Coverage is gonna come to an end now. And we are going to see what happens. Little towels. My name is Grant Smith Ellis, and I'll tell you right now, we got a lot going on. We are watching, we are listening to the Aiden TurtleBoy Kearney case, and Little Towels, we're now on lunch break. I'm back with you. My name is Grant Smith Ellis. I am a towel. Now listen, ladies and gentlemen, I want to send a special thank you, folks. There are people at court supporting Lindsey. I know we did it yesterday. Don't worry. I've already sent them some funds to get lunch or help her, and then I have funds that I'm going to get to Lindsey's legal fundraiser, third-party payee later this week. But ladies and gentlemen, special towel announcement. Oh my goodness. Ladies and gentlemen, special towel announcement. Anything that you send over until 4 p.m., just like yesterday, this is going to go to the people supporting Lindsey at court. Towel doesn't need it today. I will make do with what I have. Don't worry, ladies and gentlemen. But if you send donations, please, they're going to Lindsey. Towel, today of all days, let's do it, ladies and gentlemen. We're hoping for a guilty verdict. If you're just tuning in, ladies and gentlemen, Aidan Kearney lost his mid-morning motion for a required finding of not guilty in the Aidan Kearney and Lindsey Gaetani trial. Now it is in lunch. Aidan only has a few defense witnesses left. Ladies and gentlemen, I think we might get a verdict today. Are we going on verdict watch, ladies and gentlemen? And also, someone is in the Zoom as Hank Brennan. That doesn't mean they're Hank Brennan. Someone could have just been like, I'm going to pretend to be Hank Brennan. But yes, I want to say God bless you to the person who sent over some lunch funds for Lindsey's supporter. You know, if you are in court listening to this, we love you very much. Thank you. God bless you. We'll do as much as we can to support you, your gas, whatever we can for you taking the effort to go and support Lindsey. God bless you, friend, if you're listening to this. Towel loves you all very much. Now, ladies and gentlemen, let's see what we can do. Let's see. I already checked down. We sent one over. We're going to do recaps. And also, God bless you, Harvard Yard. Towel has absolutely appreciated. All right, hold on, ladies and gentlemen. Yeah, no, there is. I don't know if. I don't know. Yeah, no, so just so folks know, I heard that other channels are broadcasting or something, the Zoom. I found a channel that's broadcasting the audio, okay? So I found a YouTube channel that has the audio. If people are broadcasting that video, first of all, you notice there is no video on the screen right now, okay? Do you notice how there literally is just no video? Because any stream that's out there, any YouTuber that's finding that Zoom stream with the feed, with the actual video, no, that's not a good thing. Lunch recess, hold on. Lunch recess until 2 p.m. Eastern. I may have messed up that typing. But yes, ladies and gentlemen, there is no approved video feed of this court. Yesterday, if you were wondering, folks, if you tuned in and were wondering why is there no video feed or why is it pointed away from Lindsey, apparently cameras were not allowed to broadcast Lindsey's or record Lindsey's testimony or Lindsey while she was testifying. I heard it kind of over the camera, but people were saying that was shocking. I guess it was to protect Lindsey. God bless you, court. Lunch recess until 2 p.m. Eastern. All right, ladies and gentlemen, so we're waiting for lunch recess to return. Yeah, so Linda, listen, folks, if people are, I don't know, just so folks know, that Mike Crawford guy, very strange man, but if he's broadcasting the Aidan Kearney video, yeah, no, that's absolutely verboten. So the Karen Cam can be broadcast under specific circumstances, but not the visual images of this Aidan Kearney case. No, that's a violation probably. So, but yeah, YouTube channels that have the audio, restreaming those, things like that. All right, but yeah, no, what he was doing was not cool. If that's what they're doing, I didn't watch that channel. But yes, ladies and gentlemen, more importantly, let's do the one thing that's going to show folks around the world that the vulnerable matter, that we are waiting for tomorrow's obviously start of deliberations in the John O'Keefe and Karen Reed retrial. But today, ladies and gentlemen, we may be on verdict watch in the Lindsey Gaetani and Aidan Kearney trial, and we've done so much to support the vulnerable, ladies and gentlemen, every single dollar. Oh, goodness, friends, let's see what's going on. I am a towel. I'm sending as much as I can and helping out as much as I can. Now, little towels, please do everything you can to get ready for after lunch. Paul O'Keefe, folks, is on Aidan Kearney's witness list. Aidan Kearney lost, folks, if you missed it. Aidan Kearney lost his motion to get Paul O'Keefe's cell phone records, and little towel got some rice. Now, that is a big deal. Let me just tell you, it is a huge, momentous, extravagant deal. Aidan wanted phone records from Paul to be able to, and maybe they'll ask Paul questions about it, to be able to prove that Kate Mafia Masshole Peter, for whatever reason, on 2/26/2024, who was not even at the hearing, told Paul O'Keefe that Lindsey Gaetani wanted to come to court that day to support the O'Keefe family. But for some reason, Kate Peter also told Lindsey that the O'Keefe family wanted Lindsey to come to court to support Lindsey. Now, if Lindsey and Paul had just talked directly, I'm sure they both would have said they wanted to mutually support each other. But Kate Peter, for whatever reason, because she's a Kate Peter, and is very short-term thinking, in my opinion, just acted, and now Aidan Kearney and Kate Peter got Paul O'Keefe subpoenaed in the Aidan Kearney case. Now, yes, the phone records aren't coming in at all, but what is coming in is Paul O'Keefe's testimony after lunch. So Aidan Kearney is going to, his lawyers is going to get Paul up on the stand, and he has to ask Paul open-ended questions on direct, and it's going to be a ridiculous scene, and it's because Kate Peter, instead of just having Lindsey and Paul say they wanted to mutually support each other, told them each different things. Now, does it matter at all as to Aiden staying around at court after he saw Lindsey and knew that she had the order on him and went outside and stood in the bushes, allegedly? No. But it's still going to be really embarrassing for Kate Peter. So, I don't know. I guess in some sense it's cosmic justice. I feel bad for Paul O'Keefe, though. But yes, ladies and gentlemen, that's what's going to be after lunch. Now, what do you want to watch during lunch? We saw the whole jury charge conference. Does anyone need to get caught up on it in the Karen Reed case? I mean, we pretty much watched the whole thing. So I think we're doing just good, ladies and gentlemen. I think we're doing just fine and dandy. But I'll keep an eye on your Towel comments. We'll see what's going on. Do you want to watch clips of Towel asking tough questions to Aiden Kearney and Karen Reed? Yes, you do. Come on. Who doesn't? Who doesn't, ladies and gentlemen? You all know you love it. You want to see Towel asking questions to Aiden Kearney and Karen Reed. Why, ladies and gentlemen? Because I am a towel. Yes, so folks, just so you know, anyone who's... we are live streaming. I'm live streaming the case. You cannot broadcast the video. He's violating a court order. Audio only. So yeah, anyone doing that, ladies and gentlemen, please. That's just absolutely not is what's going to happen. That's just absolutely not acceptable. But yes, ladies and gentlemen, my name is Grant Smith Ellis, and we are going to watch clips of Towel interviewing Aiden Kearney and Karen Reed. Yeah, I know he may be showing it, but he's violating a court order. I know that. I shall report him post haste. You can't do that stuff. You just can't, ladies and gentlemen. I'm telling you, like, I know people are like, oh, who cares, right? Mike Crawford can do it. Just violate the court order. No, we're not doing that. I'm sorry. I'm not going to negotiate this. Violating court orders because someone else does it. Oh, but that, hello, towel friend. Yes. Don't worry about it at all. It's not you. You can sense that. I'm like, oh my goodness. It's not you telling me about him doing it. It's more like, if someone's going to do that, okay, I don't want to set the tone that, oh, someone else is just flaunting the court rules, and I'm not criticizing or being paternalistic or pedantic towards any of you, but if I were speaking to that other person, broadcast, whatever, young jerks or whatever, young jellyfish, I'd be like, first of all, I think you're a moron, and then not any of you to that guy, and then second of all, I would be very concerned because I'd be like, you're violating court orders. And the other thing is, you want to see something, ladies and gentlemen, you want to see a message that Mike Crawford once sent? Now, you tell me, ladies and gentlemen, if you think that this is the kind of thing that, you tell me, ladies and gentlemen, if this is the kind of thing that a good man would say. Now, listen, there are a lot of people, all right? There are a lot of people on both sides of the Karen Reed and Aiden Kearney cases that we kind of, just, even if we disagree, I'm very kind to them. But tell me, ladies and gentlemen, is this the kind of thing that any of us can countenance? Do you want to see what that young jerks person said about Little Towel? Listen, I want you all, I know you all are going to get very upset by this. I want you to try to compose your Little Towel selves, but do you want to see what this man said about Little Towel? That's why we don't, I don't even know. I guess people just didn't know about it. But do you want to know what this man said? Look at that, Little Towels. That is what Mike Crawford once said about Little Towel. He wants to hurt Little Towel, ladies and gentlemen. Not Little Towel. Oh, ladies and gentlemen, imagine if someone did that to Little Towel. You can't be doing that stuff. Oh, my goodness, ladies and gentlemen. I am a fluffy little towel. Ladies and gentlemen, this is a public service announcement to say Mike Crawford saying that he wants to do that kind of thing to towels is an abomination. This is a violation of intergalactic towel law. I'm also eating a french fry. But still, I want to reiterate, yeah. Hi, Lefty. You're not going to last very long if you defend Mike Crawford. I like you too, bud, but you're just going to be thrown out. We have a new towel chat rule. Anyone who defends Mike Crawford has to leave. I'm hilarious. Don't kid yourself. But that said, yes, Lefty, you'll be walking on very, very thin ice, my dear friend. Very thin ice if you defend Mike Crawford. Yes, but that said, who would ever make this kind of statement about Little Towel? Who would do it? It would take a monster, ladies and gentlemen, to say they want to do that to poor Little Towel. Oh, yep. And it does, yeah. Also, no, hold on, Olaf. Olaf's like, Mike's playing dirty with Towel. Olaf, are you being friendly to your fellow Towels? We are on lunch break. We are eating French fries, and we are nervous. Aidan Kearney has lost his motion for a directed verdict of not guilty in the Lindsey Gaetani and Aidan Kearney trial. Aidan only has a few witnesses left. Yeah, I would agree. Mike Crawford is young jerks. Alex, so Mike Crawford, let's see. He used to run... He runs a small podcast. He's a dog walker, actually. Actually, you know what? I can show you. You want to see who Mike Crawford is? Hold on. Let me show you this. Have you ever seen the Revere Beach song? Listen, this has. We're showing this only for commentary purposes. If you don't know who Mike the Nipple Rubber Crawford is, listen, ladies and gentlemen, we have to watch the Nipple Rubber in all his glory. Mike Crawford is a small-time podcast host and dog walker. He lives with his girlfriend, who used to be a radio host on WAAF, Carmelita or something. He just kind of lives like in her house. I think it's her house. He's just kind of like her spouse or something. I don't know if they're even married. But anyway, Mike Crawford's always been kind of just this. He was a progressive liberal for a while, and then he kind of, or I guess he was a libertarian. Then he was a progressive liberal, and then he now is more, I guess, like moderate. I don't know. He's weird. And when I first started getting into medical activism, medical and adult use plant-based activism, one of the people I was introduced to was Mike Crawford. And I appeared on his show for a while, and I kind of knew him. But after a while, it wasn't even just about money and stuff. That part was weird. I didn't ever wanted to do it for money anyway. It was more like I wanted to go out on my own and do my own, kind of branch off into my own identity. This was 2016 to 2018. So I started broadcasting the Cannabis Control Commission hearings on my own. I started writing my own articles, launched my own Patreon. I don't think he really liked that. So when I kind of went off on my own, he definitely kind of got a little possessive. But I was like, you don't own me. Like, who do you think you are? You're some small-time fish, you worthless little peon. So anyway, I went off and did my own thing. And Crawford's kind of been a little bit of a thorn ever since. He just kind of clout chases a lot. Like, he'll kind of look for reasons to take advantage of various stories, in my opinion, for his own personal purposes. I don't really like him. He doesn't, in my opinion, doesn't really have a lot of allies, even in the world where he was, the activism world where he was in. Kind of just like a passe, in my opinion, 90s, kind of like, oh yeah, man, like, let's go on the common, like, we'll show the authority, let's, like, rather than doing actual legislative drafting and things like that. But anyway, so this guy, when I went off on my own, definitely had a bit of a thorn in his side, not that I care. And eventually, I think his interest in the Karen Reed case happened because my mom went on, like, TV or something, and he heard about it. I was only really interested in the TurtleBoy case at first in the summer of 2023 because a man named Brian Riccio. Now, interestingly, Brian Riccio was a reporter who also used to work with Mike Crawford until they had a falling out. And this text message, I wonder where it came from. I wonder if Mike Crawford made this threat about me to Brian Riccio and then it was given to me. So yeah, it's a very interesting world. Mike Crawford then kind of like became a free Karen Reed person, the young jerks, like out of nowhere. He was just like, in my opinion, I'm going to ride this wave. And but obviously, I think he fakes it a lot, and people don't see this side of him, so that's why I kind of brought it up, and I wanted to show it to you all. But the other thing is, Crawford's like a kind of embarrassing. Like, I don't know how to explain it. I'm going to show you this video. I don't even know how to explain this, ladies and gentlemen. This video that Mike Crawford's in, he literally rubs his nipples. Okay, like I'm not over exaggerating this. He rubs his nipples, and he talks about thuggin' and effin' or the lyrics talk about thuggin' and effin' Jackson on Revere Beach, and something about a hot dog. I'm not, listen, I'm not kidding. We're going to watch this together. I want you all to calm down. It's going to be, so that's what I'm saying. Like, you all move you're all dealing with this giant towel wall, and we are going to watch Mike the Nipple Rubber Crawford while we're on break of the TurtleBoy Kearney and Aiden. All right, did I actually post it? I want to see the video of him. I just want to so bad. It's so freaking hilarious, and I edited it. Like, I didn't edit it. I put like the interesting part in the beginning, and then we watched the whole thing. Oh, I got it. Oh, you don't understand. No. That is Mike Crawford. Wait a minute. That is Mike Crawford rubbing his nipples. Hold on, ladies and gentlemen. I'm not kidding. I am not kidding. I have a picture for you of Mike Crawford rubbing his nipples. Wait a minute. Is this it? Hold on. Did I pick the right one? Nope. Hold on. I'm going to shift it. You are not going to believe this. Some of you, listen, we are going to launch Nipplegate, ladies and gentlemen. We're going to watch, listen, the video is vulgar. I'll try to mute some of it. But I just want to show you, ladies and gentlemen, that is Mike Crawford rubbing his nipples. Look at it. I'm sorry to do this to you. I'm forcing it. Ladies and gentlemen, look at Mike Crawford rubbing his nipples. Yeah, some of you may be thinking, I just want to tune in to watch the Aiden TurtleBoy Kearney case at 2 p.m. Nope. You are going to look at Mike Crawford from the Young Turks rubbing his nipples. Look at it. Look at it, ladies and gentlemen. Come to terms with it. Understand that is a man named Mike Crawford rubbing his nipples, ladies and gentlemen. This is worse than Nipplegate the first time around. Oh my dear goodness, you don't understand. That is a man rubbing his nipples. Ladies and gentlemen, I can confirm that is Mike Crawford from the Young Jerks having some kind of lotion spread on him while he rubs his nipples. And the quote that plays on the screen is, "I'll shoot you in the eyeball with my spray tan." Can this be... Okay, wait a minute. Can this be one of our emojis? No, I'm in... Listen, this is our moment of levity, okay? Some of your comments. Oh my goodness. Stop. I can't. Oh no. Okay, wait, but ladies and gentlemen, do you know what's even better than this? And listen, I want to warn you that there's some vulgar lyrics, so I'm going to turn this down, and we'll see if I can turn on captions. Hold on. Nope. I'm going to turn this down. It's very vulgar. Ladies and gentlemen, this is Mike Crawford starring in a special rap video. Yes, Mike Crawford from the Young Jerks, who has stood with Alan Jackson. His name is now Mike the Nipple Rubber Crawford. Listen, ladies and gentlemen, they don't call him Young Jellyfish for no reason. Do you understand? Listen, I think Kevin figured out that Mike likes to get a little bit of rub down, and so that's why Kevin, Yellow Cottage Tail, was like, oh, Mike Crawford's a jellyfish, because Mike Crawford likes to rub himself while being sprayed down with tan lotion. Clearly, ladies and gentlemen. Now, I need to warn you, this is not just an image, it is a music video starring Mike Crawford about Revere Beach. This is our lunchtime entertainment during the Lindsey Gaetani and TurtleBoy trial. Take it away, Mike. Is this as good as we all think it's going to be? Hold on, let me make sure it's unmuted. Mike, you can't just mute us. If you are going to do it, okay? If there's hard drugs and you and rapping, it's called... Oh, by the way, this is called Tin Buffet. That's the artist. Revere Beach, So Far From the Hatch, and it's Quick Desperation Records. Now, the artist who made the video, they got a lot of potential, ladies and gentlemen. Oh, goodness. They got more potential than Mandy Strong and the super lemon towel emoji. Oh, my goodness. But this one, folks, I don't think you understand. The music video video. Like, say what you will about the artistic content, or good art. The only bad art is art that people don't talk about. But Mike Crawford rubbing his nipples, that's the star of the show. All right, take it away. Oh, that was a little vulgar. Mike, what are you doing in these videos? That's quite vulgar. I'm going to have to watch the swearing here. That's very unchristian. Oh goodness. Oh, what? 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 Is that Mike Crawford? Wait, is that Mike Crawford with no shirt on approaching a woman on a bench? Oh my God, what is this? I remember this now. Elizabeth Little and Alan Jackson. This is who you've been associating with. Ah, look at him. Oh, look at him. Oh, ladies and gentlemen, this is worse than Nipplegate. Oh, it's double Nipplegate. Oh, goodness. No one let this man near Elizabeth Little. She did nothing wrong. Oh, no. Oh, my God, Alan Jackson. What have you gotten yourself involved with, my dear God? Karen, what are you doing? Listen, I forgot, ladies and gentlemen, that this exists, okay? I have to watch to make sure I mute some of this. You know what? We may just have to mute the audio. I know the audio is good, but there's too many cuss words. I am not going to allow Mike Crawford to engage in this type of heathenistic, ungodly cussing, or whoever is rapping in this song. Okay, hold on. We need to do a special towel poll. Hold on. Listen, this is an unscientific, sardonic, parody-based towel poll. Hold on. Does Mike Crawford, hold on, we're not being mean, we're just asking. Crawford, from the Young Jerks who rubs his nipples, need a bra? Yes! Bras are helpful. No, he should flap free. There you go, ladies and gentlemen. We have I spelled nipples wrong, but we have a very special towel poll. Does Mike Crawford need a bra? Is that a diaper he's wearing? All right, does Mike Crawford, who rubs his nipples, need a bra? The answer is, so far, 86% of people have voted that bras are helpful. Listen, ladies and gentlemen, I swear if Chloe the dog is somehow in this video from however many years ago with Mike Crawford rubbing his nipples, I'm going to lose it. All right, so I got to keep you updated on the towel poll. Mandy Strong says Mike Crawford needs a mammogram. All right, according to the votes that are flying in, 79% of people say that Mike Crawford needs a bra. 21% of people say he should flap free. So listen, I'm not really sure, it's not 100 to 0. So some of you want to see his man nipples in all their glory. Listen. This is better than that time that we were watching that Karen Reed stream, the free Karen Reed stream, and they had nipples on the side of the screen. I forgot about Mike Crawford being a nipple rubber. Oh, ladies and gentlemen, Peony and Rose has a serious question. They want to know if Crawford takes hormones. I don't know. Well, listen, ladies and gentlemen, to me, okay, I think we should analyze this. Let's actually take a moment. Let's analyze this. Is this not the perfect male form? Hold on a second. Hold on. And listen, I shouldn't do this. Listen, everyone is beautiful just how they are, all right? But ladies and gentlemen, come on. Is that not the ideal male specimen? I mean, how can you deny that right there? That's basically a male Mona Lisa, ladies and gentlemen. I mean, look at that. You know, we could zoom in even more if we want, but I mean, if you really want to, I don't want to make anyone physically nauseous, but if you really want to, if you want to do an examination, I think that basically is the male version of the Mona Lisa. So, yeah, you know, I just think you go in there, you could paint that, you could put it in the wannabe Louvre. I think it's down the street somewhere in one of the environs of Paris, one of the far-flung adornments. Yes, ladies and gentlemen, we don't just analyze Hank Brennan's feet towels. We analyze Mike Crawford's from the Young Jerks nipples as well. Oh, ladies and gentlemen, this has been one of the best lunchtime moments of levity during the Lindsey Gaetani and Hayden Kearney trial. This is why you tune in. We don't just tell you about how Hayden lost his motion for a required finding of not guilty and how Paul O'Keefe's going to testify after 2 p.m. We talk about how Mike Crawford from the Young Jerks is clearly the ideal male specimen, and we should make a modern David and put it in the wannabe Louvre somewhere in Paris based on Mike Crawford. Okay? It all makes sense, ladies and gentlemen. Now, I know you're saying to yourself, Grant, we just want to watch the video. All right? I know, Heisenberg, I know, but it has so many cuss words. I hope you know I was listening to it in my ear because I had to screen the video ahead of time while we were doing that. I was not gratuitously doing that. I had to play the video on another screen so I could make sure that all of it was at least, I mean, it's bad, but all of it was at least reasonable for me to play. I have to monitor it at certain points. And I wish, ladies and gentlemen, that we were not confronted with the fact that I have to deal with this, but we are, and it is absolutely as bad as you think. Also, come on, if we can't take a moment to analyze Mike Crawford's nipples, what is the point of doing this stream, ladies and gentlemen? Come on. Come on. Oh, I'm not playing some of this. What the hell is this? Oh my God. Why is Mike Crawford in this? What is this? What? I'm not playing some of this stuff. Some of these lyrics are outrageous. I'm not playing some of these lyrics. What? No. No, I'm not playing any of these lyrics. What is this? What? What are you talking about? Oh my God. Why does this exist? No, I don't want to see your throne. I don't want to see your nipples, your 40 ounces of grape soda, your roast beef, or your throne. What is wrong with this world? Why am I being forced? What is this? Heisenberg, I don't understand.
There's no sucking.
What is wrong with you all?
Stupid sandcastles.
What? What? I am incredulous. Listen, just being nosy. I know. Listen to me. All of you. I want to be clear that I did not watch that video. I listened to the audio and I muted a lot of it. I understand I have a personal... We led into that, by the way. We led into that, a lot of you, with that screenshot. This was our moment of levity, and me saying I don't take kindly to people trying to hurt Little Towel. What did that lead into? But me finding that old video that I listened to but did not know involved all of that. I would just like to reiterate... Mandy, calm down. It has stopped. Listen... I would like to reiterate two things. One, that is a man who is one of the bigger Free Karen Reed streamers. Okay, so as much as I was a little bit aghast and overwhelmed, there's some relevance of this to the case. There was a picture of him with literally Alan Jackson I just want to point out, like, I put that in there to make a point about how, like, Alan Jackson had taken a picture with him. But I'm not just being like, oh, this guy follows along with the Karen Reed case or follows the defense. They took a picture with him, okay? There is a grounding in there's some sort of foundational relevance, in my opinion, to me saying, okay, so if the Reed defense takes a picture with this man, then we can watch that video. However, I want to make sure that the super towel Mandy spouse has not actually fainted. I just want to make sure everybody's okay, because that was a lot. I know our moment of levity got very intense there. I know it wasn't necessarily graphic, but having to look at a man rub his nipples and do push-ups like that and just generally walk around in that way has very much affected me on a personal level. Just in my opinion, I have been personally affected. I think I am now blind. I don't mean that, I mean I cannot look at the screen because I don't want to risk putting my eyes on that again. I didn't mean it like that. I actually have vision issues, but still, that was really bad. So, now listen. That was our moment of levity. I think we all need to compose ourselves. We still have 30 minutes until district court comes back into session. I initially just wanted to watch videos of Towel asking difficult questions to Aiden and Karen. Then I somehow got off on a tangent about Young Jerks. Oh, because he was broadcasting the hearing, apparently, the Karen hearing, the Aiden hearing, and channels are playing the audio, whatever. But he was playing the video of it, which is really not okay. Like, I'm not playing the video. I have found a channel that had the audio. I played the audio, but he was playing the video of it, and so I went off in this rant. And it ended with us talking about roast beef, Revere Beach, and nipple rubbing. I'm sorry. I really, really hope you all can forgive me. Listen, I know some of you. What do you want me to show? No, listen. What do you want me to show you, Peony and Rose? I'm honestly scared at this point to ask people what... I'm honestly scared to ask this question, but what would you like to watch next? After that last video, I don't know how much more randomness I can handle. I'm not gonna lie, I'm a little disturbed. I'm nervous about whether Aiden's gonna get convicted today, but I'm also slightly perturbed. Nipple Man! Nipple Man! I love it. Alright, so... what do you want? You want, the reel, like REEL, like the reel of me asking questions to Aiden and Karen? We can do that. I'm a towel. I am a towel. So let me pull that up for you, little towels, and I'm sorry you had to look at Mike Crawford's nipples for so long. I feel like none of you are ever going to forgive me. And someone said it encapsulates FKR in a nutshell. Yeah, I mean, to some degree, like, I'm trying to make a point, like, that's ridiculous, absolutely ridiculous and absurd, and I cannot believe that exists. Now, all art is good art if it makes an impact, ladies and gentlemen. But that, I mean, that was pushing it. Now, like I said, though, the only way the art would technically be bad is if, for whatever reason, the art did not elicit a reaction. All right, so let me see if I can find this video of Towel asking tough questions to Aiden, Kearney, and mostly Karen Reed. Let's see if I can find the compilation. Noelle said that was disturbing, but hilarious. Yes, the closing statement is tomorrow. Yes. You want to watch? Oh, okay, yes, Mandy Strong. Hank's opening statement. I agree. Let's do that. I agree. Mandy Strong is the best idea. Mandy Strong is a super towel. All right. YouTube, Court TV, Karen Reed retrial, day 1. Mandy Strong, we love it. We're only going to get to see some of Hank Brennan's opening statement. I wish I had started a little bit earlier. I now feel bad about the nipple rubber video, but sometimes district court comes back into session late anyway, so we might get to see more of this than you're expecting. All right. You ready, Mandy Strong? Are you an excited towel? I'm an excitable towel. I am indeed a towel, and we are indeed watch Hank Brennan's cross. There's only so much nipple rubbing you can handle in one day, ladies and gentlemen. Yes, Mike Crawford rubbing his nipples was the highlight of the day. As Heisenberg said, towel, we've done it again. Yes, you, Heisenberg, you caused us to do it again. All right, getting Hank Brennan's opening queued up here, because when what Mandy Towel doth ask for, Mandy Towel doth receive. Ladies and gentlemen, that's what happens when you're an honorary towel spouse. You want to watch Hank's opening statement, right? I don't want to watch AJ's opening statement. He is a towel. He's not a towel. Hank's a towel. AJ is a non-towel. Now, by the way, I thought about this more. Someone was asking the other day, is it possible for something to not be a towel other than just Karen Reed and Alan Jackson? And yes, I've thought about this. And I know it sounds a little bit off, but it is very possible, in my opinion, that you could potentially be not a towel if you were a metal surface, okay, ladies and gentlemen, a metal surface that did not allow something to be picked up on it. So if you are a hard metal surface, then you are not a towel. Now, we're ready for Hank Brennan's cross. I queued it up. Wait for this. I literally think Mandy Towel is going to lose her mind. Oh my goodness, it's Hank Brennan in all his Hank Brennanness. I hope you're ready, ladies and gentlemen. We have Hank Brennan's cross all queued up. Hank Brennan's opening all queued up. We're going to watch this till the TurtleBoy trial comes back into session. Will we be on verdict watch in the TurtleBoy trial today? And then verdict watch in the Karen Reed case tomorrow? Oh, ladies and gentlemen, we're going to find out together. My name is Grant Smith-Ellis. I'm a towel. Thank you all for so much for sending your support. I hope I got what I needed over to the people who needed it, and I'm going to continue to be a towel. Now, since I think that is good, thanks very much for everyone coming together. Remember, trials don't happen that often, okay? Trials are very difficult on the families, on the witnesses. So everyone who's been sending support for Lindsey, God bless you all out there. You are wonderful humans. It does not go unnoticed. Take it away, Hank.
At 6:04 a.m. on January 29, 2022, the alarm bell sounded in the Canton Fire Department. Firefighter paramedic Timothy Natali knew what that meant. His heart skipped a beat. He raced to his equipment and he picked up his bag, which was meticulous. There was a sign and a signal, and then there was a voice commanding that there was cardiac arrest. The most serious of calls for a firefighter paramedic, that means that a person's heart has stopped. He didn't know who it was, he didn't know where it was. He took his bag, he had just gotten to the station, and he rushed to the ambulance. He was one of the most senior paramedics that morning. Another paramedic, Anthony Flamati, would be running this mission. He jumped in the back of the ambulance, the door shut, and they headed off to 34 Fairview Road. As they drove, firefighter Natali could not see anything. He couldn't hear anything other than the engine of the ambulance. He could feel it sliding across the road. It was near blizzard conditions. He calmed himself, he steadied himself. This is what the firefighters and paramedics are trained to do, to focus. And he focused on his task. He looked around the back of the ambulance to make sure that all the tools were in place. The ambulance was meticulous as well. This was Anthony Flamati's ambulance, and it was well stocked. He calmed himself, and he thought about what was going to happen. What should he be looking for? What is his next steps? He played the scenarios through his mind, and eerie calm was above him. As the car pulled up to 34 Fairview, the ambulance, he stood at the back door, and the doors opened, and he stepped out into bedlam. He could hear a woman screaming and shrieking, the cold, hard air slapping on his face, and the wind, blizzard conditions swirling around him. You will hear him tell you how he trudged towards those screams in the darkness to snow, and when he got there, he saw 3 women surrounding a man lying, not moving on the ground. He walked up to the man, and he reached down, and he tried to find any signs of life, pulse, anything, and he found nothing. And he got up and he walked over to the woman, and he walked over to that defendant, Karen Reed, and he told her that he thinks that that man is gone. And then he heard the yell from Anthony Flamati, the chief, and he said, come back, let's go. Because you'll learn that in the cold, even if somebody's heart stops, even if they're presumed to have passed, sometimes you can still save a life. So you'll see on a dash cam video, you'll hear through testimony, he went back to that man who's John O'Keefe. He went back to him, and that crew, coordinated effort, they did everything they could to save his life. They got on their knees, they began CPR, and firefighter Nuttall will explain as he kneeled over John O'Keefe, he looked up, and the defendant approached him, and you'll see it on the video. Now, he wanted any information, because when you're trying to save someone, you want to know, are they on drugs, medication, do they have a heart condition? And he looked up at Miss Reed, and he said, what happened? And you'll hear her words to firefighter Nuttall. She said, I hit him, I hit him, I hit him. And it was at that time, with the words of the defendant, that she admitted what she had done that night, that she hit John O'Keefe. Now those words didn't mean anything to firefighter Nuttall. They weren't in context, they didn't reconcile with the injuries, it didn't help him in his treatment, so he ignored it. Now, firefighter Nuttall is not a police officer. He is not an investigator, he is not a detective. He's a first responder. And so he takes that information, it was useless to him, he continues to work on John O'Keefe trying to save his life. You'll see the team put him on a stretcher. And when they lift him from the ground, even though there is snow accumulating, underneath John O'Keefe is simply grass, hard, brown, frozen. And beneath his body lay his cell phone. They bring him to the ambulance, and while they bring him to the ambulance, you'll see on the videos that other first responders speak to the defendant. One first responder, Mr. Flamati, she will say, I hit him, oh my God, I hit him. And then she was interviewed or asked questions for background information, not a criminal investigation, just background to try to help John. And she was asked questions about his background, and during that conversation, you won't hear her see the defendant with a person by the name of Jen McCabe and a firefighter McLaughlin. And she tells Fire McLaughlin, the third first responder, I hit him. They bring Mr. O'Keefe to the Good Samaritan Hospital, and his body is cold. The doctors work feverishly. They treat him, trying to save him. They try to warm his core. And unfortunately, firefighter Nuttall's first instinct is accurate. John O'Keefe passed. So why are we here today? We are here today because John O'Keefe was killed by the actions and conduct of that defendant, Karen Reed. You will learn through this case, through facts, science, and data, you will learn that on January 29th, 2022, when the defendant and Mr. O'Keefe were in front of 34 Fairview Road, all the way to the left side in a dark corner near a flagpole, you will learn that Mr. O'Keefe got out of the car. He got out as he stood by the side of the road after an argument with the defendant. That argument, that anger fueled by heavy intoxication, you will learn from the science and data as he stood by the side of the road, the defendant in her SUV drove away. She drove at least 35 feet away. The argument was over. It had ended. But then she stopped. She stopped, she put the Lexus into neutral, and she waited for 2 seconds. And the facts and the science and data will tell you that despite the fact the argument was over, she then put the Lexus into reverse, put her foot on the gas pedal, and began to press, not 25%, not 50%, up to 75% acceleration. There was a light dusting of snow, the Lexus tires spun backwards, she went backwards at least 70 feet, she clipped John O'Keefe, he fell backwards, hit his head, broke his skull, and there he lay at the corner of Fairview Road, on the ground, lying on top of his cell phone, alone. And then the defendant will later tell that when she left, he didn't look mortally wounded. Yet he was. And she simply drove away. Now, before I tell you about the data and the facts and the science, and I walk you through that, I'd like to tell you a little bit about John O'Keefe. John O'Keefe was a young man, a local kid, very well liked, loved. John O'Keefe is the son of Peggy O'Keefe, John O'Keefe Sr., and the brother of Paul O'Keefe. Grew up in Canton, worked hard, he became a police officer. But what you're going to learn, the fact that he worked for the Boston police officer, as a Boston police officer, was just a fraction of his life. It was a small, really unimportant part, because the biggest part of John O'Keefe is he was a family man. Not in the traditional sense. You see, John O'Keefe never had biological children. John O'Keefe was never married. But John O'Keefe had a sister, and she had 2 children. And when the children were 6 and 3 years old, his sister unfortunately died. And shortly after, his sister's husband died. And John O'Keefe was at home. He didn't sit by. He saw these 2 recently orphaned children, and he stepped in and he said he was going to raise them. So he put aside his career, he put aside his job, and he moved in with the children and raised them like they were his home. They were his passions, his love. He was a new parent, successes, failures, like all parents. And he raised the children with the help of people in the community, with the help of his brother, with the help of his family. And they led a good life. Enter Karen Reed. Around COVID, the defendant and Mr. O'Keefe reacquainted, and they started a relationship. And you'll hear that even though the defendant had her own home, she was staying with Mr. O'Keefe a lot, 4, 5, 6 times a week. And to most of the world, it was a pretty good relationship. They spent time together, they did activities with the children together. She helped with driving the children, feeding the children. It was a steady relationship until about the beginning of 2022. And then things began to unravel. There was tension, there was arguments. In fact, just a few days before this incident, you'll hear that Mr. O'Keefe asked her to leave, but she wouldn't. You're going to be able to read text messages of their conversations on January 28, 2022, and you will see the tension and the unraveling of the relationship. You will read about the discord between the defendant and Mr. O'Keefe. You will see that when he would ignore her calls, they would become incessant. When he would try to push away, she would come closer. You will read those text messages and you will realize that this was the beginning of the end of this relationship. That night, they decided they would go out together. I want to tell you something about data and science before we get to that night. I mentioned that underneath John's body was a cell phone. A cell phone is an amazing piece of technology. It is like a computer. It carries extraordinary data. And when they found the cell phone, the only companion to John O'Keefe that night, they studied the cell phone, and there'll be some remarkable data that you will use in this case to find the truth. I want to mention 3 different things you will find in a cell phone that are critical to this case. The first is called location data. Waze we've all heard of, Google Maps. Well, at some point that night, John put his Waze on, and Waze is like a breadcrumb. It will show exactly where the phone goes, second by second. It is the strongest, most accurate location data that you can have. And that night, John was using Waze. It also will have healthcare data. Healthcare data will show when somebody is moving. Sometimes it's qualified as steps, but it doesn't necessarily mean somebody's stepping. Moving their arms, walking, turning. It doesn't show what direction or how far, but it shows movement of a person. Healthcare data. And the third thing, remarkably, there will be an expert in this case who found a data file in the phone, and it tracks the temperature of the cell phone battery. That will be critical to to your analysis in this case, the temperature of the cell phone battery. And so with that, I want to take you back to the timeline of that night. After the discord, both the defendant and Mr. O'Keefe decided they would meet at a bar called McCarthy's. Now, McCarthy's is a local bar, a blizzard is pending, and people are getting together in a celebratory mood. They go to McCarthy's and you'll see a video of McCarthy's, and you will watch both Mr. O'Keefe, friends, and the defendant drinking alcohol. And you will count 8 vodka drinks that the defendant drank. They arrived at 8:50, they stayed till 9:45. She consumed at least 7 of those drinks in less than 2. The last drink, you'll see when they leave the bar, she puts it under her jacket, and they walk out and they go to another bar to meet other friends called the Waterfall. They reach the Waterfall sometime around 10 p.m. And when they go into the Waterfall, you'll see a video. And when I said celebratory mood, you will see a group of friends of John O'Keefe, many who are friends with Karen through John, and you'll see them clapping and happy and joyous that they're there. You'll see many hugs between John O'Keefe and his friends and the defendant and many of the people there. And they spend some time together, they're drinking, and they all do a shot. And that will be at least the 8th drink within 3 hours that you consume. You will see from the data, not just the cell phone data, but there's some other very important data. And the other piece of data that goes hand in glove with the cell phone is information on the defendant's Lexus vehicle chips. You might have heard a black box in an airplane. Was there some type of event that captured a small amount of time? Well, that was captured in the defendant's Lexus. That black box information with the cell phone data will tell you everything you need to know in this case. It will bring us step by step through the entire night to the death of John O'Keefe. And so they leave the Waterfall bar at 12:12, and you'll see that the ignition goes on to the defendant's Lexus. And both John O'Keefe and the defendant in the car, and they decide that they're going to go back to 34 Fairview Road, where we talked about earlier. They're going to go there for a get-together for one of the homeowner's sons who's having a birthday party. And so as they drive back, we'll be able to follow them to this location data. When they go back to Fairview, they don't know exactly where it is, and they get lost. And so John O'Keefe makes a phone call, has a phone call with one of his friends, Jen McCabe. And during that phone call, which the defendant listens to because she recounts it, and trying to get directions, Jen McCabe tells John O'Keefe, it's near Bella's mom's house. You'll learn that Bella, or her mom, was somebody that John had dated before this week. And so as they make their way to Fairview, you will see there's a road that comes down like a loop and that leads to Fairview. They take a wrong turn on the loop, and then they do a 3-point turn in the driveway. You'll see the exact precise driveway they turn into because some type of acceleration movement triggered that black box in the Lexus. And that's important because that's 7 minutes before the collision. And you'll see from the waves exactly where the car was. You'll see from the black box the event of the 3-point turn in the driveway, and then a return down to Fairview. But before they get there, at 12:23, a truck is coming the other way. And the witnesses in that truck will say they blinked the lights. One of them saw a man and woman in the car, John and the defendant, and then they followed the Lexus because they were going to the same house. The truck stopped at the driveway, and the Lexus, the defendant's car, will appear because of the waves and be counted second to second, never stops. It rolls very slowly all the way to the end of the yard in the corner where there's a tree line and a flagpole. And they reach that location at 12:34:33. And they're in the car and they stay there. The truck waits, they speak to somebody in the house who comes out, the person goes back in the house and they're there for about 5 minutes. We're now down to 2 minutes before the collision. The truck leaves, and now it's just the defendant and John. And while they're waiting outside, 12:27, John gets a text from Jen McCabe, park behind us in the driveway. 12:29, she texts again, are you coming in? You'll hear that Jen McCabe and others look out the window and see the defendant's Lexus in front of the flagpole at the far end. It's snowy, it's dark, it's windy, they're waiting. You will know that John O'Keefe was in that car, that Lexus, and didn't move because his healthcare data is not moving. It's not moving until 12:31:56. At 12:31:56, he begins to move. You will have 20 seconds before he falls. 20 seconds. He gets out of the car, the Lexus, and in that 20 seconds, you'll hear that user initiated. He looks at the phone, at the text message to Jen McCabe. It's now 12:32:09. He closes the phone the last time. It will be the last time he uses that phone. From the waterfall bar, you see that he keeps it in his back pocket. And at that time, 12:32:09, last user, he has 7 more seconds he will move before he lies dormant the rest of the night. We'll also have the information from the defendant's Lexus black box. And the clocks run differently, there's a 30-second variance, but it's right in the heart of that time. And you will see in the data at that time, when he makes his last movements with the phone, is when her car leaves 34 feet at least, stops, neutral, and then shoots into reverse with the tire spinning right towards him, right where he got out. You'll know they're arguing because the next morning she tells a firefighter, "I'm sad because our last moments were fighting." She drives away. They said she's made later statements that when she left, he didn't look mortally wounded. He lied on the ground on top of his phone, light dusting of snow, the snow now picking up. And he's just there. It's 12:37. Now, when he's in the car, before he gets to Fairview, the battery temperature of that phone is 77 degrees. 77 degrees in the warm car. Now that he's been outside the car for 5 minutes, it drops to 72 degrees. She drives to his house. She makes a phone call at 12:33 after she's left Fairview. She calls again at 12:36:33 and leaves a message. You'll hear it. And you will hear the anger and rage in her voice. She leaves a message. "John, I fucking hate you." Pardon my language. You will hear the simmering. And she leaves that message. He lies on the side of the road. He gets another text message that's unanswered from Jen McCabe. "Where are you?" 12:45. Battery temperature, 61 degrees. Stop. He gets almost 40 calls from the defendant that night. His phone rings, but he never answers. You'll hear from an expert that the light never initiates, the healthcare data never moves. John alone with his only companion, his phone. At 12:53, cell phone drops to almost 60 degrees. 12:59, the defendant leaves another message on John's phone. Now, she hasn't spoken to anybody. Nobody has spoken to her, but her message is out. You'll learn the message says, "John, nobody knows where you are." And this is where the plot in the cover-up begins. The evidence will make clear that she knew he was there. She did not call 911. She did not go back to him. She did not leave an anonymous tip. She left him. The night wears on. It's now 1:07. Battery temperature 55 degrees. 1:14, she calls her mother. No answer. 1:14:53. Battery temperature 50 degrees. The defendant had healthcare data on her phone as well, and you'll hear that it stops around that time. You'll later learn that she admits to falling asleep and passing out. But then she wakes. It's 5 o'clock. She is frantic. She wakes up John's niece, and she is unintelligible. She is yelling, she's screaming, she asks for the niece to call Jen McCabe. She calls Jen McCabe, and you'll hear Jen McCabe recount. Out of a deep sleep, she wakes up and she hears, "Jen, Jen, Jen, screaming Jen's name. John's dead. Hangs up the phone. Jen McCabe calls down. And then she says, what's going on? And she told, well, I left him at the waterfall. At the beginning of the cover. She tells Jen McCabe, I left him at the waterfall. Jen calls back and says, he saw you up front. You did leave him at the waterfall. She hangs up. She then minutes later calls another person, Kerry Roberts, a friend of John O'Keefe. Someone who's not friends with the defendant, but they know because they helped raise the kids and they interacted. She had nothing to do with the night before, wasn't at the bars, was home with her family. She calls her and says, I think John got hit by a plow. I think he's dead. Now Kerry, with that information, calls 911. She calls hospitals, you can hear her voice. She's concerned, not panicking. And then she gets another call from the defendant. And she tells the defendant, come to my house. I will help you look for him. And the defendant says, I was so drunk last night, I don't remember anything. Waiting for her to arrive, she learns she doesn't arrive. Instead, the defendant goes to Jen McCabe's house. Kerry Roberts, the other friend, then goes to Jen McCabe's house, pulls behind the car. And when she does, she's on Bluetooth, and she can hear the defendant saying, my taillight's broken, my taillight's broken. And she looks, and the snow packed in the right taillight, she can see a piece of the taillight missing. The defendant desperately wants to go to 34th Fairview Road, but Kerry Roberts takes over and says, we're gonna go back to John's house. Maybe he's in the house and you didn't see him. So both cars, driven by Kerry Roberts and then Jen McCabe, with the defendant, go back to John O'Keefe's house. You'll see a ring video where you see them go into the house and they look around, and you'll hear about the woman, Jen and Kerry, enlisted into this task. Look for John O'Keefe, they cannot find him. And then when Kerry Roberts comes into a room, she sees, rather than looking, the defendant simply standing there, staring at the wall. At that point, the defendant insists they gotta go back to Fairview Road. They decide to take one car. Kerry Roberts is taking charge. She's gonna drive. They leave Miss Reed's Lexus in John O'Keefe's driveway, and they drive back towards 34th Fairview Road. You'll hear it is blizzard-like conditions. It is dark. They can barely see a thing. And when they get close to the edge of 34th Fairview, you hear the defendant start to scream, there he is. Both women look and they can't see anything. She starts kicking the door. The defendant's kicking the door, let me out. Kerry Roberts stops the car and lets her out, and she sees the defendant run exactly to where John O'Keefe is in the darkness, just where she left him. Kerry gets out of the car, starts to walk towards where the defendant is, and she sees the defendant lying on a body. She can't tell who it is because the face is still covered with snow. And she comes over and looks, and she wipes off the snow from John O'Keefe's face. She realizes one of her best friends in the world is John O'Keefe. And she starts trying to do first aid. They start to move him, and coincidentally at 6:06 when they start to move him, the cold air hits that cell phone battery. It drops from 50 to 43 degrees. And they try, Jen McCabe calls 911. And that's when a police officer arrives, firefighter Natali and his crew. And when they lift him, that cell phone battery that is shot down to 37 degrees, Kerry Roberts picks it up and puts it in her pocket, and it immediately starts to warm. As she moves, the health care data showing movement starts again. At that point, nobody knows what happened. The Canton Police Department come. You can see the police cars and cruisers. They're not sure, so they look at the area where John's body is and find a glass from the bar near his body. They find blood spots. They try to put the blood spots in plastic containers. They don't know what they're looking for at this point. There's no information. They don't believe or know that there's a crime. They just know that John O'Keefe somehow ended up here with the broken glass and the blood. And so that morning, you can see the work of the Canton Police Department try to uncover a little bit around his body to see what they could find, which was very little. And then, Kerry Roberts goes and picks up Peg O'Keefe, tells her the news, and they go to the hospital. They go to the Good Samaritan Hospital, and Kerry Roberts is walking, and Peggy O'Keefe is going to go see her son with her husband. And as she walks down the hall, Karen Reed is also in the hospital. See, there was some reports of maybe she was upset or suicidal, so they sectioned her. They put her into evaluation to make sure she was safe. You'll hear Peggy O'Keefe tell her she walked down the hall to go see her son. The defendant was screaming, "Is he dead? Is he dead?" As she walked by Karen, she stopped and she said, "Karen, what happened?" And you'll hear that Karen was excited and yelling, "Is he dead?" She stops her excitement. She becomes stoic. Doesn't say a word. Peggy pays respects to her son, and then she has to go back home because she has to tell the children. Now, while she's out, the Canton Police Department send an officer to the house to make sure the children are safe because they're alone if they're home. And when the officer pulls in, he doesn't notice anything, but you'll see in his dash cam video notices something. That tail light has a big missing piece to it. They can't find the children. Ultimately, Peggy comes home, her friends have taken them, and they bring the nephew home, and he is distraught. And then Peggy hears a knock on the door. It is the defendant and her father. They want to come in. They come in, they open doors, Mrs. Peggy, and they ask, "Can we go upstairs to John's room?" And she's busy consoling her grandson. They go upstairs, they're upstairs for about 15 minutes. They come down, and quickly they leave. Now they got there from the defendant's father, drove his wife and the father to that house. But when they leave, they take two cars. They take the Lexus with the broken tail light with them back to the defendant's father's house. And you will learn that when police start getting some of the information, they learn about the broken tail light, they learn information that she had told people that she had hit him. They went down to see her. And on their way down, they decided they would get a warrant to take the Lexus. When they get down to Dighton, where the car is, you'll hear from Trooper Buchanan, who took a look and you can see the missing tail light. They went in and spoke briefly to the defendant. They took the car, they brought it back to Canton. And so, what you'll learn from the forensic evidence that will help with the science and data is that not only was the cell phone left behind, but also around that area, broken tail light was littered around John O'Keefe's body. Littered around that area. When they got to the hospital, they noticed there was a shoe missing. As time went by, snow melted, they dug with excavations, they found his shoe on a little berm on the border between the street and the grass. You'll learn days later when they did a plant excavation, they found his hat frozen to the ground. Ultimately, they would find over the course of 10 days that the snow melted almost all every piece of that broken tail light in that area. His hat, the sneaker, the glass. When the defendant left Mr. O'Keefe behind, he took with her something of Mr. O'Keefe. It's called trace evidence. You'll learn on the back of her Lexus, around the taillight area, is John's DNA, and stuck to the side, grasping one last piece of John O'Keefe's hair. Now, John O'Keefe fell backwards and hit his head after he was clipped by the car. And you're going to hear from a very renowned doctor, a neurosurgeon, who's treated thousands and thousands of cases. And the wound on the back of the head, when he fell backwards, not only cracked the skull, it's called a basal fracture. It created an injury called counter coup. After he was clipped by a car and fell backwards and hit his head on that hard rock ground, remember there's no snow, it's just a dusting at this point, the back of his brain hits the back of his skull and bounces up. When it bounces up, it leaves marks showing that impact. And this neurosurgeon will tell you, he treated thousands of patients, that this injury, to a reasonable degree of medical certainty, is counter coup caused by falling backwards and hitting your head. When the medical examiner for the state looked at it, they generally said blunt force trauma. They had it undetermined. So we brought it to the renowned neurosurgeon who does exactly this. You're also going to hear from an active reconstruction. His name is Doug Welcher. He does not work for the state police or local police. He was hired to take a look at this case and the data. He will come in and explain to you exactly what I talked about, how the data from that black box coincides with the cell phone and the movements of the car, the moments before, during, and after the defendant struck John O'Keefe with her car. Now, just a few more things I want to share with you. There are 3 charges against the defendant in this case. The first one, second-degree murder. When most people hear murder, they instantly think shooting somebody, stabbing somebody, bringing, deliberate premeditation. Her Honor will instruct you on the law. I'm not going to trample in that area, but I can tell you clearly, we are not going to try to prove that Karen Reed tried to kill John O'Keefe. We're not going to try to prove to you that she intended or wanted him dead. That's not second-degree murder. What we'll prove to you is she engaged in an intentional act, driving back at him at that speed, in the storm, in the darkness, knowing that he had just gotten out of her Lexus. She intended that act, which would cause a plain and strong likelihood of death. That's what we'll prove to you for second-degree murder. Also, operating under the influence of alcohol, manslaughter will prove to you that she drove her Lexus recklessly. She hit John O'Keefe, and because she hit him and he fell back, she caused his death. The third charge is leaving the scene after knowingly causing death. Again, she hit Mr. O'Keefe with a car. She knew he was injured. She left him behind. And he died. That's what we'll prove. This case will come down to the science and the data. The science and the data that cell phone produce the best of historians. It doesn't suffer from intoxication. It doesn't suffer from memory loss. It doesn't suffer from emotion, pride, or prejudice. It is facts. It is data. And that facts and data will lead you to the truth in this case. But after Ms. Reed was charged, she began what you'll learn as a campaign. A campaign to make public statements. 2020, Nightline, Fox 25, a documentary. And we've had an opportunity to get many of her statements in the footage, and we're going to show much of it to you. And her statements to you will confirm what you already know from the science and the data, what you will already conclude from the facts independent about what she did that night. Her word will simply confirm that her judgment is sound. And you're going to hear from her own lips in many of her statements, her admissions to extraordinary intoxications, her admissions to driving the Lexus, her admissions to being angry at John that night. And I dare say her admissions that she told Skip. I'd like to play for you clip 1. You're going to hear the first of the statements that she made after she was charged.
I mean, I didn't think I hit him, but could I have clipped him? Could I have tagged him in the knee and incapacitated him? He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out and in drunkenness and in the cold didn't come to again?
And this would have been the moment you dropped him off at the party.
Yeah, would have had to.
Ladies and gentlemen, I simply ask you to follow the evidence, follow the science, follow the data. Ignore speculation, surmise, conjecture. Stay true to the evidence. It will lead you to the truth. That on January 29, 2022, a very intoxicated defendant was angry and arguing about the relationship with John O'Keefe. And after the fight was over, she left, but she brought the fight back to him in the form of her SUV. She clipped him, he fell backwards, he broke his head, and then this man who helped, a lifetime of help, was left at the corner of that yard, left to die with no help. The facts, the data, and the evidence will bring you to the truth, and the defendant's own words will confirm everything you've already concluded.
All right, folks, that was the opening. Hank Brennan's stellar opening. We're going to the Aiden TurtleBoy Kearney case. We're back after lunch. Are we going to get a verdict today? I don't know. Tune in, find out. My name's Grant Smith Ellis.
And did you, at some point, leave the courthouse?
My first thought was.
The question was that sometimes it
Just at some point, did you?
At some point, did I leave the courthouse?
I'm going to back up a little bit.
Oh, okay, sorry.
You left the courthouse at some point, right?
I did, yep,
All right. In the course of leaving,
yep.
where did you go and who did you see?
I went downstairs, and I saw Aiden in the hallway.
And did you want to give him some information?
Oh, yeah.
And did you give him some information?
I did,
Did you give him some information about what you had just seen?
I did.
And was there any recording of that memorializing that?
Yes, Aiden asked me if I could record, and I said absolutely.
Okay. And what happened after that? Mentioned some information to him, and he asked if you could record it. Did you record it? To your observation?
Didn't want to feel like it.
You don't have to provide a whole, for lack, and it's tough to be a witness if you've never been.
Okay.
You have no responsibility to give a landscape of it.
Oh, all right.
You just listen to the specific question that's asked, you answer it, and then you just wait for the next one.
Oh, not much, but if I was to guess, $100.
And have you done that through appeals on Mr. Kearney's broadcast?
Yeah.
Separate broadcast?
Yeah.
What was the mechanism of you're sending the money to apparently that's not.
Because I think she says that.
No, I didn't ask you why. I said, how did you go about
Or free Carolyn Reed, I don't know. It's her fundraiser page.
it? Oh, she's her own fundraiser page and you use that to make your donations. Was that her?
Yes.
How about the defense fund for Mr. Kearney? Did you want to get into that?
His defense fund?
Yes.
I may have.
You don't recall?
I don't recall.
You go into a lot of defense funds, like you have difficulty remembering?
Yeah, I'm not there in age, I don't remember. You asked me and I don't remember.
Well, I sympathize with people of different age. All right.
Your all devices are turned off, folks, please.
Now, as I understand it, you went to this hearing when we were talking about on February 26th, hoping to get into personal needs of her, is that correct?
Yes,
Okay, and you didn't get,
I did not.
now were you upset when you see the time again?
Yes, I did. In the means that how she said she should get in, yes. Because I knew she was not part of this family.
Right, and perhaps if she didn't get any, we've got that seat.
No, there's nothing to it.
And
Because they forgive the ones.
how do you know Lindsey Gaetani, as I understand it, she hasn't been on the witness system?
I know her through some friends.
Some friends.
Yeah, friend, yeah.
Friend of the council. And knowing her through the friend of the friend, you were able to recognize her and know this is license to stop and
Yeah.
friend of the friend must have given you a pretty good description.
Yeah, I've actually met her through a friend.
So you met her.
Well, not directly, but I know of her, that's her.
Yeah, I'm trying to figure out how.
Well, I just told you, we're a friend.
Well, how did you recognize her?
Objection, Your Honor. I asked that maybe everybody was on.
Wait for the question to be asked, answer it, and just wait for the next one. Go ahead.
Have you seen a photograph of her?
Before that day?
Yes. When was that? So, after you hear that conversation, and by the way, did you quote it word for word, or was that sure with some?
I mean, there's only a few words said by both of them. I'm not John.
I'm part of John O'Keefe's thing.
Mhm.
I'm sure she didn't say I'm with John O'Keefe's thing.
Nope.
All
It said I'm part of John O'Keefe's.
You're very sure about the
Yeah, I started.
Okay. And, from that point, you proceed downstairs.
Yep.
And you encounter Mr. Kearney.
Mm-hmm.
Are you looking for Mr. Kearney, or was this a, accident was found?
Probably a little combination, because I know we had left.
All right. And why were you looking for?
I was looking for him to tell him what I heard,
And why would you think he?
because they weren't supposed to be near each other.
I'm having trouble making, can you make the connection for me? What? Mr. Kearney's downstairs. What Mr. Gaetani said to the court officer?
I'm assuming so.
What does that have to do with?
Because I saw it, because Aiden left. Aiden left the courtroom.
Okay. So it was important for him to know this when he's downstairs walking.
Because she was lying.
Why does he need to? That's your opinion, by the way, right? That she was lying.
Why don't you not get his job?
Fine. Why does he need to?
Because I knew that she had a restraining order or whatever the restraining order was about.
And how did you know that?
Because it was known.
Oh, it was known how?
Because I.
Why on the front page and Lindsey Gaetani left?
Sorry, it wasn't.
The Boston Globe.
Just he comes from probably following his gut, I guess.
Oh, okay.
Yeah.
So you knew that from Mr. Kearney.
And also with the friend that I told.
The mysterious friend of his.
It's not his name, but.
That's okay.
Okay.
So you knew that. I take it you thought Mr. Kearney would be interested in this information.
A little bit.
And by the way, when you find him, he had lots of building.
I met, it was like in the vestibule, like right before the leave the actual courthouse, not the courtroom.
Not the courtroom, but down near the entrance.
Yep.
Go in and out.
Yep.
He hadn't actually left the building, but he was seeing the entrance or the exit.
Yeah, someone I was, yeah.
Right where they have the note.
Yes.
So you had a conversation and he immediately asked, can I record this?
No, well, I told him what I saw, right? Yep, and he said, would you mind if I recorded it? And I said,
Change this to
"Sure."
45, because it was already at 44.
What? And he asked you, do you mind if I record this? What do you think about this? Did it trouble you?
I was fine to get it on recording.
You have a sense of what you're going to do with it after you recorded it?
No, no,
Not at all. It didn't occur to you he was going to broadcast.
if he did,
You don't know whether he broadcasted it or
I
not?
don't believe he did.
To this day, you don't.
No, I don't.
You're trying to help Mr. Curtis.
Fine, I'll, yes, in what way, for you?
By providing him with this information.
Well, I thought that she was lying.
Listen to the question.
I did answer him.
You gave your own little speech. Listen to the question.
Okay.
Were you trying to help Mr. Curtis?
If I thought it was going to help him, yes.
Thank you.
You're welcome.
Now, when you saw this, police officer, I think you told Mr. Bradle that the police officer went to the left.
Well, he was.
Well, which way was he facing?
He was facing
Towards
that way, like,
towards the Superior Court or away from the Superior Court?
And we're putting this superior court.
Okay, so he's facing
In the middle of
Superior
traffic.
Court. 50 points. What
Like
is that
that.
on the left?
No, I was saying, if he was over here and he was this way, he went like that.
Good pointing to the right.
Yes.
Okay. And anywhere in particular to the right? You didn't hear him say anything. Well, I think he told us that you were out of the show.
I was, yes, in the conversations. I know he was concerned about.
No, you don't know what he was concerned.
Maybe I don't, but you just asked me.
No, I didn't ask you. what
Okay,
he was
all right,
concerned.
okay.
Now, did you earlier in connection with this case provide to attorney or attorney? Let me show you this and tell me if this is either your affidavit or a copy of it. That's your affidavit. And that's your signature at the bottom.
It's cut off.
Yeah, it's cut off a little on the side. You signed this under penalties of perjury.
I did.
How did it come about that you offered an affidavit?
But you're going back to there, so,
Well, you're just going back a couple of years and telling me about what happened.
yeah, because that's a story to talk about the affidavit. So you say when I sign the affidavit, is that what you said about?
No, my question was, how is it that you went about providing?
I think, well, probably because he was going to trial.
Well, did somebody ask you to provide an affidavit? Did you volunteer to
I
provide an
think-
affidavit? How did it happen?
Courtney maybe reached out to me, Courtney or.
No, you don't ask her.
Oh, I don't know, I don't remember.
You don't remember. So, you don't remember how it happened, but you can agree with that.
That I,
Providing the analysis.
oh, yes.
Now, did you write this yourself or did somebody write it for you?
So did I actually type that out? That question?
No, I'm not talking about the physical process. I'm asking, are these your words?
Yes, yeah, exactly what I just said.
Did anybody write any of it for you?
Yeah.
They're not your words?
Yeah.
So, number one of this affidavit from the agree, it says I am of the age and residence of Commonwealth of Massachusetts.
Yes.
Are those your words?
Oh, because I don't know, so it's so.
You sold, you know?
Yeah, that's, yeah.
Seen objections before, you know, she signs it, she adopts an affidavit, it's her words, I mean, I don't understand the purpose of asking her if it's her words, it's implicitly her words, so.
I appreciate Mr. Bradel's testimony.
Objection overruled. There's no question, just try to wade through it as best.
I am
you
from
can.
Massachusetts, I ain't been my whole life.
We'll stipulate she's from Massachusetts. All right, now I think you told us on direct examination that you saw the opposite gesture. And then you saw Mr. Kearney move on, but you didn't see where he went. Jury number 6 of your affidavit, please.
I saw Mr. Carney stop and speak to the police officer who was
this is cut off, so. Who would, make his way across the street from the street.
Now, you just told us you didn't see where Mr. Purdy went, but you signed an affidavit saying that he made his way across the street to the registry of deeds. Is that fair?
Fair.
Now, my question for you is, somebody suggest to you the words registry of deeds?
You answer the question.
Thank you very much. No further questions.
Anything on recent records?
No, Your Honor.
You may step down.
Okay.
All right, thank you.
Lisa Oaks, please. OCHS for the record.
Lisa O.
Lisa Oaks? Lisa Oaks?
Lisa Oaks, come up.
Put your right hand. Do you swear in the matter now in hearing to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, thank you.
May I inquire, Your Honor? Thank you. Good afternoon, ma'am. State your name and spell your last name, please. And where do you live, just generally? How long have you lived there? And what's your line of work? Do you have a family locally?
Yes.
Tell us about your family, just briefly.
My nephew, this be with his two children, 13 and 15. I happen with the, caretaker of them because they lost their mom and they had 2 or 4.
Have you taken an interest in the Karen Reed and Aiden Carney cases here in Norfolk County?
Yes.
And when did that come about? Have you been following the both cases for that time period? Do you attend court hearings and come to Dedham and when things are going on the cases? Directing your attention to 2/26 of 2024, February 26th, were you here in Norfolk County across the street at the Superior Court? And what was your understanding about why you were here and what you were going to see?
The hearing inside the photo, and then outside the photo.
Did you get into the hearing or did you have to stay outside the courthouse and kind of support people? Did you see, strike that. You know the gentleman that's with me here today, Aiden Carney, right?
Yeah.
All right. And do you follow him or watch his shows and pay attention to his journalism? Did you see him at the courthouse on 2/26/24? Where did you first see him?
When you left the Superior Court, he was staying here after you.
Objection to what he was saying.
Just when you first saw him. Just we can go question by question. So the first question is where did you first see him? Was he going into the courthouse or coming out of the courthouse? So where were you when you first saw him coming out of the courthouse? Did you make any observations about his emotional state when he came out of the courthouse?
Objection.
I'd offer it as evidence of his emotional state, Judge, not for the truth of the matters asserted.
So why don't you ask the witness if she heard him saying it?
Did you hear him say anything when he came out? Okay. And what was he doing, if anything, like right when he came out?
He was walking across the street. And across the street together, and he stopped in the crosswalk and that's
Stop. The witness can finish that sentence.
Go ahead.
Yes, he also to read about the other same one.
Okay. So let's just back up a little bit. So did you personally engage with Mr. Carney when he came out?
No,
Okay. And that means when you're talking to your phone and you're kind of broadcasting out to the world. Had you seen him do that before? How often do you see him doing that?
Oh,
Where was he when he first started live streaming?
um,
Where were you exactly when you came down the steps?
I'm sorry.
On the courthouse side or on the registry side? Where did you see him go? You say we, so you went with him?
Yes,
Did you see him talk? Did you see him talk to anyone?
yes.
Who did he talk to?
All the in the process.
And did you hear what he said? What did he say?
Objection.
Then he has raining orders on him, he and then he dropped away where she began. And the officer pointed to the stuff to the registry of the.
And what did Mr. Carney do after the officer pointed to the registry of deeds building? Where did you go?
I'm sorry, I couldn't hear the answer.
Say the answer again, a little bit louder, please. Was he still live streaming at that point? And where were you after he went up there? How far away from Mr. Carney were you at that point, just in terms of feet? 40 feet? Okay. At some point, did a lot of people start streaming out of the courthouse? How long after this event that you just described did the people start to stream out of the courthouse? What was Mr. Carney doing, if you know, when the people started streaming out of the courthouse? Did the people kind of cover the entire front of the courthouse, or was it just one direction where they were going?
Walking.
So there were some people walking down the stairs and down the ramp. Were there any other people that were walking down the main stairs straight down?
Yeah.
Were there people congregating at the bottom of the stairs? Would you say it was a lot of people or just a few people or what?
What?
Do you know someone named Lindsey Gaetani? Did you see her that day? Can you tell us whether you recognized her that day, or did you kind of learn later that that was her and then go back and look?
At this point, Your Honor, checks will be sustained.
Did you recognize her that day?
No.
How do you know that Lindsey Gaetani was there today as you sit here today? Sure, how did you said that Lindsey Gaetani was there that day, right? When did you learn that?
That day.
Okay, so did you recognize her that day? How did you know she was there that day then?
Somebody pointed out that it was Lindsay.
Okay. And when they said that, did you take note of that person? Lindsay, did you take note of the person that was identified as Lindsay? Sure, but that day when the person said, "Oh, there goes Lindsay," did you look at the person that you thought she was talking about? And did you then, from then on, recognize someone who's Lindsay? Okay. And where did you see her go?
Walked down.
Did she, when she got to the base of the handicap ramp, did she walk towards the Registry of Deeds building or away from the Registry of Deeds building?
I'm not sure. I saw her when she was approaching the corner.
And did she walk, where did she walk after you saw her at the corner?
Yeah.
Was she walking away from the front of the Registry of Deeds building or to the front of the Registry of Deeds building?
Away.
At any of these time frames, were you able to see what Mr. Carney was doing? Did you, were you close enough to him to hear him if he was shouting anything? Did you hear him say anything at all when the person you learned was Ms. Gaetani had emerged from the courthouse? Were you in a,
To that. Sustained is to the final portion, but
were you in a position to hear him if he were to shout in terms of your distance from him? Did you hear him shout anything? Thank you very much, Ms. Oaks. Nothing further, Your Honor.
examination.
Those, I take it you're a regular, viewer of, this pretty shows.
Yeah.
Right? And, how long has that been the case? You will pay subscription to, pay channel, you just watch the free shows. Maybe you contributed to the Karen, that's fine.
Yeah.
How much money? How recent? Was that the only time or was there?
No,
And how about Mr. Kearney still got something to contribute to that?
Thank you.
So. I had an affidavit that you filed earlier in this case. Did you file as, did you execute an affidavit earlier in this case? There are a copy of that affidavit. It's your signature down the bottom, signed under the pains and penalties of perjury.
Yeah.
Now, I think you just told us. Just told Mr. Bravel that the first time you saw Mr. Kearney was when he's coming out of his period. Could you read for us, please, number 2 of your affidavit? But that's not true, is it? You're outside the courthouse. You say Aiden Kearney was forced to leave the courthouse. Nobody marched him out of gunpoint, right? No, I don't care what you said. But you raised an interesting point. What you know about him is what he told, right? What you know about the circumstances of him leaving the courtroom is what he told me, right? Or what you observed. Now, I think you told us that after he spoke to the officer directed him where? And did you hear the officer say, go over to the registry of deeds building?
Yeah, it's 26.
Yes, did he say go over to the registry of deeds building? You distinctly heard those words, the registry of deeds building?
Yes.
All right. Yeah. You told him to stand there. Tell him not to move from there. So you, as I understand it, accompanied Mr. Kearney across the street to the registry of deeds. And Mr. Kearney stood there. You observed him standing there. Now, do you remain there with Mr. Kearney or do you move? And how long did you remain?
Until I noticed the leaving.
All right, so do you move when you say everybody's leaving? These are people coming out of leaving the Superior Court, is that what you mean?
Yes.
Coming out of the main entrance there. And do you move at the point that people start coming out, or do you wait till they all come out, or how much longer from the time you see people coming out, do you remain standing next to them?
I wait till the class is for, or talking back over the.
So they all come out. And when they all come out, Mr. Kearney is standing next to you the whole time. In front of you. Is he live streaming?
Yeah.
And does he have the camera? Where is he holding his hands? Oh, his pistols. Probably the whole time. When he's talking to the police officer, was that what he was doing?
I think so,
And it's after the crowd is gone that you leave. Was the Kearney still there when you leave, or does he leave with you? Now, at some point, somebody says to you, there goes Lindsey. And were you able to recognize the person said there goes Lindsey, the point or anything of that nature? Anything to direct your attention to where Lindsey was in particular? Did you look at where he seemed to be looking, or?
I looked to the right and I saw her at the corner.
Okay, and when you saw her at the corner, was that the corner on the same side of the street as the Superior Court, or on the Registry of Deeds side? So she's over on the Registry of Deeds side, and what corner is she?
Right about to turn to the parking lot.
So if I were to walk down from the Registry of Deeds, she would be about to take a left, is that right? And how was it you were able to recognize them? Did you see him before?
Yeah.
And where had you seen him before?
Going to the corner.
No. Did you know who Lindsey was when you saw her going to the courts?
Yeah.
And how were you able to recognize her? In other words, I'm trying to get at what's your basis for knowing what Lindsey was?
My cousin showed me a picture of Lindsay.
Don't tell me why. Your cousin showed you a picture of Lindsay. And what was it, a recent picture? You know where that picture came from? And I think you were established because you're standing next to Mr. Kearney the whole time and you never moved. How close to him were you?
I was walking the steps to reach out to probably.
So 10 feet away, 20 feet away,
25, 30 feet.
25, 30 feet.
Yeah.
By the way, how far? I don't know how big you are, let's see, your distances. You're not. You watch any football? You ever watch the football games? No. You have a picture in your mind about how long the football field is. Could you say the distance between where Mr. Kearney was standing, front steps to the Superior Court was greater, lesser, or about the same distance? Football. And couple more questions. Write this academic such. These are all words that she brought us. So you seem to start number one, the high innovation resident of Commonwealth of Massachusetts. Those are your own words. Thank you very much. No further questions.
Nothing further.
You may step down, thank you.
Paul Keith is your own.
All of you. All of you.
Do you swear in the matter now in hearing to tell the truth, the whole truth, and nothing but the truth to help you God? Thank you.
May I inquire, Your Honor? Good afternoon, sir. State your name and spell your last name, please.
Okay, okay.
Where do you live, sir? Just in general.
Western Florida, Massachusetts.
What do you do for a living?
I'm in sales.
And where do you work?
Doing some streets.
How long have you been self-employed?
13 years.
And do you have a family in the area? Just generally. And who's your family, just in general?
Mother, father, niece, nephew, wife, children.
And you have a family connection to the prosecution of Karen Reed across the street, correct? And it's your brother had passed away, and he's the case involves his death across the street, correct? And you attend the court hearings over there? All right. And you know the gentleman with me here today, Aiden Carn, correct?
Which one I do?
Yep. And he's someone who you don't like.
No.
Right? No, I'm not correct, or yes, I am?
No, no.
Okay, thanks. And you've had a text message or Facebook message exchanges with Mr. Carney, correct?
Once or twice.
And just to summarize it, and you can look at it if you want, but just in the interest of moving along, you sent him a Facebook message saying, I'm taking you down. I hope you know that you're done. You're going to jail again, actually prison this time. I hope your kids are prepared. So I look forward to that. Is that right?
That's the small part of the conversation.
Sure.
Yes.
Sure. I'm just trying to get to the nugget of it. If you want to look at it, I'm happy to show you. But that's the nugget of your sentiment towards Mr. Carney, right?
Yes, I mean, that was sent out of frustration from all the harassment that the defendant has given to me and my family, friends, so slew of reasons.
Sure. And that's an accurate summary of your emotions and your feelings towards Mr. Carney, right?
I would say at that moment, there was words out of frustration.
Sure. And in terms of your case across the street that involves your brother, it must be difficult or annoying or frustrating or produces anger in you that Mr. Carney is a frequent visitor, a frequent commentator, and a frequent critic, right?
Among other things, yes.
And so it would be nice to get him out of there, right?
I don't care for him to be there, huh?
Sure. And so how did you come to be acquainted with Lindsey Gaetani?
We're both experiencing the same harassment from the defendant as well as followers.
So you feel like there's an affinity with you and Ms. Gaetani in terms of being criticized or exposed by Mr. Carney?
Harassed, I would say.
So back to my question, when did you meet Ms. Gaetani?
Meet her in the days that the defendant was removed from work across the street back in February 2024.
Okay, if I suggest 2/26, that hearing that was on 2/26/24?
That sounds right, accurate.
And you'll recall that was the hearing where there was a number of things on the agenda, but court kind of got done pretty quickly that day, right?
It's an afternoon session. I don't really recall what was said. I went to many court dates for the last couple of years, so said specifically.
Okay. In terms of you meeting or speaking with Ms. Gaetani, when was the first time you spoke with her?
That day I introduced myself.
What was that?
I said, nice to meet you. I applaud her strength. That was it.
Was she there? Was she invited there by you?
By me personally, no.
To your knowledge, who was she invited there by?
Someone had asked me if it was okay if she went to court that day. I said, sure. I don't remember who actually asked me that question.
Was it Kate Peter? Do you know Kate Peter?
I know who she is. I don't know if I said I know her.
Have you ever spoken with her?
I've spoken to her once,
And when was that?
once in a phone conversation, and then I believe once for defendant's arraignment.
What was the time frame of you speaking with her? When was that?
When did I talk to her?
Yeah.
We don't know, to be honest.
Was it prior to 2/26?
Possibly.
Kate Peter facilitated this entire visit of Lindsey Gaetani to court on 2/26, didn't she?
That's the one that was okay with me. She came. I said, okay. Public courthouse. At that time, the going to court, we were greeted by, we had to go through a gauntlet of people yelling and screaming at us, which was organized by the defendant and incited by the defendant.
So try to just focus on my question, okay? Because it's a question and answer process here. So when did you speak with Ms. Gaetani that day? Where were you?
We were in the back parking lot of the Registry of Deeds, where everyone meets and walk over together.
How did you come to meet her in the back parking lot of the Registry of Deeds? What was the plan? What was the organizational situation about meeting up there?
And anyone who would go to court knew that we parked back there, and that's when we met and walked over the group.
So is it your testimony that was some sort of just a spontaneous thing that you guys ran into each other back there, or was there some sort of a plan?
I pulled into the parking lot, there was a group of people, I got out, 3 people, she was one of the people that was gonna leave.
Did you know that she was going to be there?
I'm assuming she would be, because I was asked if it was okay with me. So I was under the assumption that there was a likelihood she would be there.
So you were asked by someone who you're not sure it was if Lindsey Gaetani could be at court, and then she materializes at court.
Right.
Where did you park in the Registry of Deeds parking lot? Close to the building, far away from the building, whereabouts? Away from the building? Now, would it be correct to say that you did not invite Lindsey Gaetani that day?
Personally, I didn't.
Did you or your family, to your knowledge, express any invitation to her that involved your family wanting to support her and recognize her and be with her at your brother's case?
I think it was asked me if it was okay if she went.
Was there anything about supporting her or helping her or anything? It's fair to say you were more focused about your brother's case, not Lindsey Gaetani's case? Did you walk in with Mrs. Gaetani?
I believe the group that had the parking lot all walked in together, yes.
Did you know that she had a restraining order against Mr. Carney at the time?
I believe I did, yes.
Were you trying to use Ms. Gaetani to evict Mr. Carney from the courthouse?
Was I personally? No.
Was your family doing that? Who was doing it?
Section 16. Sorry, I'm 16, you don't have to guess this.
So just coincidentally, on the first time you met Ms. Gaetani, she had a restraining order against Mr. Carney, right?
That's right.
And she had it in her hand when she went in the courthouse, didn't she?
It's still within the timing.
Did you see her with a piece of paper in her hand when she walked in?
I don't know.
Did you see when she walked into the courthouse?
Yeah, she was behind me. See her walking, so.
Did you see her when she walked into the courtroom that afternoon?
That behind me as well.
Did you see her when she came in and sat behind you? Did you speak to her at all in the courtroom? Did you have an awareness that Mr. Carney was in the courtroom on the other side of the aisle?
Yes.
Did you speak with him or see him or have any interactions with him?
Not at that point. Later in the day.
Did anyone ask you to invite Ms. Gaetani to any hearings before Mr. Carney had gotten out of jail, such as January 5th or January 18th?
That was the whole time.
Just when Mr. Carney was out of jail and when Ms. Gaetani had a restraining order, right?
Correct.
Did you speak with Jennifer McCabe that day at all?
Don't think so.
One moment, please, Your Honor. Thank you very much for nothing further. Thank you, Your Honor.
Mr. O'Keefe, if I could catch your answer correctly to Mr. Bradley's question, I think that interaction with this training, is it the nature of nothing, but they were on that day?
Correct.
Can you describe that for us, please?
Leaving court, I was ambushed by the defendant, harassed, with his camera in my face, telling me several times that I'm a disgrace to my brother.
Now, did you leave, do you know if you left the court at the same time as Ms. Gaetani, or did you leave before or after?
Both after.
About how long after, you know?
I really wondering.
Oh. I'm going to direct your attention to the screen up there. And as is typically my launch, I forgot the number, but I think what we launch is February 27th, 2024. Ms. Crawford, would you play that, please?
Oh, you really shame at all, pulling us out like that. Yeah, funny. You think domestic violence is funny? Do you? Aren't you? Do you think domestic violence is funny? Yes or no? You are a disgrace, your brother. A disgrace. You are a disgrace. I'll see whatever I want. Showed up for the first time tonight with you guys. Showed up with you guys. Disgusting. Disgusting, Paul. Disgusting. Disgusting.
Fair and accurate representation of the action with this offense. You later see it played on one of Mr. Kerman's YouTube presentations.
Yes.
Did you observe at any time during your interaction with Mr. Kearney on that occasion that he appeared to be distraught?
He was very upset.
And what was the sense of him being upset? Did you get that one?
What was the sense? I think it's because he was over the world. And he must have thought I had something to do with this, which is probably why I'm here today.
And did you observe him to be trembling, shaken?
He was mostly angry.
Thank you, sir. No further questions.
Anything I need to write?
So that's a tape recording, Mr. O'Keefe, of your interaction with Mr. Carney after court that day?
Yes.
And you said to him, don't get too comfortable?
Yes.
And your mom said, where's Lindsey? So, in other words, you guys knew exactly what was going on that day, and you were taunting Mr. Carney about the presence of Lindsey Gaetani, weren't
I
you?
should say taunting. None of that would have been said if the defendant didn't get my face in English.
Nothing further.
Nothing further, Your Honor. Thank you.
Anyone else?
Sorry. Jack Carney.
John Carney.
John Carney.
John
Jack
Carney.
John Carney?
You gotta put that, some dress from yesterday. Raise your hand. Do you swear in about an hour in hearing, tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, I do.
Thank you.
May I inquire? Good afternoon, sir.
Good afternoon, sir.
Please state your name and spell your last name for the record, please.
John Carney, C-A-R-N-E-Y.
Where do you live, sir? Just in
Canton.
Canton? How long have you lived in Canton?
2 years.
What do you do for a living?
I'm retired.
Just tell us about your family in general. I have, 2 sisters, a brother. My mother lives in Norway. What did you do for a living before you retired? I retired from the military when I came home from Iraq in 2006. What did you do in Iraq? I drove tractor trailers, hauling fuel. Have you taken an interest in the Karen Reed prosecution in the Superior Court across the street and the Aiden Carney cases as well? Yes, I have. And when did that interest start? Karen Reed, first day. Have you been following that matter? Yes. Do you attend court hearings and events in Dedham relative to that? How long have you been doing that? What, following it? Yeah. Or attending events and such? Yeah. Okay. Whatever I can. Sure. What, let's strike that. Were you present on 2/26/24 across the street at the Superior Court for a Karen Reed hearing? Yes. And that day, were you outside the courthouse or were you inside in the hearing? I was outside. And what were you doing outside? What was your plan for the afternoon? Well, I was gonna try and get in, and I couldn't get in, so I just stayed at the bottom of the steps there. Oh, sorry about that. I think that was me. Sorry. At some point, did you see Mr. Carney come out of the courthouse? Yes. Where was he when you first saw him? He was coming out the front door. Where were you when you saw him? The bottom of the steps. What did you see him do when he first came out? When he first came out, there was a bunch of people there. And he said he had to leave the court because of some issue with a restraining order. And next question. He said, let's go across the street. So we went across. Hold on, let me ask you another question. Did he do anything with his phone around that time? Not that I saw. Okay. What did he, where did he go after he came out and said that? He said, let's go across the street to the registry of deeds. Did he speak with anybody in the hall, in the crosswalk? Yes. What did you see happen there? I heard him talk to a police officer that was in the middle of the road that seems to direct the traffic.
Did you please?
He said something.
Sorry about. Not sure what clip he said to me. Yes, exactly.
He's answered me so far, ask him the next question.
I can go back and listen.
Go ahead and do it.
Thank you, Jordan. After you saw him go into the crosswalk, what happened? He talked to the police officer. Did you see what was said? I heard words, yes. What did you hear? He told him about that he had a restraining order, some lady had it against him, and he had to be so much distance away from him. And the cop told him to go over there to the registry of deeds. Okay, you just gestured when you said that. Did the officer gesture? Yes. What happened? We just went over to the registry of deeds. Did Mr. Carney go to where you saw the officer gesture? Yes. What happened after Mr. Carney got up there? He started talking to us, and we were on the flat top there, the very top there, and he was talking to us, and then behind us, the people started coming out of Superior Court.
Next question.
What time approximately did people start coming out of Superior Court? I couldn't say. How long after 2 o'clock would you say people started coming out of Superior Court? I don't know. Was it a long time period or a short time? No, it was short. It was short. What did you see in terms of people streaming out? How many people? There was a line of people. A lot of people or a little amount of people? It was a lot. Did they cover the front of the courthouse or did they only concentrate in one area of the courthouse? In the front? Pretty much the front. Do you know someone named Lindsey Gaetani? I have never met the woman. Do you know who she is if you see her? Yes. Did you know on 2/26? Yes. Did you see her that day? Yes. Where did you see her go? In front of the courthouse. Where did she go? In front, if you stand in front of the courthouse, she went to the left towards Dedham Center. So was she going towards the Registry of Deeds building or away from the Registry of Deeds building? Away. And on. Around the time that you saw her going towards Dedham Center, did you have an awareness of where Mr. Carney was? Yes. Where was he? He was behind me. How far away? He was at the top of the stairs, closest to the building, and I was on the side. I went down the sidewalk to film. 20 feet. Did you hear Mr. Carney say anything relative to that might have given you an indication that he knew that Miss Gaetani was there? No. Did you hear him say liar, liar? No. Did he say or do anything that made you think that he may have been aware of Miss Gaetani in the vicinity? No, I didn't hear anything. Thank you, sir. Nothing further.
Cross-examination.
What was it? Oh. Oh.
No, he was just drinking water.
Thank you.
You said you saw, pick up, you know, where you left off, you said you saw Lindsey Gaetani that day,
Yes.
and, you didn't have any trouble picking her out or recognizing her?
No.
And how is it you know what she looks like?
I've seen her on Facebook. Pictures.
Okay.
I've seen her in public before.
Oh. On which Facebook page have you seen her in public?
I could say.
No, I would.
No.
And you've seen her in public before where?
I want to say I saw her at the courthouse before.
All right. Has she been a regular attendee to the Karen hearings, what you say?
I don't think so. No.
You seen her in the courthouse on other occasions then?
I think I might have seen it twice.
Oh, but you remembered what she looked like?
Gotcha.
And anybody standing, you were across the street from her when you saw her, right? And was she proceeding down the ramp?
They all were, yes.
Yes, but you didn't have any trouble picking her.
No, there were other people there. that I
And
didn't-
anybody looking across the street wouldn't have any trouble picking her. So how she?
Right.
So you said that at some point you left Mr. Carney and you went down to the video.
Yes.
Why were you doing?
I'm following the trial. Just like everybody else.
Was there something particularly memorable about moving people exiting the courthouse?
No, it was just crowd coming out of the courthouse.
So you figured you'd keep that as what, souvenirs?
Yes.
All right.
Not really, souvenir.
What, did you do anything at the video afterwards?
Yes, I did.
What you did?
I sent it to, Mr. Connie,
All right, and why did you do that?
because he was looking, I guess because, he was looking for any
Well,
kind of-
tell me his reason, tell me why you did it.
why I did it,
Yeah.
because I want to help somebody who's.
If you wanted to help Mr. Bernie and you thought instead of making this video about him someone.
Yes.
Did you request that you send him a video?
No,
Was there a general request by Mr. Bernie?
not what I know.
So you just did this on your own?
Right, yeah,
Oh. So you sent Mr. Kearney the video. Are you a regular viewer of his family shows?
I look at pretty much everything,
Okay.
the Herald, everything.
You take both those out, the Herald, Howie Carr,
Howie Cobb, I look at them all.
the great.
Yes,
Okay. So, do you subscribe to Mr. Kearney's page channel?
no,
Have you donated to his defense fund?
no,
Have you donated to Karen Reed's defense fund?
yes,
How much money have you sent Karen Reed?
less than 1,000,
Close to the 500 or close to the 1,000?
close to 1,000.
Okay. So you're pretty committed to this process.
So,
Mr. Kearney is a vigorous advocate for Karen Reed, is he not?
yes,
In fact, I mentioned to say, you watch him regularly,
Not regularly.
No?
No, I watch it off and on.
Watch him off and on.
I'm in bed at 9 o'clock.
Have you ever heard him say anything negative? No.
No.
You ever heard him say anything good about the prosecution?
No.
And you endorse those things?
Yeah.
So you're here today to help him.
Yes.
Now, as I understand your testimony, when you see Mr. Kearney coming out of his Norfolk Superior Court, Mr. Kearney says, I think the words you used were, let's go across the street to the registry of deeds. Is that right?
Yes.
All right. And then after that, as you're crossing the street, presumably to get to the registry of deeds, Mr. Kearney stops and speaks to a police officer.
Yes.
And as a result of that conversation, did you say the officer said, why don't you go over there to the registry of deeds?
To go up top there, yes.
Go up top there to the registry of deeds. You distinctly heard the officer say the words registry of deeds.
I heard registry of deeds.
Like you don't know whether you heard it from Mr. Kearney or you heard it from
I believe it's the officer.
the officer. Okay, so the officer, so Mr. Kearney, is this fair? Mr. Kearney had already announced that he was going across the street to the registry of deeds, and he stops and talks to the officer, and the officer in fact tells us to go where he was already going.
Objection. Oh. Yes. Probably double checking.
Okay. Mr. Kearney, you executed an affidavit in this case, did you not?
Yes, sir.
Is this it, or photocopy of it?
That's it.
You signed it under the aids and penalties of perjury.
Yes.
And is it fair to say that you explained the events in this affidavit consistent with your testimony here today? That is, that, well, let me read it to you and you tell me if it sounds like I'm reading it correctly.
Objection, Your Honor, it's not how.
If you could just ask a question, witness will answer. As long as you're framing it as a question, Mr. Cosgrove, go right ahead.
All right. Do you recall writing in your affidavit? Mr. Kearney said there were some issues with the restraining order. He was going across the street of the registry of deeds to comply with the restraining order. And I, along with others in the crowd, followed Mr. Kearney across the street to the registry of deeds.
Yes.
And then the next thing, you recall that the next thing you write was that while you were crossing the street, you saw Mr. Kearney speak to a police officer.
Right.
And then after you finished, there's some more there, but after you finish with that account, you then say, we continue to cross the street to the registry.
Right.
Right, it's something with something where it's all your own words.
Right.
So the first sentence I noticed says, I am of age and a resident of Commonwealth, Massachusetts. Are those your words?
Yes.
Anybody revise your words and make any suggestions?
No. Says residency.
Yeah, so resident.
Yeah.
Yeah, you are a resident of Massachusetts.
I am.
Sure. And did you, at some time before, after, or during your writing of this affidavit, did you deliver it to Mr. Bradle's office? Did you mail it, speak with someone? How did you get it to him?
I talked to his paralegal.
Oh. And after you talked to her, did you make arrangements to get it to Mr. To her?
Yes.
No, what were the arrangements?
I believe, I had some email, so,
You think you emailed it to him?
yeah,
All right. And did you say you served in Iraq, sir?
I did twice.
Thank you,
sir.
No further questions.
Nothing further.
You may step down, sir.
Also. Council for
Oh my goodness, we're at sidebar. Are we about to get closing arguments? Oh my word. Oh my god. Oh my word. Oh my word. Oh, hold on. Hold on, little towels. Hold on, little towels. All right, so we're waiting for sidebar. All right, should be over. Waiting for the next witness. Hold on.
Judge, before Mr. Braille, begins his examination, I think you're transition.
Oh, it's one more.
Raise your right hand. Do you swear in the matter now in hearing
It's a
to
police
tell
officer.
the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Based on. So.
We're at sidebar in the Kearney and Lindsey Gaetani trial, folks. There's a defense witness about to take the stand. Stay here, little towels. Stay here, little towels. I'm with you. I'm monitoring, waiting for the sidebar to end. Waiting for the sidebar. We are at sidebar in the Aiden Kearney and Lindsey Gaetani trial. It could be the last defense witness. Will Aiden Kearney take the stand? We are not sure. I am monitoring. I am a little towel. All right, ladies and gentlemen, these are the moments we could be on verdict watch any minute now. Kearney's running out of witnesses. Ladies and gentlemen, my name is Grant Smith Ellis. We are at sidebar. Sidebar in the Aiden Kearney trial. We are waiting the next defense witness, ladies and gentlemen. As soon as the sidebar ends, you will know. Oh, goodness, ladies and gentlemen. I can tell you that these are big moments. We have, there's no Karen Reed and John O'Keefe trial. These are big moments. We could get a verdict soon in the Aiden Kearney case. Will we hear closings and verdict watch after this next witness? I'm Grant Smith Ellis. It was quite a day. Every defense witness tanked, and Robert Cosgrove is fierce. This is just a preview of Robert Cosgrove and how brutal he's going to be during Aiden Kearney's felony cases. Will Aiden Kearney be convicted of violating a restraining order by standing in the bushes outside of John O'Keefe and Karen Reed trial on 2/26/2024 held by Lindsey Gaetani? We are about to find out. These are moments, ladies and gentlemen. We are about to go on verdict watch. Before we go on verdict watch in the Karen Reed case tomorrow, we might go on verdict. We are going to go on verdict watch, it looks like. Okay, hold on. Could be coming back.
Good afternoon, sir. Please state your name and spell your last name. What do you do for a living, sir? I think we get it, but for the record. And how long have you been sewing for?
Born 2005.
I'm sorry, how long have you been with the Dedham PD?
About 20 years.
And tell us a little bit about your educational background, training, etc.
So, I went through the academy, graduated through that. And after that, I went to school to do my master's degree in criminal justice.
Now, do you know who the gentleman with me here is today, Aiden Kearney?
Yes.
And had you met with him relative to a case that happened back in late February of 2024?
Yes.
Do you recall when you met with him?
During one of my shifts when I was working station.
And Mr. Kearney approached you with some video from the incident that he wanted you to look at.
Yes.
How many videos did you look at with respect to Mr. Kearney?
When he first came in, I'm not sure. I think overall it was around 3, but when he first came in, I know he sent them.
How many videos ultimately did you look at relative to Mr. Kearney?
At least 3.
And they involved an incident from 2/26/24 that transpired outside of the Dedham, the Norfolk Superior Court in Dedham.
Correct.
The building across the street, correct?
Correct.
And just in a nutshell, were those videos of people leaving the courthouse that day?
Yes.
Were you focused on some people leaving the courthouse that day?
Yes.
What were you asked to do in terms of looking at those videos that Mr. Kearney supplied to you?
Excuse me, ask that goes.
By Mr. Kearney. What did he want to invite your attention to on the videos?
He had come in originally to report a false police report. And so he showed me the videos in his defense about how he didn't do it.
So he was reporting what he was stating was false claims by Ms. Gaetani, Ms. Lindsey Gaetani.
Yes.
In terms of investigating that matter, Did you look at the videotapes?
I did.
Were you able to ascertain whether or not Mr. Carney is on any of those videos saying anything towards Ms. Gaetani or at Ms. Gaetani?
I was on it.
Were the people that were making those videos, to your investigation, to your ascertainment, near Mr. Carney such that it would have appeared on the videos?
Yes, when he told me he was, that's where he was standing, then yes.
And Mr. Carney had brought it to your attention that there was a restraining order issue in the case, right?
I believe so, yeah.
And so that if there was any evidence that he was trying to communicate with Ms. Gaetani, that would have been a violation of the restraining order, right?
Yes,
And you were the investigating officer, you looked at all the body of video, and you were able to find no information consistent with any restraining order violation, correct?
correct.
Nothing further.
Cross-examination.
So, in terms of the videos, that Mr. Curran, the Liberty officer, do I understand that all of those videos, to your recollection, show people leaving your court?
Yes,
And do I also understand that Mr. Curran told you where he was standing?
yes,
You didn't actually see Mr. Curran in any of those videos?
no,
So the point of showing you the videos as, Mr. Kearney's point of showing the videos as you understand it, was to show you that he could not be heard in any of them shouting and Lindsey Gaetani.
correct.
And would it be your expectation, officer, that if somebody was trying to prove to you that he could not be heard shouting at someone, that he would deliver to you if he had a video of him shouting at that person?
If we had done enough.
But he told you he never shouted anything else.
Correct.
Did he tell you he always maintained the distance of 100 yards away?
Don't think that was discussed.
Didn't bring that up.
That's my record.
If there were a restraining order that said someone had to keep 100 yards distance from someone, and he was within 100 yards of that person, in your judgment, as a police officer, would that be probable cause to arrest that person?
Yes,
Did Mr. Kearney ever tell you, to your recollection, that he didn't see Lindsey Gaetani? Or did Mr. Kearney ever tell you that he didn't see Lindsey Gaetani?
no.
Thank you, Mr. Richard.
Just in terms of that, Officer Katie, just briefly, did you also look at Ms. Gaetani in the video?
He pointed her out, yes, I wasn't familiar with her.
And did you watch that person to see if they registered any reaction to being yelled at or screamed at by him?
I did.
Did you see any reaction on her part?
No.
Thank you.
Anything on the cross?
No, thank you very much.
You may step down.
That's all we have to the defense restaurant.
We're gonna take a break.
Wow.
Is 15 minutes enough? Okay?
Oh my goodness.
Yes.
Oh my goodness. No, Kearney, he's not testifying. That coward.
Thank you.
He's not testifying.
All rise.
He's not testifying, ladies and gentlemen. He's not testifying. Oh my goodness. We're going to have closing arguments in 15 minutes. Oh goodness, ladies and gentlemen. Oh my goodness. 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 Oh my goodness, ladies and gentlemen, it's happening. It's happening. Ladies and gentlemen, it's happening. Breaking news. Ladies and gentlemen, breaking news. Aiden TurtleBoy Kearney has pulled an Aiden Kearney again after pleading the Fifth Amendment in the John O'Keefe and Karen Reed retrial. Aiden will not be taking the stand in the Lindsey Gaetani and Aiden and TurtleBoy trial. Closing argument. The defense rest. Oh my goodness, ladies and gentlemen. Oh my goodness, we are getting ready for this. This is happening, ladies and gentlemen. We're going on verdict watch in the Aiden Kearney and Lindsey Gaetani case very soon. Breaking news: the defense has rested. Oh my goodness, ladies and gentlemen. Oh my goodness, it's happening. The defense has rested in the Lindsey Gaetani. I am typing like a mad towel. And Aiden TurtleBoy Kearney trial. Closing arguments to begin at 3:40 p.m. Eastern. Verdict watch incoming. Ready your towels. Ladies and gentlemen, this is happening. We are here for it. We are going to see this happen. Lindsey Gaetani, justice for Lindsey is incoming, ladies and gentlemen. We need to do a special towel poll. It's going live now. Ladies and gentlemen, verdict watch in the Aiden Kearney case. Closing arguments coming in right now. Oh, goodness. Just 8 minutes, ladies and gentlemen, at 3:40 p.m. Eastern. My name is Grant Smith Ellis. I am a towel. I am a very nervous towel. But, ladies and gentlemen, we're going to do this together. We are going to make it. We are going to make it until, 3:40 p.m. when we are going to get closing arguments and go on verdict watch in the Lindsey Gaetani and Aiden Kearney trial. I am a towel. I'm worn down. I've been broadcasting the Karen Reed and John O'Keefe trial for 33 days, and now I've done 2 full days of the Lindsey Gaetani and Aiden Kearney case, but I'm going to do this. We are going to do this, little towels. Closing arguments to begin in just 10 minutes, 8 minutes in the Aiden Kearney and Lindsey Gaetani trial. I hope you're ready for this. I was born ready for this, ladies and gentlemen. I hope that I actually posted what I wanted to post. Are you ready? I'm ready. Ladies and gentlemen, I think we're going to do this. We are actually going to be here when there is a potential closing argument and then directly into a verdict in the Aiden Kearney and Lindsey Gaetani trial. My name is Grant Smith Ellis. We will have that in just 7 minutes for you on Towel Stream. Ladies and gentlemen, that was a very weak defense by Aiden Kearney. I mean, that was literally a very weak defense. I've seen some bad defenses in my day as a lay towel commentator. That was bad. I don't know what this man is planning to do in his closing. It's going to be very bad, and I think the state might be heading towards a conviction here. Ladies and gentlemen, Aiden Kearney lost his motion for a directed verdict quite swiftly earlier today, and then his defense was quite poor. Every single witness tanked, and then Special Prosecutor Robert Cosgrove did exactly what Hank Brennan does in the Karen Reed trial, which is spin defense witnesses into state witnesses. Okay, will Aiden TurtleBoy Kearney be convicted today in the Lindsey Gaetani and TB and TurtleBoy trial? All right, ladies and gentlemen, the biggest towel poll we have done to date. Yes, justice for Lindsey. Heart. Or no, I hate puppies, babies, and Santa. Now, okay, if you hate puppies, babies, and Santa, I'm not really sure what to tell you, okay? The poll is live, ladies and gentlemen. Will Aiden Kearney be convicted? Let us find out. You are going to get to vote on it, little towels. We're waiting for the court to come back into session in just 6 minutes now. My name is Grant Smith Ellis. If you're tuning in, we're about to go to closing arguments in the Lindsey Gaetani and Aiden Kearney trial. Will Aiden be convicted? Oh, goodness. We are about to go to closing arguments. Closing arguments incoming at just 2:40 p.m. Eastern, little towels. My name, again, Grant Smith Ellis. I'm here. It's good to be with you. Hopefully, we will be going to closing arguments, and then we will be on verdict watch. I expect a verdict to come down today, ladies and gentlemen, in Dedham District Court related to Aiden Kearney's charge of a RO violation. Closing arguments. Ladies and gentlemen, this is going to be intense. The first time Aiden Kearney, in recent memory, has been facing a verdict of a criminal verdict of this nature. Oh, goodness. Closing arguments and verdict watch. All right, it's time. We've made it. Tomorrow, verdict watch in the John O'Keefe and Karen Reed retrial. Closing argument starting precisely at 9 a.m., maybe a few minutes before. Ladies and gentlemen, everybody take a towel breath. Everyone hold your towel buddies' hands. It is going to be one of those moments. I think, ladies and gentlemen, within the next 4 4 minutes or so, we should be ready to begin closing arguments in the Aidan Kearney and Lindsey Gaetani trial. Yes, that will mean it's a district court trial, so we will be going immediately into verdict watch, as it is a bench trial in front of Chief Judge Michael J. Pomerol of the Dedham District Court. Now, Aidan Kearney, if he is convicted here on this misdemeanor, could face anything from probation to some kind of custodial sentence, I'm sure, in the county jail. I imagine it would be some kind of probation, but the point is he would then have a criminal record, and that could impact his future felony prosecutions. We are also getting a preview of what former Judge Robert B. Cosgrove is like as a prosecutor, and my word, ladies and gentlemen, he's very quiet until he gets up on cross, and you try to answer a question in a way that's disrespectful to the court or to former Judge Cosgrove, and then he's like a judge, and he starts bellowing. He's like, stop. He doesn't let you answer questions. You start trying to answer, he gets his answer, and then he just jumps over you, and the judge allows him to do it because former Judge Cosgrove is a former judge, and so former Judge Cosgrove knows exactly how to cut a witness off on cross, and he just bellows at them. How dare you say that? Oh, really? Oh, it's wonderful. I love it, ladies and gentlemen. Former Judge Cosgrove, listen, let me just tell you, if former Judge Cosgrove and Hank Brennan team up to prosecute Aidan Kearney in Norfolk Superior Court for the 10 felonies Aidan is still facing related to the October 2023 witness intimidation and etc. related to the Karen Reed trial, okay? And then the 2 felony charges, illegal interception of an oral communication and witness intimidation related to the 12/23/23 incident at Lindsey Gaetani's apartment that has to do with Aidan allegedly pushing Lindsey over a couch, and then Aidan allegedly making a recording of Lindsey without her permission. Aidan becomes a fugitive from justice over the weekend of 12/23 into 12/26/2023, and then Lindsey gets this restraining order that in question under Section 209A of Massachusetts law related to intimate partner violence. And then while that restraining order is active, Aidan gets his bail revoked on 12/26/2023. He gets sent to jail for 60 days, gets released on February 23rd or something of 2024, and then 3 days later goes to a Karen Reed and John O'Keefe retrial. Now, Lindsey didn't even know Aidan was going to be at this Karen Reed and John O'Keefe retrial, and we heard testimony today that Paul O'Keefe, when he first met Lindsey that day, said that he applauded her strength. So we now know that a member of the O'Keefe family, ladies and gentlemen, has applauded Lindsey Gaetani's strength. So Lindsey Gaetani, the world supports you. Towels around the world literally support you, and Paul O'Keefe has declared that it is to be applauded that Lindsey Gaetani is a strong super towel who we all love and revere. And now, ladies and gentlemen, the one sort of quirk in all this was that Paul O'Keefe testified he had only talked to this woman, Kate Mafia Masshole Peter, twice or something. But one of those times, Kate told him that Lindsey Gaetani wanted to come to court that day to support the O'Keefe family, which was great. But Kate told Lindsey that, according to testimony that we heard from Lindsey on Monday of this week, that the O'Keefe family wanted Lindsey to come to court to show support for Lindsey. Now, I'm sure both of those things were true. As Paul O'Keefe testified, he literally shook Lindsey's hand when he met her for the first time and applauded her strength. However, Kate Peter, being a weird person, kind of threw a weird little quirk into this and was kind of embarrassing, but everybody quickly moved on. It has nothing to do with the underlying violation, which is that when Aidan was made aware that Lindsey was in the courtroom that day, and she didn't walk into court waving a restraining order, as was now testified to multiple times, but Lindsey did come into court, notify a court officer that she had the RO against Aidan like she's supposed to do. Court officer asked for it. Lindsey took it out, gave it to the court officer. Then Aidan, apparently either at the behest of his girlfriend or because he saw the court officer get the RO, got up, left the courtroom, went outside, went downstairs, went outside Norfolk Superior Court, stood on the lawn of the Norfolk Registry of Deeds, waited for some of the witnesses to come out, yelled at Paul O'Keefe and mocked Paul about his dead brother John O'Keefe. I don't know why. We listened to the video today. Well, Paul O'Keefe was on cross because he got called as a defense witness by Aidan, and it went down in flames for Aidan. And then on cross, they played the video. Prosecutor Cosgrove turned Paul into a witness for the state instead of the defense and played a video for Paul of Aidan, who had tried to claim he was nervous because Lindsey was there, running up to Paul and screaming at him and insulting him and saying Paul was a disgrace to his deceased brother John O'Keefe. Outside of the murder trial, a pretrial hearing for John related to Karen Reed. And then, ladies and gentlemen, there was further testimony that Aiden went across the street. A police officer at some point told him to like go across the street, but didn't really say anything more than, I don't know where Lindsey Gaetani is, so just go somewhere else. But anyway, Aiden proceeded to go across the street, the testimony revealed, stand on the lawn of the Registry of Deeds, and then when Lindsey Gaetani walked out with Megan McCabe and Colin McCabe and other friends and witnesses related to the O'Keefe trial, while they were walking down the street that separates the Registry of Deeds from the Dedham District Court, Aiden stood in a bush and walked towards them. Instead of walking the other way, Aiden walked towards them. Now, Aiden was easily within 100 yards or something. I don't know. There was a map or something they showed. Easily within 100 yards, probably like 30, 20 yards or something, maybe less. At that point, walking towards Lindsey. That's the allegation that forms the center of this potential conviction. Aiden made a motion for a required finding of not guilty. He lost. He put on 8 defense witnesses. He did not take the stand, and now we are waiting for closing arguments. Was that a good summation or what? This is why people watch Towel Channel. You tune in. You become erudite and informed. This is a public information service, by the way. It's done in the style of Lord Reed's vision for the BBC, which means that we try to educate, inform, and entertain the wider public. We use entertainment as a hook. The towel motif is certainly part of that, in order to engender cogent public discourse and ward off the usurpation of our representative forms of government around the world. If you can get on board with the mission, great. At another time, I'll tell you about our diplomatic flotilla. We have to get to Jerusalem and open a gate. It involves kangaroos, pandas, koalas, peacocks, camels, a territorial acquisitionist who's masquerading as Brewski the Irish setter, and some penguins from Antarctica, and also none your business, and we have to get an ark and go to Jerusalem to talk to a man about a gate. I don't have time to explain, but I'm also erudite and know how to explain things like criminal trials. I'm not a lawyer, I'm a towel. All right, so we're waiting for court to come back into session on that note, ladies and gentlemen. Now, as soon as court does come back into session, I will, of course, let you know. We are just waiting for Dedham District Court, of course, to resume in the Aiden Kearney and Lindsey Gaetani trial. This is a misdemeanor trial for an RO violation. As I was just laying out, I didn't mention it was a misdemeanor, but it is in district court, although you can have felonies heard in district court if they're not bound over by indictment to Superior Court. This is a misdemeanor RO violation, but it would be a big deal because a guilty verdict would give Aiden a criminal record. And Aiden Kearney, of course, did not take the stand, ladies and gentlemen. He pulled a Karen Reed, and he did not take the stand. Let's say hello to the 33,000 or so who have tuned in over on the Towel X. It's very, very nice to see you. Hello, Will, down there. Hello, 5.6K, coming in good. You're fighting strong. Hello, GOP Oversight Committee at 22K. We send our regards. Hello, Al Jazeera Arabic and the country of Qatar. We are coming for you. We are going to try to win. I cannot beat Mario Nafal. I'm sorry, but good for you at 67.6. Al Jazeera Arabic, though, we're coming for him, ladies and gentlemen. We are coming for him. Hello, Qatar. I would like to say hello to the 94 countries around the world who tune into Towel Stream. Hello to Australia and Germany, and also to the Super Towels in the UK and Ireland and Northern Ireland, which is part of the UK, and also Greenland and Iceland and Norway and Finland and Sweden and Germany and France and Italy, and also Mozambique and Mogadishu, Somalia, which is a city, not a country, but I did mention Somalia, and then Ethiopia and Eritrea, and I'm pretty sure someone watches in Ukraine, and then also Singapore and Vietnam, and Australia and New Zealand and Malaysia, and I think we have some viewers in Japan now, a lot of viewers in India. Hello, India, how are you? South America, Mexico, Guatemala, Honduras, Nicaragua, Costa Rica, Panama, Brazil, Chile, Argentina. I think we have a viewer in Venezuela too, ladies and gentlemen. We are just towel friends uniting the world, all 50 states in the United States and Canada. I don't know if we've spoken to anyone at Maduro Station in Antarctica yet to have the penguins watch with us, but I'll work on that very soon. Oh, ladies and gentlemen, we are almost on verdict watch in the Aiden TurtleBoy Kearney case. We're just waiting for the judge to come back into session here. I think there are a lot of people who are trying to figure out, ladies and gentlemen, whether or not closing arguments are going to begin. We were told it would happen sometime after 3:40 p.m. We're just waiting for the judge to come back into session now, and so I will keep you updated on that, little towels. Now, of course, Aidan Kearney did not take the stand in his own defense, if you were watching this afternoon, and the trial, the defense's case, the presentation of evidence has ended. We're now waiting for closing arguments to begin. The lawyers are taking their time to begin their preparations, and we are going to be listening in live as soon as those closing arguments begin. Now, closing arguments in the Aidan Kearney and Lindsey Gaetani trial should be relatively quick. This is a district court trial. Opening arguments were literally 5 minutes each. Once the closing arguments are presented, it is a bench trial. I don't know if the judge will go to chambers and review all the evidence. I imagine the judge is literally making his decision right now, and then I imagine I don't even know if we're going to have verdict watch. I think we're literally just going to go into trial, into a ruling. So, ladies and gentlemen, this is the moment. Now, the vote right now, it is very close, little towels. The vote is very close. After 200 and something votes, it is 57 to 43% yes that people think Aidan's going to get convicted. Now, for some reason, 43% of you hate puppies, babies, and Santa Claus. I am a little bit concerned that there are so many of you that hate puppies, babies, and Santa Claus. Also, we have broken the 600 viewer mark on Towel Stream on YouTube for the first time. Congratulations to Towel Stream viewers. It is all possible because of you, and I am a towel. Now, we're waiting for, as I said, closing arguments in the Aidan Kearney case and Lindsey Gaetani trial. It's district court, so just know the ebb and flow of the district court pace is a little bit slower than perhaps you're used to in Superior Court. It's because it's a smaller court. It's very functionally effective, but it's more at the whim of the judge. The judge wants to spend some time collecting his thoughts. We'll do that. The clerk has to get something done and filed. Okay, we'll give the clerk a few minutes. A lawyer has to go to the bathroom. Okay, we'll give the lawyer a few minutes. It's very informal. District Court versus Superior Court is very different. Justice for John O'Keefe and family, and for Lindsey. Ladies and gentlemen, we heard today that Paul O'Keefe, the first time he greeted Lindsey Gaetani,
violate
here we go.
Restraining
We're
order
live
on 2/26/24, despite the best efforts of Lindsey Gaetani and her compatriots. The government, stated in legal terms, Your Honor, the government has certainly not proven this case beyond a reasonable doubt. And you're the fact finder, and we don't need to reiterate the standard because you apply it every day as a judge. That day, Ms. Gaetani came into that courtroom wielding that restraining order like a sword, not using it as a shield. She was there for one purpose and one purpose only, and we know that from the circumstances. We know that Mr. Carney had just gotten out of jail. We know that Ms. Gaetani had the restraining order, and this was Mr. Carney's first appearance back in the case after getting sent to jail on her charges of assault and battery in this court. She came in there and she was ready with her restraining order for one purpose and one purpose only, not to be there for the Karen Reed hearing, but to evict Mr. Carney, to cause a to try to cause a restraining order violation. And I appreciate the Commonwealth saying it. Mr. Carney did the right thing and he left. There's about 19 seconds, if you look at the video, and I know you have 19 seconds between the time when Gaetani went in the room and Mr. Carney went out of there. He didn't say the F word to her. He didn't look at her. He didn't do anything. He didn't need a court officer just to get out of there. Those are all things that Gaetani said happened. They are all completely belied by the video evidence. None of it happened. So that tells you everything you need to know about the credibility of Gaetani, Your Honor. She was there to evict him. And we also know that because of her own testimony about this bus situation. She claims that she that she had to get her kids off the bus, that she had some other person getting the kids off the bus. Everything is just an ever-evolving story with her. And whenever she gets back into a corner, she brings up her children. And in this case, Your Honor, we know that she had to get home to get her kids off the bus at 3:10. So she was here not to sit around all afternoon and watch the 2-hour anticipated Karen Reed hearing. She was here to evict him from the courtroom and then get out of there because she had to get home to get her kids. She tells this ridiculous story that somebody else was going to get her kids off the bus. What responsible parent would have someone who the kids never met waiting for their kids at the bus stop? Oh, that's the rule number one that you tell your kids is you don't ever go to somebody that you don't know. And I think that's a complete fabrication after the fact concoction of a story, Your Honor. Yet another one of those. So in this case, Judge, Mr. Carney leaves immediately. He does the right thing. He goes to the government, and this is a significant legal fact, Your Honor. He went to the police and he said, where do I go? I have a restraining order. You have it on tape. You saw what happened. That never happens. We have it here. He recorded the conversation. He was live streaming, and the officer said, go over there. Gestured up to the registry. Go over there for now, actually, is the full quote. He goes to the registry. He hangs out as far up against the building as he can get. He's waiting for further action. He's waiting to report things to the officer. Why? Because of the Frank Keegan situation, which you saw in Chambers. He knows what this person is capable of, and he's in the middle of it. She just chased him into his place of work, into the courtroom. He leaves, does the right thing. He goes outside and he wants it documented. He doesn't want to disappear and run into her. He doesn't know what she's capable of. He probably doesn't even quite have a rational appreciation for what she can and can't do, because she's already sent him to jail for 60 days. He just gets out and she's trying to get him right back to jail, walking around with that restraining order, showing up to places she has no business being at, showing up to get him in trouble just 3 days after he just gets out of jail. He's shaking, he's angry, he's scared, he's upset, he has anxiety. He's trying to get away from her. So he goes to the representative of government, of the policeman, and says, here's the situation, 100 yards, where should I go? He gets sent up there. He's not a drone. He doesn't move as the crow flies. He goes down the steps, around the corner. He takes a circuitous route down the steps, across the street, and up some more steps. He's trying to comply with what the officer says. He's waiting there for the meantime at a safe location so he can report it. He's not engaging with her. He's not bothering her, whatever. He has no criminal intent, none whatsoever. And so if the alleged violation is later on, there's no knowledge and there's no contact, because he has no knowledge, no intent, she has no knowledge or intent he's there either. And her assertions are A, lies, and B, after the fact concoctions when they get back to the car and her co-conspirators, her compatriots look through the video and say, oh, there he is. All right, we have him in business. And they're also trying to get him on this claim of automobile damage, where we know from the circumstances that he could not have done that. There's zero evidence he had anything to do with that. There's zero evidence that that is even something that is a fresh situation. And Gaetani has absolutely no credibility to believe that this may have just happened right there. We don't know when that happened. There's no evidence. There's no fresh damage. There's nothing to that. So they're trying to get him on this phony motor vehicle thing. They're trying to get him on this setup of a restraining order violation, Your Honor. So all of this occurs, and Mr. Carney is live streaming the whole time, meaning he's talking into his phone. He has his phone up. He's upset about what happened. He's reporting about what just happened to him. Meanwhile, the hearing ends early. Everyone streams out. You see the video. It covers the whole front of the Superior Court. So many people have black coats on. The women, black coats, black hair, black sunglasses. You look, it's a sea of people. It's reasonable and likely and probable, and it did happen, that Carney was live streaming and looking around and didn't see Gaetani. Gaetani registers no perception of Mr. Carney. Gaetani's walking along. Gaetani never once gestures. There's never one bit of looking, pointing, call 911, telling her friends, nothing about Mr. Carney being there. She doesn't see him. He doesn't see her. That's no contact, Your Honor. At a bare minimum, the government doesn't come anywhere near proving the case beyond a reasonable doubt that there was contact. And they have to have knowledge to have contact, Your Honor. Gaetani went out of the courthouse and was walking away from the building, Your Honor. She was walking away towards Dedham Center, and then she turns and she's walking away towards the parking lot. So even if there was intentional contact, which there wasn't, she was walking away. And so whenever there's accidental contact, you can't just beam yourself up to be automatically immediately 100 yards away. If you see the person leaving, they're leaving. The situation is getting to where it needs to be. And he has a due process right that there be time that elapses for him to get into compliance. And if she's leaving the scene, compliance is being effectuated. It can't be something that's instantaneous. And of course, Your Honor, the most important thing about this is that Gaetani goes to his orbit, not once when she goes to the courtroom, but twice when she goes outside. Mr. Carney has no idea what's going on. The hearing was prematurely over. Everyone anticipated a long hearing. And Mr. Carney wanted to report it to the police. He didn't get that chance because everyone streamed out and the officer was already busy directing traffic in the walkway. So that's the entire factual scenario, Your Honor, where you see cases that come through here every day with respect to restraining orders, where people are trying to get to someone, trying to knock on someone's door, trying to show up at their work, trying to bother them. This case is the exact opposite, Your Honor. Mr. Carney is trying to get out of here. He doesn't want anything to do with her. He's got, obviously, from his anxiety and his upset, he's got some major post-traumatic stress disorder from this woman. And he doesn't want anything to do with her. And she is trying to effectuate this violation. She's trying to chase him down, just like she did to Frank Keegan, to get him arrested. That's what she does. She's not a person of good character. She's not a person of honesty. She's a person who strives on chaos and trouble and harm. And that's what's before you, Your Honor. And the last thing I want to suggest, Judge, is that imagine a scenario where this kind of conduct is rewarded by a court, is implicitly allowed to be a restraining order violation. What a message to send to people with restraining orders, that you can use it as a sword. Go find the guy and create a situation. And that's what Lindsey Gaetani did here today, Judge. That's what the evidence showed here today. So I ask that you find Mr. Carney not guilty. Thank you.
Well, the defense has done its best to make this trial about Ms. Gaetani's conduct rather than about the defendant's own conduct. But that is not the case. I don't know that I need to repeat the arguments I made to you, Your Honor, on the motion to direct a verdict about the Commonwealth having proven each and every element of this case. But I do want to review the evidence and suggest some inferences that you could fairly draw, and I would suggest you should draw, somewhat different from those suggested by Mr. Bradle. I'd like to start with the restraining order itself. Can we have number 27 on the screen, please? Sorry. Number 2, you are ordered not to contact the plaintiff in person, by telephone, in writing, electronically or otherwise, either directly or through someone else, and to stay at least 100 yards from the plaintiff. And these words are important, Your Honor. Even if the plaintiff seems to allow or requesting contact. The Bradle probably referred to the fact that Your Honor has seen these cases before, and I imagine that you have. How many times have you seen a case where someone is brought in on violation of probation or violation of the restraining order, and the defense is, Your Honor, she called me up. She invited me over to the house. She said it would be okay if I came over. And all that's true. But it's still a violation of the order. It's still a violation of the order. Only a judge can modify a no contact order. Not, I think Mr. Kearney's words, I hope I'm quoting correctly, were some meathead cop. I think he said you can't hide behind some meathead cop, but apparently Mr. Kearney believes he can hide behind some cop. But a police officer, or at least Mr. Kearney's interpretation of what a police officer said, can modify restraint. And I suggest to Your Honor that if calling somebody up and specifically asking him and inducing him to violate a restraining order is not a defense, is not an entrapment defense. And there certainly isn't an entrapment defense that arises from somebody walking into a room. In fact, we know what the law is with this sort of accidental contact. The law is the person is to leave and make prompt and reasonable efforts to bring himself in compliance with the order. The order is 100 yards. He started out fine. He got up and he left the courtroom. All he had to do, Your Honor, was keep walking and put 100 yards between him and Ms. Gaetani. But now we get the excuses, the alibis, the reasons why he never puts 100 yards between himself and Ms. Gaetani. Well, one is, I checked with the government. I did what the police officer directed me to do. Well, you heard the clip and you heard the officer's testimony as to his perception of what happened. Mr. Crane comes out and says, first thing he says is, I want to put this on record. Why does he want to put it on record? I suggest in light of both that comment and what you're seeing in the rest of the trial, you could infer that Mr. Kearney wants to put it on record because he's setting up his alibi. He does not want to leave. He wants to stand there and make his live cast and denounce Lindsey Gaetani and complain about how he was forced to leave that courtroom because he actually thinks it's his workplace. Oh, you heard it from Mr. Bradle. I assume the defendant endorses that. It's just, it's just like a mechanic in a shop. Well, Your Honor might have reached the conclusion that it's a public building. And that Ms. Gaetani has every bit as much right to enter that public building and accompany her friends, whether old friends or newly made, as does the defendant. He talks to the police officer, and apparently, if we can believe the defendant's own witness, Mr. Kearney, the police officer fortuitously suggests him to go exactly where he already told Mr. Kearney. So, I'll walk across the street. I'll get 30, 40. Let's be generous. 60. Oh, that's probably too generous. However many yards away, that'll be good enough. You know? I left the courtroom. I have it on record now. The police officer countermanded the judge's order. I've got a defense. I'm fine. So what does he do then? Does he stay across the street where he was, quote, directed to go by the police officer? Who, by the way, testifies he doesn't know who he has the order against. He doesn't know who that person is. He thinks he gestured toward Pond Street, I believe it was, and then the last he looked, Mr. Kearney is walking off in that direction. But Mr. Kearney says he's staying there because he wants to file that report. You might think his mind was on his live broadcast because that's what he's doing, not filing his report. And does he stay where he has been, quote, directed to go by the police officer? No. Does he even better get out of there, put 100 yards between himself and Mr. Gaetani? No. Rather, he begins the process of following along when Mr. Gaetani exits the courtroom among a bunch of people. So he starts out right in front of the courthouse building, and then there's a progression. Could I have photo 14, please? When Your Honor looks at these exhibits, you can see that as the crowd goes down the ramp, he moves a little off the steps and up to the right on the cornice there. And then number 15. Now he's down on the ground in front of that tree, closer to across the street. And then number 16, please. Now he's moved further. He's got his camera up. He's supposedly terrified of what Miss Gaetani is doing. It doesn't occur to him that if she's trying to entrap him, that maybe the sensible thing to do is for him to get the heck out of there. But he seems to be photographed. Is he live streaming? Maybe. Is he looking at Ms. Gaetani? Maybe. We've heard all this stuff about the various witnesses that Mr. Bradle called today, who immediately recognized Lindsey Gaetani. And we know from Mr. Carney's testimony, I think, that he picks her out right away, standing across the street. He doesn't have any trouble seeing her. I think it was him that I asked, was there anything about her that would make anybody standing across the street difficult to pick her out? No. Very conspicuous. If there's anybody who has reason to know what Lindsey Gaetani looks like, Your Honor, it's certainly the defendant. But his story is, well, I'm not sure what his story is. Is his story that he didn't move, or is his story that he did move, but he didn't see Miss Gaetani? Because Your Honor has just been told that it's reasonable that he didn't see her. Well, we have no testimony. His attorney is not compelled to testify. He has the same right of any citizen.
Objection, none.
But I suggest that nobody else can testify to what Mr. Kearney saw or didn't saw. So Your Honor is therefore compelled to rely on inferences. And what inferences should Your Honor draw that a person who is well familiar with Miss Gaetani and who is supposedly terrified that she was going to approach him and frame him and send him back to jail, and who follows her path as she walks down those steps? Oh, he didn't say that. He didn't know. Well, was he terrified and paying close attention, or was he not? It can't be both. It can't be both. And frankly, whether he saw her or not at that point, he's never removed himself. He's never removed himself 100 yards from where he first saw him. We have 28, please. That's a 100-yard radius from standing on front of the courthouse steps. You'd have to go to the other side of the Superior Court. Can we slide it up a little? thank you, we'd have to go 100. The other side of the Superior Court, beyond Norfolk Street. Someone standing in, to get 100 yards away from where Mr. Kearney is standing, more or less. Didn't give him a couple of yards either way. No quibbling, and how can you move it down in the other direction? We'd have to go back well into the parking lot behind the Norfolk Registry of Deeds to get 100 yards of play. And they had a car. They knew where they were parked. The hearing was over. There doesn't seem to be anything particularly newsworthy about watching people file out of the courthouse. But Mr. Kearney was furious that he had been evicted from his place of work. And he was going to broadcast about that, and he was going to stay there. And who cares whether he got at that point within 100 yards of Lindsey Gaetani and violated the order, because he had his excuses already and set up. By the way, I asked one of Mr. Kearney's witnesses, she wasn't much of a football fan, but she readily expressed the opinion that the difference between the front steps of the courthouse and where Mr. Kearney was standing, although I don't think she phrased it that way, I asked her the distance between me and the Registry of Deeds. Was it more or less than 100 yards? Oh, less than 100 yards. And she suggested to the court that she was absolutely. Mr. Bradle says, well, there has to be a grace period. How long a grace period does he need? Is it a grace period to do a live broadcast? Is it a grace period to walk along parallel from this county and film her? Now, he was upset, Your Honor, in part because Miss Gaetani was walking along behind Jonathan McCabe, he suggests. And that meant he didn't quite dare approach and harass those witnesses and film himself heroically badgering them with questions that he pretended that he wanted to answer. That really annoyed me. And we saw that, Your Honor, when he called his very last witness in this case, Mr. O'Keefe. And by the way, Lindsey Gaetani had left. So he was free to approach Mr. O'Keefe. And what does he complain about? He complains about Lindsey Gaetani being, it's all a plot. You're all out to get poor Aiden, the courageous reporter. And you're a disgrace. You're a disgrace to your blood. Somebody tries to interrupt him and he says, I'll say whatever I want. That's what he wanted to do. That's why he was so upset. And what he wanted to do when he walked out that courthouse door was get material for his harassment problems. And he was going to do that regardless of what the court would say. To hell with the court. I've got my alibi lined up. And all this stuff. Entrapment. She tries to entrap him. Let's suppose it's true. Let's suppose she wanted to entrap him. So he wasn't entrapped. It didn't work. He saw her enter the courtroom. He got up. He walked out the door. All he had to do was keep going. All he had to do was put 100 yards between himself and Mr. Gaetani, and he never even came. I asked her on.
Make you approach that.
Yes.
Oh, we're on verdict watch. We are on verdict watch. We are on verdict watch in the Aiden Kearney. Hold on, we are on verdict watch, ladies and gentlemen, in the Aiden Kearney case. Hold on, we are on verdict watch. We are on verdict watch. I am monitoring closely. Stay here, little towels. My name is Grant Smith Ellis, and we are on verdict watch. We are on verdict watch. We are on verdict watch. I'm monitoring closely. We are now on verdict watch in the Lindsey Gaetani, and how's it going to come down, folks? Moments here. The verdict watch is now in effect. We are at sidebar, but there is a verdict watch in effect. I repeat, we are on verdict watch. Closings are done. We are on verdict watch. After Robert Cosgrove gave an all-time great district court closing, we are now on verdict watch, ladies and gentlemen. How will this play out? Aiden Kearney's fate sits in the balance and in the hands of a district court judge. My name is Grant Smith Ellis. I'll be here with you for the moments. I am monitoring very closely. We do not yet have a ruling. Hold on. Oh goodness, these are moments. Oh, you can sense the tension, folks. You can sense the tension. How is it going to play out? We're waiting for a verdict. We're waiting for a verdict. Just a few moments now, ladies and gentlemen. Just a few moments. A verdict expected in the Aiden Kearney and Lindsey Gaetani trial. Stay with me. We're monitoring closely, and we are waiting. As soon as a verdict is announced, we'll have it here. No verdict yet. Just background talk, ladies and gentlemen.
All right.
Okay, the court is now going to its chambers.
Thank you.
We might get a verdict today. That's just a brief recess. It looks like we're going to be getting a verdict today in the Aiden Kearney and Lindsey Gaetani trial. Ladies and gentlemen, it looks like we are going to be getting a verdict. Oh my word, ladies and gentlemen, we are in a brief recess. This could be the moment. These could be the moments. Oh my word. Oh my goodness. Court is in a brief recess before a verdict is announced in the Lindsey Gaetani and Aiden TurtleBoy Kearney trial. It could be just a few moments now, folks. Live. Oh my word. Oh my word, little towels. Oh my word, it is just scenes. It is absolute scenes. This could be it. This could be the moment. Will Lindsey Gaetani get justice? We are all on the edge of our seats. My name is Grant Smith Ellis. I'm listening with you. We're monitoring. Court is in a brief recess. We don't know when it's going to come back. Let me get you a verdict watch timer. Hold on. We got to practice for our Karen Reed we got to practice for our Karen Reed verdict watch. We're going on verdict watch. We are on verdict watch in the Aiden Kearney and Lindsey Gaetani trial. Ladies and gentlemen, are we seeing a guilty verdict for Aiden Kearney? The judge is in trial right now. I'm going to add a clock on our screen, ladies and gentlemen. Give me 1 second. Let me add a stopwatch for you. Where's my clock? I have added a clock for you. Here we go. Verdict watch has begun. Ladies and gentlemen, we are on verdict watch in the Aiden Kearney and Lindsey Gaetani trial. You see it on your screen. We are on verdict watch. Oh, my word. You all have seen the numbers, ladies and gentlemen. There it is on your screen. Verdict watch away. We are on verdict watch. Here we go. The Aiden Kearney and Lindsey Gaetani trial is on verdict watch. The countdown timer is on your screen. Little towels. I need to find a better place for it than that. But here we go. It has started. Oh my word, this is one of those moments. You made it, ladies and gentlemen. You made it to the first time Aiden Kearney, first time he could be found guilty. Second time I think he's been tried criminally. Will Aiden Kearney be convicted, ladies and gentlemen? You see the clock. You see little towel is with you. It is just a matter of time now, folks. Will Aiden Kearney be found guilty? We are on verdict watch. It has been 1 minute, folks. 1 minute. I don't expect this to be a very long verdict watch, but we are on verdict watch, folks. We are on verdict watch in the Aidan Kearney and Lindsey Gaetani trial. It was an excellent presentation of evidence by Special Prosecutor Bob Cosgrove. We are now 1 minute into the verdict watch. The very second we hear back, ladies and gentlemen, you will be the first to hear it. I promise you, there will be no delay. You will be the first to hear it, the verdict in the Aidan TurtleBoy Kearney case. We are just 1 minute into the verdict watch now, but all the world awaits the verdict in the Aidan TurtleBoy Kearney case. I'm going to put up a special towel poll. We can vote on it now. After closings, will Aidan TurtleBoy Kearney be convicted in the Lindsey Gaetani trial? Yes, we love Lindsey and justice. No. Hold on. Let's do this one thing at a time. I'm doing a towel poll, and we are on verdict watch. No, I hate koalas and also bananas. Maybe some people actually don't like bananas, so that part of the poll is going to be a little bit skewed, but that's okay. What is wrong with you? How could you not like bananas? Now, we are on verdict watch. As I mentioned, it is only a matter of time now, ladies and gentlemen, and I have put up a special towel poll. Is Lindsey Gaetani going to see justice today? In just a few minutes, we are on verdict watch. Oh, Dedham District Court, ladies and gentlemen, waiting for the judge. Eager moments, nervous moments here for the defendant, Aidan Kearney, ladies and gentlemen. We have the poll up. It is a ferocious poll. It is a battle of the towels versus the invaders. It is like that time Vince McMahon bought the WCW and they tried to invade the WWF and then broke professional wrestling for 25 years. Or it was like the time that the WWF went to WCW in Nitro in Atlanta with a tank. Yes, ladies and gentlemen, it is a battle, and I also control the towel poll, which allows me to do things like this. Oh, yep, ladies and gentlemen, look at that. Lindsey Gaetani has won the towel poll, 52% to 48%, 51 to 48. Lindsey Gaetani, Aidan Kearney is heading for conviction. Lindsey Gaetani is going to get justice, and 47% of people hate koalas and bananas. I'm not really sure why so many of you hate koalas. I'm a little perplexed. What did the koalas ever do to you? For example, do you see this little koala here? What did he ever do to you? Oh no, what are you doing down there, little koala? We need you higher on the screen. Have you ever thought to yourself, I have just insulted koalas, I've told them that I don't like them, and now you have upset Chewbacca and his comfort koala. This is Grant Smith Ellis providing live coverage of Verdict Watch in the Aidan Kearney and Aidan TurtleBoy Kearney case. Nervous moments right now, ladies and gentlemen. Nervous moments as Aidan Kearney awaits his fate. We await the return of the judge. Hopefully we hear it the very second it comes live, ladies and gentlemen. We're waiting for a verdict. We are waiting for a verdict in the Aidan TurtleBoy Kearney case. Also, a bunch of people have said that they do. Here we go. Here we go.
Aidan Kearney, after a bench trial, you have been found not guilty as to one charge of violate abuse prevention order. Such charge will automatically be sealed by the Office of Commissioner of Probation and the clerk's office, unless you notify both offices in writing within 10 days that you do not want the charge sealed, using the request not to seal court record. The request not to seal form must be sent to the Office of the Commissioner by mail or email to the addresses provided on the form. If you want copies of any documents associated with these charges, you must request them immediately before the charges are sealed. Thank you.
Thank you, ma'am. Thank you very much.
Thank you, Your Honor.
All rise.
Oh, goodness.
Court says it today.
Wow. That is not what I saw coming. I thought the argument was made. I thought it was clear he violated the order. I thought it was clear he stayed around. Oh, goodness, ladies and gentlemen. Goodness, an unexpected not guilty verdict after an extended 2-day trial for Aidan TurtleBoy Kearney. Very surprising. I think a lot of people heard that evidence there, ladies and gentlemen. I think a lot of people really focused in on the evidence. And I think a lot of people were utterly baffled how Aidan Kearney remained in the area and yet somehow did not receive a guilty verdict on the judge trial. Oh, ladies and gentlemen, a very well presented case by Special Prosecutor Robert Cosgrove. A very interesting verdict. I don't think anyone saw that coming. Not at all, especially in light of the presentation of the evidence. Very surprising moments. Yeah, definitely. I think something was a little weird, folks. But you know what? That is how it crumbled. That is how the cookie crumbles. Very interesting moments, especially with the amount of evidence that was laid out there, folks. But yes, that is Aidan Kearney put on his defense. He did not take the stand, and somehow he was found not guilty. But that said, ladies and gentlemen, it was certainly an interesting day of coverage. We watched every single minute of it. We have to recap the morning charge hearing in the Karen Reed and John O'Keefe case, and then we have to recap the verdict in the Aidan Kearney case, despite Kearney not taking the stand, despite nearly every witness confirming Kearney remained in the area, despite Kearney walking up to Paul O'Keefe and yelling at him about his deceased brother, despite video of Kearney being in the bushes and walking towards Lindsey Gaetani, there was a finding of not guilty. I certainly wonder how that happened. I mean, listen, you can only look at the 4 prongs of the law and the evidence presented and make an analysis, and I am just mind blown, folks. Just mind blown. Mind blown. But yes, folks, absolutely mind blown. Just mind blown. I guess that's what you can do in Massachusetts. Oh, goodness. Well, we still have to do our recap. Also, it's a wall of towel, friends, so good luck getting through in there. You're just going to run into them. Oh, goodness. Well, ladies and gentlemen, our thoughts are, that was a well-argued case. I don't think anyone could argue after listening to 2 days that was not an excellent case laid out in full by Special Prosecutor Cosgrove. I don't understand it. I'm befuddled. It's not like there was an evidentiary argument or an argument on the law. I'm befuddled. For one of the first times in my coverage of criminal trials, I am befuddled. I understand a lot of things get pled out and a lot of things get resolved. That doesn't leave me befuddled. That's how the system works. I am befuddled. I don't even know if I can be angry, because every single one of us listened to that case over 2 days. Every single one of us heard the evidence, and I don't think a single person saw that coming that I was engaging with. Very interesting commentary on the state of the law. I guess those type of orders have very little value. What is going on as a commentator? How can we have those orders? How can we have the evidence presented in this case and then have a verdict where the order wasn't violated? Just mind-blowing. Absolutely mind-blowing. Yes, no, and listen, folks, you heard those different witnesses. You can have 7 witnesses take the stand. You can have the defendant's own words used against them. You can have, in my opinion, every element from the prosecutor's checkbox needed that they need to make in their argument checked off. That doesn't mean you can get the verdict that, in my opinion, justice demands. But you report it as it happens, ladies and gentlemen, and the judge made his decision. The decision was a not guilty verdict in the Lindsey Gaetani and Aidan TurtleBoy Kearney trial. A very interesting 5-minute verdict watch, and it was a really methodical closing by former judge and prosecutor Robert Cosgrove, which really, I thought, laid out every piece of evidence we had heard over 2 days of trial testimony. And in light of that, I think that's kind of why I'm a little baffled. I think if the jury in the Karen Reed case in 5 minutes had reached a decision like that, I would be screaming in furious anger. This case, I'm a little bit just utterly perplexed. I don't even know what to say. And I know not everyone listened to the full 2 days of testimony, but just utterly baffled. Utterly baffled. But that said, folks, there are strong rights for criminal defendants in all states, perhaps more so in Massachusetts than other states. And perhaps it's not so much just about the weight of the evidence, but how well the defendant can assert their rights. And when you commentate on these kind of things, especially when you have a personal stake in it, sometimes you have to pull back and say, well, this was a clash of what I thought was a very strong case for the state, clashing up against what I guess is a judge who saw a lot of rights for the defendant. That's how the cookie crumbles. That's how the record will go down. But I must say, ladies and gentlemen, we reported every minute of it. We covered it. We watched it. It was a 5-minute verdict watch in the Aiden TurtleBoy Kearney case. It was a very interesting, it was an anxiety-inducing verdict watch, I'm sure. Although there wasn't, I wouldn't say there wasn't going to be jail time on the table per se. A violation would have probably, guilty verdict would have probably been probation or something like that. Certainly was an interesting decision. Maybe the judge just didn't want to deal with TurtleBoy in his court anymore. I don't know. We will never get inside the mind of Judge Pomerol. But I must say, ladies and gentlemen, we did our duty. We covered it to the minute. We covered the updates. And then in a shocking fashion, Judge Michael J. Pomerol of the Dedham District Court ruled that Aiden Kearney was not guilty as charged by the state of Massachusetts related to an RO violation on 2/26/2024. The arguments laid out methodically by both sides on the case. I think that the prosecution in the trial, if we're just looking at this objectively, had a much stronger case, laid it out much stronger. So it leaves me to wonder, what was the decision making? What was in the judge's mind? If I'm a judge thinking about that case, and I'm not a lawyer, I'm just a lay towel, but it's very hard for me because there's only 4 elements of the statute. The defendant knew that the order was in place. The defendant arrived. The defendant didn't leave when they were supposed to, and there was some kind of contact. And contact is very minimal. If there's a stay away order, contact can be as little as you being within 100 yards. But looking at the elements of the statute, I don't really see which box is not checked. Now the judge has made his decision. That's the ruling. But I just don't really understand it. I don't think I'll ever be able to understand it. It has an element to it of sort of, okay, let's move on. Of course, the felony charges Kearney is still facing over in Norfolk Superior Court are still very, very serious, very serious. But perhaps this was a case of, don't want this in my court anymore. I don't know. I don't know. But yes, ladies and gentlemen, we have to get caught up on the developments in the Karen Reed case from this morning. We have to do that section of our recap. And then we will follow up with the full overview of the Aiden Kearney case. And now we have to get ready for another series of closings tomorrow morning in the John O'Keefe and Karen Reed retrial. And then we have to get ready, ladies and gentlemen, for verdict watch and deliberations in that case. So it is going to be absolutely a flurry of activity, ladies and gentlemen. And what we're going to do now is, because I know a lot of you have been waiting to get caught up on this, if you missed the charge conference this morning, it wasn't that long in the John O'Keefe and Karen Reed retrial, only about an hour. We're going to watch it. We're going to get caught up. That's going to be our recap. We need to get ready for tomorrow, especially if you're on our mock jury. I don't know what to say, folks. I put a lot of faith in the justice system in Massachusetts. I don't. I am just utterly baffled. Utterly baffled. Yeah, so just in general, yeah, I just don't know. I just don't know how that played out that way. As someone who watched the entire case, I am still utterly baffled. But all right, folks, we got to go. Life does not just stop. We must now go look at the. We must now take a look at the charge conference from the John O'Keefe and Karen Reed retrial from earlier today, because we have to watch the charge conference, or if you missed it, or you will not be ready for the jury instructions tomorrow, because listening to how the charge conference is discussed is probably one of the most important elements of how listening to how the charge conference is handled is one of the most important elements of understanding how the jury is actually going to be charged. So we're going to take a look at that. We're going to watch the charge conference. Little Towel is going to compose himself after a chaotic day. And we all send our love to Lindsey Gaetani. Hard-fought case. I don't think there's anyone who listened to that case who would say that that was not a hard-fought case by the state. And the defense put up their case as well. I don't think anyone's going to say that that was a case that the state did not put on their full argument. Multiple witnesses, expert related to the distance between Gaetani and Kearney at the time. Maybe it was the nature of the contact, just the being in the bushes. It was kind of fleeting. I'm not really sure, ladies and gentlemen. Perhaps we'll never know. Maybe one day when Judge Pomerol retires, he'll say, that was chaos in my court. I don't know. We will never know, ladies and gentlemen. Perhaps it is one of the mysteries of life. But yes, we are ready. We have to get ready for closing arguments tomorrow in the O'Keefe and Reed retrial. Yes, now that the trial's over, I definitely can check up on Lindsey. I know the Towel friends want to talk to her, want to find out how she's doing. I know you all are very, it's very important to you that she feels supported. So let me just bring up the charge conference. I don't think I can talk to her right now. She's got stuff. She probably has to talk to her friends. But let me put up the charge conference for you. Let's all watch that, all right? And then as we're watching that, I'll try to see if Lindsey's doing okay now that the sequester order's over. And I know that she is going to appreciate that Towels from all over the world have been supporting her, ladies and gentlemen. We went through that together. Whatever the outcome of a case is, we went through it together. And we made it, and in the sense that we supported Lindsey Gaetani. Lindsey Gaetani was incredibly brave. It came out that Lindsey Gaetani was told by Paul O'Keefe that her strength is to be applauded. And I think, ladies and gentlemen, that's something every single one of us can stand for today. Chloe the dog may be free. Chris Albert, Colin Albert, Brian Higgins, Brian Albert, they may all be free. But ladies and gentlemen, Lindsey Gaetani is not yet vindicated. It cannot be declared yet. We wish it would have been her moment in her day. But even on a day, ladies and gentlemen, where it may not go our way, we still must stand up and say that we are proud, ladies and gentlemen, proud of Lindsey Gaetani, proud of the witnesses who testified today against Aidan Kearney, and proud to be Americans. Our justice system may not always work out in ways that we want, but ladies and gentlemen, if you cannot stand up for a system when it renders a result that is unfavorable to you, then you will not be able to bask in the glory of a decision that goes your way. That is simply the reality of it. There can be no debate about it. Ladies and gentlemen, that is simply the situation as Towel stands right now. Now, what you hear in the background is Towel preparing you to watch the charge conference in the John O'Keefe and Karen Reed retrial. I'm going to jump us right forward to when that comes into session. Then I'm going to bring it up on your screen. You are all going to get the chance to get caught up in that. Towel's going to get himself composed. You've got to take it, though, ladies and gentlemen. Gracious in defeat and humble in victory. That's how it is. If you can't, it's going to be very hard on Lindsey and the victims who went through so much to try to bring justice in this case. And ladies and gentlemen, that is why they are worthy of our support. Anything we can do to support Lindsey, ladies and gentlemen, you know we're going to do. She is not alone. She has friends. She has put up a hell of a fight. And those are the type of human beings that, ladies and gentlemen, we are proud to support on Towel Stream. So, ladies and gentlemen, keep putting your positive words of support in chat for Lindsey. I know hopefully she'll get a chance maybe now that the trial's over to read back if she does get a chance to see them. But she knows she is loved, ladies and gentlemen. I know that the Towel friends care so much about Lindsey, and we're going to watch this charge conference while I try to compose myself, get some snacks, and also get a drink. So enjoy the charge conference. Let me see if I can extend to Lindsey all of our compassion and condolences, not just that, but our messages of support and our messages of love. And I will relay to her how much Towel friends from around the world truly care about her. Ladies and gentlemen, that is truly important to me. So we're going to do this, ladies and gentlemen. I know, we're going to do this. You watch it. I'll be back soon. I stuck with you.
117, the parties are present, the jury is not present, the matter is on for trial. If the parties could please identify themselves for the record.
Good morning, Your Honor. Laura McLaughlin.
Good morning, Ms. McLaughlin.
Adam Malik, Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Morning, Your Honor. Robert Alessi from Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti from Karen Reed.
Good morning, Mr. Yannetti, and good morning, Ms. Reed. All right, so Mr. Yannetti and Mr. Alessi, you're standing in also for Mr. Jackson and Ms. Little?
We are.
Okay. All right, so first thing we left off yesterday was whether KKKK for identification, the PowerPoint of Dr. Rentschler would be entered into evidence. It will not be based on the objection, so it is excluded from evidence. So it's marked still for identification, and your rights are saved on that. So we ready to go forward with the charge conference?
Yes, Your Honor. I guess I have a question first as to whether the court would like to entertain the argument on the motion for required finding not guilty of all the evidence.
So, no, we can do that now. So now that my ruling is on this, evidence is closed. Evidence is closed as it was yesterday. So go ahead on your required finding argument. Sure.
And this is not lengthy, Judge, 5 or 10 minutes.
Take your time.
Thank you. We are renewing our motion for required finding of not guilty at the close of all the evidence, and in so doing, Your Honor, we're incorporating our oral argument in support of this motion that we made at the close of the Commonwealth case. At that juncture, Your Honor, the Commonwealth had produced no witnesses to testify that John O'Keefe's injuries were consistent with his having been hit by a motor vehicle, and if he was not hit by a motor vehicle, none of these three indictments may stand. The Commonwealth, we believe, at that time fell woefully short of proving their case. Now that the defense has put on a case, the Commonwealth's case has been further weakened, such that none of these charges can stand. Nearly every witness, Your Honor, we have called, we would submit, has destroyed the Commonwealth's theory of the case. Dr. Russell testified for the defense. She's a leading expert on dog bite wound pattern recognition in the country, and she testified about medical injury causation and provided the jury with her expert opinion that John O'Keefe's injuries were consistent with dog-inflicted wounds, both bites and scratches. I would remind the court at this juncture that there was a dog at the very residence where John O'Keefe was found, a dog which was a longtime member of the family, which the family gave away after John O'Keefe's death. A dog which mysteriously was absent from the home at 6:30 in the morning on January 29th, when Jennifer McCabe claimed that she burst into Brian Albert's bedroom where the dog always slept. A dog which was absent from the home when the Canton police entered the home later that morning. Importantly, Dr. Russell agreed with the Commonwealth's medical examiner, Dr. Scorty Bello, that John O'Keefe suffered no injuries that were consistent with having been in a motor vehicle collision. And again, if there's no collision, there's no case. Dr. Lopesada, one of the most experienced and accomplished forensic pathologists you could find anywhere, agreed with Dr. Russell that John O'Keefe's injuries were consistent with an animal attack. And she agreed with both Dr. Russell and the Commonwealth's expert, Dr. Scorty Bello, that John O'Keefe was not hit by a motor vehicle. So the question is, in what type of murder case would a judge ever allow a motion for required finding of not guilty? In a murder case where expert testimony on both sides is that the evidence is inconsistent completely with the Commonwealth's theory of the case, that's exactly what we have here. But it doesn't stop there. Both witnesses from ARCA drove a stake through the heart of the Commonwealth's case. Dr. Wolf concluded that the damage to Ms. Reed's Lexus was inconsistent with having come from a collision with John O'Keefe. Unlike Dr. Welcher, who created, we would submit, a meaningless experiment based on no scientific method, Dr. Welcher actually did the proper force analysis and concluded that Ms. Reed's Lexus was not damaged by the body or the arm of John O'Keefe. His testimony was unimpacted by cross-examination, and it's devastating to the Commonwealth's case. Dr. Rentschler further cemented that there was no collision between the Lexus and John O'Keefe. It is simply not possible that this 6,000-pound SUV hit John O'Keefe at 24 miles an hour and caused only superficial wounds to his right arm with no injuries to his legs or lower body. The SUV did not hit him. John O'Keefe was not hit by the SUV. The case is over. But on top of all that scientific evidence, Your Honor, there were 3 additional fact witnesses who testified for the defense who corroborated that the Commonwealth's theory of the case is false. Sergeant Nicholas Barros, a sworn police officer, testified that when he saw Ms. Reed's SUV that day, before it was towed to the Canton Police Sally Port, the taillight was merely cracked. When he was shown photos of what it looked like in the Sally Port after Michael Proctor had access to it, Sergeant Barros confirmed that it was absolutely different. Karina Kolakithis confirmed that there were no problems between Karen and John O'Keefe that night, even remarking on just how sweet he kissed her on the forehead shortly before they left the waterfall. But perhaps more importantly, that kiss happened right in front of Brian Higgins. The same Brian Higgins who had been flirting with Karen Reed that month, the same Brian Higgins whom Karen had ghosted for several days before January 28th, the same Brian Higgins who had texted Karen that very night, well, and received no response, the same Brian Higgins whom Karen had given her back to all night, the same Brian Higgins who had to be restrained at the end of the night by Chris Albert on video, the same Brian Alberts who is on video, hot, angry.
Brian Higgins. You just said Albert. You mean Higgins, right?
I meant Higgins, yes. Yeah, the same Brian Higgins, who is on video, hot, angry, and gesturing to John O'Keefe to meet him outside shortly before they left the waterfall and shortly before John O'Keefe was killed. And finally, Brian Loughran, plowing Fairview Road at 2:45 in the morning, was attentive, watching everything in front of him, very familiar with the Alberts residence, and had every reason to protect the Albert family. You recall that he did protect the Albert family to a degree that night by choosing not to follow protocol and call the DPW or the police about the Ford Edge parked on the street outside their property during a snow emergency. Brian Loughran confirmed that John O'Keefe was not on the front lawn at the Albert residence at 2:45 a.m. That means that Karen did not hit him. There was no collision. All the experts agree on that, including the Commonwealth's expert, and the only eyewitness that morning confirms it. Taking the evidence in the light most favorable to the Commonwealth at this juncture, with their evidence weakened by an airtight defense to these charges, these indictments cannot stand, and we urge this court to enter required findings of not guilty on all three indictments.
All right, thank you.
Thank you, Your Honor. Commonwealth requests that the defendant's motion for required finding not guilty at this juncture, as it was at the close of the Commonwealth's case, be denied. The state of the evidence is not dramatically changed since the Commonwealth rested its case in chief. Counsel makes reference to dog or canine. I would remind the court that there is absolutely no evidence, none, not even a scintilla of evidence of a dog. There is no evidence of an absence of a dog. You have Ms. McCabe testifying that she didn't see it in the morning, which does not equate to there being an absence of a dog there. The arguments from counsel of the Commonwealth would suggest grossly exaggerates the strength of the defense witnesses in their case. The bias and advocacy exhibited by those witnesses from that witness stand do not amount to credible witness testimony that undermine the Commonwealth's case in any way, shape, or form. A couple of specific examples when it came to Officer Barros. His testimony was also that the cruiser camera footage from 8:22 in the morning at the driveway at One Meadows Ave, he indicated the damage to the taillight was consistent with the damage that he observed in the driveway at the defendant's parents' home, which was then consistent from the video or the photographs within the Sally Port. It's also consistent with 5:07 a.m. at One Meadows Ave on the still frame shots from that ring camera video. Essentially, the Commonwealth would submit that the defense witnesses all conflict with each other. You have a couple witnesses testifying about dog or animal bites. Then you have the ARCA witnesses testifying about superficial abrasions. You have Dr. LaPosada talking about the drop in body temperature, which conflicts with Mr. Loughran's testimony as far as his confusion, as far as the hours of when he sees or claims to have driven by there and not seen a body. This is the same witness who is, I would submit, very confused on times, and then also backed into a basketball hoop during the course of his plow duties on that particular early morning as well. And as the court could see from the cruiser camera video, drove by the scene countless times, essentially rubbernecking it as he's going past doing his duties. Your Honor, what the Commonwealth would submit is that his case was more than sufficiently strong at the close of the evidence in his case in chief. There has been nothing presented in the defendant's case to diminish, particularly to the standards in the light most favorable to the Commonwealth, and we request that the defendant's motion be denied.
So, Ms. Giannetti, you know I have to view this in the light most favorable to the Commonwealth.
I do, Your Honor.
And viewing it that way, the Commonwealth has met its burden, so the motion's denied. Okay? All right, so regarding the charge, so we'll start with the defendant's missing witness request. Who's arguing that motion?
We're not arguing that, Your Honor, and I apologize, but we made the decision last night to withdraw 2 of our requested instructions, which would shorten things today, I think.
Oh, okay, so everything on this is done, right? The defendant's motion to present a missing witness argument and request for instruction, you're withdrawing that?
With regard to the absent witness instruction, we're withdrawing that request.
Okay. And what else from your proposed instructions? You said there were 2. What's the second one?
The second one is that there's an entry on our request for lost or destroyed evidence where we're withdrawing that.
Okay, I had a question about that. All right, thank you.
There is a supplemental instruction that we're asking the court to give regarding the display of the sweatshirt.
Oh, that's right. You filed. I saw it in email. I don't have a hard copy of it.
That's Mr. Alessi's.
Your Honor, if it's helpful to Your Honor, I'll hand up my hard copy.
Okay, if you could do that, I'd like to go back through the rest of it and come back to that after I've read it. Okay? Who's arguing for the rest of the defendant's proposed instructions?
I am, Your Honor.
Okay, so we're going to go through them one at a time. Who's arguing for the Commonwealth? Okay, so I think you're sort of in agreement on the basis of the law, right?
Yes.
All right, so model homicide instructions, and just as last time. So that takes a lot of time out of today.
The only thing I would draw the court's attention, the Commonwealth does have a request for, and I understand the court's position might be on this, but as far as the instruction relating to murder charge, the Commonwealth is only seeking an instruction on third prong.
All right, so we will deal with that. I'm going to go through the defendant's instructions are sort of the general instructions first, so it's probably easier to go through those, and then we'll have the argument on that. So presumption of innocence, I think my presumption of innocence is a little more robust than what you've requested, so I will probably... Okay. And I will give some version. I know that there was a lot of attention paid and some appellate decisions on the each individual indictment. I'll give some further language on that. You've got an instruction proposed on page 4, reaching a verdict. I will make it crystal clear, though I think it was, and I was upheld on it, so I will make it crystal clear. Okay? So I'll give you that, Ms. Giannetti. What is evidence? I probably won't give verbatim what you have. I'll take a look at it, but I will certainly cover all these topics. So, Ms. Giannetti, you're telling me that your client wants me to give a defendant did not testify instruction?
Yes, please, Your Honor.
Again, if you want to take a look at what I gave last year, I think it's a little more robust than this.
I think we answered satisfied with the court's instructions on that, so we would be satisfied again with the court's language.
Okay. Humane practice, I will give you Bowden. I'm going to take a look, size this up with what I gave last year. I gave Bowden last year. I gave a Bowden instruction. I don't think the Commonwealth objects, right?
We would object to the instruction.
Okay. Go ahead. Do you want to make an argument?
Just briefly, Your Honor, when it comes to the Bowden, and I would incorporate, and I know there's no request for instruction for third-party culprit, but the Commonwealth would be making a similar request that counsel be prohibited from making a third-party culprit or Bowden argument.
Or Bowden? Or Bowden?
I'm sorry?
You don't think the defense should be allowed to make a Bowden to argue Bowden?
So I would submit, Your Honor, that the entirety of any testimony or evidence related to either Bowden or third-party culprit in this trial has come from questions from the defense, not from actual evidence in the case, not from testimony from witnesses from the stand, exhibits that have been put into evidence, or anything of the like. So in the instruction and the arguments are based or predicated based on evidence. Not, and obviously, as the court is well aware, there's a specific counsel are not evidence. So what the Commonwealth would submit is that the court looks at what is actually in evidence in this case. There is no basis whatsoever for not only a Bowden or a third-party instruction, but specifically for even counsel to make that argument during the course of the closing. And I understand Bowden is a little bit more loose as far as the court certainly.
So I'm going to ask Ms. Giannetti to explain to me. All right, so I disagree with you on Bowden, but I'll take a closer look at it. Ms. Giannetti, what is the Bowden evidence that warrants an instruction?
I think it's more.
Hello, Towel Friends. I'm back. I realize we can actually watch this on Towel Stream with the Karen Cam. So let me just pause. We're about 37 minutes into the morning argument. We're pausing right when David Yannetti gets up responding to Judge Cannoni about Bowden. The reason I'm changing it is you're going to see right here when we watch it back on Towel Stream. Sorry, I put Law and Crime on because I was just going to get snacks. When we put on Towel Stream, you're going to notice, ladies and gentlemen, we have the Karen Cam, and that's why I'm deciding to do this. So it is not for no reason. It is because I think it will serve our purposes. Now, that was quite a day, ladies and gentlemen. That was quite a day. So let's go back to when David Yannetti gets up. It was about, I'd say 30 minutes, 37 minutes into the start of court. So I'd say it was around here or so. It was after Lally finished. Yeah, it was right when Yannetti stood up. So here we go. I got it. All right. So is this when he starts talking about Bowden?
I don't have a hard copy up.
This might have been a little bit early. Hold on. We're going to jump up to about 37 minutes in when Yannetti starts talking about Bowden. Hold on.
Of that, not more. Solely because of that juror's occupation, education, experience, or any other characteristic. Okay. Thank you. Charts and summaries. I'll talk a little bit about chalks.
Now, tell me if we jump too far.
I'll give some.
If we jump too far or too short, Towel Friends, based on where we were at. So hold on. Let me see. How far were we actually into the day? The day started about. Hold on. I may have screwed that up. The day started at about 20, and we were getting to Yannetti's Bodie. So we were only 17 minutes in. Oh, I'm sorry, Towel Friends. I jumped us way too far. That's all right. I just wanted to give you the Karen Cam. I think you all will appreciate that the Karen Cam version is actually much better. So we're going to go a little bit back. It was about 17 minutes after court started. So that puts us, let's see, right about here. So let's go about 17 minutes from there, about 6:40. Yeah, all right. So about here, when did court start exactly? Yeah, so at 10:27. Yeah, I don't want to miss any of Yannetti's arguments. So I think it was a little before this. Sorry about that, Towel Friends.
Or anything of the like. So in the instruction and arguments are based or predicated based on evidence. Not in obviously as well aware there's a specific instruction that no matter how powerful they are, questions to counsel are not evidence. So what the Commonwealth would submit is that the court looks at what is actually in evidence in this case. There is no basis whatsoever for not only a vote or a third party vote instruction, but specifically for even counsel to make that argument during the course of the closing. And I understand voting is a little bit more loose as far as the court certainly.
So I'm going to ask Ms. Giannetti to explain to me. All right, so I disagree with you on Bowden, but I'll take a closer look at it. Ms. Giannetti, what is the Bowden evidence that warrants an instruction?
I think it's multifaceted, Your Honor. The police did not secure the crime scene properly. They used inadequate materials and active evidence. Chain of custody was contaminated and corrupted. There was evidence of the bias of the lead investigator, failure to pursue the suspects, specifically telling his friends that the homeowner was sacrosanct because he's a Boston cop too. There was just a focus say that we didn't introduce that evidence when we tried to do it. When we were
I think what Mr. Lally was saying that you asked questions but weren't given answers. And so I think that's what was said. Mr. Yannetti, I'm going to allow you to argue Bowden, and I am going to give an instruction. So third-party culprit's an entirely different animal here. I know, but tell me, are you going to argue it? Is the defense going to argue that Brian Higgins did this?
No, we're going to argue that police failed to investigate whether Brian Higgins did it.
Okay, so just so that it's clear, that you all know, I believe, third-party culprit separately is a lot different than third-party culprit as it goes to Bowden. I ruled pre-trial that there could be no attempt at introducing third-party culprit evidence regarding Colin Albert. So that was separate. But I did say that I would give you the opportunity to try and develop testimony regarding Brian Higgins and Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as three-party culprits, has not been made by the defense. So you cannot argue that either Brian Higgins or Brian Albert committed or had the motive and all of that. Not third-party culprit, pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
We understand the distinction, Your Honor, and we're strictly going with a Bowden defense.
Okay, so you can get into third-party culprit with Brian Higgins, that the police were aware of whatever you're going to argue and failed to act on it. But it's strictly for that purpose, okay? Okay. Yeah. So Mr. Yannetti, and of course I take him at his word, tells me that they're not going to do pure third-party culprit. Okay, that's great. That makes that easier. So I will give. Sure, go ahead.
While we're on page 8, I just wanted to almost let's have an objection to the instruction that's at the top of the page 8.
Yeah, I have a check mark next to that. Mr. Yannetti, tell me about this, the absence of a recording. Are you saying that the police should have recorded Ms. Reed at her parents' house?
Right. So, obviously it's not the strongest DG Batista argument that we would have to not occur at a police station, but, these days, Your Honor, it's common knowledge that everybody has access to a recorder, even on your own cell phone. It could have been done. It wasn't done. We have to rely on police memory of what my client said or didn't say when there was a possibility for a recording. So we still think we're entitled to it.
Do you think it was custodial interrogation? Or I guess I should say, do you think the evidence supports?
I think there's an argument that it was a custodial interrogation. We had police officers who, refused to sit down in the living room. They were surrounded for someone who was not familiar with dealing with the police at all. So yes, I think there's an argument that it could be considered custodial.
All right, what do you say about all this, Mr. Lally?
And I would also add, Your Honor,
Sure.
they did seize her vehicle at around the same time. So, that it goes to, I think, the issue of custody and my client being able to deny it.
Right. What do you say?
That's the very nature of the objection, Your Honor, is the non-custodial nature of this. So the trooper spoke to Ms. Reed at her parents' house, as they did with a number of different witnesses on that day as well, over the course of that. They spoke to her while she was seated on the couch in her parents' living room. The parents were present, no one was restricted from and it did not end in any sort of custodial situation. She was taken into custody, she was arrested. Yes, they did seize her cell phone and her vehicle, based on information that they had developed throughout the course of the day and from statements from Ms. Reed herself. But I don't think that transforms that conversation or interview in her parents' living room into a custodial interrogation. The bigger issue that I have placement, as far as there's already been within the same request for jury instructions or request for humane practice, and then following the DG and Batista language in the defendant's request for jury instructions,
I'll take another look at this and I'll just let you know in the morning.
And Your Honor, with regard to the compromised mental state, we agree that that does not apply to the interview at your residence. But we believe that it applies within the humane practice context.
That is where it makes sense. So, all right.
It's gonna happen, it should happen once, not.
Yeah.
I think that's fair.
Okay. Okay. All right. Prior statements, I will give some instruction on prior inconsistent, and I'll give a prior consistent statement. I will talk about the view. The absent witness instruction is withdrawn. So is the...
Not to interrupt.
That's okay. That's okay.
With regard to the view, Your Honor, we did include a language reinforcing the fact that the rock that they saw on the view was not present on January 29th. We asked the court to repeat that one sentence.
Okay. So I did not see this when I took a quick look at the view. All right. I'm not going to repeat it. All right. Lost or destroyed evidence you're withdrawing. Direct and indirect evidence. I'm going to try and give a shorter instruction on that. So I will, even the one I gave is too long. I'm trying to cut down the time the jury needs to hear general instructions that I think they're perfectly capable of hearing in a shorter period of time. All right, thank you. Credibility, the same. Law enforcement witness, I think I gave some instruction on that. I'll include that somewhere in it.
I might just reference that.
Sure.
Only language in there that I would object to.
Okay.
That's what a police officer or someone else works for a law enforcement agency.
Oh, what do you mean by that?
I think that was taken into account for the dispatcher, perhaps. We're not.
Yeah, I'll do police officer because they're police testimony. I'm not going to go beyond that. Okay, thank you. I'll do the photographs, the opinion testimony, notes. I'm not saying I'm giving exactly this, but I will give, I'll cover all those topics. What page you on? Okay.
One suggestion there was indicates Commonwealth introduced photographs and evidence.
Yeah, I'm just going to say there are photographs that are in evidence. Was that the nature of your objection?
I actually think the defense has introduced more graphic.
Yeah, so I would just say you've seen photographs. Or there were photographs and evidence. I instructed twice anyway, maybe 3 times on it, so I'll give some version of that. Juror notes, I'll give some version. The implicit bias instruction, I'm going to give exactly what the SJC told me I should give. All right, so the Commonwealth's requests are sort of in the, you start with the law and then you get into the general instructions, Mr. Lally, so let's skip to your, it's not numbered, your supplemental instructions, use of a dangerous weapon. All right, so I'm going to give that, Ms. Giannetti. I gave a dangerous weapon instruction last year on the motor vehicle.
Understood.
All right, so I'll give probably what I gave last year, and this looks like it's it. What is not evidence, evaluating, I'm going to give what is not evidence. Evaluating the evidence, there's some instruction. Ms. Giannetti, what do you think about the short instruction on jurors? It sort of makes sense to me after such a long trial. No juror is better qualified to determine the truth of the facts in controversy or to deliberate upon a verdict than any other juror, or solely because of that, solely because of that juror's occupation, education, experience, or any other characteristic. Okay. Thank you. Charts and summaries, I'll talk a little bit about chalks. And inferences, I will give some. I'll give the redacted exhibits instruction. Witness preparation for trial. Do you both want this? There was testimony on both sides. It's simply, there was testimony at trial that the attorneys, and I may say if you find, or something, preface it. Witnesses when, the attorneys interviewed witnesses when preparing preparing for and during the course of the trial.
No objection.
You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the attorneys are obligated to prepare their case as thoroughly as possible and may interview witnesses. I don't know if there's a sequestration order, if this is appropriate, though, where it says during trial, during the course of the trial. I'll just say when preparing for trial.
Yeah, we're joining in the request. I don't know that we included that in our instructions, but we're joining in the Commonwealth's request for that instruction.
All right. Okay. Expert witnesses, electronic communication. So I'm going to go through the limiting instructions I gave. I need to just do this again here. So electronic communications, I have that on my list. The emotional impact photos, humane practice. We'll get back to consciousness of guilt in a minute. I'm also going to give the prior bad acts instruction. I did that in regard to the Aruba incident, if you want to call it that. I gave a prior bad acts instruction before that testimony came in. I also gave the instruction that I will also give on the state of mind of John O'Keefe as to his state of mind being known by the defendant and the likelihood that she would act on it. So Commonwealth versus Binns in those cases.
Your Honor, with regard to Aruba, we don't believe that there was really any testimony that came in.
I thought it came in through Kaylee. I should say it did come in through Kaylee. That's when I gave the prior bad acts instruction. She testified. Okay. All right, so did I give it any other time that there's another event that I should highlight? I don't think so. All right. I think I have to add that here. So, all right. And I will look at it and decide whether I need to add it specifically. It might be covered enough. Might be covered enough when I give the electronic communications instruction. So I will think about that. All right, those were the limiting instructions I wanted to get to. So
We would object to the prior bad acts being linked to the beginnings text message.
all right, I'm going to take a look at that, Mr. Lessie. All right. Consciousness of guilt. Okay. All right. All right. So tell me where the difference is in what I gave last year from the model homicide instruction on second-degree murder and where you're saying I should not this year, Mr. Lally.
No, so the only...
1 second, let me just pull that up. Okay.
Your Honor, Collins' request is merely not for any change or alteration in the instructions that were given, other than there are three prongs of malice. Essentially, the Commonwealth is requesting that the jury be instructed
Speak up.
merely on third prong malice, as that's the only one that really applies to these facts and circumstances.
Okay.
The Commonwealth view the first two prongs are essentially extraneous in this equation, and don't need to explicate in the jury. To avoid confusion.
Do you have supportive case law for me to single this out?
I do.
What do you say, Ms. Giannetti?
I mean, Mr. Brennan essentially stated that in his opening statement.
Stated what?
Well, in his opening statement, he stated that he's not alleging that she intended to do him grievous bodily harm. he stated that in his opening. I imagine that's what he'll likely argue in his closing. You know, I don't have a position on this. I just don't know, and I think the court's going through this analysis in your head as well, whether it's permissible or not. I just raised that as an issue, but I don't have strong feelings about it.
I could say the parties agree that the first prong and the second prong are not applicable here.
I think we're just at a position where we'll refer to the court on this.
Well, I'm not going to say you agree if there's no agreement. If you can get me a case by this afternoon,
I will endeavor to do so, Your Honor. We will. I don't have anything.
I'm inclined to go with the model. I'll see if there's something I can find. You're probably better at finding it than I am, Mr. Lally, but I'll see if there's something I can find to support the position that it's just the third prong, and therefore I only have to give that instruction. I don't think I'll find anything, but let me see. Because I can understand why both of you don't want it. Just let the jury focus on what they need to focus on.
That's really anyone's business. I understand, and I don't.
You know, I suppose I could always tell the jurors that the Supreme Judicial Court has come out with jury instructions that I must give in their entire format. And that sort of explains why I say something that doesn't apply. Maybe. Maybe I'll do that, but let me see if I can find something. If I can find something that says I don't have to give those first two prongs, I'll let you know before you begin. All right.
Your Honor, before the court makes a decision on that, we see what the court is proposing if you are going to alter the...
If I alter it, it means I remove those two. That's all.
Right, no, we just wanted to...
Yeah, sure. My guess is that won't happen, but we can see. All right. So, lesser included offenses. Did you want to know UI instruction? You were...
We're asking for that.
Okay. All right. Right, I think that's it, aside from Mr. Alessi's motion regarding the exhibit. Right, is there anything else that we're missing?
Just a couple of other issues. One is with regard to the Proctor text messages, we have a redacted version now, which we'd like to submit to the court of the Commonwealth. You recall that we had agreed essentially on a redaction subject to the court's ruling.
Okay.
But it wasn't in final form. We believe it's in final form now.
And you all agree that it's in final form?
Well, they haven't seen it.
Oh,
I'm going to
okay.
give it to them now. Can I hand this to the court?
Sure, thank you. All right, so...
The only other issue, Your Honor, is we do have...
Hold on one second on this issue still. So I will give the Commonwealth this afternoon to take a look at this. And tomorrow morning, if you don't have agreement, then we'll have to deal with it. And I'd prefer not to have to deal with it, so.
I'm sure we can be in touch this afternoon. I do not believe there's going to be any problem.
Okay.
Just a couple other things before we get to Mr. Alessi.
Yeah.
One is that we do have the Dr. Wolf PowerPoint to be introduced to the evidence from.
Dr. Wolf or Dr. Rentschler? All right. And this was allowed into evidence unobjected to. I thought we already had it. We didn't?
We have to redact it, so we
Okay.
redact it. It's on a phone drive.
Okay. And the Commonwealth has seen it? All right. So they'll have to see it. So Mr. Lally, Mr. Brennan, Ms. McLaughlin, one of you has to take a look at it.
And then will the court allow more than an hour?
I'll allow more than an hour. I'll allow an hour and 15 minutes.
Thank you.
All right.
And I think I did mention that we had a proposed verdict slip for count 2, Your Honor, if I didn't.
You did not.
Okay, we do have one, we've given a copy to the Commonwealth, can I hand the
Okay.
proposed copy to the board?
Sure. Is it the same as last year's, but now with a?
It's different.
Okay. All right.
So you'll have a chance to digest that.
Oh, I digested it, Mr. Alessi. Go ahead, I'll hear you.
I'm actually
Yannetti, jeez, I'm sorry.
So, Your Honor, you'll recall, we had some spirited argument both before and after trial regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment because of the number of lesser includeds and the number of elements that are different for each lesser included. And we were uncomfortable with, there being one option for not guilty at the top of the form, and then multiple options for multiple different types of guilty verdicts throughout the remainder of the form. So what we have done is to fashion this in a way where the jury, pursuant to the court's instructions, would first decide the offense as charged, and if it's a guilty verdict,
Madam Clerk?
The analysis is over. If it's a not guilty verdict, they go into the next lesser included offense, and again, same analysis applies. If it's not guilty, they then go to the next until they finally reach the final verdict, which the lessest, or the least, I should say, of the lesser included offenses is simple operating under the influence, where they have an option for not guilty or guilty. We've also changed a little bit of the wording, you'll see, which I think makes it clearer and less confusing. When the jury is given options for theories of guilt on at least three of the charges, including the main charge, because there's this issue of either under the influence or 0.08 or greater. The way it originally read, Your Honor, manslaughter while operating a motor vehicle under the influence of alcohol was repeated twice. It was repeated once where there's an option for guilty, and then it was repeated again with both of the other options. We think that this is simpler, it's cleaner, it's clearer, and we believe that this verdict slip is the most appropriate one.
Mr. Lally?
Your Honor, as the court is probably well aware, the Commonwealth is not requesting any lesser included, and I certainly understand that if the evidence supports it, the defense requests it, that the court must give it. Having said that, the verdict slip was used in this matter last year. The Commonwealth would submit is more than sufficient and adapted to the defendant's request. The only other thing I would bring to the court's attention, I don't know if you're aware, there was a case recently, while this case was going on, tried before Judge Lau, in which he had similar issues and had, I believe, used at least part of the verdict slip from the first trial, in this case, as sort of a template for the lesser included that he instructed and the verdict slip that they utilized in action. I don't have a copy of it on me, but I can certainly get the court a copy of it. Doctor, but that may be somewhat helpful if the court is thinking of
Okay, was that our murder case?
It was not, but it had to do with felony motor vehicle homicide.
Yeah, I'll take a look at it. Mr. Turk. Mr. Turk. Mr. Yannetti, I don't believe I'm going to give this, but I'll take a closer look at it.
Well, we appreciate that. Judge Lau is an excellent judge. We think that this verdict slip it provides the most clarity for the jury. That's why we're
Okay, and that's where I think we disagree. So I will take a closer look at that. And so has it been filed officially and docketed?
I just handed it, I believe.
All right, so Madam Clerk, you have a copy up there?
The proposed, I think this is the only
Okay, that's what I was wondering. Okay.
Do you need an extra copy?
Sure. Yes. Or, you know what, just mark it for identification, Margaret. We'll do that. Chrissy, please. Just for ID.
Come on, it's LL for ID.
Thank you. Mr. Lally.
Your Honor, just one request circling back to the constitutional instruction. So Commonwealth is withdrawing its request for the instruction.
Okay.
However, would be seeking to make some argument or reference to these arguments from the jury related to specific areas which we would need judicial approval before we did. So the two areas that are sort of listed within that, if you'd like to make some arguments with the jury regarding, is the defendant's taking of the Lexus from one metal that came to her parents' residence in Dyton, and then certain statements made in reference to various clips of her statements.
Okay.
In particular, would be the one where essentially she says it's a certificate to her.
Okay. All right. Ms. Giannetti, do you want to weigh in on that?
Yes, really. Objections to that. I don't see it's her or me being evidence of consciousness of guilt. And the notion that she's driving from one residence that the police know of to another residence that the police know of, which is her parents' house. The car is open and obvious in the driveway. In fact, when the police call, she says, yes, come on over. I don't see that as being any evidence of consciousness of guilt.
Okay, so I'm going to allow them because they're permissible inferences from what's in evidence, but I'm not going to give, even before it was withdrawn, I wasn't going to give a consciousness of guilt on those.
And just to be further clear, there may be other statements.
Yes, so I did want to ask you, though, Ms. Giannetti, I think it's an argument that can certainly be made by the Commonwealth regarding the video clips that your client gave during various interviews. I think consciousness of guilt is a permissible inference from some of those. Are you sure you don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it as well?
No,
Okay. Okay, I just wanted to give you the opportunity. Okay. All right, anything else? Anything else, Mr. Giannetti? We're going to hear from Mr. Alessi, but
The Commonwealth does not object to the redactions.
that's great. Thank you. One less thing you all have to do today, okay? I know. All right, so let's make that, are we switching that new redacted version with the exhibit number? Do we know what it was before? Excuse me? The redactions on the Higgins messages, that's what you're saying you're fine with, right?
Proctor Communications.
Proctor Communications, okay.
This is testimony that came in.
Of Proctor, yes. All right, so we'll find the exhibit number and we'll just... 209, is everybody in agreement that it's exhibit 209?
Yes.
Okay.
Does the court have a copy or do they need the Commonwealth?
No, I wrote on it. I need the Commonwealth's.
So this is a clean copy.
So that will now be 209 in evidence. You know what? Can we make that 209A? We need, Ms. Giannetti, we need to keep record of the first one that was not redacted. So any objection to making this 209A?
I have no objection to that. And so original 209 will not be sent in. Is that?
It becomes.
So what do you think? Yeah. Yeah, so we'll switch it back to ID, and this will just be 209. All right, did we have an ID number on it originally? Can it still be that?
Is it actually NNN? Or is it, no, it can stay that.
Okay.
But is this the-
Oh, it's just NNN, it's not,
Well, where did it?
no, it became 209.
So
Our thinking is it needs to be sent back to letters for ID.
Yeah.
So
it'll be marked MM for ID.
That's great.
Perfect, and then the redacted version will now just.
209.
Yes.
Yeah.
And we'll hear from you this afternoon. Just somebody send us an email to the clerk's office. So someone send an email to the clerk's office today letting us know if the Wolf PowerPoint is ready to be put into evidence after the Commonwealth looks at it. Okay, so we'll take care of that. All right, Mr. Lessie, I'll hear you.
Thank you, Your Honor. If I might suggest respectfully a procedure to the court, I have spoken with the Commonwealth about what the topic is. It's obviously not new to anyone, but perhaps to expedite this matter, if I might suggest to Your Honor to avoid a more lengthier argument, it might even truncate it down to 30 seconds. If we could hear from the Commonwealth on what we have requested, and the topic specifically is entitled Defendant's Motion for Curative Instruction regarding Exhibit 88 and Introduction into Evidence of Exhibits. The exhibits is taken care of, that's no longer an issue. But I did speak with Mr. Lally, and if I could suggest that Mr. Lally can state his position as I understand it, and then I can go from there, and it may not be necessary for me to continue on.
All right. What's the Commonwealth's position?
But Your Honor, Commonwealth's position is ultimately I defer to the court as far as whether or not it's an appropriate instruction to give in the final charge. What Commonwealth would submit is that the contemporaneous instruction was more than sufficient to address the issue, and that it doesn't require any sort of differing language or further instruction given to the jury during the final charge.
All right, I'll hear you, Mr.
Thank you, Your
Alessi.
Honor. May I go to the podium?
Yes.
Thank you. Your Honor, I have given, and Your Honor has provided me previously with a generous opportunity to be heard on this, but I do need to cover some points with regard to the matter. I was hoping to avoid doing this, but given what we just heard, it needs to be done respectfully. As Your Honor knows, we have submitted this motion, and as part of the motion, it really consists of two parts. The first part is the text and the basis for what we're requesting. I'll come to that in a moment. And then attached to it are is Exhibit A and Exhibit B, and those exhibits are our best effort at transcribing, because there's not an official transcript at this point of exactly what happened. Why did we put in the exhibits? We put in the exhibits because we believe it really sets forth and illuminates quite vividly what occurred. It occurred rather rapidly, but I think this allows for a much more these exhibits allow for a much more reflective analysis. So just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88 encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand. And then at a certain time in the cross-examination of our witness, Dr. Wolf, confronted Dr. Wolf with it as part of an accident reconstructionist cross-examination, and challenging Dr. Wolf on several aspects. And this one was particularly apt, that the subject matter, not the manner of the examination, was, Dr. Wolf, you're saying this, these are your theories. However, did you consider and take into account the holes in the back of the hoodie? And that led to a series of questions and a series of answers. And I want to go right to the end, because I think going right to the end better elucidates what actually occurred and the depth of the issue and the problem here in this misconduct, which we believe was intentional. Specifically, the end is, we know, and I believe it is completely undisputed, that the holes in each and every hole in the back of the hoodie was caused by the criminalist, a witness in this case, Ms. Hartnett, who made those cuts as part of her analysis. And that was in May of 2023, long after the alleged incident of January 29, 2022. So that's sort of the end, undisputed. Now let's go back to what happened in the examination, the cross-examination of Dr. Wolf. So he's confronted, and I think, we put in Exhibit A and B of it, but what is particularly striking is on page 7 of Exhibit A, and it's the colloquy that starts in the middle, which we've yellow highlighting, Attorney Brennan saying, when you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm? Dr. Wolf started to answer, well, I know that there was cutting to, and I emphasize cutting, and then he was cut off by Attorney Brennan, and Attorney Brennan said, may I approach and receive the exhibit, Your Honor? And we note that in the context of many other statements in this regard as to what happened. So now this comes to the requested relief, and I'm going to move to the part of the argument, Your Honor, that we believe respectfully compels what we're requesting. So now I want to just state what we request. We believe what we've requested is quite modest given what happened. And our proposed curative instruction is on page 2 of our motion. It states, during the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022 from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police, I've got the acronym MSP, Crime Lab, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Please juxtapose that with regard to the instruction Your Honor had given, which was a sentence, so jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt.
Didn't I include the date you requested, the May 18th date? I thought I did.
You know, Your Honor, I think the answer is no, but because I'm doing it from memory and I don't...
This is not an official transcript, right?
Exactly, Your Honor, so I can't say it with certainty. I don't believe it was.
Okay, because that date you told me was important to you, right?
Among other factors, the date was important.
It's May 18th, right?
Yes, Your Honor.
Okay. Go ahead.
And so, Your Honor, I believe what is fair in the analysis and as objective as I can be here is, I think the curative instruction has to tether to and relate to in its details the degree of what happened. This was on a very significant topic, accident reconstruction, a significant piece of evidence, the hoodie. There's been much discussion among many expert witnesses about this hoodie,
what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident. And then to show the witness on this for the defense, it clearly left the impression to any objective observer that Dr. Wolf had somehow been incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury therefore should not weigh and value his opinion. This is very, very significant, and I underscore, Your Honor, we didn't cause this problem. We didn't cause any of this issue. So, to me, I do not understand why the Commonwealth would not support this. What we have written down here supports the truth. We all, I believe, should have the common goal of the jury receiving the truth. I looked at the jury, I'm no soothsayer or mind reader, but I looked at the jury and they looked confused when I looked over at them. But I think even aside from looking at a jury, what Your Honor did in good faith, I don't believe is clear enough on this key issue. And I'm not understanding why there would be any real contest over making it clear to the jury on this very important point. The defense, to my point of being measured at the time and being measured now, we could be requesting a lot more statements about what occurred. And I've been in situations in other trials where things have happened and there's been many more significant things stated. So in conclusion, Your Honor, the defense not having contributed at all to this issue, the significance of the issue, the significance of the error, it's undisputed about the error, to me, respectfully, all augurs for more clarity here. And the final point, there's two issues here. There's the fact of when these holes occurred, these cuts, and how they occurred. That's one bucket. But the second bucket, which is not in the current instruction, is our expert witness, Dr. Wolf, and the impression left upon him. And that is why we have the language in there, again, we believe quite measured, just the sentence at the end to take care of the harm to our witness with regard to what occurred. So, therefore, Your Honor, we respectfully request that this be given so that the jury has a clear and complete and truthful understanding of not only what happened, but also to make sure that it is what's created for the jury is accuracy, hence truth can be concluded. Thank you, Your Honor.
Thank you. I do just want to point out one thing. It was not objected to at the time it came in. That's my only comment. I will consider this. I'm going to hear from Mr. Lally. I will consider this.
What is it that was not objected?
The testimony was not objected to. I didn't hear this until I think after another witness.
Your Honor, if I could, thank you for raising that. 10 seconds for that. I will, and I made this point the very time that I made the argument last time. We were not shown that Exhibit 88 in the encasement. It was behind the witness. We didn't even know that it was behind the witness. So what happened was Attorney Brennan went up, retrieved it, and immediately went to the witness with it, showed it. We couldn't even see what was happening. There was no physical nor other ability for us to object at the time. So I appreciate you giving me the opportunity to respond to that.
All right, Mr. Lally. Keep your voice up, please.
Yes, very briefly. I'm not going to get into a belabor the point as far as the back and forth about conduct of counsel. During the heat of trial, during the heat of the extended exchange with the witness on stand, things can happen. It's basically, it was a remedy, recognized,
Acknowledged and accepted as a mistake. There were numerous offers by the Commonwealth to offer a stipulation as to the truth as far as the evidence is concerned that were rejected by the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in. There have been many, many instances of similar type conduct that didn't result in a curative instruction, and to accentuate it further in the final charge to the jury is simply improper. It was a situation that arose as far as whatever misstatement was made at the time, as far as whether it's from the testimony from the witness or the question from counsel, was immediately remedied, was taken care of. I don't think that there's any confusion by the jury, and furthermore, as I indicated, the Commonwealth offered a stipulation at the time that this occurred, which was essentially rejected by the defense. They got the curative instruction at the time. That is all that is required. It is more than sufficient, and it doesn't need to be accentuated or addressed further in the final charge.
Okay. So I'll consider it, Mr. Alessi. Okay.
Thank you, Your Honor.
All right. Anything else? Two things I'd like to talk about for scheduling. The jurors get here early. I'm going to ask if the court officers to call the jurors and ask them two things. To ask them if they can get here a little bit earlier so that we can all be in the courtroom at 8:45 ready to start. So things take a little while generally. That will assure us the closing arguments will start right at 9, maybe a few minutes earlier. The goal would be to hear arguments from both counsel and then take an early lunch break. I would ask the counsel plan on just a half an hour lunch break. I'd like, the point being, I want the jurors to start deliberating. I don't want to end the charge and send them home for the weekend. That's not fair after they've waited so long. So a short lunch, you're free to stay in the building, and court officers will help you with accommodations for that. But a short lunch, and then I'll come out and do the charge. And then at least, hopefully, there'll be some time for them to deliberate. I'm going to ask the court officers to call the jurors to see if they can stay as late as 5 o'clock or 5:30 tomorrow night. I just don't think it's fair after they've sat through so much of this trial with the various delays that we've had to not let them start deliberating.
We have no objection to that. One request we have, Judge, is during the last trial, during deliberations, the court had asked us to be within 5 minutes of the courthouse. My office is about 10 minutes away.
I'm sure we can make accommodations for that. But at some point we may have to talk about security issues. So a lot may depend on that.
Understood.
All right. Does the Commonwealth have any objection to that schedule?
No, Your Honor, none at all.
All right, so we'll see counsel in here no later than 8:30 tomorrow morning?
Sure.
We'll counsel here at 8:30. All right, thank you.
All rise, court, please.
Oh, there you heard it. Folks, mock jurors. Mock jurors indeed. Hello, Towel friends. You went from Towel back at 11:15 a.m. to Towel live with you now. That is the benefit of me being in Towel. I am with you. Hello, Murder by Maestro, PK, Ange Wittick, my King of Kings, Dark Side of the Moon, Buddy Light, Amber Am, Sarah L. Shenanigans, Deb Martell, Troy, 65, CJ5, Rachel McIntyre, Murder by Maestro, Peony and Rose, Fair Maiden Wins, Paul Doherty, RP, Phoebes. Oh my goodness, Colleen Henry, Susie Q, ladies and gentlemen, Mandy Strong. There's so many of you in the Towel chat. We got a few things that we got to do. One, obviously you just heard, oh, Laura Dixon, God bless you, dear friend, your first super towel chat. And it, ladies and gentlemen, it is a super towel lemon emoji. I would just like to say a super towel thank you to Laura Dixon. I didn't get a chance to tell my dear towel friends when they sent their super towel emojis earlier. I got to say it in chat. I didn't get to say thank you, and I didn't get to giggle after a very long and hard day at a super towel lemon emoji. Look at him, ladies and gentlemen. He is giggling. He's saying to me, Towel, I know that the world is absurd sometimes, but you just must giggle. You are a little towel. We have to console those who have fought so hard. We must seek justice for the vulnerable, and then we must giggle at lemon towel emojis. Yes, that towel emoji is a super towel. Well, it's a lemon emoji. That is a super towel. God bless you, Laura Dixon. Thank you so much for being with us, and thank you for giving me the chance while I was talking to say I love that super towel emoji. Even though we're doing very serious things, sometimes you need a moment to say, one, Mike Crawford is a nipple rubber, and two, that's a super towel emoji. Now listen, we have a very strange long tale about what we did in the lunch recess. We're not going to dramatize super towel spouse Mandy Strong anymore. I'm a little bit concerned that we traumatized honorary super towel spouse Mandy Strong during the lunch break, ladies and gentlemen. Mandy, I hope you have recovered. Murder by Maestro, I don't know if, and oh, hello, Dark Side of the Moon. Hello, Maui Swift. Hello, Troy. Murder by Maestro, I don't know if you missed the lunch break. It was a little bit intense. There may have been a man rubbing his nipple involved in the lunch break. Hi, Red Sky. Listen, I don't have time to explain. It's very possible that there was a man rubbing his nipple on the lunch break. But all right, now that we're done telling Murder by Maestro about our fun towel day, so the way that it works is that Commonwealth gives opening first and closing last. So Commonwealth did their opening first, the defense will do their closing first, the Commonwealth will do the closing last, there is no rebuttal. So it ends, the last thing the jury will hear is Hank, oh, Christina Towell, I'm so glad you're here. We have updates from you. Oh, and listen, ladies and gentlemen, I think Eva Towell might have already gone to bed, but I have a wonderful update for us before we do our wind-up. We all have to get a lot of rest. Listen, I am doing a special thing tonight. I am going almost right to bed after this. I'm going to go get, I'm going to drive around and relax, and then I'm going to go get my energy drink for the morning tonight. I'm going to get probably 8 to 10 hours of sleep. You all should as well. We have a big day tomorrow. Mock jurors, please arrive promptly. If you can. If you have an exception, it's okay. Hello, Red Sky. Ladies and gentlemen, please arrive promptly, okay, tomorrow. If you are on the mock jury or otherwise, if you want to see closings, 8:45 a.m. That is when the lawyers are expected to be in the court, ladies and gentlemen. That is when we are going to be in court, okay, in our mock court. Now, before we do that, ladies and gentlemen, I have big news for you. I know you all are excited about this. We have an updated picture of Brewski, the Irish setter, who is also a territorial expansionist. Now, you might be saying, sir, dogs cannot actually acquire territory. Yes, they can, ladies and gentlemen. We are going to give Brewski Norway. Norway, please do not be upset. All the Norwegian towels, I want you to cope with this. I am giving your country to Brewski, the Irish settler, who is a territorial expansionist. Now, you might be saying to yourself, why are we giving Norway to a dog? Well, it's been a long day. We're only like 10 hours in on Towel Stream, which is short for us. We sometimes go 12 hours. But ladies and gentlemen, it is a dog. It is Brewski the Irish Setter, who is one of the official mascots of Towel Channel, along with Bella the cat. And Brewski the Irish Setter has territorial expansionist agendas, and we're going to give Brewski Norway. Now, any of you Norwegian towels out there, I do not want you to get overwhelmed. I promise you, Brewski will be a benevolent leader. All Brewski wants to do is be an Irish setter and then also take over parts of Norway. There is nothing that can go wrong. We'll give him a set of skis and set him loose. What can go wrong, ladies and gentlemen? You don't understand. If we just send Brewski into Norway, he will become an ambassador doggo. They will never know that he's an undercover territorial expansionist, and therefore we will acquire parts of Norway for our benevolent animal-based kingdom. You don't understand. I have thought very much. Oh, Irene, you have a great rest of your night, folks. You do need to rest up. We're just doing our updates here. Yes, now while you look at Brewski, the one of the Towel Channel mascots, who's a territorial acquisitionist masquerading as an Irish setter, I want to tell you about the mock jury signups. Now, I know the doggo is going to distract you, but I got to tell you about the mock jury signups. Here's our mock jury number one. Marie 623TX, Kim Cordeau, Alicia B, Christina, Eva, Colleen Henry, We Say Howdy Here, Rachel McIntyre, Irene Grillo, Rita P from Canada, and Sarah L. Shenanigans. The 4 towel of jury 1, Ange Whittick, ladies and gentlemen. Now, for jury number 2, Tiger Lily Girl, Chastity, Artworks 2, Jew Dropser Diana Natali, Jack D65, Sun-Eyed Girl, who will be a little late, Luisa Ramirez, Curly Girly, POG 3909, Mandy Strong, and Z Travels. If you heard your name, and yes, there will also be alternates, Sandy Johnson, and the bailiff is, and maybe I go by Steph, and maybe Steph, and then the bailiff is Karen. I have a note that says the bailiff is Karen, and Karen shall protect the mock jurors. Not really sure what we have to protect them from, but you're going to do a good job, Karen. I have no doubt about it. All right, so that was the list, and the 4 towel of jury number 2, of course, is Deaf Otter, the commander of the Towel Expeditionary Force, ladies and gentlemen. Oh, it's wonderful. You're in, Jack D65. You take a good rest. You get ready for trial tomorrow, and we are almost, we're closing up anyway. I just have to check Reporter Towel Christina's updates, because, ladies and gentlemen, are we going to deny Reporter Towel Christina the ability to have an update? No, we are absolutely not. So while I'm getting Reporter Towels Christina's updates all set, ladies and gentlemen, I would just like to say, Brewski the Irish Setter, I would like you alongside me for the announcement. Ladies and gentlemen, for the first time, although it is a bittersweet day, for the first time in the history of Towel Stream, ladies and gentlemen, we have broken 50,000 viewers on the Towel X. Ladies and gentlemen, it is a historic day. It is a bittersweet historic day on Towel Stream. Didn't even really notice it earlier, but ladies and gentlemen, we have done it. Yes, here it is, ladies and gentlemen. Take a look, 50,000, ladies and gentlemen, 50.51,000, ladies and gentlemen. Brewski the Irish Setter is very excited. Yes, you can wear an AirPod. We are not banning electronic devices. Mandy Strong, you are fully permitted. You are not sequestered, and you may access electronic devices. Oh, we are all losing our minds as we get ready for closing arguments tomorrow. That's why we're hanging out as towels, because at least if we're talking to each other, we won't be so nervous. We have one more sleep until deliberations in the John O'Keefe and Karen Reed retrial. I looked at my calendar today. Do you realize that day 13 of this trial was on May 5th? We have been doing this for over a month together. I'm pretty sure we've all lost our collective minds. The only reason we're still sane is, 1, to get justice for Lindsey Gaetani, and 2, because Brewski the Irish Setter and Bella the cat, who both are honorary towel mascots, need us to continue to be strong. For Lindsey, for John, for Bella the cat, for Brewski the Irish Setter, who's an undercover territorial expansionist that we're going to give Norway to, ladies and gentlemen, we must be strong. Now, all right, so I know that Mandy Strong is very pleased that ear pods are allowed. I also want to just say, ladies and gentlemen, this isn't really about the reach of this stream. I think that for me as a public information service, I think of it in the context of, and I was talking to someone earlier about this when they were coming into chat asking sort of what's the point of all this. It's really rooted in a public service ethos. So if you're very interested in expanding the public access to the court system or regulatory bodies or whatever, that's the work that I like doing. Now, I package it. I learned these values from reading about Lord Reith, R-E-I-T-H, who created the British Broadcasting Corporation. And I strive to educate, inform, and entertain the wider public, such as to engender cogent public discourse and ward off the usurpation of our representative forms of government around the world. Therefore, the reach of this stream, to me, it's paradoxical and it's quizzical for me. It's very it confounds me. I don't really feel like it's not really about me. Like, I just walk around the street. I promise you. People look at me sometimes and just stare. I'm just like, why are you looking at me? I'm a little towel. But I don't really think about that. Like, I don't really care. But I'm very pleased that, 1, the community that is developed here is very strong and wonderful. 1 hour, Mandy Strong. 1 hour and 15 minutes for jury instructions. 1, I'm pleased that the community here is very strong. 2, I'm pleased that the reach of this stream, first of all, it's bigger. If you take a look, first of all, it's literally double the size of the GOP Oversight Committee hearing. It's 10 times the size of the Glare. It's bigger than some international networks when they do their broadcasts about big events and things like that. That to me is incredibly important because it means that the scope of the media landscape is changing. And I hope it's changing for the better because of the fact that I'm trying to create this public information service that sets a standard that if you're going to convey information to the public, yes, you can entertain people as a hook. Think Monty Python or Sherlock Holmes adaptations by the BBC with Jeremy Brett in the 80s, things like that. But really, your goal should be to use that entertainment as a hook. You bring people in so that you can teach them how to become educated and informed consumers of information. Not teach them per se what to think, but the form of how to consume information so that they can engender their autonomy within the larger public sphere. Therein creating a discourse-based ethic and a form of a structure of legitimacy within our public sphere that cannot be broken by the individualized interests of various comprehensive worldviews. Now, I have thought about this extensively, and that's why I'm so pleased about the reach of this stream. Because I don't really feel that it's appropriate to be prideful in it gratuitously because I and you all created this thing. I think it's important to take pride in what this stream has become, and 50,000 views on a stream is not a small number on X. It's huge. It's bigger than the biggest channels, the Al Jazeera, Sky News, Reuters, whatever, get, even double, triple the size of that. It's because of the fact that those principles are starting to manifest in a larger structure. Don't worry, Sunny-Eyed Girl. We'll have an alternate, and you know what we'll do, Sunny-Eyed Girl? You just jump right in whenever you want, and we will count you as a voting juror. You don't worry about it. We'll save a voting slot for you no matter how it all plays out, and I bet someone won't show up, so we'll need your extra vote at the end. It's going to be informal, ladies and gentlemen. It'll be formal to the extent you're going to be deliberating live in real time with me commentating on it, and I'm sure folks are going to love it, but it's informal. Now, I keep jumping in and out because I'm trying to explain that this is a public information service. So the 50,000 views on a stream is not a small amount. I want to mark it. I want to say thank you for it, even on a bittersweet day. And I also want to say that, oh my goodness, it's still growing. It's not really about me. It's about the fact that I think the principles reflected in the stream, the compassion, the friendship you show to each other, the justice that you try to uphold and seek for the vulnerable, the good faith discussion, even with people that you may disagree with. This is something special. I don't know where it's going to go from here. It's a beautiful thing. It means a lot to me. I'm so glad that we're able to be here together, and that's why I wanted to say that. So we are going to be, yes, we're definitely going to be doing our thing tomorrow. Don't worry about that. But I'm also going to be taking a look at Reporter Towel Christina's messages right now. Now, the reason I want to take a look at Reporter Towel Christina messages is because Reporter Towel Christina sometimes sends little updates and I forget about them, and I don't want to forget about this one. I think this one was a picture of a Grinch. Oh, yes. Oh, yes, we are looking at this. Is that David Unetti in the background? Reporter Towel Christina is like, oh, I know what's coming. It is David Unetti in the background. I love it. All right. Grinchy. She does look, that's what it is. Karen Reed looks like the Grinch. It took me forever to figure it out, but Reporter Towel Christina has finally put it together. Ladies and gentlemen, I don't want you to lose your mind at this, but we have a report from Reporter Towel Christina indicating that Karen Reed may actually be the Grinch. Now, you may be saying to yourself, Grant, that is not possible. Karen Reed is not the Grinch from the cartoon. Are you sure about that, ladies and gentlemen? Can you debate with this? Can you debate that in light of this image? Hold on, Brewski. I don't mean to cover Brewski up. I'm going to have to find a place for Brewski. This screen's getting a little crowded. People are starting to say, Grant, your screen is a little crowded. There's a lot going on. Well, you know what? You try having like 70 million towel friends. I love everything about it, but they all have a lot to say, okay? And they have dogs that I love, and they make ham sandwich memes. Now, ladies and gentlemen, I just want to make a point here that this is clearly Karen Reed. Okay, Karen Reed is actually the Grinch from the cartoon. Now, you might be saying to yourself, as I was saying earlier, Grant, that can't be true. Yes, it is. Reporter Towel Christina has the scoop, and Reporter Towel Christina has clearly proven that Karen Reed is the Grinch from the cartoon. I know it's far-fetched. But it finally came together to me. Yes, it's also possible Karen is the Wicked Witch of the West. Also, wait a minute. Hold on a second. Now, Forensic RN, have you ever thought about how the book The Wizard of Oz and its movie interpretation is actually a commentary on the election of 1986? And furthermore, have you ever thought about how that very interesting election, which I think was between McKinley and was it Williams Jennings Bryant during his first run during the free silver movement? I believe it was. So if you think about the economics in America from the 1880s until like 1896, all right, and you really think about what the motifs were, okay, in The Wizard of Oz, you have to think about the financial system at the time and the role that the debate between free silver and sort of fiat gold-based currency played. Now, in hindsight, looking at Bretton Woods in 64 and the sort of evolution to the petrodollar, yeah, okay, the free silver folks were absolutely right. I think if we did it over and like non-Hamiltonian based Jeffersonian kind of idealists were in charge in 1896 and not corporate sort of domineering interest, I don't think we would have switched away from free silver. But anyway, my point, Forensic RN, is if you've ever read the book The Wizard of Oz or looked at the movie, the crushing of those witches is very interesting, right? Because it's kind of a symbolic representation of the populist movement, like falling down onto this like behind the scenes world and crushing the Wicked Witch of the West, which I'm sure represented the interests that were out in the West, like a lot of homesteaders, oil interests, corporate interests at the time in the 1880s or 1890s when the book was written. And then the Wicked Witch of the East, who's supposed to be this like good witch or whatever, I think that's supposed to represent like the industrialized East and whatnot. And then Oz, of course, represents our entire political and economic system, where it's set up to be this grandiose sort of well-functioning machine. But then you get there and it's some guy in some like green top hat operating this ridiculous farce of a head pretending to be all powerful. That is why Karen Reed is kind of like the Wicked Witch of the West, and the Wicked Witch of the East is involved in this as well, because Karen Reed represented kind of the way entrenched systemic DOJ interests, even though it was in Boston, so it's not really the West. I guess it's the North if we're comparing it to Canton. So we'll call Karen the Wicked Witch of the North. So Karen became the Wicked Witch of the North because she was kind of like in bed with the systemic, corrupt, systematized DOJ. And then the Wicked Witch of the East is definitely like the Norfolk DA's office. And then Dorothy, I think we're going to call Dorothy in this story Little Towel. Little Towel was just going about his business, frolicking along with his little towel dog, and then all of a sudden this tornado picked me up out of my life, and then for the past 3 years I've been in a dream state, and then when I crashed down I landed on Karen Reed, and then all of a sudden I looked around and the world was full of Technicolor, and then I went on this path and I thought I was being led along this kind of good path to help people, and then all of a sudden I found out it was just imperiled with challenges, and these different segments of society, like the Tin Man who needs a heart, or the Tin Man who needs oil, and the Lion who needs a heart, representing all these different bases of society, and Scarecrow who needs a brain, and all of that. And then I realized that when I got to Oz, it was all a facade, and the justice system is actually just a way for various self-interested political groups to form overlapping concentric rings of social and political influence in order to undermine the pursuit of justice and further their own political ends. I've put it all together. That doesn't mean I'm disillusioned or going to give up faith in the system, but clearly the conclusion of this story is that I am Dorothy from The Wizard of Oz, and I am a towel who landed on Karen Reed, who is the Wicked Witch of the North. Okay? It all makes sense. It all makes sense. Now, did everybody follow along with my allegorical explication of the free silver movement in 1896 and why I am Dorothy Dorothy the Towel who fell on Karen Reed, who was the Wicked Witch of the North? Does it all make sense? You see what I'm saying, ladies and gentlemen? Okay, now someone was talking about my brain. Can we indulge Towel a little bit? Did you know one of my favorite party tricks, which is probably why I don't go to parties very often, is to list the presidents in order dating back to slightly before Lincoln? So I'd really like to do that if you wouldn't mind, okay? So let's see if I can do it. I think it's I don't go past Polk very often, but let's see if I can do it. Is it Taylor, Polk, Buchanan, Lincoln, Johnson, Grant, Rutherford B. Hayes, Chester A. Arthur, Cleveland Harrison, Cleveland McKinley, Teddy Roosevelt, William Howard Taft, Woodrow Wilson, Harding Coolidge Hoover, FDR, Truman, Eisenhower, Kennedy, Johnson, Nixon, Ford, Carter, Reagan, Bush 1, Clinton, Bush 2, Obama, Trump, Biden, Trump. There you go, ladies and gentlemen. Look at that. That was so fun. I'm trying to remember all of the U.S. presidents in order back to Washington so that I can also memorize all of the Supreme Court justices they have ever appointed, so that whenever I read a Supreme Court opinion, I can look at the justice who wrote it, understand the political constellation of when they got appointed, and easily, therefore, reconstruct their brains, their mindset based on the year they wrote their opinion and what was going on in the country at the time, and therefore read between the lines. It's a genius plan. I have done this a few times. All of you, I bet, were like, wait a minute, is he actually doing, he just, oh, okay. Yep, no, it's all up there, folks. We can just pull that out of there at random times. This all started because I wanted to talk about the election of 1896 and how Williams Jennings Bryan lost to McKinley and free silver was the main part of the election because of what happened in the 1880s. I listened to a lot of audiobooks about the American Republic. Oh, LLA, you're so kind. Listen, Forensic RN asked a question about the Wizard of Oz and whether Karen was the Wicked Witch, and then I decided I had to do one of my wonderful sort of James Joyce-inspired Viconian recursive rants about how Karen Reed is various historical mythical figures reborn, such that I can tell the rise and fall of human morality as manifest in an allegorical story. That's why Finnegan's Wake is so wonderful. You can call me Humphrey Chimpton Earwicker. In short, ladies and gentlemen. Oh, yes. Now, listen, you will never be want of discussion at a New York high society fashion party if you can talk about how historical allusions made manifest in layered literary allegories are the epitome of a reconstructive analysis of James Joyce's Finnegan's Wake. If you say that sentence to someone at a New York high society fashion party, they are going to say to you, oh my goodness, I am baffled. Here is my opinion on why you should be part of the New York high society fashion arena. And then I will say, screw Gloria Vanderbilt, I don't care about any of that, and then I'll flip them off. Because that's hilarious to me. You don't understand. Going into places like that and just saying that information and then baffling them and then being like, why are you so vulgar? And then me being like, haha, screw yourself is hilarious to me. I heard it said once that creativity is intelligence having fun, and let me just tell you, I have a lot of fun. No, listen, I only had one energy drink today. I only had one. I didn't even have a second Red Bull. I don't know what's going on. I just started. Listen, I'm not going to lie. I'm very interested. This is really what it's about. I get very excited about certain topics. The election of 1896, ladies and gentlemen. Let me just tell you, the election of 1896 is one of my favorite things in the entire world. So if you ask a question about the Wizard of Oz and it tangentially touches on the free silver movement and then I get to explain it, oh, I am going to be an excited towel. Does that have anything to do with Karen Reed being the Grinch? Nope. Nope, nothing whatsoever to do with Karen Reed being the Grinch. But you know what? I'm just thrilled that you're along for this ride. I don't know why anyone gave me a microphone and allowed me to talk for 12 hours a day to like 94 countries. I'm not sure I don't know if it's healthy for the world. I don't know if this brain is just kind of a little bit too big for one body, so it's meant to just exist in this ethereal space where other people can interact with it all the time and I'm just a conduit. I don't know. I just say things. I'm a towel. Rachel, I love American history. You don't understand. I have a 99-hour audiobook, which is absolutely wonderful. I think it's called The American Experiment or something. Well, one, I really should read, now that I'm thinking about it, I should read de Tocqueville's Democracy in America. Maybe I'll start doing that tonight. Because I don't think I should just listen to this same 99-hour audiobook that covers every single thing that's ever happened in American history over and over and over again every night. I think I have memorized everything that has happened in that book and more like 7 times over. That's why I can do the presidents. I don't just know the presidents by memory. I am listing time periods in history that I know everything about, and I'm just kind of synthesizing it into the name of a president. Anyway, so I really should read de Tocqueville's Democracy in America. I think that will kind of help me reform and reframe my understanding of the development of the American Republic, which is really what I'm looking at. If you want to know my larger schema, I'm trying to develop. So Bruce Ackerman from Yale, this excellent, brilliant professor, has this theory of constitutional dualism, and he basically says that American history ebbs and flows between periods of higher lawmaking, which he calls like constitutional lawmaking, and then just kind of regular lawmaking, like a day-to-day kind of society. And these eras of like constitutional lawmaking, he points to the founding, Reconstruction, and the New Deal, and he kind of says they're like, we approach but don't touch constitutional reformation in those eras. Like, yeah, we amend the Constitution, but like we also kind of like approach amendments but don't actually do it. Like, think like West Coast Hotel in 37 changing Lochner's interpretation of the Due Process Clause to allow states to have minimum wage laws. Like, that's an example. It didn't change the Constitution, but there was a political uprising during the New Deal that put pressure on the court to force the court to shift how it goes about interpreting an amendment because of a populist uprising, a threat to pack the court, etc., etc. And so I really look at, I'm really thinking about, are we in a fourth sub-constitutional era of Reformation? So that's really why my study of American constitutional history in particular is so important. I'm trying to project the rise of this sort of new era of constitutional reformation. And there's such a natural ebb and flow based on market forces in the United States in particular, domestically, and political headwinds, that you can kind of see, like, we get a lot of, so like, think like the Smoot-Halley tariffs in the 30s, all right, a lot of like economic protectionism. There was also a similar set of tariffs in the 1890s, actually, during the free silver kind of fallout. When you get hyper-industrialization and hyper-centralization in America in particular, you get periods of economic kind of expansion because of artificial market manipulation. And then it's a long story. Look into the collapse of the Knickerbocker Trust in 1907 and the emergence of the Federal Reserve in 1912, when Nelson Aldrich became Secretary of the Treasury, if you want to understand more. But anyway, you get these periods of economic expansion that are artificial, that are always marked by like domestic economic protectionism and like industrial centralization and like oligarchy, always. And what happens is then there's a period of like sharp contraction, and the sharp contraction is normally a harbinger of subconstitutional reformation, which is to say that every single time you get like an expanded economic bubble, economic domestic protectionism, and then a contraction in the economy, you get a rebounding in the form of a political movement that often results in subconstitutional reformation. So I'm trying to predict over the next 5 to 10 years, we're going to go through a period of very intense pain in America. But we're going to go through economic contraction, and then coming out of that, we're going to see a New Deal style, probably not economic liberal, but more socially liberal kind of reaction to that, which will manifest itself in a fourth period of subconstitutional reformation, which will facilitate the rebirth of the American Republic onto the world stage, God willing, by virtue of sort of reemergence of its founding constitutional principles and a cohesive national polity. Now, I have some bad news for you all. Unfortunately, in my study of all this information in history and data, I have concluded that it is likely we'll have to end up in a war before we actually come out of the other side of that, because domestic industrial production is only re-sparked after those periods of contraction when there is a war. So we're barreling towards that situation. It's very unfortunate, but as someone who's kind of thinking long term, my prediction is within 5 to 10 years, America will enter into kind of a new golden era, probably defined by a rebounding form of like inspired civic unity and nationalism following a war, unfortunately. And then we'll kind of reemerge like in the 50s and 60s with a very predominant place on the world scene. Probably it'll be a unique new multipolar era. We won't have like any other unified force against us, but we'll be strong. The petrodollar will rebound, and we'll use the force of our military might to get us through these economic troubles. But anyway, I've been thinking a lot about it, so that's what I think. Sorry about that. I didn't mean to go. I've just studied a lot, and I didn't mean to become pessimistic there. It's just if you ask me a question about American economic history, and then I get thinking about where things are going, I'm bound to start talking. Now, I want to point out, part of the reason why I sometimes am remiss to look down at the chat and to start taking questions is if I see something that sparks me, we will go down rabbit holes that will take us God knows where. And I love it, but I just want to let you know it's not your fault. I love it. Please ask your questions, but it can lead me to things like making predictions about the next few years and in the context of Bruce Ackerman's theory of constitutional dualism. I just want to say that it can absolutely happen. All right, so it is going to be a lot tomorrow. It is going to be a lot, and I appreciate every single one of you for indulging my spiel. I think at one point, Mike, one time, our very good friend Mike, said, Grant, can you please say those words in English? Now, entiendo español también y puedo hablar español mucho, pero no creo que es es un tiempo importante para hablo en español. You know what I'm saying? I just don't think that now is the moment. And I was speaking English, but Mike still needed me to define continental philosophy. All right. If you're still here for whatever reason, you know what's coming. You made it. We're at 53,000 now. Folks, we almost hit 60,000 views. Yes, Eva, I love... Oh, Eva, you want to know something wonderful? Because we have a little bit of time here. We're only going to watch the Call Me Hank clip. Eva, I must tell you something wonderful. And we're not doing a recap today because we're getting ready for tomorrow's closing. Eva, listen to this. Did you know there is a great... there was a great book called The Wealth of Nations by Adam Smith. Now, a lot of people think Adam Smith is the founder of laissez-faire economics. He's not. He was really more of a regulated market capitalist. You can see this in his analysis of wheat prices in like 1772. There's a great chart. I think it's on page 39 of The Wealth of Nations. Anyway, I only bring that up because you bring up your friend who's interested in economics. I knew this wonderfully smart man. I think his name was David Landis or Richard Landis. David Landis is the son, teaches at BU. I think Richard Landis was the father. I knew him before he passed away. He wrote this wonderful treatise, ladies and gentlemen, called The Wealth and Power of Nations. It was kind of a commentary on Adam Smith's treatise. And I remember I was sitting in his apartment. It was this beautiful apartment on Memorial Drive, kind of overlooking Harvard Square. It's like 110 Memorial Drive or something. I don't know. It was a wonderful apartment. It was like 40 stories up, and you could see all of Boston on the right, the Harvard athletic fields, and then you could see Harvard Square to the left. And I sat there and I thought, oh, so this is what it's like to be a very world-renowned professor. You sit on your balcony and you take in giant cities and you contemplate on existence. Anyway, so he wrote this really good book called The Wealth and Power of Nations. And I just remember sitting in conversation with him. I forget how I met him. I think I knew a mutual friend of someone in his family. Anyway, we're sitting there having this conversation, and I was a little towel. I was in graduate school. I was only like 22 or 23, and I'm sitting there with this man, and as I'm chatting away, and being a little towel, I looked up and I realized I am sitting across from a world-renowned Harvard professor, and I am explicating like Max Weber's theory of sociology in the context of Jürgen Habermas's discourse ethic, and he gets what I'm saying. Oh, it was a wonderful moment for Little Towel friends. I find myself in some interesting places. Sometimes I just go out in the world, I meet some very interesting people, and then I'm like, how did I find myself here? This is ridiculous. But anyway, ladies and gentlemen, I appreciate you all indulging me. Rage quit. Allie 90211, no! No, you... I overwhelmed Allie 90211's brain. Can you tell I'm excited, nervous, etc. for Hank Brennan's closing argument tomorrow, ladies and gentlemen? I think I have officially lost my towel mind. Listen. I'm just warning you right now. Sometimes when Towel's in a mood, I just have lots of information that I need to share, and I'm going to tell you all of it. I don't know what you should do with it. Maybe you can go write some papers about it. Maybe you can have a discussion over dinner about it. I don't know. You're still going to hear it. Yep, you know it's coming. You know Alex is like, Grant, you've already teased that you're going to do it. You must fulfill your promise. All right, fine, but we're taking a look just one more time. Look at that, ladies and gentlemen. Look at it. Look at it. It has taken over the screen. Oh no, it's taking over my head. I'm gone. Look at it. Ladies and gentlemen, it is a conquest of epic proportions. It is a conquest, ladies and gentlemen. I say it is a conquest. That number is just outrageous. It's absolutely outrageous. Hello, Will. How are you doing? I hope you are celebrating today. You can also look up, just like TurtleBoy. I think Will the Glare is actually like 6'1" or 6'2", but TurtleBoy does this when he sees towel, and that's what Will can do right now. Am I being a catty little towel? Yes, there's nothing you can do about it. Thank you, Sarah L. Shenanigans. I am having a great time ranting about history and getting ready to get to bed. All right, but first of all, I just want to say that's really actually impressive. Towel is very grateful. I hope all of you watching around the world. We've went through all the countries already today, but let me try to do it from memory. The UK, Ireland, Northern Ireland, which is part of the UK, Germany, France, Spain, Portugal, Sweden, Norway, Finland, Denmark, Italy, of course, we can't forget the Italian towels, Croatia, Serbia, Bosnia-Herzegovina, Turkey, India, Egypt, Israel towels, Mozambique, Egypt, Somalia, Mogadishu in particular. I don't know why, but hello, Mogadishu. Interior, I think Ethiopia was on there at one point. Zimbabwe is definitely on there, ladies and gentlemen. Hello to our towel friends in Australia, in New Zealand, in Singapore, in Malaysia, in Vietnam, in Japan. And if you think I'm just saying countries, I'm not. There is an actual list that there, and some of you, there is a growing towel stream audience in France, and I am very concerned that the French government thinks that you all are just going to give me northern France, which is fine. I'm totally okay with that. We will have a homeland for the towel people. It shall be called Norman Towel. But yes, ladies and gentlemen, so Towel has thought a lot about this, and I want to say also hello to the towel friends in the United States of America. In all 50 states, I am an American towel. I love America. I love the other countries of the world. I love their people, but I am an American towel. Hello to Canada. Hello to Mexico. Hello to Nicaragua, Guatemala, Mexico. I said Mexico. Panama, Honduras, Costa Rica, Ecuador, El Salvador, Panama, Argentina, Chile, Brazil, Venezuela, a number of other countries I'm probably forgetting. Ladies and gentlemen, you all have somehow turned Towel Stream into a phenomena, and I just want to laugh. All I wanted to do was laugh at Ted Daniel and say he was pink down to his underwear, and now we're hitting like 60,000 views on YouTube on X a day. I don't know what to do with myself. I'm a towel. It's not about the views, it's more about the fact that this is ridiculous. I literally just wanted to troll Ted Daniel and say, Ted Daniel, eat your heart out, and you are pink down to your underwear. You might not be a communist, and I'm not a communist, but you are pink down to your underwear, and now we are at 60,000 views. Ted Daniel, eat your pink down to your underwear heart out. That's hilarious. I just wanted to troll you, and now we are hitting 60,000 views. You don't understand. That is my life goal made manifest, my summum bonum, my eudaimonia in the Latin and the ancient Greek respectively, is to troll Ted Daniel and become the largest towel stream internationally, bigger than the country of Qatar's national broadcaster, bigger than Sky News, bigger than the GOP Oversight Committee, and 10 times as big as the Glare. Yes, ladies and gentlemen, all because I wanted to troll Ted Daniel. So the life lesson here is, if you want to try to make the world a better place, if you believe in a better future, clearly then you should try to troll Ted Daniel because he's pink down to his underwear, and then you will get 60,000 views almost on your stream. I don't really think that's how it works, but I'm pretty sure that's the message the universe is trying to send me. Oh, goodness, ladies and gentlemen. Oh, goodness. Yes, I don't even know what to say about it, ladies and gentlemen. I am just baffled. Just baffled. I'm as baffled as that ruling earlier. Just baffled. I'm going to leave it up there because I think it's hilarious. Ted Daniel one time walked up to me. One time, Ted Daniel from Boston 25 in the bathroom of court was like, "Grant, you smell like weed." And I was like, "That's medicine, Ted. Stop discriminating against me." And then another time, Ted Daniel was like, Grant, I interviewed for a documentary the other day. I talked about you. And then I don't know, I waited a year and we beat Ted Daniel on X like 2 weeks ago. And I was like, Ted Daniel, eat your heart out. And then I was like, Ted Daniel, I'm talking about you. What are you going to do about it? And then it just took off. You don't understand how much glee I take in laughing at Ted Daniel. Yeah, apparently we are just in the towel groove. Listen, we have spent 40-something days together in a row. I think we deserve some time to just pause and say we are pursuing justice. This is a serious subject, but at a certain point, we all are so nervous about tomorrow, it's very possible if we don't go to bed, we're going to lose our collective minds. I know, I didn't play the clip. I was having a really good time right there. Can you really get upset at a little towel for yelling about Ted Daniel? Come on now, come on. That's like one of my favorite things to do. Ted Daniel smells like scotch. Yeah, I should have been like, yeah, Ted, well, you smell like ethanol. Oh my God, I can't. No towel. We shall go to bed. No, we're not going to bed without playing the clip, though. You know it's coming. I know it's coming. You know it's coming, ladies and gentlemen. There's only one thing that people want to see, and I am going to give it to them, ladies and gentlemen. I'm going to give it to the people. I'm going to give the people what they want. I searched Call Me Hank on Twitter, and there's this random guy from some other country who just says the phrase, call me Hank randomly. I can't. I'm going to lose it. I'm going to lose my ever-loving mind. How long can one person keep it together covering a 45-day trial? Oh my goodness. Someone needs to write a story that's like inside the mind of Towel. The man who can say U.S. president's in order, explicate footnote 2 of the model jury instruction for consciousness of guilt, cover a number of other things, and then also talk about how Karen Reed is clearly the Grinch. All right, here it is. There it is, folks. You know you want it. The world wants to see it. I'm not going to deny the world what they deserve. I am a towel. I am but a mere humble towel. A humble towel in service of a larger good, and part of that good is playing the Call Me Hank clip. You as well, Mr. Brennan. Okay, sir, I will, Hank. You as well, Mr. Brennan. Okay, sir, I will, Hank. There you go, folks. There you go. It takes a second to come up on the screen, but you got everything you wanted. You wanted it. We got it, ladies and gentlemen. And there's only one. Is Eva Towel still here? I have to check. If Eva Towel is still here, there's one thing we'll do. Eva's going to pop up now and be like, yes, and you know what's coming. Allie90211, listen, I want you to try to contain yourself. This might get a little feisty, but hold on. We're going to do the analysis here. Hold on. Are we going to get, is it in the end of the clip or is it, hold on, maybe when he's walking away? No, it cuts out. Does it cut out his Hank Brennan's feet towels? Maybe. No, it doesn't. All right. We're going to do it. All right. Alley 90211, I need you to put on your Alley 90211 eye muffs, okay? This might get a little bit intense. Alley 90211 doesn't always do well when we do this moment, but Eva Towel is going to be thrilled. Ladies and gentlemen, as you know, feet towels are very important. Hank Brennan's feet towels are a subject of national pride, and we are going to do an analysis. As you know, ladies and gentlemen, we're going to wish Hank Brennan best on his closing tomorrow, and we're going to do the one thing towels around the world want, the one thing towels around the world demand. We are going to look at Hank Brennan's feet towels, and Alley 90211 may have to step away or put on their Alley 90211 eye muffs because this could get overwhelming for them. All right, here we go. So, Eva Towel, as you know, sometimes when you're analyzing Hank Brennan's feet towels, you have to be strategic with your clip analysis. So you can see Hank Brennan there. He's walking. All right, so you can see his feet. All right, there you go. So his feet come into frame. Now we're going to take a look as the feet come over the line there. All right, now take a look at those feet towels. All right, now you're going to see those are black and white checkered feet towels. Now you can see we can do a tactical zoom in, all right, on the Hank Brennan feet towels. As you can see, they are clearly checkerboard pattern. They clearly represent the Balinese philosophy of dualism, ladies and gentlemen. And, you know, we can really zoom in up close if you want there, and you can really see in the black and white feet towels, ladies and gentlemen, that Hank Brennan's trying to make a purpose, trying to make a point, all right? So I truly believe, ladies and gentlemen, that Hank Brennan has a purpose in life, and that purpose is to bring balance to the universe. Now you can see the slow motion analysis of the feet towels, ladies and gentlemen. It's glorious. I mean, it truly is. Checkerboard feet towels, ladies and gentlemen. What happens when I go to bed at night? Yes, the Balinese spiritual powers. Yep, feet towels indeed. What happened? So, yeah, it was tough. God bless you, Kim Cordeau. We will keep empowering Lindsay. So what happens is I normally go to bed around 8 or 8:30, 9 o'clock, and I'd say but I can get up anytime, and as long as I'm sleeping on 90-minute cycles, if I get up by I'm normally up at 3, 4 a.m., I like to read Le Monde and El País, and I like to get caught up on the news in southern Lebanon and what's going on in Yemen, and I try to track the developments in the Middle East, and then I'll take a look at the East Asian markets. I try to look at the Dow and S&P futures. The S&P future is really what you want to be looking at because it will tell you if a trigger is going to happen. But you want to keep an eye on the Nippon and the other market indexes. So by the time it's 6 a.m., I've already got caught up on all the news in Europe, all the news in Asia, and now I'm just waiting for the American markets and the news to open and court to start. So I like to get up early. I don't need a lot of sleep. I probably get 4 to 6 hours most nights, and I'm an excitable little towel if I can get 4 to 6 hours of sleep. Anything less than that, and I get a little cranky. Oh, Eva, listen, you know what? I'm excited for Brewski's new photo. We are going to do that first thing tomorrow. It's going to be one of our special moments in the lead up to the start of closing. Oh, yeah, as long as I can sleep for 90 minutes and hit a REM cycle, I am good for the next 20 hours, 18 to 24 hours, as long as I'm sitting. Physically, my body's not great, but I have mentally, my mind rebels at stagnation, ladies and gentlemen. The less I have to be stagnant with my thoughts, the better the world is. I truly trust me. All right, we're going to do a truncated closing. We've been going for 11 hours? All right, that's enough. We don't have to go for 12 hours today. Oh, yep, keep looking at Hank Brennan's feet towels, ladies and gentlemen. 11,000 views on YouTube. Oh, my goodness. Oh, my goodness, ladies and gentlemen. We are truly taking over the towel world. Yes, 54,000 views on X, 10,000 views on the towel YouTube. It is a glorious day to be a towel. Oh, goodness gracious, ladies and gentlemen. But you know what I got to do? I got to do some important things. 1, I have to talk about how Karen Reed is clearly the Grinch. 2, I got to do my favorite thing in the entire world. I'm going to say all your usernames. I don't even care. I am committed to this. If I say, thank you, Ann Twittick. Yeah, we do need an early night. All right, we all need an early night, JVA, so let's do this quick. I got to get the comments to load up, though, because there is no matter what, there is one thing that I have to do. So first of all, thank you for all your support of this stream. Do you think we did it, by the way? We might have to actually celebrate in the morning, but it's possible we just hit 2,000 subscribers on Towel Channel. I know, right? I know it was a tough day, but imagine if that's how we end the day. Let's check. 1.97K. Ladies and gentlemen, we're going to hit 2K during closing arguments tomorrow. You're going to be here for the 2K moment. Allie 90211, you're funny and cute. All right, we're going to do a truncated closing. So you can like this stream. Did you know you can subscribe to this channel? You can become a member. Thank you to everyone who sent memberships today. You all are super towels for supporting this channel. I just want to say a super towel thank you to every single person who contributed, who gifted towel memberships. I want to say a thank you to Allie 90211 for the rage quit emoji. I love it. You don't understand. It's one of the greatest things I've ever seen. It makes me feel like a little towel. I want to say thank you to Laura Dixon. That lemon super towel lemon emoji was absolutely wonderful. And then of course, ladies and gentlemen, I want to say thank you to Karen. Thank you, and Hank is a tank, and peace and love to all towels. I want to say thank you to Karen for that wonderful emoji, and then C65CJ5. Thank you for the super towel fox telling me I did a good job. I needed that today, my dear friend. Have you ever considered the fact that you are a super towel fox doing a good job? Oh, ladies and gentlemen, so many of you. And remember, I'm doing a truncated closing tonight. So I just am saying thank you to all the super towels. So give me a little second. Oh, 65CJ5, that was such a wonderful super towel emoji. Jack D65, you did try a super sticker, but I got your super chat. Thank you. You are amazing, my dear friend. Courtney Myers came through, started a membership parade, ladies and gentlemen. God bless you, Courtney Myers. You are appreciated, my dear friend. Towel hugs to you in so many ways. You are a super towel. Paul Doherty, love you, my friend. Simply thank you for being such a big supporter. Always amazing chat. So many comments. You are the best. Eve Marie Moreland, God bless you, dear friend. Thank you for your question. Such a wonderful day today. I'm so glad we got to see you. Peonian Rose, you sent a flying super towel emoji who is soaring through the air, just like Towel when his mind rebels at stagnation. Oh, ladies and gentlemen, what a glorious day to be a towel. I got the opportunity to see Peonian Rose send me a super towel emoji. Now, I also want to say Mandy Strong. I love it. Oh, God bless you, Mandy Strong. Honorary super towel spouse. Your early day emoji made Towel's day. Oh, there's no doubt about that. And I also just gave you a nice heart on your funny comment when you were like, please, we need to stop the man who is rubbing on his nipple. And I understand that was traumatizing. Mike Crawford is a strange man. Harvard Yard, my dear friend, Harvard Yard, special hugs to you, my friend. I just want to say that I want to give you a super towel hug, my dear good friend. Before the verdict madness starts, says Harvard Yard, thank you, Grant and Towel Universe, for the coverage, community, and education during the trial. Justice for John. Grant, please explain the importance of jury instruction in Grant's style. It's very important. Big love and hugs to all. And you know we did that. We're going to talk more about the jury instructions and charges tomorrow. We're going to give a big super towel hug to Harvard Yard. Emmy Horton, I love that emoji. I didn't see it come in earlier. God bless you, friend. I love a thumbs up emoji. Thumbs up to you. And Eva themselves, the super towel emoji, starting the day. Oh, my word, ladies and gentlemen. That was glorious. I am so glad I got to see that. And you know, towel friends, you know that there's one thing I'm going to say. Because we end the stream the same way every time. I know a lot of you wait to go to bed until I end the stream. But there's a way we end this stream every single time. If you've learned something today, if you've benefited from this, if you're going to go lay your head down, even on a day where it was bittersweet. We spent time together, but it was a difficult verdict to take in. You know what, ladies and gentlemen? This is what I want you to remember. Look for reasons to pay it forward. If you were educated, informed, or entertained today, or had a good time in towel chat, made a friend, made a connection, look for reasons to pay it forward. Look for reasons to do small acts of service. Look for reasons to donate to homeless veterans or an animal shelter run by veterans. Look for reasons to smile at someone on the street. Call a family member or a friend you haven't talked to in a while. Look for reasons to be a helper. Donate 200 tomato plants and have them designated honorary towels like Francis Frutrell did once. Look for reasons to make the world a brighter, better place, and look for reasons to help shift the socio-political dynamic away from preserving, expanding, and demonstrating our power to one centered on expanding, preserving, and demonstrating our ability to engage in small acts of service rooted in unconditional love. We can do it, ladies and gentlemen. We can bring about a digital epoch defined by Aquarius the water bearer waving a towel, centered on an ethos of unconditional love and compassion. That's what makes this stream so special. That's what makes you so special, ladies and gentlemen. It's because you are you. It's because I froze your towel comments. I feel absolutely terrible. Mind you, I froze the towel comment on Eva saying, Grant, you are special. Hold on, what did you say, Mandy Strong? Yes, you need to listen to both closings if you want to. But yes, I really appreciate every single one of you who chatted. And I'm sorry I missed so many of your comments. They were all scrolling, and I forgot to unfreeze the towel chat. So sorry about that. I'm scrolling them by now. But yes, look for reasons to be a helper, friends. You know how much that means to Little Towel in a world defined by despair. Get some rest. Get ready for closings. Special 7 a.m. start time tomorrow. You know Towel loves you. Every single one of you. We couldn't do all of our username reads, but you know I see every single one of you. People ask for us to do an early night, so I'm going to read usernames tomorrow, though. You know I'm going to. All right, Towel Friends on X, we say goodbye to you first. Thank you for being with us today. You get a few extra minutes at the beginning of the day, so that means at the end of the day, I spend a few extra minutes with the Towel Friends on YouTube. God bless you. Be well, be safe. I'll see you at 7 a.m., youtube.com/@GrantsmithEllis. I'm looking forward to it. Get some rest. Big day tomorrow. Jury deliberations in the John O'Keefe and Karen Reed retrial begin. And to all, what was the final number, ladies and gentlemen? To all 55,000 of you over on the Towel X, God bless and good night. Towel Friends on the YouTube, you know you get a few extra minutes. Today was a tough day. It was tough, it was hard, it was difficult. We made it through. Bittersweet moments. This is what the justice system is all about. It's about the moments where you respect the system, even when you don't come out, even when a case doesn't come out how you think it should, or how folks feel that justice demands. That is what the system is all about. We respect it. We wake up again tomorrow. We pursue justice again. There are more felony cases coming for Aidan Kearney. 2 of the felony cases involve Lindsey Gaetani as the named victim. Justice for Lindsey will be at hand, ladies and gentlemen. She worked hard. She deserves it. Send Lindsey Gaetani your love, compassion, and prayers tonight. She deserves them. Towel Stream, you kept me going. You kept me strong. You kept me going, invigorated the whole day. Get some rest. God bless each and every one of you for what you do for each other, for what you do for the vulnerable, for what you do for Little Towel, for what you do for the wider world. It means so much to me. It's what allows me to do this. It inspires me. I have nearly indefatigable energy, as some of you say, as long as I'm sitting down. Indefatigable energy some days, ladies and gentlemen, despite my collapsing physical health. And Towel is grateful that you inspire me to do that. I'm going to need a lot of time to recover after this trial. I gave it my all. I left everything on the field. I know a lot of you did as well. It was for justice for John. It was for justice for Lindsey. It was to free Chloe Dog. And it was to support Hank Brennan and the O'Keefe family, ladies and gentlemen. And I don't regret a single moment of it. We met friends. We cried. We laughed. We loved. We grew as people. And that's what life is all about. God bless every single one of you, whether you're in Ireland about to go to bed like JVA or otherwise. I know you're nervous. I know there's energy. Do your breathing, folks. Count backwards from 5. Settle your head into your fluffy pillow, knowing that you are loved, Towel Friends. You're loved by Little Towel. You're loved by your fellow Towel Friends here. Towelettes, soap dispensers, hemp towels, flannels, paper towels, electric hand dryers, beach towels, microfiber towels, washcloths or otherwise. Towel loves you. God bless. I know it's nerve-wracking. We'll be together at 7 a.m. tomorrow. It's a big day. Get some rest. God bless you, friends. Be safe. Be well until tomorrow. Towel loves each and every one of you, and you know it. Good night, friends. I'll see you tomorrow morning. Get some rest. That is a